Hello, Towel friends over on Towel YouTube. I'm a little towel. It's great to see you. I'm so glad to have you with me this morning. Have you ever considered the fact that you are a towel, I am a towel, and we are going to roll the intro.
Hold on. Wait a second. That's it.
That's it?
Yeah, that's the melody to Funky Town.
You heard the towel, ladies and gentlemen. That's it. That's the melody to Funky Town. Good morning. My name is Grant Smith Ellis. How are you doing? I'm a little towel. We got a lot going on today, little towels. We have Donna Adelson jury selection beginning in just a few minutes. We are not going to watch the judge repeat the exact same thing the judge said yesterday because at 9:30 a.m., little towels, and remember jury selection goes in the Donna Adelson and Dan Markle case until Thursday when the second round will begin. Opening arguments will then start Monday. Ladies and gentlemen, in that case, of course, there are multiple jurors in panel. We're hearing a lot of jurors have been provisionally selected after the first round of individual voir dire with deer, which is not broadcast audio or visually. And as such, little towels, we should be ready to start that trial on Friday. The big news today, though, ladies and gentlemen, at 9:30 a.m., just 1 hour and 12 minutes from now, Towel Mom Wendy Murphy will be joining us for a special live towel interview. Good morning, Rhonda and Anthony and Elijah and Vicky and Holistic Psychology and Amber. So many of you towel friends. It's great to see you. So in just 1 hour and 21 minutes or so, we will be welcoming the wonderful Wendy Murphy, Towel Mom, to the show. Now, if you have never seen Towel Mom do her Towel Mom thing before, let me just tell you, she is a Towel Mom. Now, you might be saying to yourself, sir, do you call her Towel Mom just to troll her because she doesn't exactly love that you call her Towel Mom? Absolutely, ladies and gentlemen. I think that is one of the most funny things to do in the entire world. So let us watch an interview with wonderful Towel Mom to just give you a sense of how good Towel Mom is, and then we're going to read her brief because we're going to talk about the Equal Rights Amendment today and the Due Process Clause of the 14th Amendment and the way in which strict versus intermediate versus rational basis, and technically rational basis with a bite scrutiny, apply in the context of disparate treatment for men and women under the Equal Rights Amendment or the absence of the Equal Rights Amendment. It is a wonderfully enthralling story. I'm sure we're going to talk about all sorts of wonderful things like the Woman's Party and the way in which the 19th or the 20th Amendment or the women's right to vote translated into a delayed battle over the Equal Rights Amendment. Why? Because the 14th Amendment, when it was passed after the Civil War, was part of a package of amendments, the 13th, 14th, and 15th Amendment to the United States Constitution, that mostly protected men. We were still in the era of coverture back then. And so in turn, little towels, we're going to learn today how one part of making up for the 14th Amendment only applying to men was the right for women to vote in the early 1920s, late 19-teens. And then the second part, which is still much like a dream deferred, withering like a raisin in the sun, has yet to come to fruition, which is the equal application of the Due Process and Equal Protection Clause, well, more so the Due Process Clause, pursuant to strict scrutiny analysis, which is only afforded if women have equal rights. All right? Now, it's technically women and men having equal rights in the context of gender-based discrimination by states. So let's think about things like, what if a state wanted to have a law that allowed women to drink beer at age 18 and men to drink beer at age 18, but from age 18 to 21, women could only drink 3.7% alcohol by volume beer and men could drink 5.4% alcohol by volume beer. The question thus presented to the court, and I'm not a lawyer, this is not legal advice, would be what degree of state interest is needed to justify the disparate treatment there. Now, in 1970-something, there was the famous beer case out of Wisconsin where this was decided. And the court said that the state needs more than, quote unquote, a rational basis for this disparate treatment. But the court also said the state doesn't need what's called strict scrutiny. It doesn't need to pass strict scrutiny, which would be a quote unquote compelling state interest in order to justify this disparate treatment. What it really needs is an intermediate level of scrutiny that the court will apply. And in the case of the beer case, it was found that that was an unconstitutional discrimination against women. All right. Now, fast forward to the 1990s, and you get an 8-1 decision called VMI, Virginia Military Institute. All these cases are going to come up today. Mom loves to talk about them. Now, in VMI, the question was whether the Virginia Military Institute could admit women but not men, as long as the state of Virginia afforded a separate but equal institution of learning for women. The answer was no. 8-1 decision. You could clearly tell that was I think it was Chief Justice Rehnquist at the time, trying to fashion a modern Cooper v. Aaron, but he couldn't really pull it off because I think Justice Thomas just would not go along with it, which kind of makes sense. In any event, so we have this intermediate level of scrutiny that's applied to state decisions about whether or not laws can, or court decisions that analyze whether state laws can discriminate on the basis of sex. Okay, now in some cases, discrimination on the basis of sex is okay. You can have a locker room for women, you can have a locker room for men. That comes up a lot these days. That is a compelling state interest, therefore it survives any level of review and you can have separate spaces. That does not mean that a law that treats men and women differently in other contexts is legal as well, because the analysis of whether there's a intermediate level of scrutiny reached to justify the discriminatory state action is a case-by-case analysis. And Mom wants to argue that intermediate scrutiny doesn't provide enough protection to the people most impacted by gender-based discrimination, which are women, gender and sex-based discrimination, which are women, and in turn, in order to protect women from state laws that would treat them differently and disproportionately impact them as a class, there needs to be a sort of higher level of review under strict scrutiny, which would only come about via the Equal Rights Amendment, in order to compel states to act in a way that is non-discriminatory, or at the very least, to compel them to only act in that discriminatory way when there's a compelling state interest, which is a hard standard to meet, thus narrowing the scope of permissible discriminatory treatment by states. Are we all on the same page? Excellent job. So yes, in order to understand Towel Mom, we have to understand all that context. Now, let me look. Before we read Towel Mom's brief to the federal first district, let's listen to Mom on Real Clear Politics talking about this. Why? Because there are very few people who can be like, let's watch my mom do an interview on Real Clear Politics before we interview her later. And I'm one of those people, so I'm going to do it because I think that's freaking hilarious. You don't understand. I'm a little towel. All right, so give me 1 sec. I'm going to bring this interview up. And remember, jury selection in the Adelson case is starting again, but we're not going to watch the exact same thing as yesterday. We'll eventually watch the live look into the court. But let's watch Towel Mom, because this interview is coming up at 9:30, little towels. 9:30, and this is Towel Mom's interview from Real Clear Politics, all right? Towel Mom's interview from Real Clear Politics about what we're going to talk about today with Towel Mom. And I heard Towel Mom might take some questions at the end of the interview, so get ready in chat. And I'm so grateful to have all of you with me today. God bless each and every one of you. All right, little towels. That's my mom. She's Towel Mom. See you right there? That's Towel Mom. And we're going to interview her today and ask interesting questions about women's rights, because that is what Towel Mom is very interested in, and that's what I want to ask her questions about. All right, little towels, let's do it.
So, Wendy, I wanted to talk to you today because you are involved in this very interesting women's rights case. It involves registering for the military draft. Tell us about what the case is about and why is this important? There hasn't been an actual draft in operation since 1973.
Yeah, so that might make it seem irrelevant, but I'll explain to you why it's highly relevant and, in my view, probably the most important women's rights case in the last 50 years, maybe longer. I filed a federal lawsuit in Massachusetts federal court recently to challenge a federal law that mandates men register for the draft. It's called selective service. even though we don't have one, it doesn't matter. You still have to register. And that law has been in place since the early 1900s. But it forbids women to register. And you might wonder why a women's rights lawyer would want women to register, because aren't women generally opposed to the military, opposed to war, opposed to the draft? The answer is it doesn't matter. It doesn't matter how you feel about war or the military. What matters is, as a woman, you should be treated equally under all laws. And this happens to be a very blatant example of how discriminatory the law can be. Not all laws are as obvious as this one, but this one literally says men must, women can't.
Yeah.
If you are a woman and you tried to register, you'd go to the button where it asks you what your sex is. And when you click on female, you get an error message. So it's an important case in the sense that it's the most vivid example of the kind of discrimination women are still subject to. And as we talked about last time I was on this show, women in America have never had basic legal equality. We still don't. Under the Constitution, women are subject to unequal treatment by all branches of the government, all laws, all government official treatment. I mean, everything you could think of, women are subject to unequal treatment. That doesn't mean they're always treated unequally. The point is that they can be. And people like me have been trying to fix that since the dawn of our country. And here's a good example of not only what the problem looks like, but a good device by which lawyers like me can go into court and say, here's another opportunity for you, judge, to close the gap, give women equality, and to do so by fixing this federal law, require women to register for the draft. Because frankly, if women want full legal equality, and we do, then we should accept that we've got to register for the draft alongside men. And
that's one of the things that I thought was so interesting about this when you told me about it, is I sort of couldn't believe it. It was like, wait a minute, you mean I knew you had to register for the draft. I knew that was still required. I didn't realize that it was only men, and also that if a woman goes and tries to fill out the form online, it rejects her. It seems to me that, I guess my question is, what is the argument against having women register for selective service? Because, as you point out, I mean, they're serving in the combat roles now. They're throughout the military. We have a recruitment problem as it is. We know that. And if something really happened and we needed to draft people, it would seem to me you'd want to be able to draft women, men, all able-bodied Americans.
That's right.
You'd want access to them.
Able-bodied and capable ought to trump sex.
Yeah, right.
So I think we all can agree that's logical. And several countries around the world do equally enlist and draft and conscript men and women, including Norway, Sweden, Israel. I mean, these are not crazy countries that are all, men's rights. It's really the basic human right to serve your country, that women have that feeling that they are equally worthy, that's reflected in this discriminatory law. Women want to feel equally valuable. Well, the most important aspect of this case really is that when the Supreme Court ruled on whether this law is constitutional, which was back in the early 80s, it said it's okay to exclude women from the draft because they are not allowed to fight in combat on the front lines. And that was true at that time. Well, about 10 years ago, that the last vestige of that policy and or legal requirement was erased. Women can now serve in combat in all the ways you can imagine what that means: dying in combat, fighting on the front lines, flying planes and steering the big ships. They can do everything. And because that changed 10 years ago, there has been an argument ever since. Well, now that women are on the front lines, what do we think about this law that forbids them to register for the draft? Isn't the Supreme Court decision now null and void? Because the only basis for that ruling, it's called Rosker versus Georgia, the only basis for the Supreme Court's justification in Rosker that said it's okay constitutionally to reject women was that they were not combat ready because they couldn't fight on the front lines, according to federal law and policy. That's gone now. So there have been several lawsuits filed over the past 10 years to try to get the Supreme Court to overturn Rosker.
I wanted to ask you about that because one of those cases, at least, was a man. Right?
All of them have been men.
All have been men. Okay, fair enough. But you do have someone, Jacqueline Fenora. I don't know if I'm saying her name correct, but you have you have a woman who, like you say, who tried to register, and she's the complainant in this case. But what happened with those other cases where was a man who was, I guess, complaining that why should he have to register for the draft if women didn't have to? Which is actually a legitimate question, I guess.
It is a legitimate question. It's just a little whiny because is a man really suffering by a law that requires him to register just because a woman can't? It's kind of childish, I think. But having said that, the law does allow men to mount challenges, and that is partly why several of the recent lawsuits have been men and men's rights groups going into court and saying, I'm not registering unless you make women register. And they're making one of the same arguments I'm making, which is that the basis for the Roscoe ruling is gone now. Women are on the front lines. But the real reason I filed this case at this moment in time, because again, as you said, there's no draft. We don't apparently have a war. There's no real reason to make this a hot issue. But there is a case pending in the California federal court system called Valame. It was filed as Valame versus Biden. A man named Valame sued the federal government under this law for the same reason we just discussed. He thinks it's discriminatory against him, a man, that he, when he turned 18, should register, but women don't have to. And his case, according to all of my sources at very high levels, is headed to the United States Supreme Court. So why is this important to women? Because number one, I'll be damned if a man is going to be the voice for women on such an important constitutional question. It ought to be women who speak for women when the country's highest court makes such an important decision. But also, this guy, Valame, made several kinds of claims. He filed a claim under the Equal Rights Amendment, for example. Well, that's good because he's arguing that the Equal Rights Amendment is valid, which I agree with, but he did not make good arguments. I want to make the best arguments for women. He's a man making weak arguments for men under the Equal Rights Amendment. And then the worst thing that he did, Andrew, and this is also true in all of the men's rights cases that have been filed, they're saying make women register for the draft, but don't give them full equality. Right. Now, think about that. The whole reason women have been justifiably subjugated in this country for centuries has been tied to this idea that they're not worthy because they don't die for their country the way men do. They don't serve their country the way men do. They're not the same value as men. Well, now we know women are bleeding to death alongside men on the front lines, and we, especially my case, are making the argument that if you now want us to register for the draft, you now expect us to die on the front line of battle, you damn well better give us full equality, period, as a quid pro quo. You do not ask someone to die and bleed to death for their country and make them bleed to death as a second-class citizen. That is insanity, that is unconscionable, that is irrational, and we want to make that argument. And I filed my lawsuit because none of the men's rights cases made that argument. They said, make women register for the draft and keep them subjugated as second-class citizens. No.
Okay, so you're listening to Real Clear Politics on Sirius XM. I'm Andrew Walworth. I'm here with Wendy Murphy. She's a lawyer. She is a law professor at New England Law Boston, and she's a columnist at the Boston Herald. So, Wendy, you mentioned the ERA. How does this relate to that? And also, how does it relate, or does it relate to the Scrimeti case, which we talked about before, which I noticed in your brief you make reference to it. So tie those together for me. What Scrimeti, ERA, and this latest effort.
Yeah, and hopefully I can make it simple because it's a little complicated.
Yeah, I'm sorry, but we only have like a minute left for this, but it's fascinating stuff.
Well, the Scrimeti case is a Supreme Court decision that's coming down in June. We're expecting it in June. And it is going to make the decision, not about the ERA per se, but about whether sex is mutable or immutable. Why does that matter? Because if the court says that sex is mutable, which would be a reversal from what it said 30 years ago, that of course sex is determined at birth, immutable, you cannot change it. And because it's immutable, categories with immutability deserve the highest levels of legal equality.
Right. So we talked about this before, but this is basically this is an argument made by that transgender should be treated as women under the law. And the problem with that, from your point of view, is that means that sex can change or is mutable, as you say, and that undercuts the whole notion of women being treated as a special, not a special class, but as that sort of highest class of when you look at the discrimination, right?
If your characteristic is immutable, you're entitled to the highest degree of legal equality. If you're mutable, you're not. Right. The trans people that filed the Scrimetti lawsuit said to the Supreme Court, we fall under the word sex, which has always applied to women. And because we're under the word sex and we are mutable,
right,
we are asking for second-class protections under the Constitution. Women were screaming at the time, how dare you, trans people, use the word sex and ask for second-class treatment of women under the word. No. So my case that I just filed, although you would think that the military draft isn't necessarily related to transgender issues, it absolutely is. The Scrimetti case, in combination with the Valame case, are going to give the Supreme Court of the United States an opportunity to rule on three critical questions for women. Is the ERA valid? Regardless of whether the ERA is valid, are women now required to register for the draft? And whether or not they are women finally, because they're dying on the front lines of battle for their country, are they finally entitled to constitutional equality under the 14th and 5th Amendments, even if the ERA is not valid? Those are the most important women's rights issues to be decided by the United States Supreme Court in many, many, many decades in this country. And until I filed my case, the only people that were going to the Supreme Court making these arguments were trans people and men. My case is going to put a stop to that and insist that women get a front seat and primary voice on these vital issues.
Wow.
Well, I think you see where I get it from.
Fascinating stuff. Wendy, it's always good to have you on the show. Enjoy our conversation so much.
All right, folks. My name is Grant Smith Ellis. So what we're going to do is, in the preparation for the Big Towel Mom interview at 9:30, we're going to do two things. One, we're going to read her brief. I have it ready to be read out for you. I'm not reading 31 pages. I need to save my voice for interviewing Towel Mom. The other thing is, if you have questions for Wendy Murphy, Towel Mom, she'll be joining us live at 9:30. Just 1 hour from now, leave them in the chat. I'll try to note as many as I can. And I'll try to ask some of the questions at the end of the interview. No promises. I think a lot of people are going to want to hear what Towel Mom has to say. No promises we'll get to cover topics outside of the ERA, but, I might have some questions. All right, here we go. What do we have going on? Oh, yes, Towel Mom's brief. So first of all, let me get the coverage of Donna Adelson's jury selection up for you in the top right. Of course. Good morning, Shelby. Welcome to the Towel Chat. We are honored to have you with us. My name is Grant Smith Ellis, and I'm just going to put up for you in the top right window, you're going to see the Donna Adelson jury selection. As you can see, there isn't really much going on right now. You're going to see it pop up on your screen in 1 second. There isn't exactly really much going on, so what we're going to do is read Towel Mom's brief, okay? So give me 1 second. I am a little towel. It's great to have you with me. Thank you so much for joining us on Towel Stream today. Take a look at this very special Towel Mom brief we're going to read, because this is what we're going to interview Towel Mom about. Wendy Murphy will be joining us at 9:30 a.m. Now, of course, we will be keeping an eye on Donna Adelson jury selection heading into, of course, the the Friday beginning of evidence in that case. All right. So I'm going to bring up the Towel Mom brief, and we are going to, it's a federal court brief. I have it ready to be read out for us. Let me just double check everything is all set. All right. That's Towel Mom's brief. Okay. Lots of court cases. We're going to have to skip through a lot of those. Oh, I wonder if I can just delete them. Yeah. All right. That's what I'm going to have to do. Hold on 1 second. I got to delete the cases, because otherwise you're going to end up listening to it just read a bunch of cases, and I don't really want it to do that. All right, so I got a plan. I am a towel, and I have a plan. All right. So I got Talmom's brief, and let me just delete all of the citations. So it's not that I don't want to read the table of authorities. It's just if we listen to it read 40 cases, that's going to take up gratuitous time, and we don't really need to listen to it read all of those cases. Okay? We just don't need to do that. All right? So it's like 5 pages of citations when you write a federal brief. Mom's a really good lawyer, so I'm deleting them all. I'm not saying that I don't want us to learn them. She cites the Federalist Papers. Of course she does. Because she's Talmom. Oh my goodness, there's like 40 pages of citations. Oh my goodness. All right, here we go. All right, so let me just save that. What I have to do is I can get it to read it in a voice, like a text voice. But in order to do that, I have to make the text file, like I just tell the bot to ignore certain things. I have to make the text file readable. All right, so I got this ready for us. I got that ready for us. I got everything ready, little towels. Let me bring it up on your towel screen right now. All right, filing for selective service memo. Here it is. There's Talmom's brief. Talmom filed it on PESA. There it is, as filed with the court. All right, you see it right up in the top there. All righty, little towels. Let us read it. First time I've ever read Talmom's brief. I've read them, but I've never read one on stream, so this is going to be exciting. All right, so this is what is going to happen. You're going to hear the brief get read out. We're going to skip through the citations, and then we're going to interview Talmom in 1 hour. All right, everybody ready? I'm ready. All right, it's going to start reading. Enjoy the voice. It's somewhat British. Thank you.
Case 1:25 CV 10806WGY. Document 11. File 071725. Page 1 of 31. In the United States District Court. For the District of Massachusetts. Equal means equal. Heroica Foundation. Jacqueline Fenor. Individually and on behalf of others similarly situated. Plaintiffs. Donald J. Trump, in his official capacity as President of the United States, Craig Brown, in his official capacity as Acting Director of the Selective Service System, Selective Service System. Defendants. ____. Civil action number 1:25 CV 10806. Plaintiff's opposition to defendant's motion to dismiss. Wendy Murphy. Women's and Children's Advocacy Project. New England Law, Boston. 154 Stewart Street. Boston, MA 02116. 617-422-7410. MA BBO #550455. Murphy at nesa.edu. Case 1:25 CV 10806WGY. Document 11. File 071725. Page 2 of 31. Table of Contents. Introduction 1. Legal Standard 1. Facts 1. Argument 2. I. The era is the 28th Amendment. 2. A. The deadline is per se invalid. 3. B. The deadline is invalid because it is in the preamble. 5. 2. States cannot rescind ratifications. 8. 3. Because the era is valid, plaintiffs are entitled to strict scrutiny review. 10. 4. Even if the era is not valid, plaintiffs are entitled to strict scrutiny review under the Fifth Amendment. 12. V. The MSSA is unconstitutional under strict scrutiny. 14. 6. Plaintiffs have standing. 16. A. Discriminatory exclusion. 15. B. Stigma and stereotype. 16. C. Denial of equal opportunity to participate in civic life. 17. D. Equal means equal and Heroica Foundation have standing. 19. Conclusion. 20. 6. Case 1:25 CV 10806WGY. Document 11. File 071725. Case 1:25 CV 10806WGY. Document 11. File 071725. X. Case 1:25 CV 10806WGY. Document 11. File 071725. Page 11 of 31. Introduction. This is a constitutional challenge to the Military Selective Service Act, MSSA, 50. USC 3801 et seq, which requires male citizens aged 18 through 25 to register for the draft, but forbids females to do the same. Plaintiffs assert claims under the Equal Rights Amendment, ERA, and the Fifth Amendment. Defendants have filed a motion to dismiss under Rules 12b(1) and 12b(6). It should be denied. Legal standards. Under Rule 12b(1), the court must accept as true all well-pleaded fact, s, and indulge all reasonable inferences in the plaintiff's favor. Karen v. Tightflex Corporation, 770 F.3d 978, 981, 1st. Sir. 2014, general allegations of injury suffice as it is presumed that they embrace specific facts necessary to support the claim. Worth v. Selden, 422 U.S. 490, 508, 1975. At the motion to dismiss stage, plaintiffs need not set forth evidence that would be required at the summary judgment stage. Lujan v. Defenders of Wildlife, 504 U.S. 555, 561, 1992. Under Rule 12b(6), allegations need only be plausible to support a reasonable inference that the defendant is liable. Garcia Catalan v. U.S., 734 F.3d 100, 103, 1st Sir 2013. The court must accept as true all well-pleaded facts, analyze them in a light most hospitable to the plaintiff, and draw all reasonable inferences for the plaintiff. U.S. ex rel. Hutchison v. Blackstone Med. Inc., 647 F.3d 377, 383, 1st Sir 2011. There need only be more than a sheer possibility that a defendant has acted unlawfully. Ashcroft v. Iqbal, 556 U.S. 662, 678, 2009. Facts. On the 25th of March, 2025, plaintiff Jacqueline Fanor, a female between the ages of 18 and 25, attempted to register for selective service through its online portal. Her registration was rejected solely because she is female. Later that same month, two members of plaintiff equal means equal. 1. Case 1:25 CV 10806 WGY. Document 11. File 071725. Page 12 of 31. EME, females between the ages 18 and 25, also attempted to register for selective service. Their registrations were rejected solely because they are female. Commander PP.3-4. Argument. I. The ERA is the 28th Amendment. When an amendment is proposed by 2/3 of Congress and ratified by the legislatures of 3/4 of the several states, it shall be valid to all intents and purposes, as part of this Constitution, U.S. Const. Art. V. Dillon v. Gloss, 256 U.S. 368, 376, 1921. The ERA was proposed in 1972 and ratified by the last necessary state on the 27th of January, 2020. Rankin, S., with Virginia's ratification, ERA fight advances, Associated Press, the 27th of January, 2020. Therefore, though ERA is now the 28th Amendment to the U.S. Constitution, many scholars, the American Bar Association, government officials, and even President Biden agree that because the conditions of Article V have been satisfied, the ERA is valid. See for example, H.J. Res. 25, the 31st of January, 2023, dozens of Congresspeople submit joint resolution declaring the ERA valid. Kinnaird, M. Biden says the Equal Rights Amendment is the law of the land. Associated Press, APnews.com, the 17th of January, 2025, Temple, S. ERA is the law, says Arbar. Democrats Abroad, the 8th of August, 2024. Senator Kirsten Gillibrand agrees, Gillibrand, K. Press. Release, statement on President Biden declaring the ERA the law of the land, the 17th of January, 2025. As do constitutional law professors Lawrence Tribe and Kathleen Sullivan, the Equal Rights Amendment at long last, the contrarian, the 17th of January, 2025.1. 1. Defendants argue that these government officials are merely expressing beliefs, and that beliefs cannot override binding Supreme Court precedent D.Mem.17-18, citing Dillon v. Gloss, 256 U.S. 368, 376 1921, and Coleman v. Miller, 307 U.S. 433, 452, 1939. Fair enough, but as discussed at length herein, Dillon and Coleman are not binding precedent. See arguments 1a and 1b. Moreover, statements of government officials and scholars should not be denigrated as mere beliefs, since they participate directly in the development of laws and judges routinely rely on them to determine doctrinal contours. In a healthy democracy, such opinions should bear on how 2. Case 1:25 CV 10806 WGY. A. Document 11. File 071725. Page 13 of 31. The deadline is per se invalid. Defendants correctly note that Congress burdened the states with a ratification deadline of 7 years, later extended to 10, and that the ERA was ratified long after it expired, but the ERA is valid nonetheless because Article V nowhere authorizes Congress to impose deadlines. In Dillon v. Gloss, 256 U.S. 368, 376 1921, the Supreme Court said that Article V implies congressional authority to impose deadlines, but this should be disregarded as dictum because it was not necessary to the court's adjudication of the issues. 2. Moreover, Dillon is not good law as it is premised on the notion that states must ratify amendments contemporaneously with congressional proposal to ensure national consensus. 3. ID. At 375. This arcane view has not. Courts view the strength of legal arguments. For a list of influential groups that agree the ERA is now valid, see New York City Bar Association, statement calling for the publication and certification of the Equal Rights Amendment, the 24th of December, 2024, notes 1, 3, 5. 2. Language in Dillon allowing deadlines was described as a holding in Coleman, ID, at 452, but dictum cannot be converted to a holding by declaration, and the holding language in Coleman was itself dictum because the issue of deadlines was not before the court. Coleman involved whether the Kansas legislature could ratify an amendment with no deadline after first voting against it, and whether it could do so 13 years after congressional proposal. Those questions have nothing to do with whether Congress may set deadlines. On the timeliness of ratifications, Coleman said, in a plurality ruling from a highly divided court, only that Congress has authority to determine the reasonableness of the passage of time between proposal and ratification if an amendment has no deadline. ID at 452 to 54. That is obviously not the case here because the ERA has a deadline, albeit an invalid one. Defendants also argue that Coleman stands for the proposition that this case raises non-justiciable political questions. Again, Coleman is inapt as it did not involve any of the Article V questions presented here. Indeed, as defendants concede in Section 2 of their memorandum, several courts have adjudicated the Article V issues raised in this case, including the validity of the ERA and its deadline, D.Mem.16-17, and whether the states may rescind. D.Mem.5. None of these courts ruled that the issues were non-justiciable political questions. 3. Contemporaneity does not ensure national consensus. The 18th Amendment was ratified quickly, but did not reflect consensus as it was repealed a few years later. And although it took 48 years to ratify the ERA, an arguably non-contemporaneous amount of time, national polling in 2018 demonstrated clear consensus in support of the ERA. Suffolk University /USA Today issues poll. October 2018, 75% were more likely to vote for a candidate that supports the ERA. 3. Case 1:25 CV 10806 WGY. Document 11. File 071725. Page 14 of 31. Withstood the test of time, which was made obvious in 1992 when the archivist published the 27th Amendment 4 and Congress voted to validate it 5s con. Res. 12102 ND Congress, 1991-92, H. Con. Res. 12102 ND Congress, 1991-92, some 203 years after its proposal. Government officials accepted the 27th Amendment as valid despite the lack of contemporaneity and a Supreme Court ruling decades earlier that said it was already too old, in 1921, to ratify. ID, at 375. Either Dillon is no longer good law, or the 27th Amendment is not part of the Constitution. 6. More importantly, the era's deadline is invalid because it disrupts the balance of power between Congress and the states. The framers wrote Article V the way they did because they were concerned that Congress would enact laws contrary to Article V and take power away from the states, hence, the people, and shift it to Congress. This was of utmost concern to the framers. Kalfas, M. Why time limits on the ratification of constitutional amendments violate Article V. 66 UKL Rev 437, 45253, 1999. Indeed, the 10th Amendment was adopted to protect the states from having their powers diminished by Congress. Natel League of Cities v. User E. 426 U.S. 833, 843 1976, 10th Amendment declares a constitutional policy that the Congress may not exercise power in a fashion that impairs the state's integrity or their ability to function effectively. 4. Notably, the archivist readily published the 27th Amendment on the 7th of May, 1992, after the last state ratified it, before the Office of Legal Counsel, OLC, advised him that the effective date of the amendment is the date on which it was ratified by the 38th state. Opinions of the Office of Legal Counsel of the Deputy of Justice, Congressional Pay Amendment, 16 Op. OLC 85, the 13th of May, 1992. This stands in stark contrast to the OLC's letter forbidding publication of the era despite it being ratified by 38 states. Ratification of the Equal Rights Amendment, Memorandum for the General Counsel National Archives and Records Administration, Slip Op. the 6th of January, 2020. 5. Congress has no authority to disregard Supreme Court precedent, but that is what it did when it declared the 27th Amendment valid in 1992 despite Dillon's admonition in 1921 that it was already too old to ratify. 6. That the 27th Amendment was validated despite the passage of 203 years is reason enough to invalidate the era's deadline because it is an official declaration that deadlines do not matter. 4. Case 1:25 CV 10806 WGY. Document 11. File 071725. Page 15 of 31. In a federal system, see Strahan v. Cox, 127 F.3d 155, 167, 1st Sir 1997, while Congress may regulate the conduct of individuals, it may not generally regulate the conduct of the states. Only one federal appellate court has addressed the deadline's validity, but it resolved the case on procedural grounds, saying only in dictum that the deadline is valid because of Dillon. Illinois v. Ferriero, 60 F.4 th 704, 716, 719, D.C. Sir 2023, 7 as dictum, Ferriero is not binding on this court, nor is it persuasive authority because its dictum relies on Dillon's dictum. B. The deadline is invalid because it is in the preamble. Even if Congress may impose deadlines, the era's deadline is invalid because Congress placed it in the preamble rather than the text. 8 Article V authorizes Congress to do only two things: propose amendments and determine the mode of ratification. U.S. Const. Art. V. Any authority to place deadlines in preambles must come from one of these provisions. It cannot come from Congress' proposal power because the states only have authority to ratify proposed amendments and preambles are not part of amendments. C. X. Rill. Ashcroft v. Fulton, 642 SW2D 617, 619-20, Mo 1982, language in a preambulatory resolution proposing an amendment to the Missouri Constitution must be disregarded because it is not part of the amendment. See also, Equal Rights Amendment Extension, Hearings on H.J. Res. 134 before the 7. The District Court in Ferrero also ruled that the deadline was valid, but again, it was only dictum, because the case was dismissed for lack of standing. Virginia et al. V. Ferrero, same case, 1:20 CV 00242, Decedus. Doc. 117, 5 March 2021. Another district court ruled that the ERA is not valid, primarily because the archivist did not publish it, Valame v. Biden, No. 5:2023 CV 03018. ND Cal. Thus precluding its creation. Doc. 61, pp. 4-6. In support of this ruling, the Valame Court cited Elizabeth K. D. Stanton TRV Nerona, No. 22 CV 00245 MSM, DRI, another district court that similarly found the ERA to be invalid because it has not yet been published in the Constitution. Valame at pp. 4-5. Both courts misunderstand that publication is a ministerial act. That has no bearing on an amendment's validity. Dillon, at 376. 8. Dillon offers no guidance on this issue as the deadline there was in the text of the amendment. 5. Case 1:25 CV 10806 WGY. Document 11. File 071725. Page 16 of 31. Subcom. On Civilian and Const. Rights of the HCOM. On the Judiciary, 95th Call. 57, 1978. States ratify the text of the amendment and not the preliminary language of the resolution. Congress itself raised concerns about adding substantive content to preambles when it was suggested that a deadline be added to the preamble of the 20th Amendment, with members saying it would be of no avail as it would not be part of the proposed constitutional amendment. 75. Call. Reg. 3856, 1932. Congress thus placed deadlines in the text of the next three amendments. Nor can such power be derived from Congress authority to determine the mode of ratification because selecting the mode entails choosing whether the states ratify by convention or legislative act, and placing a deadline in a preamble has nothing to do with either. Indeed, Congress determining the mode is a procedural act that facilitates the states' Article V powers, while imposing a deadline I on the states is a substantive act that restricts them. Poe v. Boatsleys, 352 F. 3D 479, 1st Sir 2003, limitation period is substantive when integral to the right in controversy. See Kalfas, Time Limits, Supra, at 464, Dellinger, W., The Legitimacy of Constitutional Change. Rethinking the Amendment Process, 97 Harv. Elrim 386, 40809, 1983. In similar circumstances, courts have not enforced preambles because they have, v.e., never been regarded as the source of any substantive power conferred. Jacobson v. Massachusetts, 197 U.S. 11, 22. 1905, see District of Columbia v. Heller, 554 U.S. 570, 578 2008, prefatory clause cannot limit or expand the scope of the operative clause. 9. In 2020, attorneys general from nearly half the states agreed that the language in the ERA's preamble is not binding on the states. Letter from state attorneys general to U.S. Congress. The 22nd of February, 2020, other than including a deadline in the ERA's text, Congress relegated a 7-year deadline to the joint resolution that proposed the ERA. No court has found that such an external limit is at all binding on the states. 6. Case 1:25 CV 10806 WGY. Document 11. File 071725. Page 17 of 31. If this court rules that Congress may impose extra-textual deadlines on the states, it will be condoning the idea that Congress has unilateral authority to amend the Constitution because it can impose short deadlines on amendments preferred by the states, to defeat them, and long deadlines or none at all on amendments they prefer, without ever affording the states an opportunity to approve or reject them. 10. This cannot be tolerated as the framers were clear that the states' amendatory powers should be equal to those of Congress. The Federalist No. 43. Alexander Hamilton, Article V equally enables the general and the states' governments, though Federalist No. 39, James Madison, the balance struck in Article V makes the amendment. Process neither wholly national nor wholly federal, the Federalist No. 21, Alexander Hamilton, strong national government could harm the autonomy of the states. This court should not imbue Congress with such authority because Congress' handling of deadlines has been arbitrary. No deadlines were in any amendments for the first 130 years. They appeared relatively recently with the 18th in 1917, and only a handful of times since, without consistency. The 19th did not have one at all, and when they were imposed, some were placed in the text, 18th, 20th, 21st, 22nd, while others were placed in the preamble. 23rd, 24th, 25th, 26th. Not until 1960 did Congress place a deadline in a preamble, claiming this would declutter the text. 10 Cong. Reg. 6628, 1955, .11 Then in 1978, Congress placed a deadline in the text and the preamble of a proposed amendment. 92 Stat. 3795, 1978. 10. Short deadlines can also cause states to ratify, as happened with the 18th Amendment. The point is not whether short or long deadlines cause certain results, it is that deadlines allow Congress to put pressure on the states in a way that undermines their constitutional powers under Article V. 11. If placing a deadline in a preamble were truly about decluttering, why would Congress clutter the era's text with language about delaying the effective date of the era for 2 years after ratification? Delaying the enforcement date does not restrict states' Article V rights, yet the states were able to vote on it because it was in the text. Imposing a deadline on ratification does restrict the states' Article V rights, yet they were unable to vote on it because it was in the preamble. 7. Case 1:25 CV 10806 WGY. Document 11. File 071725. Page 18 of 31. Importantly, the archivist issued a letter in 2012 stating that he was duty-bound to record ERA ratifications and would publish the ERA as soon as 38 states ratified it, regardless of the deadline. 12 people then advocated for more ERA ratifications, and states voted to ratify, because they believed the deadline posed no barrier. Nevada ratified in 2017, SJ Res. 2, 79th Leg. Illinois. In 2018, SJ Res. Const. Amend. 0004, 100th General Assem. And Virginia in 2020.13. If Congress may place deadlines in preambles, can they also say in a preamble, 2/3 of the states must approve this preamble? The obvious answer is no, because this would subvert Article V. The same is true for deadlines. If Congress wants the power to use preambles to restrict states' Article V rights, it must first give itself the authority to do so by changing Article V. 2. States cannot rescind ratifications. Several states purport to have rescinded their ERA ratifications, but those actions are legal nullities. 14 Because Article V does not permit rescissions and the Supreme Court has never recognized a purported rescission as valid. 15. 12. The archivist's letter was in response to a question from Congresswoman Carolyn Maloney about the legal status of the ERA. Congresswoman Maloney letter to the archivist, the 23rd of August. 2012. The archivist replied, once NARA receives at least 38 state ratifications of a proposed constitutional amendment, NARA publishes the amendment along with a certification of the ratifications and it becomes part of the Constitution. Archivist letter to Congresswoman Maloney. The 25th of October, 2012. 13. The archivist recorded these votes but later added, ratification actions occurred after Congress's deadline expired. National Archives and Records Administration, Equal Rights Amendment, List of State Ratification Actions, http URL. PDF/ERA List of State Ratification Actions 03242020.pdf. 14. In his 2012 letter explaining the legal status of the ERA, the archivist said, a later rescission of a state's ratification is not accepted as valid. See, N.12. 15. Rescissions were recognized as valid in Idaho v. Freeman, 529 F. Sup. 1107, 1150, D. Idaho. 1982, a case that was appealed to the Supreme Court but later vacated as moot. NOW, Inc. v. Idaho, 459 U.S. 809, 1982. 8. Case 1:25 CV 10806 WGY. Document 11. File 071725. Page 19 of 31. Other amendments have been validated despite purported rescissions. The 14th was adopted when 3/4, 28, of the states ratified it, even though New Jersey and Ohio had voted to rescind. 15 Stat. 706, 1868.16 Corn. Globe, 40th Corn, 2D Sess. 4266, 4295, 96, 1868. C. Coleman, 307 U.S. at 44849. Rescissions of the 15th and 19th were also not accepted as valid. Fischel, L.A., note, reversals in the federal constitutional amendment process, efficacy of state ratifications of the Equal Rights Amendment, 49 IND. LJ 147, 150, 1973. That Article V permits Congress to direct the states to ratify by convention rather than by legislative act proves that rescissions are not possible. The convention process is a unique, ad hoc event during which the states ratify through specially elected delegates who need not be members of the legislature. Their sole purpose is to decide whether to ratify an amendment. When the convention is done, it is adjourned. This process was included in Article V to allow for greater direct public participation, and to avoid the problem of entrenched political interests in state legislatures. Adelson, R., Amending the Constitution by Convention, a more complete view of the Founders' Plan, Independence Institute, 2010, at 6. Because conventions expire, rescissions are not possible, thus, all rescissions are invalid because the framers would not have permitted two modes of ratification but allowed for rescissions under only one. Rescissions are also invalid because amending the Constitution is not ordinary lawmaking, subject to shifting political winds. Hollingsworth v. Virginia, 3 U.S., 3 Doll. 378, 381, 1798. Amendment process is unconnected with the ordinary business of legislation, Hawke v. Smith. 16. The 14th Amendment was adopted on the 9th of July, 1868, when the 28th state ratified it. National Archives, Milestone Documents, 14th Amendment to the U.S. Constitution, Civil Rights, 1868. The 28 states included New Jersey and Ohio, but they rescinded on the 24th of March, 1868, and January 15, 1868, respectively. Either rescissions are not permitted, or the 14th Amendment was not ratified on the 9th of July, 1868. 9. Case 1:25 CV 10806 WGY. Document 11. File 071725. Page 20 of 31. 253 U.S. 221, 229 1920. Ratification is not an act of legislation. Amending the Constitution is a solemn process, which is why scholars emphasize that ratification is one-way ratchet, as this prevents chaos, preserves the integrity of Article V, and respects the balance of state and national powers. See Jameson, J., A Treatise on Constitutional Conventions, 629-33, 4th ed. Riverside Press 1887, Bernstein, R.B., The Sleep Awakes, The History and Legacy of the 27th Amendment, 61 Fordham.Rev. 497, 548, 1992, Dellinger, Constitutional Change, Supra, at 421-27, once an amendment is ratified, the state is committed. Otherwise, think of the Constitutional Chaos, Equal Rights Amendment Extension Hearings, Supra, testimony of Professor William Van Alstyne, noting that rescissions would be profoundly ill-advised constitutional policy. No state ought to consider an amendment to the Constitution under the misimpression that it may do it with some sort of celerity or spontaneity. That is an atrocious way to run a constitution. The policy that Ratification, when done, is done irrevocably, is terribly important to the integrity of the role of Congress and the states. See right, D, an atrocious way to run a constitution, the destabilizing effects of constitutional amendment rescissions. 59 Duquesne L. Rev. 12, 17, 2021.17. 3. Because the era is valid, plaintiffs are entitled to strict scrutiny review. Equal protection of the laws means ensuring that laws, policies, and programs of the government are enforced equally 18 and applied equally 19 on behalf of women. The era does this. 17. If the states may rescind ratifications, may Congress rescind proposals? 18. See Thurman v. City of Torrington, 595 F. Sup. 1521, 1527, Decon 1984, affording women inadequate police protection is subject to the Equal Protection Clause. 19. Rin v. U.S. 517 U.S. 806, 813 1996. Constitutional basis for objecting to discriminatory application of laws is the Equal Protection Clause. 10. Case 1:25 CV 10806 WGY. Document 11. File 071725. Page 21 of 31. By requiring that courts apply a strict scrutiny standard of judicial review. From T.O.V. Richardson, 411 U.S. 677, 691, 92, 1973, Powell, J., concurring, when the era is adopted, it will require courts to apply the strictest test of judicial scrutiny. 20 Joint Judiciary Committee. Report on the Equal Rights Amendment, Report Number 92 to 359, 92D Congress, Equal Rights for Men and Women, the 14th of July, 1971, 4p. U. Under the text of the era. J. Just as statutes classifying by race are subject to a very strict standard of equal protection scrutiny under the 14th Amendment, so too, classifying by sex would likewise be subject to a strict standard of scrutiny. Strict scrutiny is the only standard that affords women full equality because it requires classifications based on sex to serve a compelling government interest, be narrowly tailored to serve that interest, and use the least restrictive means to achieve the government's goal. Students for Fair Admissions v. Harvard, 600 U.S. 181, 206, 213, 230, 2023. Strict scrutiny requires a compelling government interest, narrow tailoring, and proof that there are no workable race-neutral alternatives. Without the era, women enjoy only intermediate scrutiny. 21 which requires only an important interest and a substantial relationship between that interest and the government's goal. U.S. v. Virginia, 518 U.S. 515, 531, 34, 1996. It utilizes no narrow tailoring or least restrictive means tests. These are crucial aspects of strict scrutiny because they prevent unnecessary discrimination. Under intermediate scrutiny, unnecessary discrimination is permitted. 20. Era ratification votes slowed after from TO. Perhaps because the court gave women strict scrutiny, albeit in a plurality, which is what the era would give women. This relieved the states of political pressure to ratify. Neal, T. Corn. Research Serve, R42979, the proposed Equal Rights Amendment, Contemporary Ratification Issues, 14, 2018. 21. Some courts refer to intermediate scrutiny as heightened scrutiny, but this is a misnomer as it is a lesser standard than strict scrutiny, hence should be described as lowered scrutiny. 11. Case 1:25 CV 10806 WGY. 4. Document 11. File 071725. Page 22 of 31. Even if the era is not valid, plaintiffs are entitled to strict scrutiny review under the Fifth Amendment. Even if the era is not valid, this court should apply strict scrutiny under the Fifth Amendment because intermediate scrutiny discriminates against women by treating them unequally. This cannot stand under any legitimate interpretation of a constitutional doctrine that guarantees people equal protection of the laws. Students for Fair Admissions, Inc., Supra, at 206. The guarantee of equal protection cannot mean one thing when applied to one individual and something else when applied to another. Citation omitted. 22. In Frontiero v. Richardson, 411 U.S. 677 1973, a plurality of the Supreme Court rightly adopted strict scrutiny for women under the 14th Amendment's Equal Protection Clause based on the nature of femaleness as a suspect class, women's long-suffering based on their femaleness, and women's alignment with race as a category worth of strict scrutiny because sex, like race, is determined at birth and immutable. Frontiero at 691-92.23. 22. While the current judicial review standard for women under U.S. v. Virginia, 518 U.S. 515, 531-34-1996, is intermediate scrutiny, it would not be unprecedented for this court to resist applying it on the grounds that it conflicts with women's fundamental rights. See for example, U.S. v. Dorobatus, 538 F. Sup. 899, 909, N11, N. Deal 1982, resisting Supreme Court precedent not requiring trial court interrogation of a defendant prior to jury waiver, Westminster School District v. Mendez, 161 F.2d 774, 779-80, 9th Sir 1947, E. N. Bank, resisting precedent permitting racially segregated schools, in re Booth, 3 Wis. 11854, resisting precedent permitting slavery, which was then overturned by the Supreme Court in Abelman v. Booth, 62 U.S. 514, 1859, but the Wisconsin Supreme Court refused to honor the Supreme Court's writ, Abelman v. Booth, 11 Wis. 501-1859. Of course, this court could avoid resisting precedent simply by validating the era because it requires strict scrutiny. Frontiero v. Richardson, 411 U.S. 677, 691-92, 1973, 23. Soon after Frontiero, strict scrutiny was replaced with intermediate scrutiny. Craig v. Boren, 429 U.S. 190, 217-1976, Rehnquist, J. Dissenting, only redeeming feature of the court's opinion is that it signals a retreat by those who joined the plurality opinion in Frontiero from their view that sex is a suspect classification for purposes of equal protection analysis. 12. Case 1:25 CV 10806 WGY. Document 11. File 07-1725. Page 23 of 31. Women have waited long enough for full equality, and they have suffered enough. Throughout this country's long and shameful history of subjugating women in the Constitution. First as non-persons with no equal protection rights at all when the 14th Amendment was adopted in 1868, and then when women were finally recognized as persons with some equal protection rights in Reed v. Reed, establishing those rights as unequal by giving women only rational basis. Review 404 U.S. 71, 76, 77, 1971. Rational basis was later elevated to intermediate scrutiny in Craig v. Boren, 429 U.S. 190, 217, 1976, but women remain unequal today because intermediate scrutiny is less protective than strict scrutiny. 24. Unequal protection is state-sanctioned discrimination that causes women to suffer disproportionately high rates of violence. 25 and injures women in their dignity, autonomy, and humanity. 26 Discrimination also causes negative health consequences. 27 Researchers even found a correlation between higher rates of violence against persons who, because of state-sanctioned discrimination, are excluded from protection under hate crime laws. 28. 24. As Justice Antonin Scalia candidly put it, the Constitution does not require discrimination against women, but neither does it prohibit it. Condon, S. Scalia, Constitution doesn't protect women or gays from discrimination. CBSNews.com, 4 January 2011. 25. UN General Assembly, in-depth study on all forms of violence against women, report of the Secretary General, /61/122/ad.1, 6 July 2006, inequality is the root cause of violence against women, UN Women, Investing in Gender Equality and Women's Empowerment, 31 October 2010. 26. Ho, J. Finding out what it means to me, the politics of respect and dignity in sexual orientation anti-discrimination, 2017 Utah LREV 463-2017, discussing philosophical and legal foundations of dignity, autonomy, and humanity in American law. 27. Krieger N. Discrimination and Health Inequities, 44 Intel J of Health Serve. 643, 655, 68,788, 2014, meta-analysis showing discrimination's negative health consequences. 28. Hatzenbuehler, M.L., et al., state-level policies and psychiatric morbidity in lesbian, gay, and bisexual populations. 99. J. Public Health 12, 2275, 2009, higher rates of psychiatric disorders among persons in states that did not extend protections against hate crimes and discrimination to them, compared to states that did. 13. Case 1:25 CV 10806 WGY. Document 11. File 071725. Page 24 of 31. Women are further harmed by inequality when they seek redress in the courts. Bson Kayla. V. Virginia Polytechnic Institute and State University, 132 F.3D 949, 971, 4th Sir 1997. Gender bias permeates the court system and women are most often its victims. Congress enacted the Violence Against Women Act to confront this bias and discrimination against women. H.R. Conf. Rep. No. 103711, at 385, 1994, see generally, Senate Judiciary Committee. The Response to Rape, Detours on the Road to Equal Justice, May, 1993. Strict scrutiny will close the inequality gap and help prevent these intolerable harms. V. The MSSA is unconstitutional under strict scrutiny. Under strict scrutiny, the MSSA is unconstitutional unless defendants can show that excluding women is justified by a compelling government interest, is narrowly tailored to serve that interest, and uses the least restrictive means to achieve the government's goal. Defendants cannot meet this burden because there is no compelling reason to exclude women from registering for selective service. Indeed, defendants make no such claim. Hence, there is no need to analyze whether the government can also prove narrow tailoring and least restrictive means, because without a compelling interest these questions are irrelevant. Defendants rely on Rostka v. Goldberg, 453 U.S. 571981, to defend the constitutionality of the MSSA. In Rostka, the Supreme Court upheld the exclusion of women under intermediate scrutiny because, at the time, women were ineligible to serve in combat, thus were less ready for military service should a draft be called. ID at 64-72. This is no longer true because women have been eligible to serve in combat since 2015. National Public Radio, Pentagon says women can now serve in frontline ground combat positions, npr.org, the 3rd of December, 2015. Because the salient facts underlying Rostka have changed, it is not controlling. Carl Label v. Selective Service, 364. F.Sub 3D 394, 405-08, DNJ 2019, declining to follow Rostka because women can now fight. 14. Case 1:25 CV 10806 WGY. Document 11. File 071725. Page 25 of 31. In combat, reasoning that, when the facts of a Supreme Court decision do not line up closely, it cannot be said that the decision directly controls the new case, quoting Jefferson City v. Acker, 210 F.3D 1317, 1320, 11th Sir 2000.29. 6. Plaintiffs have standing. Standing is established when a plaintiff shows 1. An injury in fact that 2. Is fairly traceable to the challenged action of the defendant and 3. Is likely to be redressed by a favorable decision in court. Lujan, 504 U.S. at 560-61. Injury in fact is an invasion of a legally protected interest which is a. concrete and particularized and b. actual or imminent, not conjectural or hypothetical. Reddy v. Foster, 845 F.3d 493, 500, 1st Sir 2017. N-identifiable. Trifle is enough for standing to fight out a question of principle, the trifle is the basis for standing. And the principle supplies the motivation. US v. Scrap, 412 US 669, 689, N.14, 1973. Though injury need only be a perceptible harm that distinguish the plaintiff from other citizens. ID at 689. Specific facts proving injury are not required at the pleading stage. Luyan, Supra, at 561. Defendants argue that plaintiffs suffered no injury and have not demonstrated organizational or associational standing. D.Mem.9-15 Their arguments fail. A. Discriminatory exclusion. When Miss Venor attempted to register for selective service, her application was rejected solely because of her sex. This injury, alone, established standing for a woman who filed the exact same case in New Jersey federal court. Carl Label, Supra, at 417, female plaintiff had standing to mount an equal protection challenge to the MSSA solely because her selective service application was rejected based on her sex. 29. Rostka should also be distinguished because it applied intermediate scrutiny and plaintiffs do not argue intermediate scrutiny or assent to the court applying it. 15. Case 1:25 CV 10806 Document 11. File 071725. Page 26 of 31. Discriminatory exclusion is a well-recognized injury. White v. Crook, 251 F.Sup. 401. 408-09, MD Ayla 1966, women had standing based solely on their exclusion from jury duty. C. Carter v. Jury Commissioner, 396 U.S. 320, 331 970, black people had standing based solely on their exclusion from jury service. Defendants wrongly rely on Schwartz v. Brodksy, 265 F.Sup.2d 130, DMAS 2003. In Schwartz, a female and 4 males challenged the constitutionality of the MSSA, and the female was denied standing because she did not experience injury from exclusion, much less injury based on her sex. She never tried to register, and was not even age eligible because she sued when was only 17, and the case was resolved before she turned 18. ID at 131 and N.1. The court's denial of standing to the female in Schwartz relied on language in Goldberg v. Rostka, 509 F.Sup. 586, ed. Par 1980, where standing was denied to persons who are not under any compulsion to register. ID, at 591. Persons obviously refers to males who could not register because there were no female plaintiffs. Goldberg was a class action filed by Men for Men. The class was defined as all male persons who are registered or subject to registration. Goldberg. At 588-89, citation omitted. The plaintiffs never asked to include women, but even if they had, women would have needed separate grounds for standing because the injury to males was defined as the act of registering, ID. At 590-91, and females cannot suffer this injury. A female could have established injury in Goldberg by trying to register and being rejected, but that did not happen. As women did not seek standing in Goldberg, women were not denied standing in Goldberg. In turn, Schwartz's reliance on Goldberg, hence defendants' reliance on Schwartz, are misplaced. B. Stigma and stereotype. Laws establishing people as inferior create injury by stigmatizing and stereotyping them. Reed v. Reed, Supra, Idaho law preferring men over women as estate administrators causes. 16. Case 1:25 CV 10806 WGY. Document 11. File 071725. Page 27 of 31. Stigmatic injury by declaring women less competent, Frontiero, Supra, Employee Benefits Policy. Favoring women stigmatizes women by stereotyping them as incapable of being primary Breadwinners, 30 Strata v. West Virginia, 100 U.S. 303, 308 1880, excluding people from civic service based on race is a stigmatizing brand upon black people, fixed by law that stereotypes them as unfit to serve. Miss Vanor clearly suffered these injuries because the MSSA is replete with sex stereotypes that stigmatize women and impose on them a badge of inferiority. Goldberg, 509 F. Sup. At 586, 594, 597, N.
All right, little towels. My name is Grant Smith Ellis. Thank you for listening to basically the entirety of Towel Mom's wonderful brief. Now, I have some news for you. I heard a rumor that Towel Mom is indeed in the Towel Zoom. All right, folks. Towel Mom is about to join. So here we go. Give me 1 second. Let me join this all up. Let me get my towel video on. Let me get my everything set up. Let me get the sound set up. Here we go. My name is Grant Smith Ellis. Let me turn my everything seems to be good. Give me 1 second. All right, hold on. All right. And all right. Let me add it to the screen. I do see you. Hold on 1 second. I do see you. All right, there is Towel Mom. She's going to close the curtains to give us some better light. What a wonderful way to start our day. All right, my name is Grant Smith Ellis, and this is Wendy Murphy joining us after we have just spent a wonderful hour reading through her recently filed brief. So now all of us are erudite, cogent, and ready for this discussion. So you are known as Towel Mom to very many of the listeners here, but would you mind giving us a little bit of introduction to the work that you do, and then we'll lead up to how that work culminated in this recent lawsuit. Thank you.
Okay. First of all, thanks for having me. You know, I know very little about tech, and I don't like doing these kinds of things, except if it will help promote some of the work I do. And thank you for offering to do that. Yes, my background, as you know a lot of it, but I was a prosecutor as a new lawyer. It was the first job I had as a lawyer. And it was a place where I organically observed the many ways. You're not smoking. What is that?
Oh, it's a vape. Continue, please.
Oh, that looks like smoke.
Continue.
I'm sorry. I can't help myself.
No, that's okay. You were saying you were a former prosecutor.
Yeah,
we
and,
all
I
understand.
don't want you to live forever, so I don't want you doing health things to harm your health because I love you. But anyway, okay. So I watched firsthand as the legal system disproportionately caused harm to female victims. Lots of victims suffered in the name of due process for the accused. Victims were maltreated. But it was disproportionately happening to women, and I would object and tell the judge, you can't do that. You can't discriminate against women because you're the government and it's not allowed. And judges would say, Attorney Murphy, your job is to state the law. You're the prosecutor. Your job is to state the law, not complain about it. If you want to change the law, you have to get a different job. And I eventually just took that very seriously. And after 5 years as a prosecutor, I said, okay, well, that's what I'll do. I'll leave the DA's office and do something that is creative to inject a voice for victims into the legal system. So this was in the early 90s. And I said to myself, I'm just going to do this for a year. I'm going to try to file cases to object to what I saw was happening to victims, especially women. I'm just going to do it for a year. And then once I'm done, I'll get a real job as a lawyer. And, that was 40 years ago. So the reality is for lawyers who see things that are unjust and that it's a systemic problem, you want to do something about it. Lots of people become lawyers because they care about injustice and they want the skills and the licensure to be able to do something about it. but I don't think we quite know what we're getting in for. So getting into. So for a while, I just thought I was going to do some of this work and then leave and do quote unquote real lawyering. But every time I pursued a case or fought for somebody, it unveiled another layer of problem. And so my commitment against my will became a lifelong one. And eventually, because of the cases I would file, and I did a lot of work that was like, let's say I would inject a pleading of some sort into a criminal case, and the judges would say, well, your client is only a victim. You can't file stuff. This is a criminal case. And I'd say, well, yes, I can. Well, you don't have standing. Well, yes, I do. Well, why do you have standing? I'd say, because the court sent a court order to my client, and you can't just impose a government compelled court order on a human being and tell them they have no voice to object if it's objectionable. If you want to drag my client in, you're bringing my client in with rights to say, I object. We might not win, but we get to speak. And, over time, that doctrine developed that victims do have a right to be heard. Victims can speak in criminal cases, not on all issues at all times, but certainly if a victim receives a summons or a court order, and either to show up and testify or produce records, for example, therapy records, phone records, that comes with standing to object. The judges didn't want me to show up. They didn't want victims to object, but it was constitutionally mandatory that they allow a victim to object. It's called due process. So I was really the first lawyer to do that, to show up and say, I object, and have to deal with judges saying, you have no standing. And so I had to argue standing doctrine in many cases. I still do. And most lawyers don't ever do that. Most lawyers don't ever argue about standing because it's such an unusual objection. And everybody kind of understands that if you're in court, obviously you have something to say, you must have standing to say it. But for me, because I go in on behalf of either a woman or women as a class, there's a lot of systemic objection baked into this notion that women ought to just obey, not object. And that kind of discriminatory attitude toward women was evident to me early in my career because, for example, in a criminal case, if a defense attorney got a court order against, let's say, the New York Times to force them to reveal a confidential source, and then my client, a woman, got the exact same court order and was asked to turn over, let's say, her medical records that were unconnected to the crime, I would show up, the lawyer for the New York Times would show up, we both make exactly the same objections, in the sense that this was an imposition on a third party that was imposing on constitutionally protected rights. And the New York Times would get the red carpet and the judges would say, oh, whatever you want to file. Yes, so glad you're here. What would you like to say? No one said you don't have standing. But then they turn to me and say, well, you don't have standing. You're just a victim. And I'd say, how am I different? What, in a legal sense, how am I different from the New York Times? And then there were also occasions where, the judges would say, your client just has to turn over her medical records, turn over her phone records, turn over her therapy records. And I'd say, well, what about her attorney-client records? Because I've got a file this big filled with information from my client who's talked to me about the crime. She's revealed all kinds of things. And here's my file, judge, 500 pages big. Should my client turn over her attorney-client file? Because if your argument is the defendant has a right to look at information that contains statements about that a victim makes about a crime, why can't the defense ask for my attorney-client file? And judges would just scream and yell and slam down the gavel and say, stop talking, just stop talking, because there was no legitimate difference. And I would say, but here's my file. And this file could contain evidence that proves the defendant's innocence. Do you want my file? And they would say, if you say another word, I'm going to dismiss the charges. I was just trying to provoke the court into explaining, why would you disrespect a victim's medical file and respect my file if the goal is to give the accused what he or she needs in order to, prove their case or disprove the government's case?
And do police do this a lot as well? Will they come to you and say, yeah, just give us we want everything that the victim told you, every statement she made to you as her lawyer or he made, we want all of her medical records?
I've never had a cop ask for anything. No. I mean, I've had them ask, but then I say, well, why would I give you that? That's irrelevant, privileged, confidential. No, you can't have it. There have been times, to be honest, when I know what's in my client's phone related to the crime. And so I will come into an agreement with the police because I think it's helpful to my client. Or even if it's not helpful, I'll say, okay, I agree that statements made in the immediate time period before and after the crime are fair game. And I, as an officer of the court, will go through the phone and send you screenshots of what I decide is relevant and discoverable under, some version of Rule 17. Again, Rule 17 applies to discovery, quote unquote, discovery from non-parties, and Rule 14 deals with discovery from the government. Victims are not the government.
Sure, but have you ever heard of a situation where to make material subject to Rule 14 disclosure, a bunch of stuff was taken into the possession of the state for the purpose of giving it to the defendant? Or would you?
Yes.
Oh,
yes.
wow.
Yes, it does happen. And the reason it happens is because victims don't have lawyers. So they want to be cooperative. They want to appear to be not hiding anything. I've had many cases over the years where a victim gets a call from the police. They say, we need to dump your phone. And they just hand it over because they don't know that they don't have to. And they don't know that they have constitutional rights in that phone that give them the authority to say, I object. I'd really rather you go to court and get a court order that limits what you're asking for, that restrains you from, intruding into private space, because a phone contains so much private data and irrelevant private data. Defense attorneys love to get their hands on phones, not because it contains relevant information about the crime, but because it contains personal information that they can then use to extort the victim. If you testify, I'm going to reveal that you're having an affair. If you testify, I'm going to reveal that you went to your doctor because you have an STD, stuff like that. It's always used, not always, it is generally used as a tool of extortion. Let's force the victim to turn over stuff and then we can get the case dumped, not because the evidence isn't there, but because we are terrorizing her into not testifying. I mean, one of the classic ways that this happens that very few people even understand is in the context of rape victims going to the hospital for what's called a rape kit exam. No one tells this to victims, but I have been telling this to victims for decades. And I was on the very first sexual assault nurse examiner board in Massachusetts when we first created rape kit protocol. And I objected even back then, because what happens is a victim is raped, she goes to the hospital, she's in trauma, she's really upset, she doesn't know anything about the law, she's got no experience with the legal system, and someone there asks her to fill out medical forms, because this is both a medical and a legal situation. Well, unknown to her, the doctors and the nurses are agents of the government in that context. Everything she shares with them is considered part of the prosecution's file. No one tells her that. They might give her a form that in 8,000 words explains some aspect of how she's waiving her rights but she doesn't have the capacity to understand it at that moment, and they take advantage of that as well. So a victim will go in and reveal her name, address, phone number, insurance company data, often social security number, not always, sometimes, medical history, psychological history, any medicine she's taking, medicines she has taken. Medical history itself is in there. It's an incredible dump of information. Defense attorneys love when victims go to the hospital after rape, because they get enormous amounts of data that have nothing to do with the crime that they then use in that extortionist way that I mentioned.
Are you saying that cops know this as well? That cops know that this material is stuff defense lawyers love getting specifically because it's a pressure tactic to get the charges dropped? Wow.
Yes, but cops didn't create the problem. Defense attorneys did.
But cops know about it.
Absolutely. Everyone, prosecutor, everybody knows about it. So I started teaching victims a long time ago a don't ask, don't tell idea. I'd say, go into the hospital if you need care. Don't go if you don't. Don't go just because you were raped and someone's saying you need to go to the hospital. Don't go unless there's a reason to go because you have medical needs. Your medical needs are important, but don't go if you don't need medical care because you're going to destroy your legal case. Very few lawyers will say out loud what I say, which is that rape kits and sexual assault nurse examiner programs in general disproportionately help the perpetrator and harm the victim. And it's not just what information is revealed, that's part of it. It's also that victims then submit to a rape exam, a vaginal exam. Well, why is that a bad idea? Because just like when they ask you for personal information about your medical history, that swab of the vagina is going to reveal everybody you've had sex with, often up to and including the past 2 weeks, because the body is very good at storing biological material. And, you know, it's gotten better and better. From the defense perspective, it's gotten better and better. They might take your underpants and do a different type of swabbing there. And underpants, you can't even wash DNA material out of underpants, so they can find historical information there as well. Again, defense attorneys love rape kits, love them, because they invariably find out that a victim had sex with, you know, 3 men and a goat the day before, or their underpants are, you know, even more full with information that has nothing to do with the case. And what do I mean by that? Well, if you don't know who the perpetrator is, then of course you want to do a rape kit. You want to find out whose DNA is in your body so you can go get it. But 85 to 90% of rape cases happen between people who know each other. The victim knows who the perpetrator is, and the perpetrator will argue consent, not I didn't do it. Sometimes they say I didn't do it, but mostly what they say is she consented, which means it doesn't matter what's in the rape kit. The issue is consent. He's already agreed it happened. Don't let them swab your body. Don't go to the hospital. You're just giving the defense all of the information about your recent sex life with, you know, 3 men and a goat.
Okay, but hold on, I need to interject. So can you then explain, obviously FRE 412 exists for a reason, which is known as the rape, which was in basically rape shield law. Why do we have the special character evidence rule if what you're saying is so such an insidious problem? Why even have FRE 412?
Well, Rule 412 and rape shield laws in general should be abolished. They should be ripped out of the books. They are extremely harmful to rape cases. Why? Because they presume relevancy and force you into a balancing test. The concept baked into Rule 412 is, of course, this information is relevant. Now the court has to decide, is it more probative than prejudicial, and all this nonsense. So a woman's prior sexual history, if you just use your brain, never mind the rules, just use your brain as a judge, you're required to analyze the question of relevancy. You don't need a rule, just use your brain. We paid you as a government official to understand the concept of relevancy. Does a woman's prior sexual history have a bearing on this case? And let's make it a consent defense case, which again is 85 to 90% of cases. The answer is always no. It doesn't matter. Why? Because a person, often women, are challenged in this way, but a person can have sex with anyone they want, including goats, every single day, although the goat raises health issues that we're not going to go into. But
are you sure it's legal to have sex with animals?
No, it isn't, but it's a public health issue, not a consent issue, generally speaking. So I
don't know if the animal rights activists would agree with you there, but okay.
Well, they may argue about consent, but they're not there yet. So animals, it's not really about consent for animals. It's about public health. You can argue if you want that animals should have the ability to bleat their way into consent, I guess, if it's a goat. No, the point is you have the right as a human being. It's called autonomy. You can do whatever you want with anyone and not have that used against you in a court of law. Because if it is used against you, then you're not free. Any aspect of your consensual private behavior that gets used against you becomes the nose in the camel's tent. Now, oh, well, you know, you're not really free because you as a woman have a special category where we're going to use your prior sexual behavior against you, even if it's not relevant. And that's just the way it is. We're just going to use irrelevant information against you because you're a woman. and we want to deter rape victims from coming forward. What's the best way to do that? Well, to announce that there's a rule of law that says, don't you dare report that rape, because you're then going to have to reveal to the public that you had sex with a goat. This is obviously an exaggeration of the point, but for women who are sexually vulnerable, for example, prostituted women, sex trafficked women, they're raped all the time. Like 100% of them are raped. And that's if assuming you think you can consent in a coercive context, which I don't think you can, but let's assume you think you can. Even that, taking that into account, you still have 100% rape rate for sexually vulnerable women. That woman, every time she's raped, has to think to herself, should I report this? Oh my God, if I do, they're going to find all the DNA from all the guys that I've been with. And I'm going to have to explain why I have DNA from, 5 guys and a goat. And I don't want to do that. I don't want to, I'll get killed. Sometimes it's just, I'll get killed if I tell who those DNA contributors are, or I don't want to go through it. I don't want anyone to know this is how I live my life. So it really works well to silence marginalized women, which, by the way, then increases profits for the porn and sex trafficking industry. And these questions are always about money. It's always about money. An enormous amount of money is made from the abuse of women, whether sexual or not, because of these industries. And anything that's done to make rape law more effective, anything that's done to better protect women from violence, is by definition a thing that will reduce profit margins. So we just don't have a legal system for money reasons that is willing to change things to better protect women from harm, which is why we have such disproportionately high rates across the country, but certainly especially in Massachusetts, where the industry has a stranglehold on the legislature and other branches of government. You're talking about a system where if you even dare object to the fact that we have incredibly high rates of rape, abuse, trafficking in Massachusetts, it falls on deaf ears. Women in Massachusetts die at very high rates. We are raped and beaten at very high rates. And it's not a surprise then that the Massachusetts hate crime law doesn't even protect women. Every other state in New England captures women as a category under its hate crime law, except Massachusetts. And that's because the industry is so influential here. It has successfully insulated Massachusetts from political pressure to protect women against targeted harm that they endure because they are female. So if I beat the hell out of you because you're Black or Irish or trans, that's a hate crime. But if I do exactly the same thing to you because you're female, it isn't. And not surprisingly, then the number one crime might not be number one it might be number 2 in a couple, but the number one crime in every district court in Massachusetts and in every municipality in Massachusetts is domestic abuse. Because why? It's not prosecuted. And if the message to the perpetrators is, this is a crime you're not going to get in trouble for, of course they're going to keep doing it, especially when there's money involved, which again brings us back to the industry problem.
Yep, and we're hitting a lot of different topics, but just a few things. One, a lot of people had questions about why DNA is kind of a distraction, and it's because identity isn't the issue. Crimes have multiple components. At the actus reus, the act requirement, the mental requirement, the identity requirement. But if you're not disputing your identity, you're disputing the mental state, then the DNA is not probative.
Not mental. It's not mental state. Well, I mean, I guess it is. But the point is, that's a good point, because it brings me back to what I neglected to say, which is, even if the issue at trial that's in dispute is not consent, even if, not identity. In other words, everyone agrees that what's really in dispute here is whether the woman consented. If you're a judge with a normal working, functioning brain, all you have to say to yourself is, even though this is a consent offense case, or to some extent, even if it's an identity case, all I have to do is figure out for myself whether her having sex with someone else 2 days before the crime bears on the question in dispute. Does it help elucidate the truth around the question of either who did it or whether it was consensual? There are no circumstances, none, where you can persuade me that someone's sex a couple days before a crime has a probative benefit to answering any of those questions. I didn't say I don't want a woman who doesn't know her attacker to not go to the hospital and get the DNA test done, because you got to find the guy, right? You got to find the guy. And once you do that, the guy's not going to dispute at trial that that's his DNA once the test is done. So it's not, unless it's in dispute at trial, you can't bring up stuff to resolve the disputed question. It has to be in dispute, or you can't talk about stuff. So what happened in terms of this question of DNA and rape cases is, many years ago, 50 or more years ago, judges weren't doing a good job applying the concept of relevancy. They were saying things like, well, if she consented with that guy last week, she probably consented with this guy tonight on the night in question. It was such an irrational application of the concept of relevancy because, again, it doesn't matter. You can consent 5 minutes ago. It doesn't mean you consented at this moment. And by the way, to the extent anybody cares, you can consent and then change your mind. Like while you're in the middle of consenting, you can change your mind. This goes for males and females and everybody and all the other categories. It doesn't matter that you consented. You never give up your authority over the body. Why? Because there's no such thing as slavery in this country. Nobody ever owns you. Nobody ever wins your decision-making authority because you agreed to consent to something at that moment. It is only that moment where you can give up your authority over yourself to another, and then you don't have to keep giving it up. I had a case called I was involved in a case in California called John Z many years ago. The Supreme Court in California invited me to argue because I filed an amicus brief, and it was about a case where these two people were involved in a sex act. The victim did agree to start the act, but then she changed her mind because it hurt. Well, the guy said, just give me a few minutes. She said, no. He said, just a couple minutes. No. He kept going. He was charged with rape. He was convicted. The question for the court was, is that rape? The defense argued, no, it's not rape because the guy couldn't help himself. He's like an animal. It's not his fault. And the other side, which is my brief, said, no. The law is designed to protect autonomy, self-determination, the 100% authority we all enjoy over our bodies at all times, never to be reduced by someone else's erection, frankly. So my brief was all about the importance of autonomy and why, this should be very simple. But nonetheless, I then, was on all these morning shows, ABC News and all sorts of things because it was so controversial. I'm like, what is so controversial about this? And I think it was Charlie, I forget his name, but one of these morning show things, national morning show guys said to me, but Wendy, isn't it unfair? Isn't it just unfair? And I said, well, if I invite you into my house for 1 hour and then 5 minutes later, I decide I don't like you and I ask you to leave, you don't get to stay for the hour. Oh, good point. And another guy that I was doing on a radio show said, oh, come on, Wendy, the train's out of the station. The train's out of the station. So what? So what? You might have to put the brakes on your train and that might hurt. You might get a lot of, heat when you jam brakes on the train. Tough shit. And imagine if I said that to a guy, your train's back in the station. My train is still out. So you can't stop. I get to dictate when you stop. According to my body, you got to keep going. And I get to make you keep going until I decide my train's back in the station. When you flip the gender roles like that, everybody nods. Oh, especially guys. Oh, now I understand autonomy. Yeah, well, you shouldn't have needed that lesson, but you did. So this brings us back to the question of why is DNA not really ever relevant? Because the question of consent is a mental decision. It is not a physical decision. Nothing physical in terms of DNA. You might have evidence of injury that has some bearing on corroborative proof of non-consent, but nothing in the nature of DNA proves or disproves what's in a woman's mind. So it just has no place in the legal system. and is almost always harmful to the woman in terms of wanting to be credited and believed, and very helpful to the perpetrator. And it's really, the hospital rape kit protocol is so dangerous to rape victims, but because they don't know it's dangerous, because they don't understand rape shield laws, which again are very bad for rape cases, because they don't get that, and they watch television, CSI type shows, and say, oh, I got to go to the hospital because after all, this show says it's really good to go. And they don't understand until it's too late. Once that cat's out of the bag, once the DNA is in the kit, you lose your case. There's nothing you can do about it. I have tried to suppress, I filed motions in some rape cases to suppress DNA results and to get a court order forbidding either the prosecutor or the defense from using DNA evidence that I argue is irrelevant and or prejudicial. And I've had judges say, you can't file a motion to suppress, you're not a party. And I say, I have a constitutional right at stake. My client has a Fourth Amendment right in her private body parts. She was searched by the government when they did the swab of her vagina. You're damn right I have a constitutional right at stake, and that comes with due process. So you will listen, I will file a motion, you will not rule that I don't have standing, and you will decide the merits. Under the Fourth Amendment, which speaks to search and seizure law, did the government have a right to do the search and the seizure? And even now, is it proper under constitutional principles to admit irrelevant evidence in this case that violates my client's constitutional interests? Judges get very nervous. Why is this victim here with a lawyer? We don't need another lawyer in the room. And I say, well, that's unfortunate. I wouldn't be here if you hadn't dragged me in by virtue of this government intrusion without due process into constitutionally protected space. You invited me by doing that. I'm not here. I'm not intruding. You invited me. You dragged me in. So let's talk about it, and I do this kind of stuff all the time. Again, it harkens back to why did I first start doing victim advocacy? Because these really bad things were happening and no one was objecting. I would object, but again, the judges would say, you don't represent the victim. Why are you objecting? You can't be the victim's lawyer. You're the government's lawyer. You're the lawyer for the people. And I would say, well, when you discriminate against women and the defense likes it because they're getting benefits out of that, and I'm the government and you're telling me I can't object because I'm the prosecutor, but I see you discriminating against women, who objects for women? Who corrects you? Who holds you accountable for violating the Constitution by discriminating against women? And you think you can do it because she doesn't have a lawyer in the room, but I see you doing it and I know you're the government. What are you saying? You can just do it because no one's here to object? No. So this is what I have been doing for all these years in one form or another, sticking my foot in the door and saying, I object. Whether you want to hear me or not, I object. Whether you want to read my brief or not, here it is.
Yep, and I really appreciate that full explanation. You basically said forced birth there, which I thought was a really good point related to autonomy. And then I do want to ask you about your brief, but you talk about such an important concept, which is victims they do get standing. We know, of course, if folks have, right, the Kofi Agana and Ruby case in the matter of Ruby McDonough, that's absolutely something people should look up for an example of how a victim testifying in a criminal case can get standing if they're declared incompetent, and then they want to challenge that ruling. But one hypothetical I wanted to ask you is we're talking about this tension between Rule 14 and Rule 17, neither of which give victims very much protection. But, hypothetically, say you talked about how police will sometimes approach you and say, I want to take all these records from your client who's a victim in this criminal case. And they say something like, here's an oral promise that we'll go through and we'll redact it and we won't give anything that we shouldn't to the perp. And then, you sign an agreement, you give over the documents, hypothetically. Are they promissory e-stopped from giving over those documents? Does the oral promise get incorporated into the agreement to hand over the documents?
If you give a cop your phone and rely on some kind of a verbal promise that they won't overuse what they find, then you're a fool. Never give your phone to the police. Get a lawyer to make to make the decision to do the screening.
Yeah, but
herself.
no, agree. That is what people with means and with lawyers
Not
and
just means I do 80% pro bono.
yes,
work.
but that doesn't mean everybody
They
can.
don't know. They
Right,
don't know.
or right. So
We're trying to
instead
be
of
cooperative.
well, hold on. Could I?
The problem is this. Yes, police will overuse. They will overlook. They will overdo it. They will exceed their authority, not just their legal authority, but the authority you gave them. They will exceed it. And you know they violated the agreement. Let's even assume they violated the law. There are no remedies. You cannot stuff the cat back in the bag, especially if the entire dumped phone goes to the perpetrator. Why? Because as we learned in many cases, once the defense has stuff, they are not restricted from using it. You can argue all day long they shouldn't be allowed to use it because it was wrongfully obtained. The only person in a criminal case who can be stopped, you're using a civil principle there, that's an equitable principle. It does not apply in criminal cases.
But protective orders do.
Protective orders do, but it doesn't matter. I've had protective orders in many, many cases over the years that are supposed to protect victims. When they get violated, there is no remedy.
Well, yeah, unless you're in front of like a federal judge who actually cares. But let me ask you this question.
Federal courts are different.
But let me ask you a question. I know you are very hard into this work, but can we really expect someone who has no involvement or history with the criminal process, someone who knows very little and puts a lot of faith in, for example, prosecutors, police, the people that you might feel are not trustworthy because they'll overstep, but who a regular person off the street is going to say, that's a cop, that's a badge, that's a prosecutor, they do what's right. How can we expect them to know in that moment that they're going to be misled? How can people be empowered to do that?
You can't. That's why I teach a don't ask, don't tell policy. On the back of one of my old business cards, I have what's called victims' privacy Miranda rights. And I've had these for 30 years. I used to hand them out all the time. The back of it is called victim privacy Miranda rights. And it says, as a victim or a witness, you have the right to refuse to answer questions regarding the following categories. You have the right to refuse to produce information. You have the right to this, that, and the other thing. And I do that because the don't ask, don't tell nature of this is kind of why Miranda came about when it did, right? People accused of or suspected of criminal activity needed to know that they had a right to remain silent, but there was no constitutional requirement that police advise them of their rights before they intruded. So we grew, as a pop culture kind of thing, we grew the idea of Miranda long before it became Miranda.
Well, I don't think I would call it pop culture. I think Bruce Ackerman would call it like a lower form of lawmaking that inspires subconstitutional change.
I'm sorry. Okay, you can call it that. But what I'm saying is, when you can't get the government to do what it ought to do, you got to use what you have. And I called it pop culture because it really was a movement among people to teach each other through whatever devices they could find. And today, we have social media where people can literally tell each other, don't do this, don't do that, or put signs. There are so many ways to communicate now about what your rights are and how you need to know not to reveal needlessly, because again, once the cat's out of the bag, you have no remedy.
But let's explain this to people. Most people won't speak the language of Miranda, which, by the way, I also think came about because Chief Justice Warren was a county prosecutor who knew how it was being abused. It wasn't just the rise of the popular sentiment. But I have to ask you this. Are you basically suggesting that much akin to how criminals in a criminal case get read to them the right to have an attorney, stay silent, under the Victims' Bill of Rights, which is under statute in this state, there could be something that informs victims of their rights at the very beginning of the process before they speak to police? And if so, why doesn't that exist?
Yes, there could be, but here's the problem. The victim, the so-called establishment victim organizations work for the government. They're never going to do anything remotely related to protecting victims. And the Victims' Bill of Rights law, which came about when I was a prosecutor, so I watched how it was implemented and not, it has no teeth. If there are like 35 different rights that victims have under the Victims' Bill of Rights laws, and even in states where it's a constitutional law, which is not true in Massachusetts. It's statutory. But even in states where it's constitutional, the bottom line is there are no teeth to these laws, because if you have a right, for example, the most sort of classic one is you have a right to be heard before sentencing. If a prosecutor doesn't communicate with you and just goes and makes a real, ridiculous deal with the perpetrator, so he gets probation, for example, and you're outraged, if they don't consult with you before they make the deal, that absolutely violates the Victims' Bill of Rights laws across the board in this country, and there's nothing you can do about it. Nothing.
Sure, but let me ask you a different question. I know I want to talk about the CRA lawsuit, but we talked a lot about how even with a protective order, right, it really comes down to like the prosecutor making a motion for sanctions or like contempt, or the judge wanting to do something, and then each individual piece of evidence is only subject to the 401 and 403 analysis as the protection. But can we talk about a higher duty here, because it's almost making it seem like, for example, say we were talking about the Mass State Police or something, it's like because they only answer to God, it doesn't matter what they do because the courts won't check them. Defense lawyers love it. Victims are screwed. But let me ask you one question. I
don't agree with that. They do it. The government is held accountable when and only when the rights they violate are the rights of the suspect or the
sure, I agree with you. But let me ask you this. We have a number of federal statutes, and you might say that it's kind of a nonpartisan thing, that when we see people entrusted to administer our systems of justice under color of law violate things like privacy rights or enumerated different rights, not just of defendants, but victims. That's the kind of thing. We're not really talking anymore about the procedural remedy, about the use of the evidence in the underlying criminal case. We're then talking about an abuse of someone's position under color of law. You seem to say that occurs a lot, but it's a little bit different when there's a lot of attention on it. Where have you seen penalties, if ever, exacted?
I'll tell you one good example.
Oh, go ahead.
The reality is most people incorrectly think that the Bill of Rights, to the extent some of them apply to criminal cases, only apply to criminals and suspects. That's not true. If you read the Fourth Amendment, which speaks to privacy and government intrusions generally, speaks to persons. So a victim is a person, and it is by far the most potent law you can rely on as a victim. If you're going to argue about what's at stake, never cite Victims' Bill of Rights laws. They're useless. Always cite the Constitution if you can. Never cite statutes if you can avoid them, because on balance, if your rights as a victim are statutory and you're bumping up against the constitutional rights of the accused, you will lose, because here's the Constitution, here's the statute, you lose. But if you can constitutionalize your suffering as a victim, the violation becomes a constitutional argument, then you're on equal footing. You have a much better chance of winning. So I never argue statutory rights for victims. Not never. I rarely argue statutory rights. For example, I have gone into court on rape shield matters and said, and the judge will say, well, under the rape shield law, blah, 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 blah. And I say, I'm not here under the rape shield law. I'm here under the Fourth Amendment. Well, yeah, but the rape shield law says, I said, I do not want you to apply the rape shield law. I object to you applying the rape shield law. I only want you to apply the Fourth Amendment, or the Massachusetts equivalent under the state constitution. And they get very flustered. They don't want victims to have the C word attached to them, the Constitution attached to what they're arguing. But if you don't refuse openly to have a statutory or a rule become the basis for your objection, rules are even weaker, right? So a rule might be Rule 14 or Rule 17. You get sucked into court and suddenly you're arguing about Rule 17. Never, ever argue Rule 17. Argue the Constitution. It gives you much heavier weight, and it gives you stronger arguments in general. Rules get codified by the criminal defense bar because they're in charge of the rules committees. Rules committees aren't really allowed to make substantive changes because that's a lawmaking event that has to go through a legislative process. But rule-making bodies, especially in this state and especially in the criminal justice sense, just love to exceed their authority and create substantive rules that then give them power to take stuff from victims. And because victims aren't even at the table in terms of the rulemaking, they're not even aware of it. And the next thing you know, a rule shows up and it says victims must turn over their phones upon request.
most victims would obey that. And most lawyers would tell them to obey it. Why? Because it's a rule. It says it. Well, the statute seems to support it. Yeah, but does the Constitution support it?
Yep.
Is it constitutionally legal to create a rule that violates the Constitution? No, it's a separation of powers issue. It's a, it's an ultra vires argument if you're talking about who gets to do what. But my bottom line is this. I'll give you an example of when because I never, once I realized you can't fight this, that you're just going to lose because there are no remedies. I was in court once saying, Your Honor, the defense sent a summons to the victim's therapist, and she's here because she obeyed the summons, like good people generally do. However, he had no authority to send that summons. And this is outrageous that she, the therapist, has been here for 4 hours, hasn't been able to treat her clients, hasn't been able to even understand anything because she doesn't have a lawyer, and she's sitting in the back of the courtroom for all these hours. Come on, this is unacceptable. And I want you, Judge, to hold him in contempt for violating what's called the for violating the law. And the judge would say, well, I don't have authority to punish the defense for violating the law. And I'd say, yes, you do. Well, Ms. Murphy, what do you cite as my authority? Because there's no rule that lets judges punish defense attorneys who violate the law. There's no rule. There's no statute, right? So I said, I cite the inherent authority of the court. And if you look historically at the common law around judicial powers, there is a doctrine called the inherent authority rule. Very rarely is it used because usually there's a rule somewhere that speaks to what a court can and can't do. I said, I cite the inherent authority of the court. And in addition to you punishing this lawyer with contempt, which you have the inherent authority to do, I want you to submit a BBO. Board of Bar Receivers. The judge said, I can't do that. I just don't know.
Well, the judge did that to Tim Bradle, I'll tell you, in one of the cases from about 10 years ago.
Well, but the criminal defense bar really controls the BBO, so that's not.
Oh, I agree, unless you upset bar counsel, and then it doesn't matter how much influence you have.
Right. Criminal defense attorneys almost never get in trouble with BBO because there's this understanding, wrong though it is, that criminal defense attorneys can do whatever they want. Defense at any cost is the baked-in philosophy. So
if you have a public hearing in front of the BBO where the bar counsel's really upset, you really went over the line.
You went over the line, and maybe they're yelling at you, but it's still meaningless.
Well, even unless you got sanctioned with, your license being suspended or revoked.
They won't suspend a defense attorney's license for behaving badly. It's just not going to happen.
I think you're a little jaded, but it's very important that.
I've never seen it.
Sure. I agree.
But anyway, here's what I did.
Well,
so I gave
go
my
ahead.
own remedy because the judge said, although you're right, he violated the law, violated your client, imposed on your client, cost your client money. I don't have any ability to do anything about it. I said, fine, okay. I walked out the door and sued the defense attorney for abuse of process.
How'd it work?
And I won.
Good. Let me ask you this question. It was kind of the core. Before we go to your federal lawsuit, it's a good bridge. The core there was, all right, Department of Justice, Civil Rights Section, FBI units, okay? They could very much provide the check and balance on abuse of official color of law that we see running rampant at the expense of uninformed victims in the criminal justice system. Do you want to see indictments against police officers who abuse the trust of victims and then do things like release their private information to defendants intentionally?
Yes, but
me too.
But it's a two-way street. You got to charge the police or sue them. Again, there's a Fourth Amendment issue.
Damn right.
The problem is most victims sign releases. You can't sue once you've signed.
That's like saying that if there's a contract of adhesion and you agreed to be on a home, it's a contract of adhesion.
What I'm saying is the issue has already been resolved. When victims go to hospitals after they've been raped, they sign consents where they basically agree that all the contents of the rape kit and everything in their file can be shared publicly. It's terrible. They don't understand.
But you can argue the validity of the contract.
It's been challenged. It's not successful. It will not happen.
Under every circumstance? That's impossible. It's a case-by-case analysis.
No one's ever going to succeed in arguing that an agreement between the government and the victim is not binding. That's for the purposes of contract law. For the purposes of federal law, let's talk about 28 USC 28 USC 1853
for
It
example.
doesn't matter.
No. So, for example,
No
I'm not talking about that. Say the evidence was tampered, for example. Like, say the evidence was tampered with.
The victim has no.
That's not what we're talking about. I'm talking about under federal law. Forget the contractual remedies for the violation of the agreement the victim signed to turn over the information. Under federal law, what type of things could be charged in that circumstance? Forget about whether they will be. What type of crimes could be charged? It's got to be a federal crime to tamper with evidence in a proceeding, to do so in a way that facilitates the release of protected information under the Constitution, and it's under color of right. How is it any different than how Suffolk County Sheriff Stephen Tompkins was indicted last week for using his official position? It wasn't regular extortion; it was extortion under color of law.
Not going to happen. It doesn't matter. I have filed federal and state matters. I call them lawsuits because they're often declaratory or injunctive because you can't sue the king for money.
But federal DOJ, should the DOJ indict?
Doesn't matter. You can't sue the government.
No, I'm not asking about you. Should the DOJ indict, not suing, should they federally indict police officers who commit these kind of violations? It's a simple, direct question. We're not talking about civil process.
They won't.
But they
won't.
indicted.
They can do a lot of things. They can prosecute criminal defense attorneys who lie.
Federally indicted.
It's not going to happen ever.
They indicted Matthew Farwell.
That's a murder case. That's different.
Okay, what if it was covered up? What if
you want a remedy against bad behaving government officials? You need to think about filing what are called creative litigation options. So mandamus, declaratory relief, injunctive relief, some of the writs, special writs, anything you can file against the government where you're not asking for money.
Sure.
Is far easier to do because the court will actually listen. The court will analyze. Did they act within their authority? That doesn't require a payout at the end. It requires an analysis of what their authority is and did they exceed it. Can you get injunctive relief? In other words, they did this. Can you now stop them from doing it again? Can you get declaratory relief, which is just a court saying this was illegal? Now, you might think that's not worth much, but a court ruling that a cop violated the law, even if it doesn't come with a money award, is huge.
Oh, yeah, sure. And let me ask you just one more question, because maybe we misunderstand. It's the murder is in the original jurisdiction of the state police, right? So the feds can't actually charge a murder. What they charge in the case of Sandra Birchmore was murder of a cooperating federal witness under 28 U.S.C. 1853. Now, the reason I ask that is, originally the same state police unit that investigated Karen Reed for John O'Keefe's death investigated Matthew Farwell for Sandra Birchmore's murder. And both Brian Tully and Yuri Buchanan used to work in Stoughton with Matthew Farwell. Now, what would you say if indictments came down federally for the MSP unit who covered up Sandra Birchmore's murder? Would that surprise you?
Anybody who covers up a murder should be indicted. That happens all the time.
It does? Cops get indicted for covering up the murder of a girl?
Yes, they do.
When was the last time you saw that other than the Farwell situation?
It happens a lot. I've seen it many times.
I'm rolling my eyes at you.
I've seen it many times in my life, cops and prosecutors who cover things up and get caught. They don't usually get caught. That's the problem. And this case, is a good example of what happens when they do get caught. But the reality is it happens. It happens. If you cover something up and get caught, and there's the political will to do something about it, which often means somebody has to die first because they won't do it if it's not a dead body. But yes, it does happen. Yep. And people get thrown out of office. And even you sometimes see even judges getting involved in payoffs. Do judges take payoffs sometimes? Yes. Do they get caught? Very rarely.
Yeah, state police. Right. Yeah. And
so do I want to see judges get prosecuted if they take payoffs? Yes. Good luck.
Well, that wasn't the question. Was about, do you want to see the state police get prosecuted?
I'm just saying that, but the judges are the government, police are the government, prosecutors are the government. Anybody acting on behalf of the state should be sued when they violate the law. But you can't sue the king, and they all fit the definition of the king. So what can you do? You got to do creative legal options like mandamus.
And indict them. And that's why I think Matthew Farwell.
It's not going to happen. The king protects the king.
Yep. And
it's not going to happen except when there's a dead body. Not going to happen. You see it once in a while, usually because there's a dead body or a lot of public clamoring. But generally speaking, the government protects the government. Why? Because there's something at stake that's common to all of them. It's called a pot of money. The state protecting the state is thing one.
No, and you're absolutely right. And I think, except in the very rare cases, this behavior goes completely unchecked constantly. And what you've brought up there is that the reason why people treat victims with abhorrent neglect and, in fact, in some cases, abuse, even when they're within the system, is that they feel untouchable. And so
they feel untouchable because they are untouchable. That's not how they feel. It's generally true.
Right.
It's like why men rape. Because 99% of the time they get away with it. Men wouldn't rape if they thought they'd get caught. There's a lot of research around that. You can go after the government, but you have to be clever. For example, the Supreme Judicial Court decided a case this week against a select board in Nantucket. A woman who was a family who was very upset about disgusting racist language being spray painted on a building that was black. Church. I don't know if it was a black church. It was a community house of some sort, which was clearly attached to black people. They were upset that the select board was covering up information about who actually did it. So what they did was try to speak about it at select board meetings. And they would go, the people who cared about the cover up would go to the select board meetings and say, I'd like to talk about the cover up. I'd like to talk about the police not investigating. I'd like to talk about this board not holding people accountable. And they got shut down. Over the course of time, these people who were angry about the cover-up said, we're going to go to court and sue you. Well, guess what? You can't really sue for money. And so they didn't. They sued for a violation of free speech. What that probably means is, best case scenario, they win the point, which the Supreme Judicial Court said, yes, this is a violation of free speech. You can't be silenced. You can do whatever you want at a government meeting. You can be rude. You can be, you can accuse people of corruption, and you can't be silenced. But you don't necessarily win money. What you might win is a ruling that this can never happen again, which puts the board back on its heels. They behave better. Why? Because now they're afraid that maybe the next case will be a money case, because there are exceptions to that rule that you can't sue for money, and those tend to involve things like
the loss of qualified immunity, like violations of civil rights under 1942, 1982.
81, 83, the kinds of cases where you're not quite immune anymore because it's the Constitution.
Because you were acting under a color of right and you violated a principle.
But you were violating at this level, really high.
Like a core constitutional principle, like the right to privacy?
Core constitutional principle, violation of fundamental rights.
Now, let me ask you, you do seem to be saying here that there are multiple remedies if qualified immunity is stripped. Now, we often see qualified immunity come up in the case where cops beat someone to death, and it's very rarely stripped in that case. Here, we're talking about qualified immunity being stripped because of a deprivation of a core constitutional right. Now, I want to ask you something else before we have to get to your federal lawsuit. People are very interested in it, and we have some questions from the users. But first, what just as a core reform measure, so, I obviously was recruited into the antitrust section of the DOJ. I didn't really want to do it, but I do think what would really interest me is if the DOJ, among its 75 sections, had a specific section for enforcing the constitutional rights of victims in the context of police officers and public officials, like a public integrity section just for police officers who violate victims' rights. If such a section were proposed, and if I were running it, would you support it?
I don't know. I mean,
the answer to that question is an unequivocal yes, and also a middle finger to the state police.
I don't waste my time on things that are going nowhere. So
don't give me that nonsense.
Even if you persuaded me that this idea,
I'm going to do it just to spite you. I legalized cannabis just to spite you. Don't mess with me.
I'm just saying, I work in a context where everyone and their mother thinks they have a grand idea. They're going to pass a law. You know what I say? Don't bother me.
Well, you remember when you used to say,
waste my time supporting a law, because the bigger problem is enforcement.
Yep, and remember,
don't tell me you think a law is good when it's not coming with meaningful enforcement. I won't do busy work.
I agree with you.
Waste my time.
I agree. That's why it's not just the statute, it's who's running the section of the DOJ that's enforcing it.
It's a political issue you cannot control.
Oh, well, yeah,
will.
I'm a towel. But let me ask you this very specific question. Before we transition on a lighter note, do you remember as a kid, you used to always say to me, Grant, you know what? If you want to use that damn cannabis, you've got to change the law. Now, what did I do? I marched right up there to Beacon Hill. I created a statute with my colleagues, and then we created a regulatory codification to ensure its enforcement would be in line with our priorities. That's what you do.
I would love to give you credit for changing the
Not
law.
just me.
Unfortunately, it's a gazillion-dollar industry that changed the law, and they're continuing to do so for money. They don't give a shit about people who get addicted or struggle or suffer. Marijuana is not simple. It is not always healthy. Some people become extremely addicted, and it interferes with their quality of life. Not everybody.
I know, and the alcohol industry loves when people say, listen, the alcohol industry loves when people say that alternative medicine is addictive. I know, listen, I understand. I understand. The alcohol industry, I understand.
That some people benefit from alcohol. I don't care. What I care about is that moneyed interests drive change, and that is across the board.
Yep.
And moneyed interests don't care about people.
That's why the alcohol industry. That's why the alcohol industry. That's why the alcohol industry hates.
It's big food. It's big pharma.
Right.
It's marijuana. It's everything.
Listen,
Everything.
is it true that the alcohol industry and big pharma hate anything that comes from the ground? Yes.
No, they hate
Oh,
people taking their money.
Yeah.
They
Alternative.
don't care about people. They care about money.
Alternative medicine is
anything that cuts into their profit margins is a problem.
like alternative medicine.
And exactly, and we come full circle to the problem, which is violence against women makes enormous amounts of money for big porn, which is the number 2 lobbyist.
I agree with that.
In Washington, they lobby as free speech.
I agree. MindGeek.
Fraudulently.
Yeah, I agree. MindGeek, the company that owns Pornhub, is a huge lobbyist interest. And you have to ask yourself, why do we have a situation where consenting adults can get charged for prostitution for exchanging money for sex, but if you film it, it's legal. It opens the door to human trafficking, and people don't want to talk about it.
Anywhere there's money to be made, it's rendered legal, and or they just don't enforce the laws. Like, some people think it's so great that there are now age restrictions on who can access porn online. Make no mistake, there is profit to be had in the industry figuring out the market at the age line, right? This isn't about protecting children. The kind of money we're talking about is so powerful that you could even end up voting for a law that appears to be about, supporting bike lanes, and it's actually funded by the trafficking industry for some reason. It's so hidden. These dollars are so hidden that when you think you're voting for something that looks good, like there have been some recent changes in laws around strangulation, both in Massachusetts and around the country. And everyone's like, isn't this great? And all the women's groups said, isn't this wonderful? We're making strangulation a crime. No, before the changes, strangulation was a very serious felony for which you could face mandatory time behind bars. It was considered a life-threatening felony, and it was almost like using a deadly weapon. Then the porn industry went to town in literally every state in this country, but packaged what they were doing as good for women, protective, respectful, and they got all the corrupt rape crisis centers to support it, and created a misdemeanor crime around strangulation, and only in certain circumstances, based solely on whether you basically almost die. So all forms of strangulation in porn, unless you die, have now become either legal or misdemeanors rather than highly threatening felonies. And yet all the experts know that if there's hands on the neck or in the face, anywhere up here, that is the most risky form of physical contact that is most likely to lead to a woman dying. We have now bumped that down to spitting on the sidewalk, and yet all the women's groups celebrated. Why? Because they got funding from the porn industry funneled through porn-funded groups like the ACLU that sent their dollars to these women's groups who then said, we support this, we lobby for this, this is wonderful, this is wonderful. All I'm saying is, anytime anything is proposed as a legal change that might affect violence against women, you can assume it is bad for women, good for profits.
Yeah, and you make a really good point about strangulation, because even the people who think they're like misguided in their use of strangulation, listen, I'm not in any part of government, as you know, Mom, and I think even people who are could not in real time necessarily get the difference between the jugular and the other vein, and if you screw that up, you are going to kill someone. So I don't know why people choke other people. I don't understand. It's very dangerous.
Strangle. Never use the word choke.
Why? What's the difference?
Very important difference. Language is everything. Choke, although it has a double meaning, and it could mean hands on the neck, it also has the possibility of distracting your brain from thinking differently, because it could be you just didn't swallow your hamster. Strangulation is a violent felony, right? When you use choke, there's no choke in the criminal code.
You know where it comes from? It's because, you know why people use that lexically nowadays? It's becoming more common. In MMA, a move that involves doing that is called a choke. They don't call it a, I know.
The porn industry is also behind MMA, the eroticization of violence, making violence exciting to the cortisol in the brain. What I'm saying is, choke is the chosen word of the porn industry, so we never use it.
Oh, I understand.
Even if it doesn't offend you,
right,
knowing that they want you to use it is why you must never use it.
I understand. So that's interesting, because now you just think of it as like an MMA term, but that's very interesting. It does show the power of words, though. All right, we have some questions. Let me try to get to them. So first question from Vicky Towell, who is from Canada. We had Vicky Towell's 2 cats up as the animal of the day yesterday. They're adorable. The first question from Vicky is, well, first she says, thank you, Towell Mom, for being here. What does the current DOD under Pete Hegseth think about your position in your lawsuit?
Well, let me talk about the lawsuit before I answer that, so people know what the hell she's talking about. She's right. Thank you for reading. Thank you for reading what I shared with Grant, because it's complicated. It's not a straightforward case in terms of all the layers, but it certainly does beg some questions about who thinks what, and Hegseth has a lot of, let's just say, potential to cause havoc to my case, and I'll explain by backing up to the beginning and then give you the Hegseth piece. So I sued earlier this year in Massachusetts federal court, accusing the federal government of discriminating against women because of a federal statute that requires men to register for the draft but forbids women to register. So it's explicit in the sense that it is black and white discrimination, which, by the way, most discrimination today is not black and white. It used to be. 50 years ago, there were laws that said men can do this, women can't, from serving on juries to serving as executors for wills to, all sorts of things, right? It was black and white. Men can't, women can't. Over the course of time, that has become the rare exception to the rule, because most discrimination against women happens in enforcement, which is not in black and white. It's all about, subtle legal standards that allow weaker enforcement of all laws when it's on behalf of a woman, and really strong enforcement of laws when it's on behalf of a different person. So the enforcement piece makes it a little cloudier to see why women still suffer as unequal people. But I want to start off by saying the law became attractive to me as a vehicle through which I could file this case, because my goal really isn't about making women sign up for the draft per se. It's about creating legal equality for women and using this black and white example of inequality to make people see the problem better. So what do I mean by women are unequal? Well, I have another document I can share with you, a recent law review article that Grant can link to. It was published in Ohio Northern University Law Review a year ago, and the subtitle of which is Constitutional Terrorism, which refers to women's current status as second-class people subject to unequal enforcement of all laws. And I mean all laws, from freedom of speech to laws about how you get your dog license, to laws against slavery, and to laws that are supposed to protect you from abuse. All laws can be applied differently and worse to a woman. That's what it means to have second-class citizenship. Well, where did this come from? Well, historically, our original Constitution was very explicit that men have rights, and although it didn't say women don't, by use of the word men, it was clear that women were not in the game, if you will. Then we had the Civil War, which ended with the Reconstruction Amendments, 13th, 14th, and 15th. 13th abolished slavery, most people know. 14th created equal protection and due process rights for persons, but it also gave voting rights just to white men. Most people don't remember that part. And then the 15th Amendment, a few years later, gave voting rights to Black men. Women were completely left out of the Reconstruction Amendments, which wasn't inconsistent with what our Constitution had provided before, but now it was clear. Now it was really clear. And what it meant, so this is around 1868, 1870, it meant that although the Constitution now says that persons shall have due process and equal protection rights, when women went to court after the 14th Amendment was adopted in 1868 and said, well, we're personal protection rights, the courts said, no, women are not women. And they never explicitly said that. They just never recognized women as persons from 1868 on until, and most of my students finally became person amendment in 1970, which was not that long ago. When women became person, however, the most important aspect is how we became persons and what it actually meant. The case was called Reed versus Reed, which is why I have a daughter named Reed.
Oh, I didn't know that. Knew you had a daughter.
It's one of the reasons.
I didn't know that was one of the reasons. Oh, by the way, so your internet, it's not, people were asking if the stream got delayed. For the last 20 seconds, your internet connection went in and out. So we only heard a little bit about 1972 onwards. You might want to start up to the Reed v. Reed, because it wasn't you, it was the Zoom. So over the last 10 seconds, people didn't exactly hear what you said.
Okay. So in 1868, it was adopted. It gave equal protection. You weren't a person under the law. You couldn't assert equal protection rights. Women tried. Right after 1868, women tried to go to court and argue, well, we are persons, so we have equal protection rights. No. The Supreme Court consistently declined to entertain equal protection claims on behalf of women who were treated unequally. And that didn't change until 1971, when the Supreme Court said, okay, fine, women can be persons. Only in 1971 did we become persons. And you might think that's terrific, except that the court said women's personhood rights under the 14th Amendment will be subjected to unequal enforcement. So we got unequal equal rights, which makes it really hard for people to grasp, comprehend, understand. How the hell can you have unequal equal rights? How is that possible? Well, the reality is it is possible, and it is the law, and it is still the law today. It was the law as of 1971. We have been fighting ever since then to bump ourselves up from unequal equal protection rights to full equal protection rights. And the device we embrace to make that happen is called the Equal Rights Amendment. You look frozen to me. Are you frozen?
Yeah, because the Zoom was buffering. I froze my camera so your audio would be better. Now they can hear you.
Okay, good. So, since 1971, and even before that, women were fighting to establish the Equal Rights Amendment as another amendment to the Constitution, because remember what I said about the 14th Amendment. What it took away, what it didn't give to women was voting rights and equal protection rights. So women said to themselves, right away, we need to go fix the Constitution with our own amendments. First, we'll get voting rights, which we did. It took a long time. We didn't get them till 1920. With the 19th Amendment, we got voting rights. And then immediately, led by Alice Paul and the National Women's Party, we went from voting rights immediately to a proposed Equal Rights Amendment to fix the 14th Amendment's equal protection problem and make women part of that. That went nowhere for a long time, from 1920 when it was 23 when it was first proposed until 1971, when we were rising up and getting Congress to pay attention. And there was a lot of momentum in Washington to get Congress on board with proposing the ERA, which under Article 5 of the Constitution means once Congress approves it, it then gets sent to the states for ratification by 3/4, which is 38. 38 states would have to approve the ERA. Well, coming up to 1971, there was so much momentum for the ERA that we just assumed it was going to be successful. There was so much support for it. It was the civil rights movement, and women were part of that. I don't even separate out women's rights and civil rights, because civil rights are women's rights and vice versa. So the problem was, again, these moneyed interests didn't want women to succeed with the ERA. So the Supreme Court kind of got involved, if you will, in taking some air out of the ERA's balloon by giving us personhood in 1971. Remember, the ERA was eventually passed by Congress in 72, sent to the states thereafter, and it kind of fizzled. Because, you have to both get Congress and then the states to approve a new amendment. Well, on its way to Congress, so again, in 1971, the Supreme Court kind of injected itself into the controversy by deciding Reed versus Reed and giving women personhood, albeit third-class personhood, because women's equal protection rights would be unequally enforced. And when it did that, there was a lot of celebration because we were at least persons, but we knew it wasn't good enough. So we continued to fight for the ERA, but our argument was weaker. It took some of the air out of our balloon because we couldn't now say to Congress and to the states, we're not even persons. You need to do this ERA thing because we don't even have personhood. So it was both good and bad, if you know what I'm saying. And in my view, the Supreme Court did that on purpose to weaken the political fight for the ERA by giving us a little bit of what we were demanding. And nonetheless, we got the ERA passed through Congress a year later, but here's what happened. Until 1971, the ERA simply said equality of rights under the law shall not be denied or abridged by the United States or by any state on account of sex. Very simple. Because of the Reed versus Reed case diminishing public demand for the ERA, just, saying we already gave you some of this, so you don't really need it anymore, Congress was able to attach a restriction to the ERA, which was a 7-year deadline, meaning Congress will pass the ERA, send it to the states for ratification, but the states only have 7 years to get it done. Before 1971, and from when it was first proposed in 1923, there was no deadline. The 19th Amendment didn't have a deadline either, and it took us a long time to get that done, so it's good it didn't have a deadline. Well, we also didn't want a deadline on the ERA because we knew, geez, it took us that long to get the vote. We'll never get this done in a short amount of time. We need however long it takes. But politically, Congress couldn't get away with attaching a deadline until Reed versus Reed. And then they went right to the deadline, stapled the deadline to the ERA, and it went right through Congress only after the deadline was added.
And hold on, I'm audio only. We had a question about what a deadline is. So you did a really good job. I think a lot of people get that what the Equal Rights Amendment is to make up for the fact that the 14th Amendment really didn't protect women. Now the vote has been checked off, so to speak, but the due process equal protection part not checked off. And what people are wondering is, you're talking a lot about a deadline. I think for you and I, it's parlance. But a deadline is how long the appropriate or requisite number of states technically have to pass an amendment. Now, what you're saying is you can attach a deadline outside of the amendment, but that doesn't make it a deadline. It's just words on a piece of paper. But what is a deadline in what is this all about? Why does this matter to whether the ERA is valid?
So because without a deadline, women would have as long as they need to get the states to ratify once Congress approved it. Again, under Article 5, the way the amendment gets amended, the way the Constitution gets amended is Congress has to propose an amendment, and then it has to send it to the states, who have to ratify it by 3/4 of the states. That's 38. Without a deadline, we could take as long as we need. Once Congress passes it, we can take 500 years. It doesn't matter. But Congress attached a deadline after the Reed case, which they could not have gotten away with politically had Reed not happened. So a lot of academics like myself do criticize the Supreme Court for doing what it did in the Reed case, because it made it possible for Congress to get away with attaching a 7-year deadline. Once the deadline was attached, most women's rights advocates at the time said, we're screwed. We're never going to get this done in 7 years. Like Alice Paul, who I love and was really fearless and incorruptible. Alice said the day that Congress passed the ERA, but with the deadline, Alice said she was crying. There's a famous story about her crying, and somebody approached her and said, are you crying tears of joy? And she said, no, I'm crying because we just lost. The deadline is a guarantee we will not win. And she was right. So right away after this ERA passed, 22 states, I think, ratified very quickly. And so there was this sense that things were moving well. But pretty quickly, the momentum stopped. The momentum stopped in 1973. And the reason for that is the Supreme Court decided 2 more cases, both of which were celebrated, but neither of which was actually what women needed. Nevertheless, they completely took the political campaign down to a zero. And here's why. In 1973, the summer of 73, the Supreme Court decided 2 cases, Frontiero versus Richardson, and then Roe versus Wade. We all know what Roe versus Wade did. They created constitutional protections for abortion rights, and it did so under an enforcement standard of strict scrutiny. Why does that matter? Excuse me. Strict scrutiny. God. My goodness, I'm so sorry. Strict scrutiny matters. I think I'm just talking too much. Strict scrutiny matters because it is the gold standard by which courts enforce claims of discriminatory treatment. Remember, I said Reed versus Reed gave women equal protection rights, but gave them an enforcement standard way, way lower than strict scrutiny, called rational basis. Strict scrutiny means discrimination is going to be highly rigidly scrutinized by the court. And if there's any reason not to do it, and if there's a way to get the government's thing done without doing it, then the law gets stricken. Under rational basis scrutiny, which is at the bottom, the government can do basically what it wants. It just has to come up with some plausible excuse for why it's doing it. If it says, well, this is cheaper. Okay, you win. That was rational basis. I do a triangle to explain the concept. It's a little bit easier to conceive of it through a triangle because it's a bit abstract. But if you have a triangle and you draw 2 lines across it horizontally, and there's a little piece of a triangle at the top and a big piece at the bottom, the little triangle at the top represents how much discrimination is tolerated by courts. And it's a little tiny piece, so very little makes it through that triangle. Women were at the bottom. That's where rational basis is. An enormous piece of the triangle, lots of discrimination makes it through because the level of judicial scrutiny is so weak. Women got rational basis in Reed versus Reed, and in 1973, we got bumped up to strict scrutiny. Why does that matter? Frontiero versus Richardson gave women strict scrutiny, and overnight, states stopped ratifying the ERA. Why? Because when women went and said, you need to ratify the ERA, this is a really important amendment, women need it, we've been fighting since 1868, the states said back, you don't need the ERA anymore. The Supreme Court just gave you strict scrutiny. You got bumped up from rational basis to strict scrutiny. You don't need the ERA anymore. Sorry, we're not going to ratify. It gave states that were not yet ratified a plausible, not objectionable excuse for not ratifying. So really the ratifications grinded to a halt starting in 73. I think there was one later that year, maybe one a couple of years later. Before the deadline, this was all about before the killing the ERA's ratifications before the deadline. So again, I said the 7-year deadline from 72 to 79 is the window we had. These cases happened in 73, and there was zero political will. Maybe a couple of states ratified. By 76, there was no political will to ratify. There were maybe a couple of states after that that ratified. But by 1976, everything was dead, basically, on the ERA's ratifications. And that was the year the Supreme Court decided Craig versus Boren, which bumped women down from strict scrutiny to that middle piece of the triangle called intermediate scrutiny, much, much weaker than strict scrutiny, which we had for all of 3 years, but not as low as rational basis. We got this invented category called intermediate scrutiny that
we might have to pause here because we did go through your brief, and I think people understand that when Tao Mom's talking about the pyramid here, when we're talking about scrutiny, what it is referring to in lay language is what standard the court applies when it's looking at state action. So a very good way to think of this, maybe Mom, you can explain this, is let's use 2 examples. Let's say Wisconsin wants to make a law allowing women between 18 and 21 to only drink 3.7 ABV beer, whereas they want to let men between 18 and 21 drink 5.4% ABV beer. Let's say the Virginia Military Institute wants to only allow female cadets but not male cadets. Can you explain the 3 different standards that the court could apply in those cases to determine if the state's action met the sufficient burden? So rational basis, intermediate, strict scrutiny.
Well, let me put it to you this way, because it's a little difficult to do it through those case examples.
Because those are the 2 cases on point?
No, it's not that. It's just that they don't really explain the difference. Under strict scrutiny, the government cannot discriminate against a group of people unless there is a compelling reason, and there's no other way to accomplish their compelling reason but for this degree of discrimination. So in other words, let's say the government said, we want, I'm trying to think of a good example. We think there ought to be, Black only water fountains, for example. And a Black person goes to court and challenges this as discriminatory. The court has to ask itself this question: is separating water fountains based on race a compelling government interest? Well, there was a time when the government would have argued, I'm not saying this would work today, but this is what they would have said. Yes, because, we need to protect people from each other's germs from different races. Let's say they said that. The court would say under strict scrutiny, that's not a compelling government reason to separate people, because you have no statistical support for that claim that drinking from the same water fountain causes a public health problem. So you don't have a compelling reason to discriminate. And even if you did, you have to also show that this idea of separating water fountains is the least restrictive means by which you can protect the public health. This assumes you actually have a public health claim. You also have to show that there's no other way to protect the public except to separate water fountains. So under strict scrutiny, that would absolutely fail and be perceived as absurd, discriminatory, and outrageous. Under intermediate scrutiny, if, for example, the issue was that the government passed a law saying, we're going to require the proof in cases involving violence against women to be more onerous than violence against other kinds of people. And let's assume women sued and they go to court and say, this is discriminatory. Number one, under strict scrutiny, the government would have to prove that it had a compelling reason to treat violence against women worse. They would have to have a compelling reason. Under intermediate scrutiny, they only need an important reason. And an important reason might be, well, so much abuse happens in the home, we don't want to undermine the integrity of families, so we want to make it a little harder for women's cases involving women victims to be prosecuted because we don't want to disturb the integrity of the family. That's enough as an important state interest. It's not a compelling government interest, but it might be an important state interest. Then at the bottom, I'm sorry, but then, the other piece of it is you don't have to show that this is the least restrictive means by which you can accomplish that goal of preserving the family. You don't have to show that. You don't have to show least restrictive means at all. So if I go in as the lawyer and say, another way to preserve the family is provide more services, allow women, mandate that women receive fully equal pay, like all these different ways that you could actually keep the family together are better than allowing women to be beaten in their homes. I could make that argument under strict scrutiny and I would win because I have given the court an alternative way to satisfy their interest of preserving the family. Under intermediate scrutiny, because I'm not allowed to make the argument that there's another way to do this that's less discriminatory, that imposes less on women's rights and equality. I can't win under intermediate scrutiny, even if I can show that there's another way to do this that's less imposing on women. That's the difference.
For example, would a separate but equal facility meet the threshold under potentially? I know it didn't in VMI. Potentially.
Yeah. And another good example is, which I mentioned earlier, women are not protected under the Massachusetts hate crime law. That would be illegal under strict scrutiny, and it's legal under intermediate scrutiny.
And then go ahead.
No, because the state could make the argument that there's an important reason we don't include women in this category, and that important reason is fill in the blank. It might just be that it's difficult to differentiate between hate crimes against women and crimes against women that aren't technically hate crimes. The kind of administrative burden of figuring out the difference could be an argument that you could make under intermediate. You could never get away with that under strict.
And then going to strict scrutiny. So I think a lot of people get a little nervous about this because they think, strict scrutiny means men are going to be in women's locker rooms, women are going to be in men's locker rooms. That's not what it means. But let's hold on. Let me just explain the test because you use very complex legal terms, which I love. Some people love, but let me just translate it. What it is once we get up to strict scrutiny, which you will explain, it's not that the government can never create something like a female-only locker room. It's that there's a three-pronged test. Could you explain that? And then why it's so important to have this heightened test and why it doesn't mean that men are going to be in women's locker rooms, which people just don't understand. It doesn't mean there never can be a law treating men and women differently. It's what the government has to assert as the reason, and the court has to apply a higher test.
Exactly. And so just as an aside and kind of another way to conceive of this, it's legal equality doesn't mean sameness. I mean, black and white people aren't the same. They have different colored skin, right? So they're not the same, but being equal under the law is a different issue. So let's say under strict scrutiny, for example,
let's use the locker room examples because in Massachusetts,
I'll use the locker room, but I also want to say under that race gets strict scrutiny, and yet there are laws that are allowed to discriminate based on race. For example, if a movie director is making a film and they want to hire a black actor, they're allowed to choose a black actor without somebody saying that's racist, even though it is racist because they're choosing a person based on race. Why is that allowed? Because under strict scrutiny, a law that allows movie companies to choose people based on race when it's necessary for their artistic endeavor, under strict scrutiny, you can do that. If there were no scrutiny at all, if everything was about sameness, there would be no small triangle of opportunity to do things that are necessary for other reasons and justifiable under the rigid standard.
So it's kind of like an exception to the Fair Hiring Practices Act.
It is. It's
okay.
BFOQ, but also the point is, no one's ever thought that strict scrutiny meant sameness because there have always been these legal doctrines recognizing that differentness is not inequality, but you have to be careful, right? You can't have separate but equal schools, for example, after Brown versus Board. which is great, logical, and it would have been asinine to continue to push the Plessy rule. But the reality is Plessy versus Ferguson, which allowed separate transportation for Black and white people, right? It wasn't even about schools. Plessy was about trains, I think. You could put people who are Black in one train and separate them from white as long as they got the same train. Separate but equal is not tolerated generally under strict scrutiny. It is very tolerated under intermediate scrutiny, which is why, for example, in the university context, we have a separation of Title IX and Title VI. Title VI covers all sorts of categories: race, religion, national origin, ethnicity, and is subject, in terms of what Title VI speaks to, it prohibits discrimination in education based on those categories. And it actually also includes non-education. It includes federally funded programs that aren't even about education. Women, on the other hand, got segregated out for Title IX. We wanted to just be added to Title VI back in the 60s when we were fighting about this. We just wanted to add women to Title VI. Extremely well-funded sources said, no, we'll give you your separate law, and we'll call it Title IX, and that'll just be for sex, and it'll be treated differently and worse than Title VI. Well, wait, that's not fair.
And you're talking, just to clarify, you're talking about the Civil Rights Acts, which were started in, I think the first one was in 55, but the real robust one wasn't until 64. And then there were amendments to the Civil Rights Act, like the Education Amendments in 71 or 72, and then the Title IX amendments. What you're really talking about is the full canon of civil rights laws that exist, but that's separate from the Constitution.
Title IX only applies to education, but it's the point is, when women were fighting in the 60s for equal rights under both the Constitution and under civil rights laws, we said we want to be part of the 1964 Civil Rights Act, which includes Title VI. Stick us in there, which prohibits discrimination in federally funded programs, including schools. We want to just add sex as a category. Please do it. This was simultaneous with us asking for equality under the Constitution with the ERA. We had these two things going. And well-funded interests said, we're not putting you in Title VI. We're going to give you a separate and unequal space under the education amendments, where you will get this seeming promise of equal treatment in education that looks like Title VI. It had the same language as Title VI. So that when you go to school, you're going to be treated the same as race, national origin, et cetera. Well, separate but equal doesn't work like that. There's no such thing. Separate is inherently unequal, and that's exactly what happened right away. Title IX became subject to very different and much worse enforcement standards compared to Title VI, because that is constitutionally permitted under intermediate scrutiny. So that's just a good example of what happens to women under intermediate scrutiny in the context of civil rights laws. Here's Title VI, really bad. If you get in trouble under Title VI on a college campus, you're gone. They do really aggressive,
especially with anti-Semitism, right? That's a very big thing right now. But not the flavor of the week. Yeah, I'm just saying, what is an example of Title VI? I don't even know what that is.
Title VI is the same as Title IX, except it applies to race, religion, national origin, and so forth, ethnicity. So my point is, when Title VI was adopted, and it also applies beyond the school, it applies to all federally funded programs, whereas Title IX only applies to education. It doesn't apply to other federal programs. So when we went to Congress in the 60s to sort of fight for equality, we said we want equality under the civil rights law. And while we have that, we'll be pushing for the ERA to be ratified in the states. So we're going to have civil rights equality while we're waiting for constitutional equality to come to fruition through ratification of the ERA. We did both things. And Congress said, no, we're not going to give you equality under civil rights laws. We're going to give you second-class status under civil rights laws by segregating out sex and giving it Title IX. And then because the language was the same as Title VI, which is to say, the language says, there shall be no discrimination based on race, religion, national origin, and this one said there shall be no discrimination based on sex. The language was the same as Title VI, but because women didn't have equal enforcement rights under the Equal Protection Clause, in other words, the Equal Protection Clause of the Constitution modifies everything. So if you're not required to enforce all laws, including civil rights laws, equally on behalf of women, then you can legally, as the government, create a separate and unequal law called Title IX. And even though it's much worse than Title VI, it looks the same because the words are the same, but because it's separate and the Constitution allows separate and unequal enforcement, Title IX has always been treated worse. You're much more likely to get away with harming a woman on campus than harming any of the categories that are.
Oh, and Mom, can I jump in a bit about this? Because a lot of people, I don't mean to take us on a sidetrack, we are going to get back to the lawsuit and the question about Hegseth. And by the way, I'm here. The reason my camera's paused, if anyone's wondering, is it saves bandwidth so you can hear Towel Mom's audio better. The reason why I want to jump in right now is what you just mentioned. Could you repeat that last point that you were making? I can play it back as well.
Oh, yeah. So women were fighting for two things in the 60s. One, the ERA, because we wanted to fix the Constitution to give women equal protection of the laws, and we didn't have it. We still don't have it, but we didn't have it at the time we were fighting for civil rights. So we said we want constitutional equality, which you haven't given us ever.
I remember the question. I'm so sorry. So you were mentioning the Title IX disciplinary process on campus, and a lot of people have been following the Idaho 4 case involving a guy we only refer to as BK and the four victims, Maddie Mogan, Xana Carnoodle, Kaylee Gonsalves, and Ethan Chapin. Okay. Now this case is very brutal. I know you've probably seen a little bit about it on social media, but some of the new documents that have come out and that what people want to hear your perspective on is, what do you feel about the fact that Brian Koberger BK was pursuing a degree at, I believe it was Washington State University at Pullman, and his own professors were reporting that they couldn't give this man a PhD because he was getting so many complaints from the female students on campus. How often do you see female students trying to bring reports to campus administrators and it just being silenced? And how much of that might be playing into why there's so much hush-hush about what BK was doing prior to the Idaho 4 murders?
Well, it's a very good question. I don't know the answer because I don't know the case very well. I did hear that he was in an advanced degree program and that there had been complaints about him in terms of his treatment of women on campus and elsewhere. It is unequivocally true that schools disproportionately ignore threats to women, violence against women, sexual assaults, all forms of discrimination. It's sort of one of the reasons why on a campus, whether K to 12 or beyond, if you use a derogatory word about an Asian person, a gay person, if you use a slur that's based on race, you will get expelled. Maybe not forever, but you'll get in bad trouble. And if you use the most derogatory word against a woman, you will not. I mean, it's kind of, that's part of the hierarchical sense of what it means to be under Title IX, which is a, ugly stepsister, if you will, law compared to Title VI. Title VI is incredibly strong. The Department of Justice has authority, and in some ways, I don't want to call it a mandate, but they're compelled to do more to enforce Title VI. Title IX, they can, but don't have to. It's like they can ignore it. So the concept of Title IX being a second-class, different and worse form of civil rights law is important, because most people don't even think of Title IX as a civil rights law. They won't use the language. They don't think it's a civil rights law. It is. It absolutely is. But there is so much money behind not treating women equally under any law that if you even use the language civil rights when talking about women, there's a sense of recoiling. If you use the phrase women as a class, there's a recoiling. Women are absolutely a social and political class. We are, and always have been, a class of people, but the law really resists using words like class and civil rights to describe women, because there's a lot of fear that women could unite if they started to think about themselves as a class. And we have incredible potential as a political class because there are 170 million of us in this country. Half the population are female. If we came together and united and voted together, resisted partisan politics, fiercely refused to align with either party, and just said, we are nonpartisan and incorruptible, and we will vote against anyone who doesn't do what we want, we would control the government tomorrow. The fear of that is so deep in the government that they do things like manipulate linguistics to inhibit women from seeing themselves as a class. And there's a lot behind like this concept of intersectionality that's kind of an academic watering down that feels good. Oh, don't focus on yourself as a woman because you've got so many other issues. You're Black, you're gay, you're trans, whatever. No, women need to and often want to prioritize their sex-based suffering to the exclusion of other issues, because most women suffer first and foremost and most harm based on sex. They might also suffer based on other things, but invariably, if you ask a woman, what kind of discrimination do you endure the most? Is it based on your race, your religion, your sex? They always say it's because I'm a woman. I suffer unbelievable. Every woman says it, and yet we don't come together around it because there's an incredible pressure on us not to prioritize sex-based suffering, to be intersectional, because otherwise you look like you're disrespecting your Black sisters or your gay sisters or whatever. No, all of my friends and colleagues don't want to bear the burden of having to always mind everybody's everything. All of my colleagues want to prioritize the femaleness of our sameness and use that united power for political reasons to solve all sorts of problems, right? If you don't come together as an identifiable class, you can't get anything done because you are a watered down mess of nothing when it comes to voting power. If you worry about all your different ways of suffering and all your other issues,
Yeah,
and you know, abortion is a good example. Only 2% of women get abortions any year. It's not the most important women's issue, not even a little. It's just not.
But to be clear, you certainly don't feel that states should be able to like do things like force women to give birth if they're victim of an SA or so. But and we have states that are doing that. So your response to
yes, I don't care that they're doing that. What I care about is women fighting in the weeds rather than saying the real remedy for abortion restrictions is the ERA. Your voice around all the things you care about is weak unless you are an equal person under the law. So if women got elevated to full personhood with strict scrutiny, everything we care about would be more fixable.
Wouldn't it be nice if politicians, and I agree with you, but wouldn't it be nice if politicians maybe didn't force victims of SA to give birth to the children that were byproducts of that horrifying crime? Wouldn't that be nice?
I've written a lot about this too, because again, this is not something people understand very well because of how it was propagandized. In 2012, I want to say, Congress passed a bill giving states grant money in exchange for them passing laws giving parental rights to rapists who impregnate their victims. So think about that. Congress passed a law giving states money if they then passed laws giving parental rights to rapists who impregnate their victims. People thought this was a great idea because of how it was presented. They said, well, this is just going to, the way they worded it was, this is going to give the states the authority to pass laws taking parental rights away from impregnation rapists. When I read it, I said, this is just a big lie. It's a big propaganda lie because the way it was framed as you can now take parental rights away from impregnation rapists presumed they had rights to take away. But the reality was the law at that time, and still to this day, does not give parental rights based solely on DNA. So if you're a rapist and you rape someone and you cause pregnancy, that doesn't give you parental rights at all. You don't get.
Right. So can you explain to me where then, setting aside that precedent, where any politician, I don't care what part of the spectrum you're on, would then, knowing that's the law, say, well, you know what, if a woman is a victim of SA, we're not going to allow her to get an abortion. How can someone get there ideologically, knowing that parental rights could be at play for the person who committed the SA? How could any politician get there ideologically?
Because I testified about this at the State House when the Massachusetts legislature passed a law.
No, sir, hold on. We're talking about Texas passing a law saying, and this is on the books. So I need to understand.
I'm going to answer your question. This is the answer. When I testified in Massachusetts, because there was a proposal, once that federal law came through, there was a proposal in Massachusetts to change the law to give parental rights to convicted rapists who impregnate their victims. When that came through, I was waiting for my time to testify, and the lawmaker who sponsored the bill said, we have to do this because there's a lot of federal money here for us. That is, in fact, related to why abortion restrictions end up being proposed as well. It's never about morality. It's never about what's good for victims. It is often about controlling women, which again translates into dollars. It's often about forced birth, which translates into control.
So you see a system like Texas where if you get SA'd as a woman and you're forced to give that birth, you see that as a way of the state saying, that was your fault. You were not supposed.
Not just your fault. It might not be your fault, but once you become pregnant, your body has no absolute autonomy anymore. I mean,
that's horrifying. No, I can see the argument.
That's the nature of abortion. Even with.
But I can see the sure. But I can see.
Even with Roe versus Wade, women did not win autonomy over their bodies because it became a doctor's decision, really, right?
But,
what trimester are you in? The doctor got to decide if you could do something with your body or not. Roe versus Wade was celebrated as a great victory for women, but a lot of women were angry because other countries don't have any restrictions and they have very low abortion.
Right. And I am very religious. I just want to be clear. Everyone is entitled to their own beliefs. I don't ever want to superimpose my religious beliefs on the legal system, not to mention some monetary profit for some doctor or some other thing. What I'm purely interested in is I can demarcate ideologically for people I don't necessarily agree with. I can demarcate their issues with abortion that is not in the context of the result of an SA or something like incest. I can understand the debate. But I don't even understand how there's an Overton window or a spectrum of argument about what should happen in the case where a woman who is a victim of SA should do. I don't think there's any argument pre-Casey, pre-Roe, post-Casey, post-Roe, post-Dobbs for any state imposing a law that forces a victim of SA to give birth, regardless as to the permissibility legally. I don't understand it ideologically. Forget about the doctors, the state.
Dobbs. Under Dobbs, everything changed because Dobbs said there is no constitutional right to abortion so that the states can do what they want.
But how could the Supreme Court not realize that by saying that? What they were saying is there's no protection for a victim of SA in a state that wants to force them to give birth.
Is that people need to advocate within their state for an exception.
Okay, well, no one's going to change Texas's view, which is why I don't understand how these Supreme Court justices can go to bed at night knowing that there's even one woman out there who is a victim of an SA that has to give birth to that child without an option.
You think that they care about people? They don't.
They do.
They care about money.
Then I don't want them on the Supreme Court.
Then but this is not.
All right, I'll get them off the damn Supreme Court. Oh yeah, well we wouldn't have got West.
I want to say this about Dobbs, which is hard for people to conceive as well because it's a little bit complicated. By getting rid of the constitutional basis for abortion, the only thing women are left with is due process as a restriction on forced birth, right? So where does the due process line sit compared to where things might have been sitting line drawing wise when there was a constitutional basis for abortion? It's a very different line, but it's still a line. And the current battles in the states are oriented around that line, with the conservative states saying the only line is the life of the mother. Everything else is underneath the line. And other states saying, no, the line is somewhere over here where it has to do with if you get raped, if your health is at stake. Like, these are the lines the states are drawing, but the only line left, because abortion is no longer a constitutional doctrine, The only line left is life. And that's because that's a due process drawn line. You can't take someone's life. That's it. Now, just come back a little bit, because we talked a little bit earlier about the 1973 cases that
That's what I was going to go back to. Go ahead.
undermine the ERA. Those two cases were Frontero versus Richardson and Roe versus Wade. What do I mean by they undermined the ERA, even though women were so happy? Well, as I explained, Frontero gave us strict scrutiny, so all the support for the ERA died. And then by the time 1976 rolled around and they bumped us down from strict scrutiny, that top little piece of the triangle, down to intermediate, there was no hope left that the ERA would be ratified within the deadline. Everyone knew it was not going to happen. The ERA was dead. By 1976, the ERA was dead. Roe versus Wade sort of sealed the deal on killing the ERA in a slightly different way. The Supreme Court was adamant that it was not going to treat abortion as an equal protection issue. It had to have a separate case where the issue of abortion was a thing unto itself, not part of equal protection. They didn't want women to argue that abortion was an equality issue.
And do you think this is because we have not seen a new fundamental right defined under the Equal Protection Doctrine for 50 years or more? Is it a hesitancy by the court to expand the scope of fundamental rights?
No, it's not just that. The Supreme Court wanted abortion to be excluded from Equal Protection Doctrine. Forget fundamental right. Remember, there's two categories that fall under equal protection. One is fundamental right, one is a class-based classification. Those are two different things. Sometimes they overlap. The Supreme Court wanted abortion nowhere near either of those categories. So it created its own rule and just called it, our ideas about abortion.
Which was more about medical, doctor, state.
Just that, they called it a penumbral interest.
Sure.
This, that, and the other. They just made sure.
Well, they called it the penumbra of interests related to the doctrine of privacy.
They called it a penumbral interest, meaning lots of different aspects of the Constitution contribute a little bit to the.
What was it? 4th, 6th Amendment, 14th.
Privacy, due process. They just mixed it all up into soup and called it a penumbra, which they invented. They invented the penumbra the same way they invented intermediate scrutiny.
How's that any different than any other unenumerated right?
Well, that's true, except that lots of rights are unenumerated, and we can't pretend that that there's actually such a thing as true textualism. I mean, corporations got equal protection rights when
Santa Clara County v. Southern Union Pacific, 1886.
When you give somebody, when you give a corporation equal protection rights and everyone agrees it's not in the text of the Constitution, you can't then say that you're a textualist, right? So. What
do you mean you're a textualist if you're a textualist, which I am not, you're a textualist when you want to be, and you're an interpretivist when you want to be.
Yeah, but commensurate, consistent with that is when the Supreme Court just makes stuff up, like intermediate scrutiny.
You call it making stuff up. What I would say is that it's and you were mentioning this earlier about the political machinations for change. We have to think about Ackerman's theory of subconstitutional dualism, because that properly frames not only FDR's supermajority in the 30s, but also West Coast Hotel v. Parrish in 37, which was not the Supreme Court making stuff up. It was undoing Lochner because of the political pressure on the court from FDR supermajority, which means these two things are intertwined. You can have Supreme Court decisions that are not driven by money or ideology, but instead by political pressure on the structure of the court. And remember,
you can say that, but then ultimately that's also only about money and power.
But yes, but my point is, Congress is not impeded in its ability to influence the court. It can affix the start date of the court's terms. It can pack the court. It can impeach justices.
You can think what you want. My rather cynical view after many years in this business is that there's only one strategy. All the different branches participate in effectuating it, and they pretend to have disagreements when it suits our fancy because it keeps us busy thinking it matters who we vote for. It doesn't.
Well, but that part ties into my argument, which is that's why I love Ackerman's, who's a law professor at Yale, "We the People: Foundations," Volume 1, 2, and 3. His argument is that most of the time we're just in cycles of normal lawmaking, which is exactly what you're talking about, the usurpation.
Maybe, except that Ackerman doesn't support the ERA.
Well, okay, but hold on. Let me just get to the point. I promise you I'll listen to your critique of his position on the ERA. What I want to make the point about here is that Ackerman says you're right to be jaded for most of American history. But we have seen at least 3 epochs, the founding, Reconstruction, and the New Deal, where there was something brewing in the American consciousness that, notwithstanding the machine, was able to bring about a fundamental revolution without a constitutional amendment in the way the Supreme Court related to the people. And you can't deny it, and here's my argument for it. You can't deny it because we don't, hold on, let me argue. You don't get to Brown v. Board in 54 without West Coast Hotel v. Parrish in 37. You don't get there without FDR's supermajority. Therefore, Ackerman's right.
I don't agree at all that there were ever periods of time when the Supreme Court was not completely controlled by corruption. Whether in the beginning they had opportunities to write their words in lofty style because they were new, they wanted to, pronounce principles and sound, like they had integrity. And there may have been lots of justices along the way who had integrity. As an institution, the Supreme Court has always been corrupt, always. It doesn't mean everything they do is corrupt. But it does mean that they do things for a reason that have nothing to do with what we think the case is about. And it's just gotten worse.
But that doesn't imply corruption. That's
it
does not. You're imputing a motive on a result that you might.
It's not a motive. It's just anti-democratic.
Well, of course, we are not a democracy. We are a representative democracy, and frankly,
anti-representative democracy.
You want to know what makes us an You want to know what? Hold on. What makes us an anti-representative democracy? When you compare the constituency, the Constitution, I'm not talking about the wording, the actual makeup of politicians in Europe compared to America, we are a government by lawyers. It's you lawyers who screwed this country up, not you. It's you lawyers who made us an administrative, bureaucratic state.
This is the United States of corporations, and you know it.
The United States of lawyers. Corporations are only as good as their lawyers. There would be no.
Lawyers are just the tools.
There would be no
Corporations control everything. The lawyers are the tools. They need to exist institutionally to make the corporations have distance that they need, so that it doesn't seem so obvious. But let me go back.
Go ahead.
Because I do have a law review article that I mentioned before, the subtitle of which is Constitutional Terrorism, that lays out a little bit more of the.
Do you realize it's next to your head, right, on the screen? The article is literally next to your head. So go ahead.
Good. It is a very simple explanation of how this country, from day one, intended to enslave women, both as non-persons and then as subjugated persons, where we still are, for money-related reasons. It's just that simple. There's a lot of money to be made when you can force a class of people into a legal status where you can earn from them and not with them. Of course, Black people were there as well for different reasons. That, although that disappeared to some extent with the 13th Amendment, there's still, just from the structure of law itself, there's still a process in place by which keeping Black people unequal in practice is very real.
Jim Crow.
Not just Jim Crow. Jim Crow and the so-called Black codes were ways of under enforcing the 13th Amendment, and in part, those laws help to make Congress do more, which is good. Like, in other words, you want to provoke
60 years later.
I'm just saying there are reasons why enforcement matters almost more than what the law itself says.
Agreed.
You can't make the enforcers change unless bad stuff happens. Because if all of a sudden overnight we all just obeyed the 13th Amendment, we wouldn't need to fight about black codes because there wouldn't have been any. Right?
Well, you know what? The only reason there were black codes, not to interject, it was because we had an opportunity to use the military occupation of the South to compel them to enforce, not only ratify, but enforce. But then President Lincoln got shot, and the administration and Congress that came in during Reconstruction was favorable to Jim Crow. Let's be honest, that's the only reason why there wasn't, the 14th Amendment wasn't properly implemented.
Well, and sharecropping and peonage and all of those ways that the system maintained. What I like to remind people about is that the way that Black people were treated in the aftermath of the 13th Amendment, both in terms of sharecropping, Jim Crow, Black codes, is exactly how women are treated today, only you can't even object. At least you could go to court and complain that those actions taken against Black men after the 13th Amendment were arguably illegal under the 13th Amendment. You could do that.
A lot of good that did, Plessy.
No. What I'm saying is there needed to be legal activity after the 13th Amendment to really find, where the lines are. We don't even have that. Like women, you can't even go to court and complain about unequal treatment as a woman because the Constitution allows it. So, when you think about like sex trafficking, which is a form of slavery, but because women aren't entitled to equal protection against slavery, it's legal to disproportionately enslave them. Even if you could prove that sex trafficking as a systemic matter discriminates against women, if I went to court and said, listen, this is discrimination against women, look at all these sex trafficked women, it's discriminatory, the judge would say, yes, it is, and that's legal. If I went on behalf of a Black person, because they get strict scrutiny and they have the 13th Amendment, the clarity of the 13th Amendment, the combination of those two things, and where our laws have come on civil rights since then, I would get in trouble as the government if I tried to enslave Black people. And by the way, I'm not saying they don't suffer some form of enslavement through all sorts of things that are reflected.
You have an easier way to make a claim because of the. Although I would argue, and I think you'd agree, that
you can at least make a claim.
Yes.
Women can make a claim. When I argue to judges that women are being treated differently and worse, they nod. They don't object. They're like, yeah. And what's your next point? So anyway, this brings us to the ERA.
To your lawsuit, that's what I wanted to ask. It seemed like you found a novel way here to bootstrap in a claim, and my reading of the brief was it was an opportunity to say, look at what argument, if the ERA was valid, I could make in this context. And I don't think a lot of people were saying, well, does she want women to be in the military or in the draft? It's not really about that. It's using this as an example. What would the ERA look like, and what standard would be applied? And maybe that's what you want to tell us about now. Yes. Oh, and by the way, don't forget the Hagseth question, but let's talk about the lawsuit first.
Definitely relevant. As I mentioned much earlier, there's not a lot out there that's black and white about men can, women can't. This is one law where it's explicit. And I think you've already gone through this. Men must register for the draft when they turn 18, and women cannot at any age register for the draft. So that's been the law for a long time. It was constitutionally challenged in the 80s, and the Supreme Court ruled in Roscoe versus Georgia that it's okay not to put women in the draft because they can't fight on the front lines of combat under military policy. And if we do call for a draft, which by the way, we haven't had since the early 70s, if we do call for a draft, the people in the draft pool need to be militarily ready. Women aren't, because we can't put them on the front lines. Therefore, the Supreme Court said that's a legitimate reason under intermediate scrutiny to have a discriminatory law that says men must register for the draft, women.
And this was in 83?
81, I think.
So it was between the Beer case and VMI.
Yeah.
Oh, that's good. I want to add that to my repertoire of.
Intermediate scrutiny is still the standard today.
Of course, but.
It was an intermediate scrutiny case that said it's okay to discriminate against women in this context because women can't fight on the front lines of battle.
Right, and I wanted to just pull out here, the intermediate scrutiny is the key takeaway. We now have 3 cases on that, the Beer case that we've learned about. Right. No, of course, we haven't learned about a lot of them.
There are so many, and I go through a lot of them in my law review article just to explain where the doctrine has been applied. But many people will argue isn't intermediate scrutiny good in some ways because it allows some discrimination that might be favorable?
Sure.
For example, women can get affirmative action under intermediate scrutiny. No, it's a fiction. If you think intermediate scrutiny is good for women because it's the thing that will protect women from having men in bathrooms, which we talked about before.
Sure.
The answer is no, because as an exception to strict scrutiny, one of the ways in which you get around strict scrutiny prohibitions, right? So strict scrutiny is very strict, doesn't allow discrimination unless there's a compelling state interest. One of those compelling state interests is safety. Another one is privacy. I mean, the government has often recognized that safety and privacy are legitimate bases for making the argument that separate treatment is okay. You can't just say, well, I feel like I want to be private, so I'd like separate space. The point is not that you're going to prevail, it's that it's a legitimate basis for arguing an exception, in the same way that you can argue an exception when Hollywood wants to hire a black person. It's a legitimate argument. It doesn't mean you win, but it's a legitimate argument.
So you're saying they can do it under strict scrutiny too? That's important to remember, because and also it's not. Let's also remember, to be fair, it's not rational basis. Some people only have rational basis.
Which is that's right. Trans people only got rational basis.
Children of. Go ahead.
No, in Spermeti, one of the bad things going on right now is that LGBTQ advocates, the ones that are corrupt, the ones that actually don't support equality, even for gay and trans people, they have been asking courts for intermediate scrutiny, knowing full well that they could ask for strict. They might only get intermediate, but they could ask for strict, but they're not even asking. They're asking for intermediate and then claiming to be the heroic lawyers of these marginalized groups. That's pissing women off because we're over here arguing for strict scrutiny. They are using the word sex categorically, which is fine, but asking for only intermediate scrutiny and in that sense disrespecting the fight for the ERA that has been demanding strict scrutiny for decades. So there's a little bit of tension there. But I work with some trans groups. Many of them signed on to an amicus brief in my case that we're talking about, and they're also pissed off that certain corrupt advocates for trans and gay people, all the LGBTQ law firms that are making all the headlines, are harming LGBTQ people by only asking for intermediate scrutiny. And they don't have an answer to the question, why aren't you asking for strict? You might win intermediate, but why aren't you asking for strict? At least shine a light on the nature of the problem, because that's where equality rests. It's up there with strict scrutiny.
Sure. And I just want to...
They won't answer.
Yep, and I just want to point out, we don't talk a lot about it, but rational basis is the kind of thing, they're not asking for that, obviously, those groups, but rational basis is, and we don't talk about it a lot because these are the most unheard, that does exist too for some of our most vulnerable people who don't even get intermediate, don't talk about even strict scrutiny being on the table, they'll never get it. And now these groups, there aren't a lot of them, it's like children of undocumented immigrants, age rational basis, yeah.
But the point about intermediate is everyone agrees it is second class legal status. Everyone agrees it's wrong.
But it's not third class. So it's like we have first, second, and third, basically.
Yeah, and then there are people who will say, well, I'll just be happy with second because at least it's not third.
Yeah.
No. I'm not telling you how to feel about what you end up with. If you want to be happy with second, that's fine. You can never persuade me that it's acceptable as a lawyer to go into court and say, I represent a gay man and I would like you, judge, to treat him as a second-class person. That is unethical. That is unethical.
I get it. Yep. And so I get that point. So let's now transition back, no pun intended, to the point. And we are very tolerant, by the way, on this channel. The rules in the chat, which we enforce. Towel Mom doesn't see the chat, but no being discriminatory, no being derogatory, no sea lioning, no gaslighting, and then no Kate Peters. Anyway, so the question that I wanted to ask you next is about the draft. It was a military readiness question.
So let me go back to the lawsuit.
Well, specifically to bring you back to the narrow point of the military readiness question, the previous case that was decided, you were saying intermediate scrutiny in 81, it was because women really weren't allowed to serve in combat roles. But right now, as a lot of people know, a lot of our best fighter pilots, women.
It's not just that.
A lot of our...
In 2015,
yeah.
So 10 years ago, all military branches allow women on the front lines.
Oh, sure.
The basis for roster has disappeared. all military branches allow women on the front lines. That's a different issue than leadership. All military branches allow women on the front lines. Therefore, the basis for roster is gone.
Does that include the special forces?
All branches.
Wow,
all
that's great.
Everything. Yeah. So since 2015, there has been a bit of a, chess game about who's going to get the case to the Supreme Court first to get them to overturn Rosker.
And let's pause here. So the reason why there's room to move to overturn this is there's been what's called a change of circumstance, because the prior case was decided when women could not serve in combat roles. Now we know women are in combat roles. Now, not every woman who goes into every branch is going to be in a combat role, but there are women in combat roles. It is permissible as of now, and we're going to get to whether that will change or not. But right now, women are in combat roles on the front line fighting daily to protect our country.
Yeah, and they have since 2015. And by the way, women have been on the front lines in some branches forever. It has never been true that all branches forbid women on the front lines, but some did, and now none do. So the basis for Rosker is gone. Since 2015, many groups have tried to file lawsuits, primarily men's rights groups, saying, now that women are on the front lines, we want them to register for the draft. Women's groups have generally stayed quiet about it, although there have been some saying, yeah, we support that. We want women to have equal rights. We don't want them to just have equal rights that are good and not, the hard ones.
Well, not that it's bad. Military service is very honorable, but it's a service.
But some women's groups do describe themselves as anti-military, anti-draft, and that's fine. So men's groups.
Wait, what? We have people in the this is news to me. I didn't know this. There are people in the United States who are opposed to our own military. I'm not okay with this. They sound like traitors.
Yeah, well, there are. And a lot of women's groups will say feminism is anti-war. You cannot be a feminist if you're pro-war. I say stop trying to divide feminism.
Well, and let me be clear. There's a difference between being pro-war and pro-military. Like, I don't care. You want to be anti-war as like a Catholic priest, whatever. I'm not going to tell you can't be anti-war. But this is very different than opposing the military.
There are many groups that are anti-military. But
go ahead.
The point is, we end up getting lost in the wrong battle, because feminism is fundamentally only one very basic concept: social, political, and economic equality. That's it. If you think those things, if you think those things are important and you believe in them, you're a feminist. You can't be a feminist and say, well, I don't really believe that. You can't be a feminist because you don't get to just take the word feminist and make it mean something it doesn't. It means social, political, and economic equality for women. Well, if that's true, then it means you sign up for the draft. You might not qualify, you might fail the physical, but you got to sign up. It's not complicated to me, and you kind of get in trouble if you say we want equality for some things but not others. So I don't take a position on war and military. I just say this is a law. The government passed it. It treats women differently and worse. It's not acceptable. I'm suing about it. Now, mind you, this isn't the first time I've sued over the ERA. I told you that how we didn't get to 38 states by 1979 when the deadline expired, which, by the way, had 3 years added before it really expired, because we extended it to 1982 and only made it to 35 states. We never got to 38. People assumed the ERA was dead because the deadline expired, but then the 27th Amendment was ratified.
And this is what's called, I'm eating a Pringle, the Madison Amendment, which has to do with congressional pay.
Yes, the Madison Amendment was ratified in 1996, I think. God, I used to remember that. And yeah, I think it was. Anyway, or 19, well, whatever, maybe you can.
Might have been 92.
92. When the Madison Amendment was ratified by the 38th state, women went nuts. It was 92, because that amendment had passed Congress in 1789. They got 203 years to ratify. And it was only about the timing of congressional pay raises. So women were like, what? Why would an amendment about the timing of congressional pay raises have 203 years of a window to get the states to ratify it, but women's equality got only 7 years, 10. What? That is unacceptable. So we started fighting again and saying, we will not accept an arbitrary restriction on our amendment where you give over 2 centuries to this other amendment. We're going to fight, get 3 more states to ratify, and then you want to argue about the deadline, we'll go to court and argue in the courts that the ERA's deadline is invalid because of the 27th Amendment. So that was our plan. And then things got really good in 2012 for women because the United States archivist, whose job it is to put new amendments in the Constitution once they get ratified by the last state, issued a public letter. And the letter said, if the ERA gets 3 more states to ratify, I will put it in the Constitution regardless of the deadline, and I won't count any of the states that tried to rescind because rescissions aren't valid. So we all went like, wow, are you kidding me? 2012, we got this invitation from the archivist to go get 3 more states, which we did. We got Nevada in 2017, Illinois in 2018, and Virginia in 2020. Well, when the 2020 final vote came around from Virginia, the archivist reneged, said, no, I'm not putting it in. Why? Well, Trump was in office at the time. Trump's Department of Justice issued an opinion letter saying, you can't put it in the Constitution because of the deadline.
President
So
Trump. You're talking President Trump?
President Trump at the time. This was early 2020. So I sued the archivist to force him, at the time it was a him, to put the ERA in the Constitution, not based on his promise, but because the 38 states ratified and the deadline was not valid. We had very good constitutional scholars on our side who, in addition to the 27th Amendment argument, said, you can't put a deadline on how long the states have to ratify because, number one, how constitutions get amended is described in Article 5, and there's nothing in there about deadlines. And number one. Number two, you have to have a balance of national and state rights powers. There has to be a balance. If you give Congress the power to put a deadline out on how long the states have to ratify, you've just given all of the power to amend the Constitution to Congress. States really have no role because they can put a short deadline on what they don't like and a no deadline on the things they like. It's just outrageous.
It's a Federalist versus anti-Federalist question.
It's a Federalist argument. That's right. And, it's not complicated. And a lot of scholars agreed with us that the deadline is outrageous, really outrageous. Mind you, deadlines are also fairly new. Until the early 1900s, no amendments had deadlines. It was kind of an invention around the time of the Prohibition Amendment, kind of an invention that Congress came up with to force the states to support prohibition. When you can put a deadline on, you can then spend enormous amounts of money to pressure the states to ratify. And that's why they did it. Then the question, started to come up, well, can they do this? And we don't really have a good, clear answer from the Supreme Court. There's been some dictum in a couple of cases that suggests it's okay for Congress to put a deadline in, but again, it's not a holding. So then, one of the issues was, well, why did the Supreme Court say that Congress might have the authority to impose deadlines? And the answer is because they think there should be some degree of contemporaneity between congressional proposal and state ratification.
Well, they did. You're saying they did in 1921 under the Dillon case, but that makes no sense in light of the Madison Amendment.
Well, not only that was 100 years ago, right? So the country is a little bit more complicated these days. And it's really important to understand that when the Supreme Court said, not in a holding, that it makes sense for Congress to impose deadlines, because if the congressional decision is somewhat close in time to the states ratifying, you have consensus, national consensus, and we want amendments to reflect national consensus. Obviously, deadlines don't really serve that purpose. Number one, because a 203-year gap on the 27th Amendment obliterates the idea that deadlines are even remotely valid. But the second argument is that consensus is improved by contemporaneity. You can have consensus, as we do with the ERA, and there's been, 50 years or however long it's been since it passed, 72, whatever year we're at. We've got consensus around the ERA, and it's been a certain number of years. So if consensus matters, deadlines shouldn't matter, right? Consensus should matter if we care about that. Anyway, the point is, because the Trump administration blocked publication of the ERA, and I just mean, like put it in there, just put it in there. That's all. The archivist is a librarian. No, it's not a court. It's just a guy who prints the Constitution, and he refused to do it. So I sued him. At that time, Trump was in office. His DOJ was fighting against me, and Biden and Harris were running. So women's groups said, oh, we have to vote for Biden Harris. They both said during the campaign they support the ERA. Well, everybody votes for Biden Harris. They get in November. My lawsuit is still pending. Another lawsuit was filed after mine by the last 3 states to ratify. They filed in DC federal court. Mine was in Massachusetts. So Biden gets in. January comes, he takes the oath of office, and we're sitting here waiting for him to stop fighting against our lawsuits, number one, and number two, tell the archivist to stop blocking the ERA and put it in the Constitution. He did nothing, absolutely nothing. And he kept fighting against me in my lawsuit, and it fought against the DC case, making exactly the same arguments that Trump had made against the ERA. It was really bad what he did, but it was also important that we suddenly could see that neither political party actually supports the ERA. The Democrats say they do, they lie. The Republicans kind of openly don't, and it is what it is. So both cases were resolved on procedural grounds, didn't give us the relief we wanted, which was a court order validating the ERA. And because they were resolved on procedural grounds, we didn't make much progress.
What you mean by that is they didn't reach the substance of your argument. It was dismissed on procedural grounds, so you had a chance to argue the substance again in another procedural context.
Right, and the DC court did address the merits, but again, it was only dictum because they ruled they didn't have jurisdiction. So it's not really binding, and in any case, it's certainly not binding on other jurisdictions because the Supreme Court didn't get involved. So we have a DC case that does talk about the merits and says the deadline is valid, but we don't really have a holding, and we certainly don't have the Supreme Court having made the decision. So we're just going to keep fighting until we get the Supreme Court to answer the question. Well,
and it's interesting to note, by the way, that D.C. case with the bad ruling was not your case. It was the people who filed on behalf of the states that ratified.
Yes, and one of the interesting things about their case is they were 3 states were suing the government. Their best and only real argument in terms of why they would have a right to sue the federal government is the 10th Amendment, and they failed to file a 10th Amendment claim, which was suspicious from the get-go. So I never thought their case was filed in good faith. It was really a strange case that because it wasn't filed in good faith, they didn't even make the claim they needed to make around the 10th Amendment, which gives states authority to sue the federal government. So they really set themselves up to fail, and they were criticized heavily for it. We, in the meantime, we lose our case on standing grounds, which was also illegitimate. And my 2 best standing arguments were just ignored by the court. When we appealed to the First Circuit, I said, you can't just ignore my 2 best standing arguments and resolve the standing question on the one you like the best. I made these other standing arguments. You can't just ignore them. And the court ignored them. Just ignored my best standing arguments, which, just tells you something. Standing doctrine is often political and not legal. So it is what it is. Flash ahead, 2023, a guy named Vikram Valame, an 18-year-old college student, filed a lawsuit in California federal court against the Selective Service Act, men must register for the draft law, saying it discriminates against men, that men have to register for the draft and women don't. He said, this hurts my feelings as a man, so I have standing, and he refused to register.
Is he some kind of communist?
No, he actually works for the Cato Institute.
He's a right-winger who opposes the military. Why?
Yeah, because it hurts his feelings that women don't have to register for the draft. So he made a couple of arguments in his case, the first of which was the ERA is valid. So, I'm watching this case saying, oh, so here's a guy who supports my argument that the ERA is valid, that the deadline is not valid. This was in 2023 that he filed. So I'm saying, oh, this might be a good case, right? Because here's a guy saying women deserve equality. Well, but it was kind of flying under the radar because he was filing it pro se. I mean, he was clearly supported by lawyers because he was writing stuff he would have no capacity to understand. And he was doing it while working at the Cato Institute. I mean, it's just so obvious that he was pretending to be pro se just so nobody would pay attention. But the case was designed to go to the Supreme Court, to give the Supreme Court an opportunity to kill the ERA, but in a men's rights case where he wouldn't even be asking for what we would be asking.
Wait. So the last pro se case that I really read about going to the Supreme Court wasn't even pro se. It was Gideon in 63, where Abe Fortas got appointed in forma pauperis, or whatever it is in the Latin, and he didn't even get up there pro se. So are you saying this guy, Vic Valame, filed pro se, and now this is on its way to the Supreme Court? Did he get appointed counsel in forma pauperis?
Well, they are probably going to give him counsel now that he's headed to the Supreme Court. So I'll tell you what happened. He did it pro se to make sure nobody paid attention, because this case was going on a rocket ship to the Supreme Court. And we were told by the American Constitution Society that his case is going to the Supreme Court. And they always have their ear ground on which cases are going. So I didn't find out about it until late 2024. And I quickly filed my own lawsuit because I read the papers he filed. I read his briefs. He was asking the court to rule that the ERA is valid, but also asking for intermediate scrutiny, which is the most severe form of betrayal, because the only thing women get from the ERA is strict scrutiny. It's the only thing. The Supreme Court has previously said women will get strict scrutiny when they get the ERA. It's the only thing, it's the only benefit the ERA gives them is strict scrutiny, mandatory strict scrutiny. So here this guy is saying the ERA is valid, and I want it to be considered valid. And by the way, then women still only get intermediate scrutiny. And under intermediate scrutiny, Rosker has to get overturned because women are now fighting on the front lines. So I immediately filed my case, and I included reference to his case and saying, I'm filing this because this guy thinks he gets to go to the Supreme Court arguing not only for the ERA, which is fine, but arguing what the ERA means, which is continued subjugation of women. And he thinks he and the men's rights groups that he is assigned to are going to be the voice of women at the Supreme Court on the question, is the ERA valid? And do women now have to die on the front lines of battle because of the ERA? And by the way, let's just still keep them second-class citizens? Hell no.
Wait, so you're saying this was on a fast track to the Supreme Court, so what you could and maybe I'm misinterpreting this, but this is the way the Supreme Court could present it to people as them giving this big win to women, but they could also then, there's nothing forcing the Supreme Court other than prior statements by Scalia and some dicta saying that a strict scrutiny would apply. There's nothing that would compel the court to attach strict scrutiny to the ERA. They could just apply immediate scrutiny.
Moreover, they get to say this is what the plaintiff asked for.
Right. Well, that's of course what they would do.
This comes back to the same issue I mentioned about LGBTQ lawyers. If you don't ask for strict scrutiny, the court can't give it to you.
Well, yes, but what about this concept that this, at least not with the people represented by lawyers in the LGBTQ cases, but with the argument, you could argue that the pro se plaintiff, Vic Valame, is entitled to liberal construction of his pleading by the court. They don't have to read it. He doesn't have to make every argument.
Yes, he does. At the Supreme Court level, if you don't ask for strict scrutiny, they won't even entertain it.
But it's not a prohibition. Obviously, they will never do it, but they could read in strict scrutiny if they want it. They'll just never do it because they want intermediate scrutiny.
But they won't do it, is my point, because they don't want to. But separate from that, Valame didn't even argue that strict scrutiny is required under Supreme Court precedent, not dictum, precedent.
But isn't that why they liberally construe pro se pleadings? They assume you're not going to know how to do that?
They still won't give it to him because that's the whole point of his case. I mean, you're missing my point, which is that his case was a strategic file for the purpose of giving the Supreme Court an opportunity to kill the ERA without even entertaining the voices of women.
So they don't want to win at all. They just want to rule against it in the context of this case where women won't have a voice. So you filed your lawsuit.
Overturn Rosker make women die on the front lines of battle, but remain second-class citizens under intermediate scrutiny.
But I thought so you like the idea of women being in the draft, but it's important to you if that happens, they get strict scrutiny.
Well, that's my final line in my brief. If I'll be damned if this court is going to require women to die on the front lines of battle, bleed to death alongside men, same blood, same color of blood, same dead body, as second-class citizens. Absolutely not going to happen. It's a moral argument, but it's a beautiful moral argument because it kind of ties the court's hands and says, you're about to decide the most important issues in women's history, and women aren't even at the table. So when I filed my case, I pled in the complaint, this is filed because this man has filed a similar case and he is committing malpractice against women. That's why I filed. So I've written about that to some extent in my briefs, just to point out that we're not just doing this, we're doing this to demand a seat at the table. So he appealed to the Ninth Circuit. The Ninth Circuit in July, the day I filed my brief, by the way, Ninth Circuit ruled the ERA is not valid in a very dismissive one-page ruling.
Was it a panel of judges or one?
Yes.
How many? 3? What was the vote? What was the vote?
They all agreed. The ERA is not valid. And if the Supreme Court is going to overturn Rosker, it's their business, not ours. So this is a perfect tee-up for the Supreme Court to do what we were worried they would do. Rule on the merits of the ERA and overturn Rosker, requiring women to fight front lines and die and register for the draft, but as second-class citizens. That's exactly the case that the Valame ruling gives the Supreme Court. It's a golden platter.
So no ERA, Rosker's overturned, women in the draft, intermediate scrutiny.
Yep.
Which is, but that, so, and I don't want to make it seem apoplectic here. Currently, there's intermediate scrutiny that's already existing. It's just the difficult part here is we could end up with a situation where women have to register for the draft. There's no ERA, and they don't get an increase in scrutiny, and they basically give away this bargaining chip that could have helped them legally.
Yeah, and then they die as second-class citizens. Because remember, historically, women, when they have fought about things like the vote, the opposition has said, you're not really entitled to equal treatment because you don't fight equally. You don't register for the military. You don't go to the draft. You're not bleeding to death. Because men bleed to death for their country and you don't, it's okay to treat you differently and worse. That's always been a, behind the scenes, sometimes very open, but it's there. Like, why are women unequal? Because they don't fight for their country the way men do.
And I hate to bring this up, but is what's going to make the polity see women as the equal citizens they are, not just the draft, but more and more women in the military? Is that because I don't know why this country, I don't want to say that we're a very militarily based country, but we really are. We're very patriotic.
I'm not arguing that as the reason. I'm saying, how dare you even consider reinforcing women's subjugation and demanding.
No, I agree with you. I'm forward looking and saying, okay, so
the solution is to get women to die.
No, of course, and that's not what I'm saying. I just want to be clear to clarify my position. I was saying, so say taking it as a sad, descriptive, anti-normative reality for both of us that this plays out this way, and women end up in the draft, and there's no ERA, and there's intermediate scrutiny, and Rosker's overturned. Well, politically looking forward, accepting that as a descriptive reality, are we going to get to a point where, okay, then women are going to be in the draft, women are going to be in combat roles, people are going to be seeing them. This is a very patriotic country, regardless of what political party you're in, unless you're a communist, apparently. What are people going to think when they start seeing these women and the caskets coming home, God forbid?
We'll still struggle because women have died in battle for many, 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 many years.
It's true, but what is going to be...
The reason it's not likely to be that helpful to the cause is because we're never going to die at the same level as men. Men are physically, in general, men are physically more ready militarily. They're just because women can be drafted doesn't mean they're going to succeed in getting on the front lines. At this point in time, and I think even moving forward, the number of women who will end up on the front lines simply because we don't really fight wars like that anymore, but also, bleeding to death as part of war the visual of that, I don't think is even going to be so common moving forward. We're going to have biological wars. We're going to have information wars, tech wars. So I do think there are places for women to become more military without bleeding to death. But for the time being, it has been a thorn in our sides that we haven't been drafted. It's a hard thing to argue against when someone says, well, you can't really expect equality since you're not even serving your country equally. It's that social contract argument. Now that this guy filed this, because I wouldn't have filed it if he hadn't, our job is to demand a seat at the table, period. Like, there's not a lot more to my case than being able to make the moral argument and saying, don't you dare decide this issue that will affect women, not men. Don't you dare decide this issue based on that little shit's case in California. How dare you? You know how much this is a women's issue. Don't let him determine for you, number one, whether the ERA is valid. And his argument is kind of shitty. If you read it, it's just not a well-developed argument. He's not a good advocate for the ERA. And then to know that the ERA is the basis for his case, and yet he's not asking for strict scrutiny, is just the ultimate betrayal, malpractice per se, malpractice.
Well, you can't commit malpractice if you're pro se, but.
Well, it's still malpractice for, scrambling to find a way out, because this was the plan, but they weren't planning on me filing my case. In fact, something interesting happened in 2022, right before Valame filed. The National Organization for Women, for the first time in history, withdrew its support for women being drafted, which it had had in place for decades. It withdrew it upon request, withdrew it and said, we no longer think women should be drafted because we're just anti-military. There's no doubt in my mind they did that because they were asked to do it, because they knew Valame was going to file his case, and they knew that now would be the leading litigation group likely to get involved in trying to inject a voice for women into Valame's case, and they needed to keep them quiet. So now withdrew its policy, which kept them quiet. They didn't complain, they didn't say anything, they didn't do anything, they just stayed on the sidelines. They didn't count on me, an independent attorney, finding out and fighting back the way that we are. So it's possible the calculus has changed now. They were hoping for a smooth sailing, men only voice on the issue. We now have a problem, they now have a problem because we've done our thing. I've already asked my court to rule, because Valame is doing a disservice to women, and he's already going to the Supreme Court September 17th.
It got granted cert?
That's when he has to file by.
Oh.
And my oral argument is September 15th. That's not an accident. I am going to, whether my judge rules in my favor or rules against me, either way, I'm filing my case with the Supreme Court when he files his cert petition, and I'm going to make very clear that this is an outrage. If the Supreme Court dares grant him certiorari and doesn't tether my case to his, to ensure that the court hears all the important voices before it makes the decision and doesn't just listen to a man argue in favor of women's subjugation.
So pending. So you're not going to use a procedural mechanism like a denial of a TRO at the lower federal court to seek a review in the form of a petition for a writ of certiorari to the Supreme Court. You're just going to go under a new petition?
I'll file an amicus brief. An
amicus brief to his case.
Yeah, an amicus brief to his case, arguing that he's an outrageous, disgusting human who's trying to subjugate women without even letting women object. Yeah. So I'll do an amicus brief and demand that the court tether my case to it, because the Supreme Court has authority to reach down and grab my case.
Oh, sure. But couldn't you have also gotten on the shadow docket by applying for a temporary injunction or a TRO at the federal district court, having it denied, and then filing an appeal of that?
Yeah, but TROs cause too many delays.
But just to get on the shadow docket, you could get that up to the Supreme Court on the no?
Yeah, it's just, first of all, there's no guarantee, and TROs cause very bad delays. There's a case in New Jersey. I don't know if you've heard of this. There's a case in New Jersey where a men's rights lawyer represented a woman. I think the case was filed in 20, I don't know, like a couple years ago. Federal court case. Might be, wait, it might be, I'm sorry. I think it's filed in New York, but it involves New Jersey, and I'll tell you why. Men's rights lawyer from California represents a woman who tried to register for the draft, was denied. He filed a lawsuit, same as mine, made the argument that this discriminates against women. They didn't make an ERA argument. They just made an argument that it discriminates against women. And the woman judge was kind of dragging her feet on the ruling. Let's just say she was concerned about, I don't know what legal issues, but she was dragging her feet partly because some of the courts are saying, let's let Congress fix the problem. We don't need the courts involved. And even in one of these cases from a couple of years ago that went to the Supreme Court, Justice Sotomayor dissented from the denial of cert and said, we need to fix this, but we'd rather Congress acted, and Congress hasn't acted.
I saw that cited in your brief.
Yeah, Congress could fix the law and moot my case, and that might happen. And this is kind of where the Hegseth thing comes in. Hegseth can't do what Congress can do, but Hegseth could say, we've now changed our policies again, and we're taking women off the front lines. That would undermine the argument. It wouldn't kill my case, but it would undermine the argument.
Because Roscoe would then, there would be no change of circumstance, really, exactly. Because Roscoe would be applying.
Yep. And the other thing is that so Hegseth could make a difference. Congress could vote to fix the law and allow women, require women to register. Both of that would actually moot my case because I no longer have the statutory problem. I could argue capable of repetition yet evading review.
Right. That's a good argument.
It's not a problem because there's been so much back and forth on this. But the point is, it's all about how the Supreme Court currently feels about dealing with Valame's case and whether our case is going to cause enough of a ruckus that they can't really get away with doing the wrong thing with nobody objecting. So here's a funny little other story. I told you Now, for no reason, revoked its policy supporting women being able to register for the draft. That kept them quiet. When our case was filed, we solicited amicus signatories to a brief that was filed in addition to mine. Those amicus signatories that we requested to support our position included the Feminist Majority, National Women's Law Center, NOW, of course, the ACLU, I'm trying to think of all these other sort of main groups, the American Association of University Women, the ERA Coalition, which is a group that claims to support the ERA and has no reason for not supporting our case, but has refused. Every one of those major women's groups refused to support our case, except the National Women's Political Caucus. This is a wonderful amicus supporter of ours. They have so many supporters of theirs that the Supreme Court has to understand. We're talking about enormous numbers of women that are outraged. And the fact that the corrupt groups decline to support our case without justification, there's absolutely no reason they're not supporting our case. They know everything about it. They just cannot explain why they won't just put their name on a brief. They can't explain it except for the fact that they're corrupt and they're anti-ERA while claiming to be pro-ERA because they've been captured. I know that's an issue you often talk about, but because they're being funded by the dollars that benefit from keeping women subjugated, they won't actually get on board with a case that might, in fact, get women elevated. So we've been able to showcase through the amicus brief signatories who the true allies are, led by the National Women's Political Caucus. And we're going to make sure the Supreme Court understands that this is a lot of women. This is a huge number of women, and they're watching. They're watching what the Supreme Court is doing. They're watching what this little shit in California is doing, Valme, and they're not going to take this lying down. They're going to rise up. They're going to be livid. They're going to be furious. They're going to protest. Whatever it is that we do, it's going to be significant. So that leads me to believe that it's possible Congress will vote to change the law just to moot my case. If that happens, fine. We'll wait for the next opportunity, but we're not going to stop fighting because the ERA is still valid, in my opinion. It is valid because it has satisfied the criteria of Article 5, which requires vote by Congress, ratification by the states. That's it. And we've done those things. The deadline is, reasonable people disagree about whether the deadline is valid. I'm not going to say that I'm 100% right. Reasonable people disagree, but a lot of constitutional scholars agree with us that it's not valid. And it's because of the concern that it creates this anti-democratic imbalance, giving all the power to the national government, which already has too much power. The power of the people, they speak through the states, and we get to say what we think the Constitution ought to have in it as amendments. And if we think it needs amending, then Congress shouldn't really be able to trounce that desire. 90% of the public believes the ERA should be valid. They support it, and yet they have zero ability to get it done because this deadline, is kind of a stranglehold. We need an answer. We need an eventual answer from the Supreme Court. Is the deadline valid? If it is, the ERA is not valid. If it isn't, the ERA is valid. Once we get that final answer, and let's say they say the deadline is valid, the ERA is dead, then we have a new strategy. What do we do now? How do we go about creating equality for not just women, but LGBTQ people as well? How do we go about that without the ERA? What is our next best option? One of the things I've been doing with my students at New England is what's called a strict scrutiny project. So while people are running around trying to figure out how to amend the Constitution, I've got my students working on filing briefs in every case where a woman or an LGBTQ person is seeking equal treatment under the Equal Protection Clause. We are demanding that all lawyers ask for strict scrutiny. They've never done it. Nobody's ever asked for strict scrutiny, just basically saying to a judge, I realize that currently the law from the Supreme Court is you should apply intermediate scrutiny. I don't agree that that's the right standard because why? The 14th Amendment says persons shall have equal protection of the laws. Women are persons. We deserve equal protection of the laws, not unequal protection of the laws. Do the right thing. Do the right thing.
But why don't you just have your students with a big network across the country made 303 lawyers in their second or third year, and then just file? Why don't you give these victims, all these lawyers, you give them students as counsel under 303?
We've submitted briefs, and like we submitted a brief in the Texas abortion case, we submitted a brief in a Nevada case saying the lawyers fighting on behalf of women through these abortion restriction cases are not asking for strict scrutiny. They need to. It's unethical to ask for less than
sure. But let me ask you. But I'm asking more in this question. Why can't we have a center at Nestle that all it does is certify 303 student attorneys for the purposes of representing victims?
No, we don't need that. We need
what?
No. What we need is a place at Nestle under my Women's and Children's Advocacy Project, which I run under the Center for Law and Social Responsibility. We need a strict scrutiny project where the students under 303 or otherwise can routinely file briefs in courts around the country, often with a push of a button if it's a federal court, demanding strict scrutiny even when the lawyers for women and LGBTQ people don't ask for it.
Sure, but what about the people without lawyers? Why is there no center to give lawyers for victims in the criminal or civil process? I'm frustrated.
I know, but you've completely abandoned what I was talking
I
about.
heard your point.
I want to say something else.
Well, you get the root of my point, right? Which is if the lawyers were just if the student lawyers were just representing the victims in the cases, they would make the strict scrutiny argument every time.
No, it's not the victims that are entitled to strict scrutiny, it's women. And the cases where we're filing the briefs are cases where there's an equal protection challenge. You can't represent a victim and mount an equal protection challenge. They're complicated. They're very difficult to do. But I want to emphasize something, two things. Remember when I told you there were 2 cases in 1973 that caused harm to the ERA, that caused it to die? The first was Frontero versus Richardson because it gave us strict scrutiny. And then in 76, the Supreme Court took it away in Craig versus Boren. They bumped us down, and they only bumped us down after it was clear the ERA would not be ratified by the requisite number of states. The other thing they did in 73 was rule in Roe versus Wade. The Supreme Court ruled in Roe versus Wade that abortion would be a thing to be protected, and it could only be restricted under strict scrutiny.
Yeah, but and so
we got strict scrutiny under both things.
Yeah,
protection and abortion. Well, guess what?
Well,
they took strict scrutiny away in Craig versus Boren in 76. They took strict scrutiny away for abortion purposes in 1992, Planned Parenthood versus Casey. That was a real bump down because as soon as Casey came down, restrictions in the states went crazy.
Yep.
And of course, you know what happened with Dobbs. The point being, the Supreme Court ruled in 2 cases in a way that gave women the appearance of equality. Then they overturned themselves because the only reason the court issued those decisions, Frontero and Roe, was to kill the ERA in the states. That is an argument I make in my brief. I explain how Ruth Bader Ginsburg participated in it and caused the death of the ERA while she was claiming publicly to be supporting it. And I explain, and I'm not the only law professor who makes this point, and I explain how 1973, Supreme Court, two Supreme Court decisions were intentionally decided for the purpose of preventing the ERA from becoming part of our Constitution.
Yeah, and I think we got in the weeds on that, but it was very important, and the strict scrutiny analysis is a key component of this. But to wrap it, to bring us back to the original question, then I have a few more questions, and we won't take too much more of Towel Mom's time. A few more viewer questions, towel questions. One of the questions obviously was about Pete Hegseth, and we kind of touched on it, which is, will the DoD make a move to kind of take women out of combat roles? We saw transgender and other people taken out of combat roles. We see the way the passports are being handled changing. That kind of speaks to, I think, Pete Hegseth potentially thinking about who's in combat roles, which is a reality. I don't want a long answer there, but I think you'd probably agree with that.
The only thing Hegseth can do to wreak havoc in my case is to take women off the front line. So far, all he's done is take women out of leadership positions. That doesn't affect my case. If he takes women off the front lines of combat in any military branch, much less all, then we don't have the conditions we need to overturn Rosker. We still can argue about the ERA, but we don't get that. We don't get the opportunity really to argue that Rosker is no longer good law.
Yep. Excellent. Okay, so let's go to some of the other questions. We had a statement from Carla earlier, and I just wanted to give you a chance to weigh in on this because it was kind of what we were discussing before we went into your brief. Wouldn't there be situations where, akin to a domestic violence victim going back to her abuser over and over, where like there might be an inability to remember the victimization, shame, embarrassment, a lack of respect, previous trauma, and then you don't have to necessarily comment on that, but Carla also weighed in and said, have you ever heard of a situation where 2 cops were allowed to force a woman to show them and watch sexual videos and then threaten the victim if the victim asked for a female cop to look at those sexual videos? Have you ever heard of that?
The law currently allows female victims to ask for a female cop, but it's treated like an accommodation. So if it's not reasonably available, they're not required to do it. There's just too much discretion built in there. They're supposed to, but they're not mandated, so they don't have to. A woman who is forced by a cop to do anything has the same grounds to sue as a person who sues because the police used excessive force when trying to stop them from committing crime. In other words, excessive force is a big doctrine, and people tend to think of it as what you do when you want to sue the police for shooting you when they could have just grabbed you. But it really applies across the board. Any cop who uses force on a victim can be sued for excessive force. We don't see it very often. We don't even hear about it really, but you have to be careful. So suing police is generally speaking disfavored, except for certain types of things. And the certain types of things tend to be oriented around the rights of drug dealers, because again, we're talking about an enormously influential industry. Drug dealers have basically the same stranglehold on lawmakers and others that they have, that the porn industry has. So if it protects profits for drug dealers to be able to sue for excessive force, then that's a doctrine that's going to be respected.
Yeah, I think they call certain people legal realists. I think they call you a jaded legal realist. But I'm saying that as a commentary on the fact that no, civil rights cases do not only succeed for drug dealers. That's a broad overgeneralization.
No, but you have to be naive if you think that you can sue a cop for anything. The fact is, a special rule exists for excessive force that if the law were not hand created to serve a certain industry, the rule about police misconduct would extend to all kinds of lawsuits, but it just isn't.
Yeah, and listen, and so for me, that's why I see not just the DOJ doesn't need to be reformed. Put me in there. Let me run a section of the Department of Justice that only goes after cops that take advantage of victims in criminal cases. No one will do it because I will rain hell down on them. Now it's not just me, okay? I need a whole team, but you have a division of the Department of Justice that's focused entirely on this. Watch how quickly it stops. Throw the handcuffs on them, it stops. You start arresting cops for doing this, it stops. I will perp walk them myself.
You're trying to kill an ant with a...
No, I'm trying to use a big stick. I'm trying to walk tall and carry a big stick. You can call me Teddy Roosevelt.
You don't have to kill an ant with an elephant when the alternative would also work, which is to say, pass a law requiring police to notify victims that they have certain rights.
It's only as good as its enforcement. You made the point to me over and over. I know what my life... I am going to create a division of the Department of Justice.
What I'm saying is, to the extent it requires police to do something, it's the type of behavioral change that could give the law people, the law department, the bean counters, pause before they say it's okay, you can get away with that. That's okay,
but still, that goes against the very premise of bright line reasoning. And let me just make the point. We as lawyers, I'm not a lawyer, but the legal profession looks down on cops, and we pretend like we don't. First of all, it's wrong, but we give them bright line reasoning because they don't know how any of this works. Do you know what they fear? You know what cops fear? Federal prison. Unless you tell cops that at every turn they're going to federal prison if they screw up, they will not care. They're not going to follow a victim's Bill of Rights. No, they don't care. They don't care.
They care much more about being sued because the bean counters...
No, they do not care about being sued. No, I've read the internal emails.
You cannot sue police for cover-ups. That's why...
You know who pays if... Mom, do you know who pays if the police get sued? Do you know who pays if the police get sued? The taxpayer. You know who pays if the police go to federal prison? That cop.
No, you cannot ask to kill an ant with an elephant when another thing might work.
Nonsense.
However, one way to build a staircase to possible prison as a result, because again, right now it's an ant and you're an elephant. If you instead create policy change with the hope that if it doesn't work, it goes to a legislative change, with the hope that if it doesn't work, you do get that.
No negotiation. No negotiation. Federal prison. No. Oh yeah. No. You know what?
Since you're asking for something you can't get and not willing to do the things that might get you there slowly, you'll just have to have nothing.
No. You know what I will do? I will dedicate my life to getting the kind of influence within the Department of Justice that will allow me to get appointed to a division that is dedicated to putting cops who take advantage of victims in the criminal process in federal prison. And then every single time one of those...
And then you're turning 80 and you've
No. And every time one of those cops go to federal prison, I am going to put their picture on my wall. I'm going to build the division until it becomes one of the central components of the Department of Justice. Mark my words, write it down. This was the day I committed myself to it.
Your wall will...
I'm going to do it for you.
It will have no picture.
Oh, bro, I take that as a challenge. You told me I couldn't legalize cannabis. Don't tempt me. All right, now I have...
weren't the one. The billion-dollar industry was, and you know it.
Nonsense. I just helped.
Oh, Grant, if there's one thing I can tell you, the answer to every question is this. It's always about money.
That might be true, but not for me. Not for me. Now,
No, but then if you want to get shit done, you got to play the game. You want
Nope.
to play? You play.
You don't like-
You don't want to play, then you might not matter.
or, listen, I'm the type of person who likes to write the rules for the games, but let me tell you this. Selma, who's our Canadian friend, sends $5 and says, I have a question for Towel Mama. Where does her drive and intellect come from excuse me, I think it's about me, but okay, it's about you. Question for Towel Mama. Where does your drive and intellect come from? Were your parents engaged in law? Your drive is amazing to see. My mom just talked about God all day. Go ahead.
But that's okay. You know, we don't need to all be doing things that are crazy like this. No, my dad was a firefighter. He's still alive. He's a great guy. He was a firefighter, and I wanted to be a firefighter just like him. And I was like 8, and I said, I'm going to be just like you. I'm going to be a fireman. And he said, well, no, girls can't be firefighters. You can be my secretary, or you can work in dispatch. And I said, oh, that's stupid. I'll become a lawyer and fix that. That's just so dumb. So that's why I became a lawyer, that there was this obvious silliness to the thing he told me about what I could do with my life. That became a big form of inspiration. But when people are driven by injustice, I think it tends to show a high degree of intelligence. Not all very intelligent people seek justice. Not all people who care about justice are highly intelligent, but there can be a correlation because it's just a discomfort level that's deep and they don't know what else to do. I certainly fit that bill. I could read when I was 3. By the time I got to kindergarten, my teacher would put me in charge of the class because I could read. So she could go to meetings and I'd read to the kids. And I just always had that sense that I should be in charge. It's both a curse and a blessing. I mean, I'm pretty fearless, but I also think that it does matter even when it doesn't. Now, I will say this. From when I was a young, naive lawyer, thinking that I could just go out and fight and win and it would be, easy because I just had to show people how bad the injustice was and they'd say, oh, thank you. Now we'll fix the system. I learned pretty quickly that's not exactly how it works. So I have tailored some of my practice over the years to focus more on the individuals that I help and less on the systemic stuff, but I keep my feet in both places. So, and I do this with my students as well. I teach them to be litigators, but I keep their heads in the clouds a little bit because the best academic thinkers, the best change makers know where the lines of the legal doctrines are. You got to know those doctrinal contours so you can get a sense of where you can go next. You can't go too far too fast, it won't work. But if you're right at the edge and you know where the edge is, then the work you're doing in the trenches representing real people where you might have a case that could help push the line. If you can't connect those two things, you're not going to be effective in either sphere. So I try to keep my litigation skills up alongside my skills as an academic. And I try to be good at both, even if it's not easy, just because I think it's an unusual set of skills that an activist lawyer has to have at all times. You just have to. So I share a little bit about why I do what I do. I think it's outrageous that women are raped, beaten, and killed at such high rates and no one seems to care. When anyone else is killed, the politicians come out of the woodwork and no one ever comes out of the woodwork when a woman is killed. A woman in Massachusetts, pregnant woman, was just found dead in her boyfriend's home. He clearly killed her, and he also killed her primarily, I think, because she was pregnant. She's female. He didn't want her to stay pregnant. She was 11 weeks along. He probably, I don't know the details, but it's clear he killed her because she's female. That should be a hate crime, but it isn't in Massachusetts because women aren't protected. And even if it were, why aren't the politicians coming out expressing outrage that this happened to this woman? Why is it no politician's business? Why is no one saying anything? If this were any other kind of dead person killed in such a brutal way, there would be a press conference at the State House and Maura Healey would be screaming from the rooftops. She never, ever, ever, ever speaks up when we have bodies of dead women all over the place. She never does. She doesn't care about women's issues at all, even though she's a woman. So we have to be careful. Don't just vote for a woman because she's a woman. Vote for the person who cares about women. especially when it comes to violence. 6 women a day, roughly, are killed by men in this country. That is an exponentially higher number than all the other protected class categories combined. 6 a day. That's an enormous number. And yet, no one talks about it as an epidemic. No one talks about women as a class being targeted and being victimized at very high rates because they lack equal protection of the laws that are supposed to protect them from these kinds of violent acts. The amount of silence is deafening. The enormous noise that I hear when someone else dies, even if it's just, 2 people a year die from whatever, and there's all these press conferences about it, drives me crazy that there's this hierarchical attitude about the value of women's lives, that lots of them die and it doesn't matter, and one person of another type dies and it matters enormously. When this guy in Georgia a few years ago shot and killed a bunch of women who worked in spas. I'm using that as a code because obviously they were also doing prostitution of some sort, and maybe against their will, I don't know. But when he shot up a bunch of those women, they were women for the most part. I think there was one guy, and the majority were Asian women. But he was very clear. I killed them because of sex. I killed them because I have an addiction. I killed them because they're female. I killed them because of porn. I did not kill them because they're Asian. I don't care that they're Asian. I don't have any feelings about Asian people. He was going to go from shooting them to death to Florida to shoot up a porn business that he was getting his stuff from. That was related to his motive. The only press coverage about that was this was all about hatred toward Asians. And no one agreed. No one thought this involved hatred toward Asians. It wasn't at all about hatred toward Asians. It was about hatred toward women. And his obsession and his mental illness or whatever it was, it had nothing to do with Asians.
But as a counterpoint, the guy out in California, that sick man came up in the BK case. Elliot Rogers, that sick man who filmed himself, killing women. There was a lot of attention, to be fair, to some of these sick men.
When men are serial killers against women.
Well, mass shooters or something like that. There has been attention on people like that who targeted women. I think it would be unfair to say there wasn't.
There can be attention. What happened in the Georgia case and what happens even in the serial killer cases is nobody calls it a hate crime. Nobody talks about it as women being targeted.
Well, do you think Elliot Rogers, I think most people would agree. I think this goes to your point. What Elliot Rogers did was a hate crime. He shot women because they were women to start a movement targeting women. It's more than a hate crime. It's terrorism.
Is that the Ohio case?
No, that was this. This was a long time ago, and it only came up because of the Idaho 4 case. It was this guy in California like 12 years ago. He was a crazy man who filmed himself saying that he was like the leader of some movement that hated women, and then he just started shooting.
An incel guy?
Yeah.
Well, so here's the thing. Women are protected under federal hate crime.
Oh, got it.
And they are protected as a category under most state hate crime laws, but not Massachusetts. I shouldn't say most. Half the states do protect women, half don't. Federal law does.
So the fact that he did it in I think the guy died. He was a coward and took his life in the sense that he killed all these people. So he would have been, if he had lived in California, he might have been charged with some kind of terrorism or hate. Oh, come on. He went on a mass shooting spree targeting women.
Hate crime. No serial killer of women has ever faced.
Oh, wow. But what if, now this was a different situation. We'll never know because he's dead. But what if that man with that video of him as he's doing the shooting saying, I hate women, all this stuff, is that enough to get a hate crime modifier?
We've had many cases with
recorded saying during the murder that they're doing it. That's a whole different level.
Listen, I'm telling you, we have had many examples of men saying, I'm killing women because I hate women. It doesn't matter.
Right, this was a mass shooting, though, which is not, this is terrorism.
More than 50% of mass shooters kill out of hatred.
Sure. But here we have the reason why I'm bringing this up is you either can have a hate crime modification on sentencing, which enhances it, an enhancement.
You still have to be charged.
Sure. Or you can have the hate crime charged. Now, setting that aside, this person didn't just shoot at women, right? He committed terrorism. If he lived, he probably would have been charged federally with terrorism. There is no way that him filming a video while committing terrorism, declaring his hatred of women, would not have, at the very least, resulted in some kind of discussion of whether it was a hate crime against women.
Nope, wouldn't have been charged. Let me tell you why. Because despite women being a protected class, there is incredible political pressure never to bring the charge. The only reason they're added is to prevent people like me from suing for the exclusion. But last week, the U.S. Attorney in Boston announced the targeting of women for a sex trafficking charge, and that was their language. Women were targeted for this sex trafficking guy, and we're getting rid of him. And
well, they make a lot. That office does a lot of good work. So they targeted a guy who was sex trafficking someone and he was targeting women. And in their press release, they talked about how he was victimizing. Yep. That's a good thing.
He was targeting where's the hate crime charge?
Okay, but I understand that. But before we're too critical here, I don't understand the components of the federal hate crime law. But I have read federal.
It's animus toward the class.
Sure, and I have read federal sentencing documents where someone's behavior towards women as a member of the class of women resulted in an enhancement. So you can't say that they've never used it.
No, there's a nice try. I'm about to catch you, my little son, my very tall son. There's only been one federal hate crime charge involving.
Not the charge, the enhancement.
It doesn't matter whether it's there's only been one indictment that mentioned the hate crime statute, either as a charge or a sentencing enhancement. One.
An indictment doesn't. You would not mention a sentence enhancement at the indictment.
Yes, you would.
No, you would bring it up in the sentencing document in the pre-sentence.
It has to be alleged in the indictment.
For it to be a sentencing enhancement?
Right. There's only been one, and it's a charge. One case. It was in Ohio.
Mm-hmm.
Was because the leader of an incel group online and in writing, along with a bunch of other people, said, we are going to go to the University of Ohio. I forget if it was Ohio State or whatever. It was an Ohio university. It said, we are going to go to the university and shoot up the girls because they rejected us for sex. Something to that effect.
Yeah.
Nobody was killed, but the online banter was so explicit. Right? Interstate transmission of a threat to commit a crime. Yeah, well, I mean, as a federal crime, this certainly fit the bill. And the guy was charged with a hate crime. It was the first ever federal hate crime charge involving a female. But would this guy, Elliot Rogers, under that similar standard, if he's making a video, firing a weapon, saying, I am shooting this weapon because he of his motive. He wouldn't face the charge. I'm trying to explain. But in the indictment, could they have done the similar thing? Listen. It wouldn't happen. The only reason it happened in this case is because the university didn't want the women to be killed as the thing that would have to happen before something got involved, because the university would have been sued up the wazoo. So they went to the feds and said, can you prosecute them based on the threats? We don't want to wait until they do it because it'll cost us a fortune, right? That's the only reason. Yeah, I understand, but this is I think I get a little bogged down in your legal realism because I realize you've been doing this for a very long time. I'm just telling you the truth. But to say, for example, the families, say the guy had lived out in California. Just in a lay capacity, would never say to the families, you should not ask for a hate crime charge because they'll never do it. Of course you should ask if it was a hate. Right, but that's way too legal realist. I've done it many times. There is no USA in this country that would charge a hate crime based on a request by a victim. Then that's never. In there. If there aren't people in there who are willing to do that, put them in there. Nope. Yeah, but they're not. It's not going to happen because it's a bipartisan problem. I don't care if it's multi-partisan. Wants to recognize women as a category of people. Okay, well, that's the issue. That's great. Political. I understand, but it's about doing what's right based on the principle. So, like I said, if you have to make a section of the DOJ to make enforcement against bad cops who are abusing victims a priority, then you make it a priority. Let's come back to the beginning. The amount of money that gets spent at the federal and state level. Oh, we need Jesus. keeping the language away that makes women sound like a
Then they need Jesus. If their primary concern is money, then they need to read more of the Bible. Speaking of the Bible, Anthony Barton, well, not the Bible, I guess the Old Testament, Anthony Barton left a comment saying, in Israel, women have to serve their country just like the men in the IDF. We don't need a response to that, but that's a good question, a good statement. I got a question from Steph, but before we get to that, Mom, you wrote a new book recently. It's actually up on the screen. What exactly is it about? I believe I posted the Amazon link earlier, and what's the title and where can people find it?
People can buy it, and I would love to hear comments. And please make a comment on Amazon if you do, because I love hearing what people think. I don't make any money really from this because my publisher gets the dollars, but it's called Oh No, He Didn't, Brilliant Women and the Men Who Took Credit for Their Work. It was a lot of fun to do. It was a labor of love. And the reason I wrote the book is because I was researching some stuff for my constitutional terrorism law review article. I happened upon a story about a woman whose work was credited to a man, and I said, "Ooh, maybe I should put that in a footnote as an example of what can happen legally when women aren't entitled to equal protection of the laws, because it's easier to steal a woman's work if she's only going to get unequal enforcement of laws against stealing work, right?" So I said, I think I'll put that in there. It's a nice expression of what inequality looks like in practice. And I said, I'm just going to go buy a book on the topic, and then I'll cite the book in my footnote. And there wasn't one. So I really felt compelled to write it. I said, I can't believe there's no book about this topic of men taking credit for women's work. It's just shocking to me. So I was simultaneously writing the academic paper with the book because I couldn't not do it. And it was kind of challenging and fun because my lay brain writing the book, trying to make it accessible to lay readers, was speaking in one voice, and my lawyer brain trying to write, intensely academic stuff for a law audience was functioning at the same time, and I sometimes had trouble turning one off and putting the other one on. So I think my book came out a little legalistic, and I think my law review article came out a little bit sassy.
That's, I think, I haven't read the law review article in full, but I have read parts of the book. I find the book very interesting, but I also found the breakdown of the due process test or the strict scrutiny test in your brief very interesting. So maybe I'm an outlier. Thank you for that answer. Steph says two things. Steph says, I wish I had a mom like Wendy, but my mom isn't like Wendy at all. My dad doesn't think women can do anything. He got upset that two women came to install the air conditioner the other day. Oh, Steph's Canadian. I can't do anything. I don't know what to tell you, Steph. I don't think it has to do with him being Canadian, but anyway. The question then Steph has, go ahead.
There are women who don't do things because they don't think they can. They don't have a lot of encouragement around them. And I think when women do try to do things, they're so excited because they're shocked that they can do that which they thought they couldn't do. Like I one time needed a backsplash, a tile wall in a couple different places. I wanted tile, couldn't find anyone to do it. So I just said, oh, hell, I'll do it myself. Hanging tile is not hard, but I didn't know it wasn't hard. So I just tried it, and I was willing to fail. And that's what I would say to your mom or to you or to anyone. Be willing to fail. It's okay. It's really important to fail. Failure is learning, and failure is really where you get resilience and fearlessness. I don't mind being wrong. I really don't mind being wrong. I like being right, but I don't mind being wrong. And I certainly don't mind, breaking something or wrecking my wall or making the wrong argument. I don't mind at all. And that makes me more willing to take risks. It also makes me a good learner, because if you don't fail, how do you grow? If you just keep doing the same thing over and over. I just want to tell you one quick story about Grant, and then I'm going to go because I am going to go to yoga. Yoga is helpful as well. I just recommend it to anyone who believes that rest of the mind is good. It just is good, no matter what you do. Breathing and meditation and yoga are all part of relaxing the cortisol and, keeping your body healthy, not stressing it. And you can always be a better anything if you just do a little bit more um, a little bit more, I don't know, to insulate yourself from the stress of what you're doing, especially if you want to do something that's hard and challenging and that people don't like or that's unpopular. You got to stay focused on keeping yourself healthy. So I want to tell you this about Grant just because he could, if I interviewed him, we'd have a very interesting set of conversations that would be very different from the one we just had. But when Grant was born, aside from the fact that he was this amazing kid, before he was 2 years old, he could count to 10 in 3 languages. I mean, he was out of control smart. And he wasn't just counting to 10 in 3 languages like 1, 2, 3, baby language. It was 1, 2, 3, uno, dos, tres. He had the diction of a 12-year-old and was a sponge, So I'd say, well, let me teach you to count to 10 in Russian. And he would get it. I didn't even have to really work at it. He was extraordinary. And people thought, wow, this kid scares me. Where's he going and how big is his brain? He did have a large head, as I do, and I think there's a lot of space in there for big brains. And then, focusing on philosophy as a kid is kind of a strange thing when you're little. He very smoothly incorporated thoughts about the way the world worked. Even when he was so young, like first grade, he had this horrendous first grade teacher. I forget her name, Grant will remember. And she would sit the kids down in the beginning of the day in a circle in front of a board, like an easel. And she'd have the schedule of the day there. So at 8, they're going to do something. At 8:30, they're going to do, art. At 9, they're going to do snack. At 9:30, they're going to do something else. And then recess came at like 11. And every single morning he would go in and sit in the circle and the teacher would be going through the schedule and his arm would go up. Excuse me, do you think we could do recess before math? Because I find that recess before math, and he had an argument for why recess should come before math. Or do you think we could do lunch before library? Because I get very hungry when we go to the library, whatever it was. She would beat him down, and not physically, obviously, but criticize him. Why do you always raise your damn hand? You need to stop raising your damn hand. And he would be like, yes, but I have something to say about how you organized our day. And I'd like you to listen to what I think. And she eventually, when I had like my first parent-teacher conference about this, she was giving me an earful. And I thought, wow, this is a dangerous teacher who can't see the value and the beauty in a brain of a little boy who's simply trying to say, I got big thoughts here, and I'm not just interested in you telling me what to say and think and do. I have my own thoughts. And how can a teacher not run with that? Turn that child into, something special. But she couldn't. She was a horrendous teacher. She eventually quit. And it turned out, I found out she was a victim of domestic abuse and was just living a bad life at home, which, didn't made me feel a little bit bad for her. It doesn't excuse how bad of a teacher she was, but all she wanted to do was wrestle this kid down and not respect the enormity of his brain. Now, flash ahead a few years later, Grant's in middle school. He had to be, I don't know what you are, 12-ish? I don't know. He was in like 7th grade, I think, 6th or 7th. And they had an assignment. No, it had to be, I think it was 6th. It was an assignment where they had one piece of paper with 3 sections. And it said, please describe 3 things you like or dislike about space, because we're going to start to study space. And I kept saying, did you do your homework? Did you do your homework? Yep. No, you didn't. Let me see. No, I don't think you did it. Yes, Mom, I did my homework. Show it to me. And as he's walking out the door to go to school, he shows me, and there's nothing in the first section, nothing in the second section, and like 3 sentences at the bottom. I said, you are in such trouble. You're not leaving your room. I'm so angry with you. You didn't do your homework. He said, bye. And then a few days later, the paper came back and it had the highest grade, like Check Plus or A, whatever they gave kids back then. It was the highest grade. And I said, how is that possible? It's an empty paper, except for a few sentences at the bottom. And this is what he did. He left the first two blank, and then at the bottom, he said, I left the first section blank to convey a sense of the infinite because I find the concept of infinite space fascinating. He said, I left the second section blank to convey a sense of nothingness because I also think nothing is interesting about space. And in the third space, he said something about, I don't know, some physics concept that had to do with gravity or whatever. I don't even remember what the third one was because it was actually an answer. Maybe he remembers. Maybe you can say, Grant, what you remember. But I thought, this is a good teacher. A bad teacher would have said, you forgot to answer two questions, and would have punished him, frankly, for being clever about his third answer. So I mention that only because, how do you go about seeing yourself in the world and where you belong and what you ought to be doing? When you have a really big brain, it's hard to rein in. And Grant knows that I am pressuring him all the time to finish law school, pass the bar, get a real job, blah, 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 blah. And I still see that as important. But there's a whole world out there of opportunity for people with very big brains. And they don't always follow the path that people think they should follow or that they could follow. And life is extremely short. I don't have to just be old like I am to understand this. And I think young people sometimes don't get it. Some do, but it's such a blink of an eye. You go from born to dead so fast. And before you know it, there's 6 generations coming after you, and you're not even a memory anymore. The notion that life can be so meaningless for people who just go from the physical nature of, coming into existence and dying, and then in the middle you just obey, do the right thing, follow the path, death of a salesman kind of stuff. It's very challenging for young people today. There's a lot of hopelessness, there's a lot of fear. How do you find your path without feeling like the path has found you and that it's not the right one? So I say that because if any of you are regular listeners to Grant's podcast, is this called a podcast? Yeah.
No, it's a public information service which is designed to fill the gap left by the collapse of funding for such services in the domestic and international arena.
Okay, well.
And you're talking to the people who support the platform and allow it to exist, and who consider it very real.
I'm going to call it a podcast, and I'm just going to say, to the extent.
Well, Lord Reith is offended.
Okay, well, I don't know. Just forgive me for my age-related deficits. If this is a place where you get inspiration, Grant, and that people inspire you, and vice versa, it's a mutual love fest sometimes. Then I think finding your path is doable. You got to have guides, inspiration, support, critics,
principles,
but also listen to others. Listen to others. It doesn't make me wrong that I see a path for you that you don't see for yourself, and it doesn't make me right. It's just support, guidance, criticism. Everyone needs to listen. And I say that as someone who isn't always a good listener. Life is so short that the notion that you might waste your time walking in the wrong direction, I've never thought of it as much of a waste, because everybody goes in a certain direction. You learn something, you go in the other direction. But I do think that choices matter, and you can't just be principled. It's not a lifestyle. You can't just go forward toward some silly ideal, because then you die. You haven't lived. You haven't lived.
And the reality is none of us, and I think we're not really speaking to a gap in the generations, we're speaking to a gap in the ages. There was a prior age that was defined by human relationships and analog existences and small communities and families. Now we are in the digital age. People's communities, people's families span countries, continents, time zones. There is no more regular day-to-day life. We're all figuring it out together, and this new digital era doesn't have its principles defined yet, and it's certainly not defined by those of an old age that is still flickering, although ever more dimly, by the day.
Well, I'll take an offense at that, but I will also say this. I don't care what the digital age offers by way of community. I don't disagree that there's some there. What I will always say is connectedness is not digital. Connectedness through digital is the antithesis of what's actual about our connectedness, and that is the biological, the energy. You know, we are, you don't have to be a philosopher to understand that nature and humans are all one. You can't have that through electronics.
That's how the pagans felt about Jesus.
I don't care. There's a physicality to walking outside, stepping on dirt,
Yeah, that's going to be.
and touching and hearing and communicating and connecting with other humans. Humans matter.
They
Humans
do.
matter. And you have to make them matter by making the effort.
But the reality is eventually our bodies will not be the vessel by which we make human connection. That is how we are evolving. We will not require our bodies.
That may be sometime in the future. For now, humans have value. You talk about the concern you have for humans all the time. You can't be human through the internet. You have to be human with humans. Make yourself.
You know, Mom, we don't call it.
Phone down. Go outside. Sit under a tree. Talk to a human.
Yeah.
Go touch a human. Don't just live online.
Oh, and there's room for people like that in this world as we evolve, but they won't be making the policy decisions. They'll be living, driving motor cars, and praying for the return of street lamps. It's not happening.
No one's praying for the return of street lamps. All people, digital and otherwise, are praying for humanity. And you don't have to be religious to pray.
Yeah, we're not going to make it. I'm sorry, we're not going to make it.
Humanity depends on humans. There's nothing complicated.
Mom, humanity is fragile. It cycles. We're going to get a big flood, and it's going to go away. What we should preserve is some kind of stable cultural ethos as we transition into a digital arena so we can leave this planet. That's where we're going.
Well, we're going to leave it at that so that you...
Thank you, Mom. But also...
I want to have your digital future, and I'll have my human future.
Yes, and I want to end it on a positive note in two ways. One, I didn't get to answer the question now, but I'm going to have Steph send you a DM on Twitter. She's very interested in your thoughts on the John Benet Ramsey case. I told her you're a subject matter expert.
No, just give her my email. I'll send her my book, which gives you all the details.
Oh, Steph, there you go. Not only are you going to get an answer to your question, she has a book. Now,
I know exactly what happened. I mean, it's not even in dispute.
Yeah, and Steph's exact question, I know you have to go to yoga, but just so you know, what she wants to know is, what does Towel Mom think about the postulate that John Ramsey or the oldest son will ever be charged or face justice for John Benet's murder?
It's not going to happen. There's too much money involved. But just so you know, the child died from benzodiazepine overdose, respiratory failure. The rest was staging to cover up the fact that the child was being pimped. It's really simple. A lot of children die from benzos because pornographers and pimps give them to children to keep them not just compliant, but to create amnesia so that they can't tell when the drugs wear off. The Ramseys were interviewed at length about all the benzos in the home. They didn't have good answers for why they were there. You know, her vagina was a mess, the child's vagina. John Ramsey's unusual Israeli wool sweater fibers were found in the underpants that she was redressed in a new package, 3 sizes too big, that had been ripped from a package of Bloomies, day of the week Bloomies, that Patsy bought in Bloomingdale's in New York for an older cousin of John Benet's. So they didn't come into contact with his sweater through laundry because they were removed from a Christmas gift for her cousin. John had no answer for how his sweater fibers got inside the crotch area of those underpants that were obviously not hers. I could go on. The undigested pineapple in her stomach. was, you know, if you've ever been a mom and you got to give your kid some kind of bitter medicine, you're always told by the doctor to mix it with an acidic fruit to offset the bitter flavor. She had undigested pineapple in her stomach. There's a bowl of pineapple on the kitchen table. She died at midnight, which means she ate the pineapple within 2 hours of death because it was undigested at autopsy. Both parents adamantly refused giving the pineapple to the child. Patsy's fingerprints were on the bowl, Burke's were on the spoon, or vice versa. One was on the spoon, one was on the bowl. Both parents adamantly denied giving the child pineapple, but she obviously ate pineapple from that bowl. And why would you deny giving your kid pineapple? I mean, the only reason is because you know there were drugs in there and you can't admit giving her the pineapple because that's like admitting you gave her drugs. So they both just said, I don't know how she got the pineapple. I don't know. They also said they brought her home from a Christmas party around 9:30 that night, put her straight to bed. She fell asleep in the car and never woke up. Well, but she ate pineapple around 10 and the parents were awake at 10. So, you know, come on. The first 3 search warrants in the case were for child porn on John's computers. This is not a complicated case.
So who did they know? Some person in Colorado government?
I don't know. I listen. I'm not going to speculate about what interests.
Aren't they dead? Isn't one of them dead?
The mother's dead. I'm not going to speculate about why the right thing didn't happen. I will say this: when a mother and a father are both involved and they each agree to be each other's reasonable doubt, you get what I call the cross finger pointing problem. They prosecute John, he blames Patsy. They prosecute Patsy, she blames John. Both of them walk. They agree to be each other's reasonable doubt. It makes it a challenging case.
Isn't that why you have co-conspirator liability?
Yeah, but then you have to show conspiracy, which they may not have had. You know, it's a tough case. It's why the defense bar has this statement. Nobody talks, everybody walks. You just agree to be each other's reasonable doubt by staying silent. There's so much more to the case. There really is. Than what has been revealed. And one of the reasons we keep seeing documentaries that are misleading about the truth, and one of the reasons you tend to see them every 10 years is because the judge ruled that the case file would be turned over to the public after 10 years if there was no prosecution. So at the end of 10 years, they came up with a fake suspect, bandied that about in the press for a while, got another 10 years. The next 10 years went by, they came up with a whole new argument about DNA. This is not a DNA case, never was, never will be. That went away. They got another 10 years. Next year is the 40th year. Is it 30, 40, 80, 90? Oh, yeah. Next year will be, I think, the 40th year. Anyway, whatever year we're at, every 10 years, you're going to see a big burst of propaganda. It's going to make it seem like there's some mysterious new piece of evidence because that gives them another 10 years of keeping the file secret. But for now, 90% of the case file has never been released. The little bit that's out there has been released mostly by the Ramsey side of things. And so it's extremely misleading. And, you know, I just think the public should always be suspicious if a little kid dies, that it might be a benzo overdose because it's really common. If you give a child benzos sporadically, they will die from respiratory failure. Not will, they are likely to suffer terribly from respiratory failure because you can't spike a benzo like that on a little kid. And the older they get, you know, they tend to get a bigger dose. So you can't spike like that and not expect the child to suffer. And you can't recover. When you get respiratory failure, you can't recover. You can't like shake the child out of it. It's not that kind of problem. So
kind of like the Lindbergh baby. It was probably the parents. And
I don't know that case at all, but I will say this. Anytime
the baby in the Lindbergh case was mentally disabled and Charles Lindbergh was embarrassed, so it's thought that he killed the baby and covered it up.
That might be. But when I'm talking about benzo deaths today, because a lot of parents who are addicts will pimp their kid in exchange for drugs or, you know,
or just evil people.
Well, people who want money. You can make a fortune pimping your kid. I mean, before the internet, it was a really hard business to get into. Now you can do it at home. The point is, anytime you see a news story about a little kid who's either missing or shows up dead in a river, ask the question of yourself, did they rule out benzo death? Because parents who pimp their kids know that if the kid ends up dead from the benzos, they have to get rid of the body somehow just long enough for the drugs to dissipate.
Oh, and could that be what's going on with this situation out in California with the missing baby and the two parents who obviously they're just trying to keep the body from being found long enough so the drugs won't be discovered?
Yeah, it could
Wow.
be. It could be. That is a very common scenario. But all I'm saying is it might not be the case. Just ask the question. Have they ruled out benzos? Because child porn is an enormously expensive business, a profitable business, and the number one makers of child porn in this country are the parents of the victims or the mother's boyfriend,
or some very shady. I am sure that they are the ground soldiers making it, but the money behind it is definitely the people that were involved with Epstein.
Yeah, it's like drug dealers. They do the street level stuff. And people who pimp their kids,
Yeah,
they're like street level drug dealers.
Yeah, and I recommend the Fort Bragg Cartel. It's a great new book just out over the past month that explains just like sometimes there are powerful interests that run children, there are government actors that run drugs. That's how they fund hip pocket operations, and it's very dangerous.
Money, this is what I always say: race trumps sex, politics trumps race, but money trumps everything.
Yeah, well, except for Jesus. But that said, Towel Mom, I appreciate this interview. I'm going to lead you out by saying people can follow you on Twitter at WMurphyLaw. They can contact you, your school email page. You can find her at Wendy Murphy at the New England School of Law. You'll find all of her contact information. If you're a law student, if you want to get more involved in her projects, you can reach out. There are always things to work on. I'm sure she can find a way for you to help, even if you're not a law student. Towel Mom, thank you very much for giving us over 3 hours of your time. It was actually more than that. It was a great discussion. We will look forward to passing around your book about John Benet Ramsey, and you're clearly an expert in all things the Constitution. So thank you very much.
Love you, my son.
I love you too, Mom. You have a great rest of your day. All right, folks, thank you very much to Towel Mom for spending some time with us today. Wasn't that wonderful, Towel friends? Didn't Towel Mom do an excellent job? She gave us almost 4 hours of her time. She would never give anyone 4 hours for an interview except for Little Towel. So I hope everyone learned a lot. We had a great discussion. I'll make sure to get that full 4-hour clip up eventually. When we get talking about the Constitution, Towel Mom and I have a lot to say. That was great. Thank you so much for tuning in. I am so glad you all got your questions answered. I think I saw Lindsay turn up at a certain point. We had some great questions from Steph and Anthony and Selma. Thank you all so much. We learned a lot. We chatted. Towel Mom is very smart. You can see I can kind of keep up with her. I speak her language a little bit, but she starts getting going there. Title VI of the Civil Rights Act. Oh, geez, you're going to have to explain that one to me, Towel Mom. That was great, Little Towels. I am honored that we got to spend that time together. My name is Grant Smith Ellis. That was fun. Felt like 5 minutes. We had a great time. Thank you, Tanya. It was great to see you. Holistic Psychology, Peggy, Vicky Moore. How great was that? Now, I need about an hour for lunch. Okay? So, a couple things. One, Towel until at least tomorrow needs your help. So if you want to help Towel, feel free. Number of ways to support this channel. We normally do it every 2 hours, but we just spoke to Towel Mom for 4.5 hours. So there's Donna Adelson jury selection going on. We're going to get caught up in the new U.S. Letter from U.S. Attorney Leah Foley regarding the Karen Reed, John O'Keefe, Michael Proctor case. But if you want to help Towel get lunch today, I got a Towel cheeseburger yesterday. You can see the Venmo up on the screen. You can see donation information. It's a public information service. Towel Mom was a little baffled. She called it a podcast. It's our podcast, Towel Mom. It is a public information service designed to educate, inform, and entertain the public, such as to engender cogent public discourse and ward off the usurpation of our representative forms of government worldwide. Towel Mom was like, no, it's a podcast. No, it is not a podcast. How dare you? How dare you, Towel Mom? Anyway, that was a great discussion. I hope you'll buy Towel Mom's book. It's well worth the read. We'll send around that John Benet Ramsey link. Steph's going to email Towel Mom from her Nestle academic page on the public Google. All right, so if you want to help Little Towel, feel free to go ahead and scan that Venmo link. I'll go ahead and drop the links in the chat. I'm going to go get a Towel cheeseburger. I think I have just enough to be able to do so. I only have to make it till tomorrow, Little Towels. I didn't do the greatest job this month. That's fine. I'm a Little Towel. All right, yeah, I know. I went 4 hours with no cigar. It was hard. It was hard, ladies and gentlemen. It was hard. Towel's getting riled up and arguing about the 14th Amendment with Towel Mom. I got a nice video to show you, ladies and gentlemen. I got a nice video to show you that I put together. It has to do with the letter from U.S. Attorney Leah Foley. And it was a pretty good job from Little Towel. It's 51 minutes, so we're going to spend the next 51 minutes watching this while Towel eats lunch. We'll check in on the Donna Adelson hearing. There's not much going on. It's more jury selection. And then Donna Adelson's trial should start Friday morning, okay? Final jury selection should finish up. We'll have our jury tomorrow, opening arguments Friday morning, 30 minutes each side, then on to the presentation of evidence. Now, if you missed the letter from U.S. Attorney Leah Foley to the Norfolk DA regarding Michael Proctor, the Karen Reed case now confirmed as closed, it was all over the news overnight, Little Towels. I have the full thing up for you right now. God bless each and every one of you who's been supporting Little Towels Public Information Service, and thanks very much for tuning in today. Now, as Towel gets ready for lunch, let us go right over to this video that is going to help you understand the new letter from U.S. Attorney Leah Foley while I make Towel lunch. Worst comes to worst, I will just make french fries. I think I have some frozen french fries. I might have a few pieces of chicken as well. I just have to get to tomorrow, August 21st, and then I'll be all right. I don't know why it works like that. I think it's because of the way YouTube does it. But August 21st is like the day of the month when I can finally not need your help. So one more day. Towel also had to Towel did a lot of things this month. Towel did his best. I'm a Little Towel. Let's watch. Thanks very much for being with me. And if you're wondering, my name is Grant Smith Ellis. I'm hanging out with you. I made the letter as large as I can make it. And let's take a look at the new letter from U.S. Attorney Leah Foley's office released in the context of the Brian Walsh case. It is a letter from U.S. Attorney Leah Foley's office to First Assistant Lisa Beatty of the Norfolk County District Attorney's Office. And the letter talks about, and it really requires some context. Remember, I'm not a lawyer. I'm not your lawyer. I am a towel. None of this is legal advice. But it really requires some context to understand because it's like a speaking letter, and it's a letter that has a lot of odd undertones to it. I read it a few minutes ago, so I understand what it's talking about. And in general, what the letter says is, in order to effectuate the prosecution or help the Norfolk DA prosecute the cases involving Brian Walsh and some of the other criminals because of the, quote, serious nature of the charges, in order to facilitate compliance with Rule 14 discovery obligations, the U.S. Attorney's Office under 28 CFR 26.1 is going to facilitate the release. Personally, U.S. Attorney Leah Foley is going to facilitate the release of documents related to Michael Proctor from the now confirmed as closed federal probe into John O'Keefe's death. However, what the letter also then goes on to say is what they will not give, what the U.S. Attorney's Office will not give, and by the way, this letter confirms that the probe of John O'Keefe's death by the federal government is over in the last page. We'll get there. But what they're not going to give over, says U.S. Attorney Leah Foley, is they're not going to give over material from Michael Proctor's grand jury testimony, the federal grand jury testimony. Now, they give two reasons for it. One, it would violate federal law for the U.S. Attorney's Office to do that. And then, second of all, they argue that it's redundant because Michael Proctor testified under oath in Reed's first trial, so therefore all of these defendants seeking Michael Proctor's grand jury testimony don't really need it. Third, the U.S. Attorney's Office states that the only material in Michael Proctor's grand jury testimony relates to the Reed case, if that testimony even exists. They're being a little wishy-washy about how they talk about it. So therefore, there's no grounds for them to release it to any of these other defendants, the Brian Walsh defense, or some of these other defendants. And then furthermore, the U.S. Attorney's Office says that the other defendants have no standing to intervene in the protective order that currently exists related to the Reed case material via federal court. And therefore, two things follow from that. One, if a state court issues an order compelling the Norfolk District Attorney's Office or the U.S. Attorney's Office to turn over protected federal grand jury material related to Michael Proctor, then the U.S. Attorney's Office will move under the relevant section of the law that I just referenced to move the matter to federal court. That is basically a message telegraphing to all the defense attorneys, don't do that, and none of them are going to do it. because it will get immediately removed to federal court for the purposes of confirming that the state court order attempting to provide Michael Proctor's grand jury testimony to the feds would violate federal law, and so they could get the federal court by the U.S. Attorney's Office removing the matter to federal court could basically quash the order to compel production of the federal grand jury material. Furthermore, the U.S. Attorney's Office also says in this letter with regards to that grand jury material, if a party is aggrieved by the release or by what U.S. Attorney Foley's office chose to release under 28 CFR 26.1, then the appropriate remedy is for them to file a TUI request. Okay, this isn't being released pursuant to a TUI request, which is enumerated under Section 25 of the DOJ Operations and Sections Manual, which is itself an interpolation of U.S. ex rel. TUI v. Reagan from 1985. Now, this has to do with what happens if parties to a state court criminal case want to obtain documents from a federal court, federal investigation that's ongoing, in the context of discovery obligations, for example, due to the defendant in the state court case. So, as such, U.S. Attorney Foley's office concludes the letter by saying, well, basically, you have a remedy at law here, the defendants, attorneys in some of these other cases, Brian Walsh and others. You have a remedy at law here, which is you can invoke the Administrative Procedures Act after filing in due course and appropriately a TUI request under U.S. ex rel. TUI v. Reagan. And then if that TUI request is insufficient or inappropriate, then you can appeal it under the Administrative Procedures Act in federal court. What you can't do is try to do an end run around U.S. ex rel. TUI v. Reagan by getting a state court to compel production of the grand jury material, the federal grand jury material involving Michael Proctor. And then you also don't have standing to intervene at the U.S. District Court in Boston to get the protective order either amended in scope or changed, and the U.S. Attorney's Office isn't going to accede to the request by these defense attorneys to move to amend the scope of that still ongoing protective order, even though the Reed and O'Keefe federal probe is over, in order to facilitate the transference of these federal grand jury materials. So how do you interpret all this? We're going to read it, but I already read it, so I just told you what it says in lay English, basically. So how do you interpret all this? Well, basically what it means is that the U.S. Attorney's Office doesn't want any of these defendants, these state defendants, Brian Walsh and others, to be able to get away with what they did because Michael Proctor has this bad reputation, and so the U.S. Attorney's Office is going overboard to facilitate reciprocal discovery compliance by the Norfolk County District Attorney's Office to ensure those cases can't be dismissed on procedural grounds or whatnot due to failure to comply with discovery obligations. But the U.S. Attorney's Office is then foreclosing the ability of those defendants to argue that the absence of the Proctor federal grand jury testimony justifies dismissal of their state court cases by layering into this letter a bunch of stuff that basically makes it clear that there's nothing in there that's going to help those defendants. And furthermore, if they move to try to get these materials at all through any process other than the TUI process and or an appeal via the Administrative Procedures Act, the U.S. Attorney's Office is going to rain all hell down on them by removing the case to federal court if there's a state court order compelling production of those federal grand jury materials. Does that all make sense, ladies and gentlemen? So that, yes, Selma, it was great to see you. Glad you were able to pop in. But that's what we're dealing with. Let me pull out my telephone in case you have any questions. I'm going to read the letter for you in full, but that's what the letter means in lay English, in my opinion. You really have to know what you're reading to understand it. You have to be an expert, for example, in U.S. ex rel. TUI v. Reagan and things along those lines. So in order for you to do that, ladies and gentlemen, what I suggest is that you listen to the explanation that I just gave, and then as I pull up the comments here, give me 1 second. I want to be able to watch along with you. I want to watch my stream. There it is. I want to be able to read along with your comments because this is not the easiest thing in the world to understand. So if you're just tuning in, we're going to go over the letter. I just gave you what's called a primer. All right, so a primer is an introduction to that kind of thing. The trial is an introduction to that kind of thing. So, actually, let me be very clear. Somebody was getting upset at me. Sorry, somebody trolled me. They were getting upset because Kate Peter got caught doing something bad, so I had to block them. I'm not going to let you distract me right now, by the way. So the block button, not in the comments, it was on Facebook. The block button is my best friend right now. So we're going to talk about this. And by the way, the work that I do, this is a public information service, and, you know, for example, I try to help in different ways. That doesn't mean I always talk about it, but this is first and foremost a public information service. So God bless each and every single one of you for supporting this public information service. Thank you very much. My name is Grant Smith Ellis. Thank you for tuning in with me today. No matter what slings and arrows people throw at me for doing this work, I don't care what coverage we're talking about. I don't care what interests are involved that get frustrated about it. I'm going to keep doing it because my commitment is first and foremost to the people who are interested in the power of cogent public discourse to ward off the usurpation of our representative forms of government. So, all right. I should not read people trolling me on Facebook. All right, here we go. Dear First Assistant Beatty, as you are aware, in response to a joint TUI request by the parties to Commonwealth v. Karen Reed, docket number 2282, CR 00117, Norfolk Superior Court, my office, this is from U.S. Attorney Leah Foley's office, it's the first assistant, or not the first assistant, it's an assistant U.S. attorney who writes the letter. My office produced certain federal records, the quote confidential materials, to the parties in that matter. Now, when they use confidential materials, that, like, see how it has two quotations there? What they're saying is that's referring to what's in the immediate sentence before, certain federal records, okay, which will hereafter be called the confidential materials, to parties in that matter. The confidential materials are subject to a protective order issued by the U.S. District Court for the District of Massachusetts, and that order provides the parties to destroy those records upon completion of the Reed matter. As you are aware, the trials in that matter, including testimony regarding communications about the defendant, Karen Reed, by now former Massachusetts State Trooper Michael Proctor. You have advised my office that the Norfolk County District Attorney's Office is prosecuting other cases Proctor investigated, quote, other matters. Because the protective order only permits the parties to use the confidential material in the Reed matter, and you believe that the Norfolk County District Attorney's Office may have discovery obligations under state law to produce some of the confidential materials in the other matter, you have asked my office to seek an amendment to the protective order to allow, one, the Norfolk County District Attorney's Office to produce from the confidential materials any statements by Proctor to the defendants and their counsel in the other matters, and two, so like the Walsh case, etc., two, assistant district attorneys prosecuting the other matters to sign the protective order, review the entirety of the confidential materials, and produce any other of the confidential materials to the defendants and their counsels in these other matters that the Norfolk County District Attorney's Office would be required to produce under the Norfolk County District Attorney's Office criminal discovery obligations. Okay, so there you go, ladies and gentlemen. You can see what the Norfolk County District Attorney's Office, which was asking for basically in response to prodding from the defense attorneys in those other matters investigated by Proctor. And so that is what the U.S. Attorney's Office is responding to. It's a letter to the Norfolk County District Attorney's Office in the context of the Norfolk DA being able to comply with their discovery obligations under Rule 14 in these other criminal cases that Proctor investigated. Now, please note here, this was sent on August 5th, 2025, so this is recent. We're only talking 2 weeks ago. And in the world of letters from the federal government or to the federal government that are by officials, this is a quick release. It came out in Discovery, I think. Dee Dee posted it over on Twitter, and I reposted it. It is serious, folks. So, pursuant to 28 CFR 1621C, which permits the United States to produce federal records to any law enforcement agency in the absence of a TUI request. Now, so do you see what this, it's actually 1621C. I said 16.1C earlier or whatever it was. It's 28 CFR 16.21C. I might have said 21.1C or whatever. So, pursuant to 28 CFR 16.21C, which permits the United States to produce federal records to any law enforcement agency in the absence of a TUI request. So remember, the Norfolk DA is a law enforcement agency. What this is saying here is U.S. Attorney Leah Foley, and if you read 28 CFR 1621, it does say this, okay? We've shepherdized this before. I'm not a lawyer. This is not legal advice. But if you read it, and we can take a look at this. So let me just show you what U.S. Attorney Foley's talking about here, okay? So I think it is appropriate to at least make some contextual sense. So let me bring up the 28 CFR 1621, okay? I'm going to bring 28 CFR 16.21, all right? So we're going to take a look at this part, and I'd like to get it from the DOJ themselves. Yep. All right. Hold on. Yeah, the Gov site is fine. All right. So here's the relevant law that we're talking about. All right. Before U.S. Attorney Leah Foley's office starts going into it, let's take a look. All right. So there we are. We're taking a look at 1621. All right. And we're looking at specifically C. All right, so the real premise of this is this subpart sets forth procedures to be followed with respect to the production or disclosure of any material contained in the files of the Department of Justice, any information relating to materials contained in the files of the Department, or any information acquired by any person while such person was an employee of the Department of Justice as a part of the performance of that person's official duties or because of that person's official status. In all federal and state proceedings in which the U.S. is a party, and in all federal and state proceedings in which the U.S. is not a party, including any proceedings in which the DOJ is representing a government employee solely in the employees of individual capacity when a subpoena, order, or other demand, hereafter referred to as a demand, of a court or other authority is issued for such material information. And then B, for purposes of this subpart, the term employee of the DOJ includes all officers, etc. Now, this is the relevant part. Nothing in this subpart is intended to impede the appropriate disclosure in the absence of a demand of information by the department law enforcement agencies to federal, state, local, and foreign law enforcement, prosecutive, or regulatory agencies. So this is where it comes from. Remember when U.S. Attorney Leah Foley went on Dan Ray's Nightside and said that she couldn't confirm or deny the end of the federal probe into John's death, but that it was routine for federal DOJ authorities to release to state and local law enforcement partners that certain information about investigations? This is it. Unprompted, without a TUI request, nothing in this subpart is intended to impede the appropriate disclosure in the absence of a demand, a TUI demand, of information by the department, law enforcement agencies to federal, state, local, and foreign law enforcement, prosecutive, or regulatory agencies. So basically, the U.S. Attorney Leah Foley's office is saying, you don't even have to submit me a TUI request. I'm just going to give you this material, some of this material, pursuant to my authority under that section of the federal regulations. That's what that sentence is referring to. So now take a look at where the sentence goes from here, okay? So pursuant to 28 CFR 1621C, which permits the United States to produce federal records to any law enforcement agency in the absence of a TUI request, I am producing to the Norfolk County District Attorney's Office all of the Proctor communications previously produced as part of the confidential materials. Now, you would say, okay, that's everything, but it's not. It's like 98%, because listen to where it goes. Given these records are produced pursuant to 1621C, they are not subject to the protective order, right? So there's the protective order from the district court in Boston. U.S. Attorney Leah Foley's kind of doing an end run around in an authorized way to release certain material that is simultaneously subject to the protective order, but now also being released in line with federal law and the existing protective order under 16.21C, which gives U.S. Attorney Foley's office, although I'm pretty sure it has to go like all the way up the chain to Main Justice in D.C., the authority to unilaterally disclose certain information, notwithstanding an existing federal protective order under 16.21C. Everyone following along here? It's very convoluted, but if you know what you're reading, it makes a lot of sense. All right, so here's where we're going next. Given these records are produced pursuant to 1621C, they are not subject to the protective order, and the Norfolk County District Attorney's Office can use them as appropriate in the other matters. So the Norfolk County District Attorney's Office, to comply with Rule 14, this is what it's saying in other words, can release these matters now because even though they're subject to the protective order, because U.S. Attorney Leah Foley's office released them under 16.21C, they can be used in those other criminal cases. as you will see, most of these statements are already reflected in the Reed trial record, and none appear to concern defendants in the other matter. So that's a step. I mean, the judges in those cases are going to be like, okay, so it doesn't even pass. There's two standards for relevancy, okay, 401 and 403. This doesn't pass the basic relevancy analysis under 401, not to mention getting to the probative value or sort of the balancing test under 403 relative to the relevance balanced against the prejudicial impact, or we don't even get to step 2 of the analysis. Just under the basic relevancy test, this statement from the U.S. Attorney's Office renders all of these arguments, whoever that lawyer was, Rosemary or Walsh's lawyers, it just kneecaps them. And this is a tactical kneecap by the U.S. Attorney's Office, who clearly does not like criminals, because this office is kneecapping all of these defendants, all right? Notwithstanding what Proctor did. The U.S. Attorney's Office right here is being like, don't even try. Nothing in there is relevant. We're putting this on record, sending it to the Norfolk DA, who's going to turn it over to the judge in discovery. Don't even try. And they're telegraphing, and watch, it gets way more brutal in the end of the letter, but they're telegraphing to these defense lawyers, don't do it. Don't do it. And you can sense, like, I didn't know this was coming, but I could have told you before I even read the letter that's exactly the position this office would have taken, in my opinion. I don't know them, I don't talk to them, not that office, but what I'm saying is that's the way, in my opinion, that you would directly start this letter. Okay, you would basically say, listen, we're going to turn this over, and what you're doing is you're not helping the defendants. The letter says right there, there's nothing in these statements about any of those cases. They're doing it so the defendants in the other matters can't use it as pretextual, apparitions to try to get their cases dismissed or cause public furor. I think this was a response to that Rosemary, or whoever that lawyer was representing some of the other Proctor defendants. They were making a lot of noise, okay, but this is the U.S. Attorney's Office saying, well, make your noise about some of the other stuff, the search warrants that Proctor was withholding from Lally, whatever. But don't make it about the federal probe, or we're going to come down and crush you. And that's exactly what this letter goes on to say. Let me see if I missed any questions. But anyway, so just to focus more on this letter, all right? So we get to the top, we get to the next part of the letter, where it says that, as you will see, and this is a letter to the Norfolk County DA's office, but it's really to the defense attorneys. As you will see, because remember, it's the Norfolk DA who has the discovery obligations under Rule 14 that could cause, if they don't fulfill them, the defendants to get the case thrown out. And the DOJ here is favoring the Norfolk County District Attorney's Office and saying, like, no, those defendants are not leveraging Proctor's involvement with the now confirmed as closed federal probe into John's death to get their cases dismissed or anything like that. That's what this is. And so to continue analyzing this, as you will see, most of these statements already are reflected in the retrial record, and none appear to concern defendants in the other matters. My office is nevertheless producing them to facilitate the Norfolk County District Attorney's Office prosecution of the other matters. It doesn't say so they can comply with Rule 14 and the defendants can't make the argument to get the case thrown out, but that's what that sentence means. Okay? Now, next paragraph. To the extent the confidential materials contain federal grand jury, this is the caveat. And you can tell here that this is not, like, there's a limitation under 16.21c, and it either has to be due to the interpretation of 16.21c or its precursor language by the court in U.S. Ex Rel 2 E.V. Reagan in 85, or it has to do with, like, the U.S. Justice Department Operations Manual and Section 25 of that manual in particular, and there must be a balancing of authority related to the disclosure of non-federal grand jury material and grand jury material pursuant to 1621c, which tells me that the protections for federal grand jury material are stronger than the unitary authority of the DOJ and the U.S. Attorney's offices throughout the country and in Washington to disclose material unilaterally pursuant to 1621c. That is some serious stuff, and it makes sense because grand jury testimony is actually being taken in the name of the court. The grand jurors are charged in the name of the court. That's also why what Jessica Leslie did, the grand juror leaker related to these cases, was such a big deal, little towels, all right? So do we understand where this is all going? U.S. Attorney Leah Foley under 16.21c can release a bunch of confidential material from the now confirmed disclosed federal probe into John O'Keefe's death. But what U.S. Attorney Leah Foley cannot do, even under 16.21c, is release protected federal grand jury material. So here's where this comes up. Now watch how circumspect this letter is just about that federal grand jury material. To the extent the confidential materials contain federal grand jury testimony by Proctor, and without confirming or denying that such testimony exists or was among the confidential material, I roll my eyes at that, but I loved it. My office would be prohibited by federal law from disclosing that testimony for use in the other matters absent a court order. Now, that would say, okay, so they'll just get a state court order. No, listen to where they go from there. Moreover, my office would not have a sufficient basis to move the U.S. District Court for a disclosure order under the circumstances. Remember, we're talking, they disclose the other non-grand jury stuff, but the federal grand jury stuff from Proctor, they won't even admit exists. And if it does exist, they're not turning it over. And here's, not only are they not turning it over, they won't go to federal court. The U.S. Attorney's Office won't go to federal court to amend the scope of the existing protective order to facilitate the transference of this grand jury material. Now, here's where we go next. Moreover, my office would not have a sufficient basis to move the U.S. District Court for a disclosure order under the circumstances. My office's investigation pertained to the circumstances underlying the Reed matter, and therefore any grand jury testimony by Proctor in the confidential materials would not have addressed the other matters. That means, according to this, there is nothing related to the other matters, the other criminal defendants that were investigated by Proctor, nothing that he was asked about in his grand jury testimony. And in fact, it says the office pertained, the investigation of the O'Keefe and Reed probe pertained to the circumstances underlying the Reed matter, and therefore, and it doesn't say only, but it says to the circumstances. And therefore, any grand jury testimony by Proctor in the confidential materials would not have addressed the other matters. So that's just another reason under the relevancy test to say, first of all, you're not getting this material, and second of all, it's not relevant to you 6 defendants, so you're not getting it. Let's see. Yes, Michael Proctor is trying to get his job back. He has a public hearing in front of the Civil Service Commission on August 27th. All right, next question. Next question, I thought we were playing trivia. Now, furthermore, assuming arguendo, which means they say, assuming arguendo, for argument's sake, that the confidential materials contain, I want him to say arguendo, come on, arguendo, like, let's set the standard, that office wanted to say it. It must be like a little too formal. They would say arguendo in a motion, maybe not in a letter. But furthermore, assuming for argument's sake, which the Latin phrase for that is arguendo. Furthermore, assuming for argument's sake, and they know that, they probably wrote arguendo there first, but then someone was like, well, it's a little too formal. That's my opinion. They're very smart at that office, I believe. Furthermore, assuming for argument's sake that the confidential materials contain Proctor's grand jury testimony, Proctor testified at the first trial in the Reed matter and would have been subject to impeachment with that grand jury testimony. The trial testimony from the Reed matter, therefore, would be more than a sufficient alternative to assess Proctor's bias. It's the least it's like the least burdensome alternative means if they don't want to disclose it. And so what the U.S. people misunderstood this on Dee Dee's Twitter feed. I saw a few people misunderstanding this. What this is saying is that, and it's really weird that they're doing this, but they're saying basically like, listen, Proctor testified in the Reed case. Reed's lawyers, Alan Jackson and David Yannetti, had access, and Alessi, no, it was the first one. So Alan Jackson, David Yannetti, and Eliza Little, and Tanis Yannetti, okay? First trial. They had access to that confidential material. They could have used it to impeach Proctor, and therefore, because Proctor was subject to cross-examination when he testified at the state court trial, and incorporated by reference into that cross-examination was the fact that David Yannetti, Eliza Little, and Alan Jackson and Tanis Yannetti had access to the federal grand jury material related to Proctor. That is a sufficient basis for Proctor's state court testimony in the Reed case standing alone to serve as sufficient purposes for any potential further impeachment needs of the 6 defendants who are moving to try to get the grand jury testimony. It's a wild wild structure, but it's great. I mean, that's the right analysis. But what it's basically saying is, if Alan Jackson and David Yannetti and Tanis Yannetti and Eliza Little didn't have access to those documents, then maybe Proctor's testimony during the first trial wouldn't be enough to argue that that is a sufficient alternative grounds upon which these 6 defendants can pursue impeachment against Proctor, like impeachment of his testimony in their cases. But because Yannetti and Jackson and Little and Tanis Yannetti did have access to the federal records, it is enough to say that because Proctor testified in the Reed case, anything you need to impeach him on, you can get from the state court testimony. It's brilliant, and it's undercutting the arguments of the defense attorneys in the other matters, the Walsh case and otherwise, who might want to get that material. It's brilliant, all right? They're undercutting them tactically at every step. They're basically saying, don't even bother motioning the courts about this. We're just going to run you over with this stuff. We're going to absolutely bury you in federal law and process, and we're right, and we have all the power. That's what this letter is saying. It's not saying it to the Norfolk DA. It's actually helping the Norfolk DA's office, perhaps begrudgingly. Well, I also wonder if the feds forced the Norfolk DA's office to clean up that MSP unit, like Tully and John Fanning and, Yuri Buchanan and whatever. I wonder if the feds forced them to clean it up. That kind of makes me think that this makes a lot more sense to me now. Like, it's not that the feds don't like Michael Morrissey right now. It's that they didn't like that unit. I don't think they like Karen Reed, the current DOJ. I don't think they like Jessica Leslie. I don't think, well, they're protecting her, I think, but I don't think they like Karen Reed or Turtle Boy or Alan Jackson or David Yannetti. I don't think they like Kate Peter or Brian Tully or Marty Kraft or Yuri Buchanan or John Fanning or Nick Garino. All right. And so that's why I think there's apoplectic levels of chaos right now, because the reality is the only people who got out of this unscathed were the Norfolk DA and Hank Brennan. Okay, and I truly believe, although I can't confirm this and have spoken to the man other than when he told me I could call him Hank, I truly believe that Hank Brennan negotiated a deal wherein the Norfolk County District Attorney's Office gave up his own guys, the Norfolk County DA, Michael Morrissey, gave up his own guys related to the Birchmore cover-up. And I have real reason to believe this because in August of 2024, when Michael Morrissey found out that Farwell got indicted for Sandra Birchmore's murder under 28 U.S.C. 1853, murder of a cooperating federal witness, Michael Morrissey sent Brian Tully and John Fanning an email saying, is this true? Which means Morrissey, from the very minute he found out Farwell got federally indicted, was ready to give up Tully and Fanning. Tully and Fanning were partners for like 20 years. Remember, Sandra Birchmore was the woman who got murdered by a former Stoughton cop, allegedly, Matthew Farwell. And Farwell used to work in Stoughton as a police officer, where 2 of these members of Morrissey's state police unit, John Fanning and Yuri Buchanan, used to work. Now, you might be saying to yourself, Grant, this is a lot to keep track of. Is there any way maybe you can give us a chart? Yes, I just have charts just waiting to bring up. You know what I'm saying? Like, I just have a chart. That's the chart. You see the chart? That's the chart. Have you not seen the chart before? That's the chart. All right? That's the chart, ladies and gentlemen. It is not just a chart. It is the chart to end all charts. That explains everything. All right? It even involves Lindsay Gattani's unredacted phone extraction being released by the same MSP unit. It wasn't just that Aidan Kearney, Josh Levy, Rachel Rollins, David Yannetti, Karen Reed, Alan Jackson, and others did bad things involving leaking protected grand jury information, in my opinion, and using it to weaponize public perception around Reed's case in order to poison the jury pool. It's also that the Norfolk DA CPAC unit, in my opinion, covered up Sandra Birchmore's murder and then worked with Kate Peter to investigate Aidan Kearney and Karen Reed, which involved leaking Lindsay Gattani's unredacted cell phone production under color of law, which was also a bad thing that Brian Tully did. And so therefore I believe Hank Brennan negotiated some kind of weird deal where the Norfolk DA gave up his own CPAC unit, the MSP unit that used to work for him under former Commander Brian Tully, related to all of this. And that's why we see this weird tone, okay, this really weird tone in this letter. It's like it's a letter that helps the Norfolk DA, but yet you have Kate Peter threatening the Norfolk DA on Twitter over recent weeks. And it's pretty clear why. The Norfolk DA, Michael Morrissey, is clearly on good terms with the feds. But Kate Peter, Brian Tully, and the other folks involved with the Birchmore stuff, the Lindsay Gattani stuff, whatever, got thrown to the wolves, as did all the people involved with Jessica Leslie's leaks, because Rachel Rollins and Josh Levy are out of power at the DOJ now. That's why the Free Karen Reed movement is in frigging apoplectic chaos as well. So you got people around Kate Peter and Marty Kraft and Brian Tully literally melting down because they have no protection anymore from the Norfolk DA's office. And then you got Aidan Kearney and Karen Reed and all their people freaking out because they have no protection from the DOJ anymore, because Rollins and Levy are also in the crosshairs of the federal investigators, in my opinion. It's freaking apoplectic levels of chaos, and this letter spells it. And a lot of people, I don't think they understand how to read these letters, and I'm not being pejorative. I'm not a lawyer. This is not legal advice. But these are letters where it's like a lot of the language is not direct. Like, you have to infer based on what the letter is accomplishing tactically and the tone it's taking and the posture it's taking, who they're supporting and why and what their ends are. And the ends of the U.S. Attorney's Office in this letter are very clear. They want these cases prosecuted. They don't see a problem cooperating with the Norfolk District Attorney's Office, and they don't want these to fan dance, weaponizing specters and apparitions to induce artificial reasonable doubt at the expense of the fact that there was a federal investigation of John O'Keefe's death, and that MSP unit related to Tully and Proctor, not in the context of the Reed probe and O'Keefe probe, but at least in the context of Birchmore and then the Turtle Boy stuff and the Lindsay leak, was weird. All right, like the feds are basically saying, okay, we're all right with the Norfolk DA, but they don't say it in this letter, but like the tone of this letter coupled with developments over the past few weeks reaffirms a lot of what I've been thinking, which is that Hank Brennan and Leah Foley have been the adults in the room the whole time since January of 2025 and figured out some kind of like way to solve all this chaos and protect the justice system, and they're just not talking about it fully yet. That's what I believe is going on. So, as a result, and I just really want to narrow in on this, what this letter is saying, and it's going to become more and more clear here, is that the U.S. Attorney's Office wants these people convicted. They don't want them using the defendants using Proctor. The U.S. Attorney's Office doesn't appear to want these defendants using Proctor as a shield to avoid conviction. Well, that's a weird position to take, right? Like, so that means you must have felt that way about the Reed case, but we didn't see this kind of intervention, right? We saw it a little bit before the Reed case, but it was very mild confirmation of the end of the probe through the Canton PD and the Norfolk DA's office, etc. But, it wasn't like this. It didn't tip their hand. So why not do that? Why let the public in the jury pool, why not let them on to this a lot earlier? I think I know, because I was right, and that probe of that second trial was a honeypot. It was a 100% honeypot. It was a honeypot to catch Turtle Boy and Karen trying to interfere with the state court jury, and I bet they did catch him. This DOJ wanted to get Karen. I think they still do. I think they really want to get her. She killed a cop, allegedly, in the civil suit. Allegedly. They want to get her. She killed a cop. Like, you put your hands on a cop right now, the DOJ will rain hell down on you. She allegedly killed a cop. So I think they want to get her. And I think if you read into this letter, like, inductively, the posture of the U.S. Attorney's Office, they want to get Karen Reed just as bad as they want Michael Walsh to be held accountable and some of these other folks. This is incredible. I mean, the tone of it is so, it's interesting, because I feel like the one thing that throws a wrench into all of this is they're not afraid to charge cops, the DOJ, but I don't think they want the public to have the perception that cops are dirty. The DOJ seems to want to support prosecutions of criminals while also making an example of like bad cops and bad prosecutors and bad sheriffs, especially if they're Democrats. Now, there's something larger bubbling up here too. The DOJ just sent a letter to Mayor Michelle Wu in Boston that led Wu to have like this firm press conference today targeting the federal government. One second. Hello, I'm back. Sorry about that. This is one of those days. If you get certain kind of calls on a certain kind of day, you got to answer it. All right, so let's pay attention. Why? So sorry about having to go away there for a second, but this is one of those days. All right, so let's continue reading this letter. If you're just tuning in, what we were talking about is why the nature of this letter is so insightful, okay? And the reason why it's insightful is it talks a little bit about it gives you hints into what the U.S. Attorney's Office is thinking. And what the U.S. Attorney's Office is thinking is they don't want people repeating what Karen Reed did. They don't want the defendants putting out these apparitions like innocence of innocence that are not real, okay, for the purposes of subverting public perception and poisoning the jury pool. And this is how they're putting a stop to it. That's my read of it. So let's get back to the letter. We were just getting into the part of the letter where the U.S. Attorney's Office is asserting the grounds for why there are alternative remedies for disclosure that do not require, alternative remedies for impeaching Proctor that do not involve giving over this grand jury material, all right? And the biggest argument was, listen, Proctor was subject to cross-examination by people who had access to those federally protected grand jury material in the first Reed trial. Therefore, whatever that record is from the state trial, the questions are sufficient and an alternative to Proctor to have to the feds disclosing the grand jury information, because the defendants in the 6 other cases, the Walsh case, the other cases, can just use that Proctor cross-examination as grounds to impeach him if they need to. It's brilliant. Finally, okay, so hold on. So that was the sentence. Furthermore, assuming arguendo that the confidential materials contained Proctor's grand jury testimony, he testified at the first trial in the Reed matter and would have been subject to impeachment with the grand jury testimony. The trial testimony from the Reed matter, therefore, would be more than a sufficient alternative to assess Proctor's bias. Finally, any grand jury testimony by Proctor would be cumulative of other sources of evidence of Proctor's bias as to Ms. Reed already available to the defendants in the other matters, the Walsh, etc., including the extensive trial record in the Reed matter, the Massachusetts state disciplinary proceedings against Proctor, and all statements produced with this letter. Similarly, my office will not seek a further amendment of the protective order at the U.S. Federal District Court to allow ADAs prosecuting the other matters to review the entirety of the confidential materials for potentially discoverable information. Now, remind you, it may seem like they're saying the Norfolk DA's office can't do this, but they already let the Norfolk DA's prosecutors do this in the Reed case. What they're saying is they're not going to seek federal court permission to allow those other ADAs to look at these materials for the purposes of facilitating compliance with discovery obligations. And the reason why is for the reasons just laid out, which is there's nothing in there that's discoverable really for those other matters. And so they're not going to do this, and they're not going to move at the request of basically the defendants in those other matters to go to the federal district court. Even though it seems like it's a request coming from the Norfolk DA's office, really it's a request from the Norfolk DA's office to facilitate discovery compliance, and it's coming from the defendants, Brian Walsh, etc. And so here we go. There is no reason why, there's no reason why the non-Proctor records within the confidential materials would be relevant to the other matters, given the scope of my office's investigation. Hold on. Similarly, I have to reread this. Similarly, my office will not seek a further amendment of the protective order to allow ADAs prosecuting the other matters to review the entirety of the confidential materials for potentially discoverable information. Oh, I get it. So U.S. Attorney Leah Foley's office is saying, I'll turn over what I feel comfortable with under 1621C. I'm not turning over stuff under that's protected federal grand jury information, and then I'm not turning over certain other stuff. All right. Basically, U.S. Attorney Leah Foley's office is saying we'll release some stuff to you. It's not really relevant to your case, but we're not giving you the whole record. And furthermore, we're not letting the DAs in those other matters, the ADAs, go through the material and have them decide what's discoverable. We've decided under 1621C. That's the end of it. So that's what that says. There is no reason why the non-Proctor records in the confidential materials from the Reed case, is what that's saying, within the confidential materials would be relevant to the other matters, given the scope of my office's investigation. which is in the TUI records from the Reed case. It's talking about just that investigation, not anything else, not Birchmore, not CDL, not anything else, just the summer 2023 and February 2024 investigation into John O'Keefe's death, federal, okay? There is no reason why the non-Proctor records within the confidential material would be relevant to the other matters given the scope of U.S. Attorney Leah Foley's office's investigation. As mentioned previously, U.S. Attorney Leah Foley's office's investigation focused on the circumstances, and this is that one investigation that produced TUI records for the Reed case, focused on the circumstances underlying the Reed matter. Because remember, we're only talking about the confidential materials turned over to the Reed defense and prosecutors in the TUI request related to the Reed case. Okay, so it's not even touching on other investigations. As mentioned previously, my office's investigation focused on the circumstances underlying the Reed matter, and the confidential materials included here only those materials from that investigation that were highly relevant to that matter. We, so her office, accordingly have no basis to believe that there is anything else relevant to the other matters, which means the Walsh matter or any of the other defendants investigated by Proctor, in the confidential materials, which is just the TUI response sent to the Reed and defense and Reed prosecutors. Further, supporting this position, besides Proctor's statements, the Norfolk County District Attorney's Office and Defense Counsel in the other matters, so in like the Walsh case, have not identified any documents or categories of documents that might be included in the confidential materials from the Reed case that are relevant to the other matters, the Walsh case, etc., despite many of the confidential materials being referenced during the public proceedings in the Reed matter. Nor would it be appropriate for U.S. Attorney Leah Foley's office, the Norfolk County District Attorney's Office, or any defendant to comb through the confidential materials on the mere possibility that such relevant information might exist. My office appreciates the concerns of the Norfolk County District Attorney's Office, Defense Counsel in the other matters, Walsh, etc., and the state judges presiding over the other matters. My office, U.S. Attorney Leah Foley's office, is keenly aware of the seriousness of the charges in some of the other matters and wishes to see that justice is done. So this is an anti-defense position. Now, Rachel Rollins and Josh Levy would not have taken the position. Court is back in session. We're almost done with the letter. My office is keenly aware of the seriousness of the charges in some of the other matters and wishes to see that justice is done. This response, I believe, does that while balancing the United States interest and compliance with federal law. Given this response and the fact that the Reed matter has concluded, there you go, confirmation, federal probe into the Reed case, over, boom, there it is, in writing. Take it home, take it to the bank, seal it and deliver it, make a cake, put it in the sky, fly a plane, tell Turtle Boy about it. Given the fact that the Reed matter has concluded, there it is, and it could also be the state matter. But either way, they also confirmed that the Reed federal probe was closed 3 times in this letter. So given this response and the fact that the Reed matter, which I think might be the state matter, but either way, if you didn't see it above, it confirmed that the Reed matter, the federal probe, is closed as well. Given the response and the fact that the Reed matter is concluded, the U.S. requests that the Norfolk County District Attorney's Office comply with the protective order, the existing protective order, and destroy its copies of the confidential materials according to the deadline set in the U.S. District Court's July 21st, 2025 order. So I think it was August 21st, 2025. They gave them 30 days. So those records are getting destroyed 2 days from now. I nevertheless want to make 2 points that I hope will guide the Norfolk County District Attorney's Office decisions about future action. First, given that the federal court's protective order sets forth strict parameters for dissemination of the confidential materials and noncompliance with that order affects the federal interest, the United States is obligated to ensure compliance with the protective order. Should any Massachusetts court authorize the unsealing of the confidential materials in a manner that is inconsistent with the protective order, the United States may need to take appropriate action to ensure that the protective order, as a federal court order, and the United States interests are adequately enforced, which could include removal to federal court of any adverse ruling pursuant to 28 U.S.C. 1442. So what that's saying is that if any state court tries to unseal these materials, not even just tries to unseal the grand jury stuff, if anybody anywhere tries to unseal these federal materials, I mean, they can be given over in discovery, but if anyone tries to unseal them at any point, the U.S. is going to intervene, and if they lose, or if they can't intervene, they're going to just remove it to federal court. To be sure, the United States has no interest in that course of action, particularly that it believes it has provided any material from the confidential materials that could be relevant to the other matters, the Walsh case, etc., as permitted by law, and the parties in the other matter have more than ample publicly available material concerning Proctor's bias, as to Ms. Reed. Second, in the United States' view, it would be inappropriate for the Norfolk County DA or defense counsel in the other matters, Walsh, etc., to seek to intervene in the U.S. District Court matter and move to amend the protective order. Not only is there no basis for either party to intervene in that federal court matter, but any such motion should be dismissed because the parties have failed to comply with the so-called TUI regulations, 28 CFR 16.21, etc. These regulations, the predecessor of which was upheld by the Supreme Court in U.S. XRL 2 v. Reagan 340 U.S. 462 pin site 468 1951, I thought it was 85, requires parties seeking federal records to meet certain requirements, including submitting a written demand identifying the specific material sought and its relevance to the proceeding, 28 CFR 1622D. To the extent certain Norfolk County DA's office, assistant DAs, and the defense counsel have submitted TUI requests seeking federal records concerning the Reed matter for use in the other matters, the U.S. has or will consider them in due course. To the extent a party submitting such a TUI request is dissatisfied with the United States response, the only legally appropriate avenue for challenging the U.S. decision is to file an action in federal court under the Administrative Procedures Act, 5 U.S.C. 551, etc., not seek to amend the protective order. Should you have any questions, you can call the U.S. Attorney's Office. So there you go, ladies and gentlemen. I'm going to switch back to the other matter, our other matter, and we're going to watch what's going on in the Donna Adelson case. Oh, okay, so, hello, little towels. It's me. I'm back. I had some chicken. I had a frozen pizza. No, that I got at CVS the other day. That was that frozen pizza. It was delicious. It was a Detroit-style crust from DiGiorno, and it was okay. I don't know. It was worth the $6. I split it in half and ate it over 2 days. That's how you spend $3 a meal on pizza. And then I had some heated up chicken that I made. It was good. I made it into little squares, and then I coated it with some Chick-fil-A sauce, and then I ate it. It was pretty good. It was like saucy nugs. Now, it wasn't originally in chicken nugget form. I had to cut the chicken up and dice it, but it was very good, little towels. Oh my goodness, Sunken Grave, I entirely understand you missed trivia yesterday. Don't worry about it, my dear friend. We will teach you about tea towels. I heard Super Towel Steph sent me a tea towel. Now, you might be saying to yourself, are we going to play some towel trivia? Yes, we are. I'm excited. All right. And Donna Adelson jury selection still ongoing, but there's nothing going on. We won't see any actual court feed until tomorrow. All right. So, little towels, I heard a wonderful piece of news that I got a picture of tea towels. I've always wanted to see tea towels, ladies and gentlemen, my whole life. I have just wanted to see a tea towel. All right, my whole life, that's all I've ever wanted to do. And now I hear, according to Steph Towel, that I have a picture of a tea towel. Oh my goodness, it's a tea towel. Ladies and gentlemen, it's an official tea towel. I didn't think it was humanly possible. Steph Towel has come through in the clutch. This is why she is a Canadian hero, ladies and gentlemen. The Canadian Mount Rushmore consists of Vicky Towel, Steph Towel, Winnie the Pooh, and Bret Hart. All right, now take a look at this tea towel. Now, Sunken Grave, I think we have to get some of these for Ed. All right? Ed needs a tea towel. Here we go. This is a tea towel. Oh my goodness, ladies and gentlemen, do you even know how to contain yourself? Look at this tea towel, sent in by our very own Canadian hero, Steph Towel. Oh, the Sunken Grave, God bless you. Here's to some hipster tea towel and her finger towels. As long as it gets you clean with soap, I am not opposed. Oh, ladies and gentlemen, this is a glorious day. We have the permission of the greatest soap dispenser this side of any ocean to officially use tea towels for our cleanliness purposes. Sunken Grave would also like to remind people, too, let me make sure I get the exact quote right. Let me read it for you. Hold on. Here we go. The quote is, "Hello, people of the forest. Please always wash your hands 3 times a day. I am a soap dispenser." And then Sunken Grave was kind enough to send along a super towel chat that says, let me read it out for you. Here's to some hipster tea towels, there's one, and or finger towels. As long as it gets you clean with soap, I am not opposed. God bless you, Sunken Grave. The world needs more benevolent soap dispensers. We put our faith in the glorious and wonderful soap dispenser friend. Can a soap dispenser be a friend? Of course it can. Soap dispensers are friends to all people. Now, the wonderful towel friend LS would like to let us know that tea towels are in most shops in Britain that sell soft furnishings and or stuff like that. Their house is full of them for drying dishes. Oh, folks, Steph is here. You know what that means. Not only do we have a picture of a tea towel, it's Towel Trivia theme song time. Who's ready to play some multiple rounds of Towel Trivia? I'm ready. All right. The first thing, though, is we're playing the Towel Trivia song. Pete Bunny Towel, how was your nap? Did you enjoy the interview with Towel Mom? It was erudite and cogent. Have you always wanted to study the Constitution, Pete Bunny Towel? He says yes. All right, you know what time it is. If this song starts playing, grab your tea towels, grab your Canadian heroes, grab your ruse. Don't vote for Mayor Wu, vote for Roo. It is time for Towel Trivia, Little Towels. Now, as we get the Towel Trivia theme song up, let me show you Towel's scores from yesterday. All right, let me show you the scores. Here are the scores, Little Towels, from yesterday. Let me bring it up on the towel screen. All right, here we go. Scores from yesterday. All right, scores from yesterday, Little Towels. Here we go. Scores, please. Where are they? I got to bring them up to the front, huh? There they are, Little Towels. Yesterday's round. You see it right there. There are the scores. We had Towel wearing the crown. I took Steph's crown from her. I feel a little guilty about it. Steph is a Canadian hero, but I took her crown anyway. Yesterday's round was, of course, 8/19/2025. It was round 24 of Towel Trivia. And you can see it right there, Little Towels. We had in first place Towel wearing the crown overnight. Root Towel, I had 43 points. Root Towel, one of the greatest showings we've ever seen of all time, Little Towels. I was very proud of Root Towel. Root Towel coming in at second place with 42 points. In third place, Allie and Brew rounding out the podium, 39 points. In yesterday's round, we also had Jill Towel with 35.5 right outside the podium, fourth place. Vicky Towel, fifth place, 27.5 points. Steph Towel only played half the day, almost took the podium, sixth place, 24.5 points. Nanya Towel led to my wonderful rant about stochastic weaponization of the public sphere. Nanya Towel, 19.7 place. Holistic Psychology, absolutely excellent performance. One of the greatest heroes of the Bavarian peoples. The Bavarian Empire lives strong in the heart of holistic psychology. 16.5 points in eighth place. Ninth place during her first ever participation in Towel Trivia. She was getting questions right all morning yesterday to herself and then started participating, got them all right. Ninth place, 12 points. Faith Towel, congratulations. 10th place was Paula Towel, rounding out the top 10 at 11 points. Excellent job. Right outside the top 10, Peggy Towel, 8.5 points yesterday with 11th place. Bunny Towel, hello Pete Bunny Towel, hello Bunny Towel. Pete Bunny Towel says hello. Bunny Towel came in with 8 points, tied with Elijah Towel, 12th place. 13th place yesterday, Julia G. Excellent job, 7 points. 14th place, Nancy Towel, 5.5 points. 15th place, Colleen Henry and Buck, the greatest super towels of all time, 4 points. 16th place, Barbara with half a point. And in the position of honor, Elizabeth Lander, 40 million bonus points for picking Grant as a warm, fluffy towel answer, which wasn't correct, but I thought it was hilarious. Ladies and gentlemen, let's listen to the theme song, Towel Trivia, incoming in 3 minutes.
Welcome to Grant's Towel Trivia. You know Grab your wrench and your towel. More fun than a barrel of monkeys. Grant and his cigar is on the screen with a smile. He's got lots of questions, so we'll be here a while. All of us contribute in our own special way, and it doesn't matter who wins at the end of the day. We're the top community, and we won't stop. Steph is at the top, she never does flop. Ollie, Ruth, and Nancy are sprinting towards the finish line. Kitty's 1993 is not too far behind. Tater, Bug, and Dewdrops are smart and so kind. For one family, we're family. Ruth and Captain know their stuff. Jeff's waiting on the clue. Claudia's got the answers, but Bunny does too. Lydia's sharp as a tack. Deb Fodder's on the ball. Sometimes we grumble when our scores get called. Now Harvard Yard keeps guessing answers that ain't up on the board. Don't ask me how, but she just scored. Bossy Texas Chick and Bell are in last place again. They're always at the bottom, but one day they will win. Ooh, that's alright. That's a Nickelodeon. Every day's a new adventure in Towel Trivia Town. KR's not guilty, but that won't get us down. From the brightest to the struggling, we all play along in this corner of the internet where we all belong. So here's to all the players and the hosts so fine in this little slice of heaven where we all do shine. Towel Trivia time. Towel Trivia. Welcome to the Grant Smith Ellis Show. When you know you know. Ooh, 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 Towel Pride.
Pete Bunny Towels rocking out. We were rocking out, little towels. Let's play some towel trivia. Thank you so much for tuning in. My name is Grant Smith Ellis. Here we go. You know how towel trivia works. I put a question up on the board. All right, if I get the question right, then I get a point. If you get the question right first in the chat, according to my phone, you get a full point. You get the question right subsequent to that, you get half a point. Now, if I get the question wrong, right? I didn't mean to say that. If I get the question wrong, okay, you can get up to 2 points if you get the question right first in the chat, according to my phone. All right? Your phone might show it differently than my phone. We go with my phone. Or your computer. We go with my phone is the mediator. That's the scorekeeper. If you get it right subsequent to the first person when I get it wrong, you get a full point. All right? If we're in a double bonus round, which I will declare ahead of time, those are rounds that I know a lot about. If we're in a double bonus round and I get it wrong, you get 4 points if you get it right first. 2 points if you're the subsequent right answer after that. If I get it right in a double bonus round, regular scoring rules apply. Why? Because the point is to reward you for getting questions right that I don't know about subjects I know a lot about. That's why you get 4 points. Can you wait? Oh, and all right. So, Peggy, we talked about this. Here's the problem. So what we're going to try to do today is we have some people who by accidentally get lag. Some people it's their internet. Everyone, if they want to play, the best way to play is to do two things. Grab your towel phone. All right? Grab your towel phone, and in the bottom left of the window, if you're using a phone, of the window of the YouTube, go ahead and click the video. Bottom left, it should say live. Go ahead. If it doesn't say live, if it says like minus 20 seconds or something, go ahead and click it and have it jump to live. Another option, in the top right on your phone, all right, there's going to be a little spinny wheel. Click that spinny wheel. It's going to say playback speed. Change that to 2x. That'll bump you live, all right? Now, the reason we have to do this is I only have a set window where the timer on the question counts down. I must select an answer before that timer runs out, or it doesn't even show us the right answer. So I can't hold back on announcing the answer. But I also want people to understand, there are people in chat who may be answering because on their stream for their internet, they are live and they're seeing the question and the answer a little bit behind you. That's okay. Nobody's like cheating. It's just they unfortunately will never be able to get the double points because they're never going to be able to answer first. It's a consequence of the internet lag. So the way I would explain this is I will hold off on revealing the answer as long as possible. And the best way to make sure you're live is to do one of those two things I talked about earlier, jumping forward in the stream or clicking settings and setting 2x. And Steph, I'm sure, will be happy to help in the chat. If you have any questions, Steph's a genius with that kind of thing. Oh, yeah, and it's not about the competition of it all. It's just I do want people to know that I do as best as I can to make it a fair, fun, kind of non-competition process. All right, we're playing. The points are like don't really matter. All you get is a crown that doesn't really exist to wear until the next day. All right. Alrighty. So who's going to take Towel's crown today? Speaking of that little towels. All right. So first round right now. Now I know some of you are fans of Towel Trivia. I am a fan of Towel Trivia. We're going to start off with the general category. The way we start off is this is just a general category. No specific category comes up. Sunken Grave's like, you're going down. Holistic psychology. So Sunken Grave Holistic Psychology may not understand your English sarcasm. I'll just relay that is absolutely sarcasm. And no one is going to take holistic psychology actually down. We all think holistic psychology is wonderful. Alrighty, so, as I mentioned, my name is Grant Smith Ellis. The first round of the day. Oh, it was sarcasm. Oh, goodness. Grant, tell me how to speed it up. Grant tells me how to speed it up, but I'm not technically gifted. Oh, yes, you are, Allie Towel. You just got to believe. And if you have questions, just ask Rue. Just be like, Rue, have you ever thought about the machinations of interacting with digital technology? You seem to be an intelligent future mayor of Boston. If Michelle Wu can operate a cell phone, then so can Rue. You see what I'm saying? This is going to become a theme until Michelle Wu's next election. I'm just going to talk about this all the time because I think Rue would be a great candidate for the Boston mayor. Alrighty, little towels. First category of the day, the daily challenge category. You know what that means. If we're looking at a daily challenge category, it means the questions are hodgepodge. I have no idea what they're going to be. And if they start asking about the damn commies again, I'm going to file some kind of complaint. That's another way to do it, Allie Towel. That's another way to do it. You know, we say that's the way to whip it up, whip it up, whip it up. That's the way to whip it up. All right, there we go. Towel trivia. I'm going to make the questions as large as I can. All right, there you go. All right, ready? Everybody ready? Daily challenge. Let us begin. First question. What slogan, beloved by dairy farmers, was first used in a TV ad about a radio caller, a mouth stuffed with peanut butter, and Aaron Burr? What slogan, beloved by dairy farmers, was used in a TV ad about a radio caller, a mouth stuffed with peanut butter, and Aaron Burr? Got milk, need butter, drink dairy, say cheese. Got milk, need butter, drink dairy, say cheese. It was definitely got milk. So that was an interesting one, not one you see every day, little towels. Towel got the first point. All right, who else remembered got milk? Steph Towel. Steph's Canadian. She still knew about helping American dairy farmers. Nancy from the 508, half point. Who else we got here? Jill. Great to see you, Jill. Half point. Sunken Grave, the greatest soap dispenser this side of the Mississippi. Half a point. Elijah Towel. Great to see you, dear friend. Half a point. Holistic Psychology coming in, grabbing half a point. Peggy Towel. Great job on the board. Half a point. And Allie and Bo. Half a point. There you go. Sunken Grave's like, I got my half point. No, but the people love you, Sunken Grave. Don't you understand? As we love Ed, we love Sunken Grave. You know what I'm saying? The people demand soap dispensers. The message has been heard. The hands have been defined by their cleanliness. And the people demand their savior, Sunken Grave. All right. What would the world be in the absence of a man who proselytizes about soap dispensers, ladies and gentlemen? We would be nothing. We would have no moral guidance, and we would simply be a vacuous group of souls astray on a rock drifting through space aimlessly. Yes, it is the cleanliness of our hands and our soap dispensers that keeps our moral souls purified and history on target. Someone Graves like, oh, I started a movement. This is wonderful. It's reaching the Germans. It's reaching the future mayors of Boston. It's a beautiful thing, my friend. Next question. Speaking of that, what luxury Swiss watchmaker shares its name with the world's first video global radio navigation system? Which luxury Swiss watchmaker shares its name with the world's very first global radio navigation system? Verichon Constantin, Breguet, Patek Philippe, Omega. Verichon Constantin, Breguet, Patek Philippe, Omega. I have no idea. It was Omega. I should have known it. I should have known it. Steph Towell took the 2 points. Nancy from the 508 grabs a full point. Jill grabs a full point. Excellent job. Elijah Towell coming in, grabbing the full point at Towell's expense. Holistic psychology grabbing a full point, making Towell very obviously realize that he doesn't know what Omega is. Allie and Bro also rubbing it in Towell's face, as is Peggy Towell. Great job, Peggy Towell. Overall, excellent job. I'm proud of you. You all understand very complex stuff. And that's what I'm saying, holistic psychology. It's not why you're right. It's that you got it right. That's what I've always said. I don't know if that's the best way to go about intellectual learning, but, still counts. Next question. What retired NPR radio personality is known for his signature look of red tie, socks, and sneakers? Which retired NPR radio personality is known for his signature look of red tie, socks, and sneakers? Is it Scott Simon, Garrison Kelly, or Ira Glass, Terry Gross? Scott Simon, Garrison Kelly, or Ira Glass, Terry Gross. Show me Garrison Kelleher. That's the only one I'd ever heard of. I got it right because I'm a little towel. Elijah Towell nails it. Full point. Nancy from the 508, half a point. Who else we got here? Who else we got, little towels? Good guesses so far. A lot of people thought it was Ira Glass. I almost went with that as well. Allie and Bo picking up half a point. Good answers, good answers. Steph, good guess. I almost went with Ira Glass. Next question. Let's do it. Which exquisite bloom associated with Buddhism has the same name as a 2009 Prince album and a 2011 Radiohead song? Is it daisy petal, lavender bloom, rose flower, lotus flower? Which exquisite bloom associated with Buddhism has the same name as a 2009 Prince album and a 2011 Radiohead song? I have no idea. Show me daisy petal. Oh, lotus flower. Jill picks up 2 full points. Allie and Bo pick up a full point. Elijah Towell picking up a full point. Peggy picking up a full point. Steph and holistic psychology both picking up a full point. Excellent job, Super Towels. Someone's like, how does Steph get the answer right so fast? It's because she has super fast T1 internet. You know what I'm saying? The damn Canadians, they power their cars on maple syrup, and they have T1 internet that just dominates us all. All right. Nancy Towell got a point in there. I missed her. Thank you, Nancy Towell. If you don't hear your name shouted out with a point, unless I'm laughing because the category is so hilarious, you probably didn't get your point. Nancy Towell got her point. All right. Here we go. Next question in our daily challenge. Which former Air America radio personality went on to become a junior senator in Minnesota? Which former Air America radio personality went on to become a junior senator in Minnesota? Was it Rachel Maddow, Bill Maher, Al Franken, Thom Hartman? Was it Rachel Maddow, Bill Maher, Al Franken, or Thom Hartman? It was Al Franken, ladies and gentlemen. They used to say he got a little freaky. You know, they call him Freaky Franken up on the hill, apparently. Al Freaky Friday Franken, ladies and gentlemen. Jill was the first one to get it right. Number 3 is the correct answer. Sunken Grave went up to a full point, but nailed it. Sunken Grave knew about Al Freaky Franken. Elijah Towel, excellent job. Half a point. Who else? Oh, very good guess. Yes, Al Freaky Franken. That's what they call him, ladies and gentlemen. Rachel Maddow was never a senator, and by God, she'll never be one. If Rachel Maddow becomes a senator, all hell is broken loose in the United States. Someone's going to have to call, like, I don't even know who you call if Rachel Maddow becomes a senator, but, you know, that's a bridge we'll cross when we come to it. They must have some special phone somewhere, like, Rachel Maddow becomes a senator, they pick up the phone, they push the button. It's just apoplectic levels of chaos, you know what I'm saying? All right. Yes, Al Franken was on SNL. Sorry, I was eating some pizza crust. It was good. Next question. Who panicked Americans with his radio version of War of the Worlds in 1938? Who panicked Americans with his radio version of War of the Worlds in 1938? Was it Orson Welles, Clark Gable, Albert Einstein, Ernest Hemingway? Orson Welles, Clark Gable, Albert Einstein, or Ernest Hemingway. Listen, Einstein's War of the Worlds, very famous, ladies and gentlemen. Orson Welles was the right answer. All right, Peggy Towell. I didn't say that. I think we just gotta. We may not have to just call women we don't like men. I don't know if that's the best way to go about. Like, I just don't want to start doing that. You know what I'm saying? Peggy Towell, I understand you ideologically disagree with her. I think we should just, on the whole, if the Emmanuel Macron's wife situation indicates anything, we should express our dislike with their opinions and not just label them men. That's just my opinion. Okay, I don't think we should do that. All right, speaking of that, Steph Towell, nothing to do with that actually. Steph Towell, first one, got a full point. Nancy Towell, half a point. Jill, half a point. Allie and Fro, half a point. Elijah Towell, half a point. Peggy Towell comes in, redeems themselves, half a point. Sunken Grave, greatest soap dispenser of all time, half a point. And Holistic Psychology, half a point. All right. Let's go right into the scores. Oh, we have a tie for first. Oh, goodness. We have two power competitors, ladies and gentlemen, leading the charge. We have a Canadian hero, and I believe, for the first time ever, she's at the top of the leaderboard. All right? It is absolutely ferocious competition. I'm tallying up your scores right now. Here are your scores for round 25, Little Towels. Drum roll, please. Scores. There they are, Little Towels. We have, in first place, Little Towels. It is Jill Towell and Steph Towell tied with 5 points apiece. I believe this is Jill Towell's first time at the top of the leaderboard. Congratulations, Jill Towell. After one round, here we go, ladies and gentlemen. Jill Towell is in first place. There you go. First place for Jill Towell. 5 points for Jill in a tie with the Canadian hero, Steph Towell. 5 points apiece. Tied at the top of the leaderboard. Second place, Elijah Towell, an ever-present threat. As I mentioned, they play all the rounds. We're all screwed. Elijah Towell's genius. Second place, 4.5 points right off the lead. Excellent job, Elijah Towell. Oh, excellent. Jill's first time at the top of the leaderboard. Obviously, a great day. That's all right, Sunken Grave. The people love you. The people demanded soap dispensers, and the people were rewarded. Second place, Elijah Towel, 4.5. Third place, you know him as Little Towel. He's Little Towel. Third place, 4 points. Excellent job. Excellent job. Our podium is Jill and Steph tied in first. Elijah Towel, Towel, first, second, and third. Right outside the podium, we have a two-way tie. Two ferocious competitors. You know them as Allie and Nancy. I know them as Allie and Rue, the future mayor of Boston, and Nancy Towell. 3.5 points each, right outside the podium. Fourth place, two-way tie. Excellent job, Allie and Rue, and excellent job, Nancy Towell. Fifth place, we have a two-way tie. Peggy Towell, Super Towel Peggy, and Holistic Psychology, the most wonderful, largest fan of finger towels in all of the Bavarian Kingdom. 3 points apiece. Tie, ladies and gentlemen, for fifth place. In sixth place, the position of honor, ladies and gentlemen. Sunken Grave, the biggest supporter of Ed of all time, the greatest soap dispenser this side of the Pacific Ocean, and north of the Atlantic Ocean, the Antarctic Ocean, which is also called the Southern Ocean. Ladies and gentlemen, Sunken Grave. All right, we are about to go to the next category. Are we thinking double bonus round, or do you want to vote on categories? All right, throw some category suggestions out. Oh, yes, that's right. I have to translate into German. All right, hold on. Hold on, I got you. Hold on. I got you, my dear friend. Hold on, I got to play it. Sunken Grave is, not Sunken Grave, Holistic Psychology is German, so I'm going to translate this. Hold on. Hello, Holistic. Sorry, hold on. Hello, Holistic Psychology. You are a wonderful human being. I announced that you were in, a tie for fifth place with an astounding 3 points. Then I mentioned that you are the largest fan of finger towels in all of the Bavarian Kingdom. May God bless you and your peoples forevermore. And also, I am a towel. Okay, so I have to deliver a message to the German delegation. Please give me a second.
Hallo Holistic Psychology, du bist ein wunderbarer Mensch. Ich habe dir bereits mitgeteilt, dass du mit unglaublichen 3 Punkten den 5. Platz punktgleich belegt hast. Dann habe ich erwähnt, dass du der größte Fingerhandtuch-Fan im ganzen bayerischen Königreich bist. Möge Gott dich und deine Mitmenschen für immer segnen. Und ich bin auch ein Handtuch.
I am glad we are all on the same page now. I am so thrilled, ladies and gentlemen, to have been able to speak to our German compatriots. You may be saying to yourself, what is going on? Well, we are an inclusive stream. You want what your score position translated to German? I am your towel. All right, so what category would we like to do? The Civil War, or Wendy Murphy, or Scientology? All right, we are going to do the Civil War first, and then Wendy Murphy. Okay, as a category. Civil War, the U.S. Civil War, ladies and gentlemen. It was a category selected by the German hero, Steph Towell. She's going to be on the German Mount Rushmore. I just need to find a way to build it. Next category, beginning now. Oh, hold on. Holistic Psychology has said something, and I'm going to translate it. Hold on. I'm not really sure. Hold on one second. Hold on. I'm not necessarily great at at German, but hold on, I got it, hold on, let me see, German, hold on, to English, thank you very much. All right, I'll find out what's going on. That's not what I wanted. Hold on, I'm trying to be inclusive here, 1 second, I just want, okay, in the Kingdom of Bavaria, I was joking, hold on, I was joking, Holistic Psychology, because a very long time ago, we were watching an episode of Sherlock Holmes, and they mentioned the Kingdom of Bavaria. I think it's the first episode in the series. So I've just decided that everyone in Germany is from the Kingdom of Bavaria. I know that the Kingdom of Bavaria doesn't exist and never really existed. I didn't mean to mislabel your where you're from. I just kind of think of that as a little inside joke. All right. Oh, it was Allie Towell that suggested the Civil War. I think Steph Towell had suggested some categories above, and I was just reading really quickly. So Allie and Bro selected the Civil War category. I got you, my dear friend, Holistic Psychology. All righty. Let us begin the next round. Clearly, we have a lot of fun during Towel Trivia. All right. Next round. Here we go. The U.S. Civil War. Which conflict arose over issues of slavery and states' rights? Oh, come on. World War I, the Revolutionary War, the War of 1812, the U.S. Civil War. Which conflict arose over issues of slavery and states' rights? World War I, the Revolutionary War, the War of 1812, the U.S. Civil War. Sorry, I should have waited a little bit longer, but I think hopefully everyone managed to figure out that this was the U.S. Civil War. The first one to get it was Steph Towell. Then we got Nancy from the 508 coming in getting half a point. Jill picking up half a point. Excellent job, Jill Towell. Then we got Sunken Grave picking up half a point. Then we got Allie and Elijah Towell both picking up half a point. Where's Elijah Towell? There's Elijah Towell. Excellent job. Pooh Bears, a lot of good category suggestions from Steph coming in. All right, next question. Next question, Little Towels. Steph has fast fingers. What year did the famous Battle at Gettysburg take place? Which year did the famous Battle at Gettysburg take place? Was it 1815, 1945, 1776, or 1863? Was it 1815, 1945, 1776, or 1863? 63. Ah, yes, the famous Battle of Gettysburg in 1776. Towel, ladies and gentlemen, got it right. It was 1863, number 4. Steph Towel, super fast, internet, super fast towel fingers, got it right. Holistic Grave tried to snipe. Holistic Grave, Sunken Grave tried to snipe, but Steph Towel pulled it off. Jill Towel coming in, grabbing another half point, keeping pace with Steph. Nancy from the 508 coming in, picking up half a point. Elijah Towel also picking up half point. These have been pretty easy, but we're working hard. Vicky Moore, the Canadian hero, fills out the Canadian contingent, grabs half a point. And Allie and Bro pick up half a point. Excellent job. Next question. Which state was the first to secede from the Union? Which state was the first to secede from the Union? Was it Virginia, South Carolina, Georgia, or Texas? Was it Virginia, South Carolina, Georgia, or Texas? Ooh, the first. I'm going to go Virginia. South Carolina. I was close approximately. Sunken Grave picks up 2 full points. Oh, a lot of people thought it was Virginia. Jill picks up a full point. People thought it was either Virginia. Oh, Fort Sumter. That's absolutely right. Yep. I should have remembered that. Great memory, Sunken Grave. Excellent knowledge of American history, my dear friend. Came through with 2 big points. I don't think it's an oopsie, Allie. A lot of people went with Virginia. We were in the right geographic area, but yep, it was South Carolina. Excellent job, Sunken Grave and Jill. Oh, I think Ruth Towell mentioned they'd be able to be here some days, but they had some things going on and that we would see them at the end of the week. But it's also a time zone thing. We're playing in different time zones around the world. Here we go, Little Towels. Who served as President of the Confederate States during the U.S. Civil War? Who served as President of the Confederate States during the U.S. Civil War? Was it Stonewall Jackson, Andrew Johnson, Jefferson Davis, Robert E. Lee? Was it Stonewall Action Jackson, Andrew Johnson, Jefferson Davis, Robert E. Lee? Well, they all had roles, but it was absolutely number 3, Jefferson Davis. Oh, good guess, Steph. Robert E. Lee was like a high-ranking general, but yeah, very good guess. Sunken Grave comes through with the full point. Jill picks up half a point. Who else we got? Elijah Towel, half a point, little towels. Who else we got here? Who else? Holistic Psychology and Vicky. I think Allie Towel picked this category. Both get half a point. I like this category. It has some easy questions, some hard questions. Some questions that were that one was actually one of the ones where you had to know each of the individuals because they all were in the Confederacy. So who was the president? That was a good question. Well, Steph, the perils of being there are really good things about being Canadian. This might be one of the downsides. All right, I got admerked. Hold on, I got admerked on my own stream, ladies and gentlemen. All right, here we go. I'm ready. Next category. Here we go. Which Union general's campaign is known for the destructive march to the sea? Which Union general's campaign is known for the destructive march to the sea? Is it Robert E. Lee, Ulysses S. Grant, George B. McClellan, or William Tecumseh Sherman? When Georgia howled, ladies and gentlemen, it was Sherman's march to the sea, I'm pretty sure. Yes, When Georgia Howled was the book I read about that. When Georgia Howled. It was William Tecumseh Sherman, ladies and gentlemen. Sunken Grave, picking up another full point. Elijah Towell and Jill both picking up half a point. Excellent job, Elijah Towell. Excellent job, Jill Towell. Nancy, Holistic Psychology, and Vicki Moore all picking up half a point. Excellent job. Where's Nancy Towell? There's Nancy Towell and Allie and Bro picking up half a point. They are super towels. I've been to Sherman's grave in St. Louis. Well, God bless him. He made Georgia howl. Last question of this round, little towels. What was the name of the Confederacy's first ironclad warship that fought in the Battle of Hampton Roads? What was the name of the Confederacy's first ironclad warship that fought in the Battle of Hampton Roads? Was it the CSS Virginia, the CSS Hunley, the USS Monitor, or the CSS Alabama? Was it the CSS Virginia, the CSS Hunley, the USS Monitor, or the CSS Alabama? CSS Hunley. Virginia. Oh, we got screwed. We got screwed. Virginia was not the answer to the other one, but it was the answer to this one. Who's going to grab the 2 points? Holistic Psychology picks up a big 2 points. Excellent job, Holistic Psychology. Only one to get it right so far. Allie and Bo pick up a full point. Jill picks up a full point. Monitor versus the Merrimack. Love it. Love it, Sunken Grave. You got it, and you are German. That's true, Holistic Psychology. Hold on. Hold on one second. I must deliver a message before I add up the scores. All right? I must deliver a message. This is becoming a tradition on Towel Stream. Towel, would like to take this honorable opportunity to proclaim that Holistic Psychology got 2 points for an astounding and impressive knowledge about the CSS Virginia. We shall now make some kind of statue in their honor involving a finger towel. Okay, I have a message for the German contingent.
Ich, Towel, möchte diese ehrenvolle Gelegenheit nutzen, zu verkünden, dass Holistic Psychology 2 Punkte für sein erstaunliches und beeindruckendes Wissen über die CSS Virginia erhalten hat. Wir werden nun eine Art Statue zu ihren Ehren errichten. Dazu gehört ein Fingerhandtuch.
And for those of you who speak English,
Hi, Towel, would like to take this honorable opportunity to proclaim that holistic psychology got 2 points for an astounding and impressive knowledge about the CSS Virginia. We shall now make some kind of statue in their honor, involving a finger towel.
Thank you very much for your attention to this important message regarding our German delegation. The Hunley was a Confederate submarine that failed. They recovered the bodies in either the 90s or early 2000s. Oh, that is very sad. Holistic Psychology would like us to let us know that they are going to be getting a finger towel as a trophy. I fully support this, ladies and gentlemen. Finger towels for everyone. Finger towels for everyone. Someone called the German Prime Minister. We obviously have German announcements during trivia now, which I think is the greatest thing of all time. You don't understand. We play trivia and we have announcements, ladies and gentlemen, in German. All right? I'm having a great time, Colleen Henry. Absolutely. I hope Buck Towel is just utterly baffled. He's like, the man on the TV knows me and he speaks German sometimes. What is going on? All right, here we go. Here's your scores. Ladies and gentlemen, there are your scores. Hold on. Let me scroll down a little bit. Oh, no, I know what I need to do. It's that. I just need to move your scores up a little bit. And there you go. The scores heading into our next round of Towel Trivia. We've never had this before, ladies and gentlemen. Look at that descending order. Look how beautiful it is. Look at it, ladies and gentlemen. There are 3 points separating first and fifth or sixth. There's 4 points separating first and sixth, actually. Ladies and gentlemen, 987. You love to see it. Someone who has OCD would absolutely be thrilled right now. 987, ladies and gentlemen. I might have a little OCD. That's okay. 987. Jill Towel, Towel, Steph Towel, there's your podium, 987. Ladies and gentlemen, 987. Jill Towel in the lead. Excellent job. Jill Towel with her first ever lead in Towel Trivia, and she's holding on to it, no doubt about it. Towel, you know him as a Little Towel, I'm a Little Towel. Second place, 8 points. Third place, Steph Towel, Canadian hero, half British, half Canadian, half German, all Canadian hero. First, second, and third. Now, we have multiple Canadian heroes. Don't you worry about that. Fourth place, including Vicky Towel. Fourth place, right outside the top 3, ladies and gentlemen, right outside the podium. Elijah Towel by only half a point, tied with the honorable Sunken Grave, the greatest soap dispenser this side of the Indian Ocean. Ladies and gentlemen, Ed's biggest supporter, Sunken Grave, and Elijah Towel tied fourth place, 6.5 points, just half a point off the podium. In fifth place, we have a two-way tie. One of them is the greatest German of all time, Holistic Psychology. The other is Allie and Rue, the future mayor of Boston. Allie and Rue, Holistic Psychology, tied. 1, 2, 3, 4, fifth place, 6 points. Peace. In sixth place, Nancy Towel, all alone in sixth place, 5 points. Excellent job, Nancy Towel. In seventh place, Peggy Towel coming in with 3 points. Excellent job, Peggy Towel. And eighth place, Vicky Towel in the position of honor, 1.5 points. Another Canadian hero. The Canadian contingent is doing excellent. Vicky Towel's just warming up for the sprint. I know what's coming. She's going to charge up that board. Here we go. Allie and Rue would like to declare that they're not happy being average. I have no doubt they're about to charge up the board, especially because we're going into a double bonus round. All right. You know what? For the double bonus round, let's use the intro. Double bonus round. This is going to be our theme song for when the double bonus round plays.
Hold on. Wait a second. That's it.
That's it?
Yeah, that's the melody of Funky Town.
You heard the Towel. Double bonus round. That's the melody to Funky Town. Double bonus round, ladies and gentlemen. Double bonus round. That's going to be your signal that a double bonus round is incoming. All right, so what's the double bonus round going to be about? Let's do something fun. It's got to be something I know a lot about. All right, how about... Oh, goodness gracious me. The double bonus round. The double bonus round, I don't know. We'll do Wendy Murphy as the next category, Steph. All right, we have 2 left for this segment. But for the double bonus round, I don't want to do Wendy Murphy because it could ask some really hard questions I don't know about, which you would think's weird, but trust me, the internet knows a lot about towels now. All right, here we go. We already did Karen Reed. I got to think of something new. What have I been learning a lot about? What do I know a lot about? I'll come up with it. Hold on. No, we've done Kubrick. I only watched so many things. You know what we're going to do? The 1978 film Being There, starring Henry Fonda. The category is the 1978 film, 1978 film Being There, starring Henry Fonda. All right, the 1978 film Being There. All right. And ready, ladies and gentlemen, it is the 1978 film called Being There. Oh, actually, we could do Simpsons. I guess the film is... No, we'll do Simpsons. That's fine. We'll do The Simpsons. The Simpsons is the double bonus category. Nobody's heard of Being There. It's a great film. The Simpsons is the bonus category. So I changed course because I realized that would just be completely unfair. So good job for Elijah Tell was like, I'll take on the double bonus category. I know, we're switching to The Simpsons. All right, here we go. Double bonus category, The Simpsons, ladies and gentlemen. Here we go. Yeah, you just want to steal points from Little Towel. Here we go. In which U.S. city does the show take place? In which U.S. city does the show The Simpsons take place? Is it capital city, hometown, Shelbyville, or Springfield? Is it capital city, hometown, Shelbyville, or Springfield? Oh, it's not Shelbyville. That's their rivals. It's not capital city. Homertown's not even a thing. It's Springfield. Little Towels. Who was the first one to get it right? Jill picks up a full point. Nancy and then Allie and then Steph all pick up half a point. All right, there's Nancy, there's Allie, and Steph Towel all picking up half a point. Then Elijah, Sunken Grave, Holistic Psychology, and Vicky Moore all pick up half a point. So where's Elijah Towel? There's Elijah Towel, half a point. And Sunken Grave, half a point. And I think I got Holistic Psychology and Vicky. Excellent job, Little Towels. Excellent job. Admerked. Hold on. Got to bring back my chat. I got admerked. Excellent job, everyone, on the first question out of the gate. Next Simpsons question in our double bonus round. What is the name of the bar owned by Mo Sislak? What is the name of the bar in The Simpsons owned by Mo Sislak? Is it Homer's Lounge, Moe's Tavern, Joe's Pub, or Marge's Bar? Is it Homer's Lounge, Moe's Tavern, Joe's Pub, or Marge's Bar? It's Moe's Tavern, ladies and gentlemen. Moe's Tavern. Point for Little Towel. Oh, I don't know. That's a good question, Colleen. Steph Towel, half a point. Jill Towel, half a point. Nancy from the 508, half a point. Allie and Bo, half a point. Elijah Towel, half a point. Holistic Psychology, half a point. Vicky and the Sunken Grave, half a point. Excellent job. Paul asks, what does sore horses mean? I don't really know. Where is that sore horses? I don't know. Not the sidebar. I don't know where'd that come up, Paula. I don't know what a sore horse is. All right, next question, Little Towels. Oh, Sunken Grave was talking about it. I understand. What is the fictional name of the town where the series is based? Oh, come on. What is the fictional name of the town where the series is based? Capital city, Shelbyville, Springfield, Ogdenville. Capital city, Shelbyville, Springfield, Ogdenville. You can tell by my displeasure, I don't know why they would repeat the same question in the category, one time calling it fictional, one time calling it a U.S. city. That was just not a very good question. But we nonetheless got it right. If you selected number 3, Springfield, Steph Towel gets the full point. Jill and Allie Towel both get half a point. I have to be very precise with the scoring because there's a lot of people very close. Nancy, oh, good guess. Good guess, Nancy. It started with the earlier trivia question. It tried to trick us by repeating it. Exactly, holistic psychology, but you got the points. Vicky Moore, half a point. Excellent job, Vicky Moore. And then Elijah Towel picking up half a point. And Allie and Rue say, stupid AI. All right, little towels, give me 1 second. Going to load up the next question. All right, little towels. Here we go. Next question. Thank you. Which character voices numerous characters, including Chief Wiggum and Krusty the Clown? Which voice actor voices numerous characters, including Chief Wiggum and Krusty the Clown? Nancy Cartwright, Dan Castellaneta, Harry Shearer, or Hank Azaria? Nancy Cartwright, Dan Castellana, Harry Shearer, Hank Azaria. I think it's Dan. Hank Azaria. I think that's the guy who plays a poo. I didn't know that. Wow, so who's going to get this one first, ladies and gentlemen? We are looking for number 4, and the answer was hold on, let me double check. I have to switch to live chat. The first one to get number 4 was Elijah Towel. That was a tough one, and Elijah Towel comes away with 4 points because it's a double bonus round. 4 points. Jill picks up 2 points. So if you got number 4, Colleen picks up 2 points. If you got number 4 on this one, 2 points for you. Nancy picks up 2 points. And Allie and Bo pick up 2 big points. Excellent job. Excellent, excellent job, little towels. Tough one to get there. I thought it was the guy who voiced Homer. I was wrong. But that was a double bonus round, so Elijah Towel just picked up 4 big points. Let me just make sure it was Elijah Towel. Yes, it was. All right, next question. Here we go. Who is the Springfield Elementary janitor famous for his Scottish accent? Who is the Springfield Elementary janitor famous for his Scottish accent? Reverend Lovejoy, Groundskeeper Willie, Principal Skinner, Kent Brockman. Reverend Lovejoy, Groundskeeper Willie, Principal Skinner, Kent Brockman. Show me the groundskeeper. It's Groundskeeper Willie. Ladies and gentlemen, Steph, first one to get it right. Jill, half point. Elijah Towel, half point. Sunken Grave, half point. Nancy, Holistic, and Vicky all pick up half a point. Where's Nancy Towel? There you are, Nancy Towel. And Allie and Bo, half a point. Excellent job, excellent job, excellent job. Last question in this round, little towels, last question in this round. Paula will do Gilligan's Island next, my dear friend. No, I said we would do Wendy Murphy. All right, we'll do Gilligan's Island after that, all right? I love the show Gilligan's Island. You know what I'm saying? I love the black and white version. I love the color version. It's a good show. Next question. Which character is the avid stamp collector battling alcoholism? Which character is the avid stamp collector battling alcoholism? Is it Sideshow Bob, Bonnie Grumble, Comic Book Guy, or Carl Carlson? Is it Sideshow Bob, Bonnie Grumble, Comic Book Guy, or Carl Carlson? Bonnie, ladies and gentlemen. It's Bonnie Grumble battling alcoholism through the series. Steph Towel, ladies and gentlemen, picks up the full point. Jill, half a point. Nancy Towel, half a point. Number 2 was the right answer here, folks. Allie and Brew and Vicky Towel both pick up half a point. Excellent job, little towels. Excellent job. Yep, he did collect stamps. I think it was in one episode, like the really artistic episode where you go into his apartment and like elephants fly around. He's a little weird. He's like detoxing, and then you learn he collects stamps. Then he gets sober eventually. Then he gets drunk by accident and crashed the helicopter. It's a bit of a weird show. Long story arc with Barney and his sobriety. You walked into my wheelhouse with The Simpsons there. I got one wrong, but for the most part I knew him. All right, little towels. We have had some adjustments, as you could say, on the scoreboard. We have people just flying around. Allie Towel and Rue set out to make a point. They made it. Who else moved up on the scoreboard? Oh, who's that? All right, who do we got moving around? I think that's Nancy Towel. Vicky Towel making some progress, ladies and gentlemen. Colleen Henry and Buck make an appearance on the board. All right, here we go. Your scores. We got a few more rounds to go before we watch our next video that we're going to watch. I think we're going to watch something about Koberger, BK, or the Idaho 4, because there's a few interesting developments that have occurred. So give me 1 second, little towels. Let me shrink this down. Hold on. Thank you very much. All right, and then let me add. There's Colleen Henry and Buck Towel on the scoreboard. There's your scoreboard. Jill Towel retains her lead, ladies and gentlemen, for the first time ever. Jill Towel is absolutely dominating the field. First place, 14 points after 3 rounds. Incredibly impressive so far. Excellent job. Jill Towel, standing tall. First place, 14 points. In second place, ladies and gentlemen, you know him as Little Towel. He's fighting hard. We're playing some towel trivia. He's got 13 points. He's holding on. He's chasing Jill. Can't quite keep up. 13 points, little towels. Excellent job. Yes, we can watch the Adelson opening statements from the Charlie trial. We can do that next. Next, we'll be watching George's opening statement from the Charlie trial. And if we can do the defenses, we'll do that too. In preparation for Donna Adelson's trial beginning on Friday, ladies and gentlemen. In first place, as I mentioned, Jill Towel, 14 points. In second place, ladies and gentlemen, Little Towel, 13 points. In third place, Elijah Towel, 12.5 points. Excellent job. Elijah Towel charged up that leaderboard, nailed 4 points on a single question. Podium position heading into our next round. Elijah Towel, third place, 12.5 points. First, second, and third, ladies and gentlemen, heading into our next round. Jill Towel, Elijah Towel, 14, 13, 12.5. Gotta love that synchronicity. Fourth place, right outside the top 4. She's one part of the Canadian contingent. One of our Canadian Super Towel heroes, ladies and gentlemen. She is Steph Towel, 11 points. Excellent job. George's co-counsel gave the opening. Got it, Colleen. See, I've watched some of George's openings. I didn't know who gave the opening in Charlie's trial. Good to know it was George's co-counsel. Fourth place, the Canadian Super Towel, Steph, 11 points. Now, fifth place, they set out to make a point. They said average isn't good enough. Rue is going to be the future mayor of Boston. Don't vote Michelle Wu, vote Rue. Rue and Allie Towel, fifth place. They're charging up that leaderboard, though. Don't sleep on them. I'm telling you, Allie, literally, don't sleep on them. They will literally charge up that leaderboard while you're not paying attention. Allie and Brew, fifth place, 10.5 points. Sixth place, ladies and gentlemen, right behind Allie and Brew, the Super Towel Nancy, fighting hard all day. Had an excellent performance yesterday. Another excellent performance so far today. Just 3.5 points outside of podium position. Sixth place, Nancy Towel. Seventh place, ladies and gentlemen, we have a two-way tie. We have the greatest soap dispenser this side of the Mississippi. And in terms of the other side, we have holistic psychology. Now, in terms of holistic psychology, hold on, I have to write this out. Psychology. I would just like to say that the German people would be well heated to elect her into some kind of official position, and also they should give her an unlimited supply of finger towels. This is an official towel decree. Someone tell the Foreign Office. All right, ladies and gentlemen, we don't even have a Foreign Office. Here's the message to Holistic Psychology, who is in 7th place with 8 points. You are also in 7th place with 8 points, and you are a towel. All right, let me convey this message. Thank you for your attention to this German public service announcement.
Aus der Sicht der ganzheitlichen Psychologie möchte ich nur sagen, dass das deutsche Volk gut daran täte, sie in ein offizielles Amt zu wählen. Außerdem sollten sie ihr unbegrenzte Fingerhandtücher geben. Dies ist eine offizielle Handtuchverordnung. Jemand soll das dem Außenministerium mitteilen. Sie sind mit 8 Punkten auch auf Platz 7. Und sie sind ein Handtuch.
I'm going to learn how to speak German by the end of all this. That's excellent. In 7th place, ladies and gentlemen, two-way ties, sunken grave, and holistic psychology, 8 points apiece. In 8th place, Vicky Towell, one half of the Canadian contingent, all Canadian hero. Vicky Towell coming in at 8th place, 4.5 points. 9th place, Peggy Towell doing excellent today, coming in with 3 points. And in 10th place, Colleen Towell, 2 points. Paul said, I'd just like to say to the German people, the supply of towels, this is a decree. Imagine if they ever put me in some formal government post and I go to Germany and I get up to give a speech. I'm like, I just want to begin this speech by saying, you German people, you have redeemed my faith in the power of finger towels to bring about world peace. Yes, it was once said that the greatest phrase one could utter is civic romanus sum. Well, ladies and gentlemen, I am here to tell you that the greatest phrase of our era is Ich bin ein Handtuch. Okay? The people of the world need to hear this speech, okay? I must be allowed to go to Berlin and tell them that I'm a towel. Oh, goodness. Oh, goodness. All right, we're going to play our next round, but we need some moments of levity every now and again. The people of Berlin will embrace my message. Mr. Gorbachev, tear down that towel. I feel bad for the people who tune in. We're talking in German about towels. Oh, goodness. The Germans will hold me in contempt for this. All right, hold on. I have a message to the people of Germany. I'll try before we begin our next round. No, this is very important. All right, hold on. To the people of Germany and the world, I think it is incredibly important to relay to you that over the years, the greatest phrase was once civis romanus sum. In our age, the greatest phrase is now is now I am a towel. In the furtherance of world peace, I demand the communists tear down the towel walls that divide us all. Thank you. Okay, here's my message.
An die Menschen in Deutschland und der Welt. Ich halte es für unglaublich wichtig, Ihnen zu sagen, dass der beste Spruch der Geschichte einst Civis Romanus Sam war. In unserer Zeit heißt der beste Spruch heute, ich bin ein Handtuch. Im Interesse des Weltfriedens fordere ich die Kommunisten auf, die Handtuchmauern niederzureißen, die uns alle trennen. Danke.
I'm pretty sure if I went to Germany, they would be utterly baffled. 1 minute I'd be talking about Kant as a Privandant up in Königsberg. The second I'd be declaring the establishment of the Bavarian Empire. And the third I'd be like, oh, by the way, ich bin ein Unhandtuch. And they'd be like, what? Who unleashed this man on us? I am a hand touch, not a beer leaner anymore. Oh, what have we done? We've set history on a very interesting path. One day I will speak to the people of Berlin, and I will invoke the phrase, Ich bin ein Unhandtuch. You don't understand. Oh. Right, no, see, nothing to do, the commies aren't really the problem in Germany. I'm just saying, like, Mr. Gorbachev, tear down this towel. All right, here we go. Last pursuit of this round is going to be Wendy Murphy, and then maybe we'll do Gilligan's Island after openings. All right, Wendy Murphy, law professor Wendy Murphy. Ladies and gentlemen, law professor Wendy Murphy is the category. Grant won a Supreme Court case even before he was conceived. That's what I'm saying. Holistic psychology, we must absolutely teach the German people how to laugh. Okay, you know what I'm saying? I'm going to go to Germany. You are going to be my press assistant or my press lead. You'll be the leader of my German press team. I'm going to go into Germany. You're going to convene some sort of like Berlin-based speech for me. I'm going to go there and I'm going to wave a towel at the people of Berlin and I'm going to say, this is the moment of towel-based liberation. Now please give me Northern France. All right, I never forgot about Norman Towel. We are capturing Northern France. Don't tell the French. Well, Steph, listen. Here's how we're going to pull this off. When I negotiate with the Germans, all right, the only thing I'm really going to do is tell them how much I love techno music and how much I love the song Klanga by Gostana. All right, and then I'm going to play that song. Then I'm going to get up in front of them all, and I'm going to be like, listen, I am one of your peoples, okay? I speak your language. I do wear all black. I could probably go over that little club there, you know what I'm saying, and get in. You know what I'm saying, bro? I could just walk up the dude. It's a vibe check, you know what I'm saying? I'll be like, I'm down, bro. You know what I'm saying? He'd be like, all right, you're a towel. I'd be like, you're a fucking, ich bin ein Handtuch. You know what I'm saying? And so I could relate to the people of Berlin. Now, I don't really know why we have to do this. They're already an advanced industrial capitalist economy, but I just kind of want to preach to them about the value of towels. All right, then I want the German press to have to write up articles about how this man went into the middle of Berlin and just started talking about extolling the value of towels. I think it will be freaking hilarious, okay? You don't understand. And then Holistic Psychology and I can go over to that club there where you have to, like, pass the vibe check to get in at, like, 2 p.m. on a Tuesday. We'll have a really fun time. Bossy Texas Chicken Bella! Oh, Holistic Psychology, let me get you the song, okay? I can't play it for us on the YouTube, but let me get you the song. It is a very important song in the history of Berlin. Okay. Okay. Song about Berlin. All right. Hold on one second. I'm going to find it. I know what song this is. I'm going to listen to it when I go for my walk later. It is called like Gosten or something. Hold on. Gosten, Berlin, techno song. I'm going to find it for you, Holistic Psychology. Hold on. I might have to actually go into my, I might have to go into my Spotify to find it, but I'll find it. You watch. Now you might be saying, why are we taking a break for you to do this? Well, first, my, oh, I got it. I found it. Let me know what you think. I can't play. I wish I could play this for you on stream. I don't think, you know what's interesting? I don't, might be a remix, but I still don't think I can just play it on stream. I love this song though. Can I play like 10 seconds of it? Sometimes they don't even let you play 10 seconds of it. But I found the song for you. Give me 1 second. Hold on, Holistic Psychology. Why are you doing this to me? Why are you bothering me right now? I just want you to load up the song. All right. I have a plan. I found the song. Give me 1 second. It is called, hold on. It is called Klanga, K-L-A-G-A, and the band is Gostan. All right. Now I wish, you know what? Maybe I actually, it is a deep house kind of like remix, so maybe I can play it. All right. No, I'm just going to share the link for you. All right. So here is the link, and this is the song. All right. So you can find the song right here. I will sing it. Maybe I could play a few seconds of it. I think, well, I don't even want to, even though it's a techno house remix. Just take a look at the video if you want to hear it. We're going into our next category, Law Professor Wendy Murphy. Here we go. First question. Which university has Wendy Murphy been associated with? New England Law Boston, Harvard University, Yale University, or Columbia University? Is it New England Law Boston, Harvard University, Yale University, or Columbia University? Now, she did serve as an adjunct at Harvard for a while, but I think the answer is New England Law Boston. Yes, it is, Little Towels. Towel got the first question right about his mom. Steph Towel, full point. Good job, Steph Towel. Paula Towel grabs half point for getting it right about Towel's mom. Colleen, Henry, and Buck Towel get half point. Vicky Moore, Allie, and Bo all get half point. Excellent job, Vicky Moore. Excellent job, Allie and Bo. Peggy Towel comes in, picks up half point. Peggy Towel listened to the interview this morning. Thank you so much, Peggy Towel, as to all of you who listened. Sunken Grave, half point. Jill Young, half point. Holistic Psychology, half a point. Excellent job, Jill. Excellent job, Holistic Psychology. Bossy, Texas Chick, and Bella. No, Bossy, Texas Chicken Belly, you should have heard me debating with Towel Mom. At certain points, I was telling her I was going to dedicate my life to creating a unit of the DOJ to arrest cops who abuse the trust of victims in the context of criminal cases. And then I told her I was going to put their pictures up on my wall. And then she was like, you're never going to have any pictures on that wall. And I was like, you've just made me commit my life to this. It was a moment. It was a very nice Towel Mom and Towel Son moment. You know, we could have hugged it out. You know what I'm saying? I talked a lot about Brian Tully and Sandra Birchmore. I wouldn't exactly say that made Towel Mom very comfortable. I think Towel Mom might have some dual loyalties as to the state police. But you know what? Kate Peter shouldn't try to talk to Towel Mom. I'm so much smarter than Kate Peter. Sorry. You know, it is what it is. And don't talk to my mom. How dare you? How dare any of you, not you in the chat, how dare any of those people try to talk to Towel Mom? Who do you think Towel Mom's going to support at the end of the day? You people, like Kate Peter and you all, or the state police, or me. She's going to support me, all right? You know what? I'm a Towel. I am her son. You are just some random freaking people, all right? So you bad Kate Peter. You stay away from Towel Mom. Bad Kate Peter. Bad. Yes, and then Towel Mom started scolding me about the cannabis, and I was like, well, it's a cigar. And then also, I'm sure the alcohol industry loves that you're saying that. And then she was like, yeah, alcohol's bad too. And I was like, all right. Yeah, we had some trolls. Turtle Boy popped in. It was a 4-hour interview, Boxy Texas chick. Even Turtle Boy popped in at one point. I banned him very quickly. I'm a towel. Oh, it was like a 4-hour interview with Towel Mom. It started at 9:30 and went till about 1:30 p.m. Next question about Towel Mom. Towel Mom's trivia category now. Which type of law does Wendy Murphy specialize in? Environmental law, corporate law, SV law, international law. What type of law does Wendy Murphy specialize in? Environmental law, corporate law, sexual violence law, or international law? Well, if you watched the interview earlier, you know it is SV law because she's a victim's advocate and I'm a little towel. Who got it right? Steph Towel was the first one to get it right. Steph Towel's a super towel. Colleen, Henry, and Buck paid attention to the whole interview because they're super towels. Nancy Towel paid attention. Excellent job. Allie and Brew, Bossy, Texas Chicken Bella are on the board, ladies and gentlemen. Bossy, Texas Chicken Bella are in last place again. It's okay because one day they did win. That's the truth, ladies and gentlemen. That is the truth. Jill Towel picks up half a point. Excellent job. Oh, very good guess, Paula Towel. She does do a lot of like corporate accountability work, but I think the SV answer is probably the most apropos. Peggy Towel was having a great time paying attention during the interview, learning a lot from Towel Mom. Half a point. Sunken Grave, half a point. Excellent job. Vicky Moore had a great time during the interview, learning a lot from Towel Mom. Half a point. No, I don't think so, Peggy Towel. I think from the beginning, Towel Mom was just like, oh no, she had like talked about it a lot, so I think she just didn't want to. And I think the other thing is, I'm pretty sure like Kate Peter and some of those people try to get in Towel Mom's ear, and if they're talking to Towel Mom at all, Towel Mom shouldn't be involved with that stuff because those people are trying to protect Brian Tully, in my opinion. So like, if Towel Mom has dual loyalties, like she can't really do that anyway, because how's she ever going to like hold the state police accountable, like, and stuff like that, Because it wasn't just Turtle Boy who did bad stuff or Karen Reed, it was Brian Tully and Kate Peter, and it's really hard to have like people who have personal relationships in all this, like whoever knows whoever, like it makes it very hard, all right? And Towel Mom's always going to side with a little towel, all right? But I'm not going to I don't think anyone should put Towel Mom in the position where, like, Kate Peter's going to go try to manipulate her and all this stuff. Just leave Towel Mom out of it. And I don't even want Kate Peter talking to Towel Mom. I think that's creepy as fuck, and it makes me really weirded out. I know who else talks to Towel Mom, like, just randomly reaching out to her. It's weird as fuck, and they try to manipulate her, and I'm like, why are you talking to those weird people? And she's like, I don't even know who these people are. Then I'm like, stop fucking texting them, But I don't mean to cuss, sorry. I cussed again. I apologize. I should have said effing. I missed Nancy's last point. That's very true, little towel. Thank you very much. I went back and got it. I was ranting there. Sorry about that. Towel Mom also has a new book out if you missed it. You can find that on Amazon.com. Wendy Murphy, oh no, he didn't. Absolutely consider taking a look at Towel Mom's book. All right. So here we go, little towels. Next question about Towel Mom. In which legal framework has Wendy Murphy made significant contributions regarding SA laws? In which legal framework has Wendy Murphy made significant contributions regarding SA laws? Is it Title IX, common law, the Constitution, or Federal Trade Commission law? Is it Title IX, common law, the Constitution, Federal Trade Commission law? She's going to be pissed about this because she wants it to be the Constitution, but it's Title IX. It really should be the Constitution. She's a constitutional scholar, but the answer is Title IX. I am very proud of Towel Mom. I'm very proud. All right, who got it right? Who got Title IX right? Jill, congratulations. Excellent job. Full point. Colleen, Henry, and Buck Towel picking up half point. Who else got it? Sunken Grave. Excellent job, my dear friend. Who else got it? A lot of good guesses because technically Towel Mom knows a lot about the Constitution, but she's best known for her Title IX work. Vicky, half a point, and Allie and Bro, half a point. Now, I don't think it's being unfair to Towel Mom in calling her a Title IX expert over the Constitution. She is a constitutional scholar, but she is a Title IX expert. She's probably the foremost national Title IX expert that exists. She wrote the whole thing not wrote the law. She wrote the book on campus disciplinary processes and how Title IX's a hook to give sort of certain rights to victims in that process. She is the expert on that. Title IX. So a lot of people think of Title IX as about granting equal rights to women in education, all right, in sports in particular. But it's a lot more than that. The way it worked was the Civil Rights Act of 1964 ended up getting amended or updated through a bunch of different acts. There was Title IX for education equity. There was Title VI for civil rights. There was Title 7, I'm pretty sure, for education equity. Not education equity, for other types of rights. I forget all the Civil Rights Acts, but one of them was Title IX. Now, by granting equal access to education, regardless as to sex or gender, what it did was it did a few things. One, it forced schools to provide equal funding for female sports. That's what it's most known for. But it also created a bunch of rights for women on campus who suffered harms disproportionately because of their gender or sex, and that is what created the campus disciplinary process in America at colleges and universities, and that's Title IX. Okay, so when you hear about a Title IX coordinator at a university or a college, every Title IX coordinator in the country knows Wendy Murphy, and she knows every single one of them. You're talking thousands of schools. She is the nation's foremost expert on the campus disciplinary structure, in particular as to how those processes and procedures impact the rights of victims when dealing with redress to the schools that might be sort of impacted by implicit or overt bias towards women. All right, that's Title IX. Don't worry, Paula Towel. It is, Title 11, I don't know, but Title 9 is something that people think is about women's sports, but is really about women's rights. So that's just why I wanted to clarify that. Bossy Texas Chicken Bella had a question about Title 9, and I am moving on to the next question. What notable role has Wendy Murphy held in relation to high-profile criminal cases? What notable role has Wendy Murphy held in relation to high-profile criminal cases? A prosecutor, a judicial clerk, a defense attorney, or a victim advocate? A prosecutor, a judicial clerk, a defense attorney, or a victim advocate? So she's been a prosecutor, but I think they're going to go with victim advocate. Yeah, victim advocate, little towels. Victim advocate, number 4. Oh, she was known as a prosecutor, but she's most known in high-profile cases. Paula Towel got it as a victim advocate. Yes, indeed. No, well, I don't think she's ever done a defense case, Sunken Grave. I can't say she's very friendly to defense attorneys. Yeah, Chapter 11 is, but I don't think Title 11 of the Civil Rights Act is. Sunken Grave, I saw that nice smooth answer switch, but that one's not going to work. Jill Towel picks up half a point. Don't worry, those of you who guessed prosecutor, you weren't wrong. She is often known as a prosecutor, but not really. When she was a prosecutor, it wasn't really of high-profile cases. Steph, not knowing anything is the first step to knowing something. Next question, little towels. Next question. What institution did Wendy Murphy critique for handling of sexual harassment cases? Which institution did Wendy Murphy critique for handling sexual harassment cases, for their handling of? Was it Yale, Stanford, Harvard, or Princeton? Was it Yale, Stanford, Harvard, or Princeton? It got her in a lot of trouble, actually. They hate her to this day. Harvard University, ladies and gentlemen. Even though my dad was an alumni, they definitely were never going to let me go to law school there because Towel Mom definitely sued them. It was Harvard. Listen, you got the cojones to take on Harvard. That tells you kind of, my Towel Mom I have a lot of faith in her in the sense that she is willing to take on whoever normally. Jill was the first one to get the full point. Excellent job. Sunken Grave picking up half point into the double digits. Great guess, Elijah Towell. Good guess, Vicky, but no. Holistic Psychology picking up half a point. Allie and Bo picking up half a point. Steph's like, I'm a dishonor to Wendy. Oh, it's all right. We didn't even discuss that. Sorry, I burped. We didn't discuss that today during the interview, so. Paula Towell picking up the last point of this segment. So if you've been playing, you've been having a good time, we're going to do maybe one more round before we watch the opening from the prosecution in the Charlie Adelson trial. My brother went to Brown, says Sunken Grave, so go Bruins. Well, absolutely. They weren't on the list. They weren't someone when Towel Mom sued, so there you go. All right. Oh, goodness. We've had some changes in the leaderboard. Oh, we have a two-way tie for fourth. Oh, goodness, a two-way tie for fifth. Oh, we got Bossy Texas Chicken Bella on the board. Here we go. Let me show you your scores. I've never seen anything like it. The competition is fierce. Towel Trivia brings out the very best in us all. Ladies and gentlemen, your updated scores for Towel Trivia are as such. We're going to play one more round before we watch the opening, and that round is going to be about Gilligan's Island. But for now, ladies and gentlemen, the Towel scores, it's never been so close. Let's tell Jack D65, you are a Super Towel, and my name is Towel. So let's take a look. Little Towels in first place. Little Towel. I fought hard. I got 5 of 6 questions. Oh, wait a minute. Pause. We have one more question about Towel Mom. Everybody pause. I thought it said the round was over. Jack D65, it's so great to see you, my friend. You are a Super Towel. Did you know we did a 4-hour interview with Towel Mom today? Now listen, I realized there was one more question to go. I didn't realize the round wasn't over. I can't believe it. We have one more question out of nowhere. Let's go. In which publication did Wendy Murphy publish a notable article on victims' rights? In which legal publication did Wendy Murphy publish a notable article on victims' rights? Was it the Yale Law Journal, the Columbia Law Review, the Harvard Law Review, or the Boston College Law Review? Was it the Yale Law Journal, the Columbia Law Review, the Harvard Law Review, or the Boston College Law Review? Oh, BC. I should have gone with BC Law. Steph gets the 2 points, ladies and gentlemen. Steph gets the 2 points. Yes, Jack D65. I interviewed her from 9:30 a.m. until 9:30 a.m. to 1:30 p.m. Nancy from the 508 got that one. Excellent job. Who else got it? Jill and Allie Towel both picking up half a point. Jill just took the lead. Wow, I spoke too soon. I shouldn't have put the score up. Sunken Grave and Holistic Psychology both picking up a full point. Paula Towel with a full point. 47 bonus points for being a Super Towel. And Jack D65 gets 48 bonus points for being a Super Towel. Nunya's trying to snipe points from the shadows. Here we go. We got a new scoreboard. After that last question because I got it wrong. That was a tough one, though. Towel Mom publishes a lot of articles in a lot of different publications. Here we go, Little Towels. I got your updated scores, including Jack D65 on the board with his bonus points. Here you go, Little Towels. Here's your score. First place, retaining. Oh, Vicky, I got your point. Hold on, Vicky. Let me add your point there. First place, ladies and gentlemen, retaining their crown, heading into Gilligan's Island round before we watch the opening from the Charlie Adelson trial. First place, Jill Towel, 18.5 points. That last question allowed Jill to retain their first place status every single round, I think, so far. First place for Jill. 18.5. Little Towel, ladies and gentlemen, right behind Jill. I was in the lead until that last question. Second place, 18 points. Third place, Steph Towell, representing the Canadian contingent, 15 points. Excellent job, Steph Towell. That's the podium. Jill Towell in first, Towell in second, Steph Towell in third, 18.5, 18, and 15 respectively. Excellent job. Podium position right now. Right outside the top three, absolutely not average in any sense of the term, Allie Ann Brew, fourth place, 1.5 points outside the podium, 13.5 points. I got your point, Vicky Towell. Don't worry, I added it. Excellent job, Allie Ann Brew, right outside the podium. Fifth place, the ever-present, ever-threatening Elijah Towell, 12.5 points. Fifth place, excellent job, Elijah Towell. Sixth place, we have a two-way tie. Nancy Towell, and the greatest soap dispenser this side of either the Atlantic or the Pacific Ocean, which means every ocean, basically, because there's only two sides of those oceans. Well, four sides. I'm getting lost at this point. Sunken Grave and Nancy Towell in a two-way tie for 6th place, 11 points apiece. Seventh place, Holistic Psychology, ladies and gentlemen, doing excellent. A Super Towel German of all Super Towel Germans, and the future queen of the Kingdom of Bavaria, which doesn't exist yet. Do we call it a queendom? What do we call it if she's a queen? A queendom of Bavaria? I'm going to work on that. I'll speak to the Prime Minister. I won't violate the Logan Act. I'll make sure. I'm going to read it over a few times. In any event, seventh place, Holistic Psychology. 1, 2, 3, 4, 5, 6. Seventh place, Holistic Psychology, 10.5 points. Eighth place, Vicky Towell with her last point added on. Excellent job, Vicky Towell. Eighth place, 7 points. Good job. Half of the Canadian contingent, all Canadian hero, Vicky Towell. And that was 8th place, I believe. Let me double check. 1, 2, 3, 4, 5, 6, 7. 8th place. 9th place, Peggy Towell coming back, charging up the board. 9th place, 4 points. How do you feel? Pete Bunny Towell, is Peggy doing well? Well, he's vociferously banging his head on the microphone, so he thinks you've got the spirit in you, Peggy Towell. Peggy Towell in 9th place, 4 points. 10th place, rounding out the top 10, the ever-vigilant Buck Towell, the ever-vigilant Super Towel Colleen Henry. 10th place, 3.5 points. 11th place, Paula Towell, doing excellent, 3 points, joining a little bit late, but still 11th place, 3 points. Great job, Paula Towell. 12th place, Bossy Texas Chicken Bella. They are bosses, they're from Texas, they're chicks, and one of them is named Bella. Bossy Texas Chicken Bella. Hi, Bella. I'm a towel. You're a towel, too. Half a point in the position of honor. And in the extra super duper position of honor, Jack D65, 48 bonus points for being a super towel. So, Sunken Grave has been to the Indian Ocean, and he prefers lakes to oceans. I totally get you. You know, I bet Ed likes lakes over oceans, too. Oceans are a little scary. The next questions are going to be, ladies and gentlemen, about Gilligan's Island. Then we're going to watch the opening from the prosecution in the Charlie Adelson case. So if you're just tuning in, the next series of questions, Little Towels, are going to be about Gilligan's Island. Yes, I know all of you love Gilligan's Island. I've always wanted to learn about Gilligan's Island. Vicky, we love Gilligan's Island. How can you not love Gilligan's Island? It's one of the greatest shows of all time. It brings us back to a simpler time. Towel Mom longs for the day. Some people pine for the fjords. Towel Mom longs to watch Gilligan's Island and go back to the days of yore, the happy days of yore, no pun intended. Basically, just turn on Nick at Night from the 1990s and Towel Mom would be very happy. All right, so the next category, and I'm sure Allie and Rue are thrilled as well, the TV show Gilligan's Island, ladies and gentlemen. The TV show Gilligan's Island. And this is the last category before we watch the opening from, what is it called? The Charlie Adelson trial, ladies and gentlemen. I also have to spell Gilligan's Island correctly, so, you know, this is not, spelling is not exactly my forte. If I don't spell it right, the bot's going to just be utterly baffled. The show is called Gilligan's Island, all right? Not Gilligan Island, Gilligan's Island, okay? Gilligan's Island, ladies and gentlemen, the TV show Gilligan's Island, all right? Here we go. I think I got it. It's the spelling that really did me in, you know what I'm saying? All right, the TV show Gilligan's Island. All right, let me get this up and ready here. Towel trivia. Let me switch this one over to, nope, not English to German. That one. Here we go. Towel trivia. The category is little towels, as mentioned, Gilligan's Island. The moment we've all been waiting for. The tension builds. Here we go. In which ocean did the characters get stranded? The Indian Ocean, the Atlantic Ocean, the Pacific Ocean, the Arctic Ocean. In which ocean did the characters get stranded? The Indian Ocean, the Atlantic Ocean, the Pacific Ocean, the Arctic Ocean. It's definitely the Pacific. Pacific, number 3, little towels. I'll make the question bigger after this one. Steph Towel was the first one to get it right. Towel also got it right. Who else? Nunya coming in, grabbing half a point. Nunya Towel. Who else? Hello, Skipper, says Elijah Towel. Bossy Texas Chickabella, half point. Allie and Bo, half point. Elijah Towel, hello to Skipper. Hello, Skipper, to yourself, half a point. Sunken Brave, half point. Nancy and Jill and Holistic Psychology all get half a point. Nancy, and where's Nancy Towel? There's Nancy Towel. And Jack D65 on the board, ladies and gentlemen. Half a point. Got to give Vicky Towel. Did Vicky Towel get a chance to answer? Booing my 8th place. Oh, I'm having connection problems. Oh, I understand. Jack D65. I think Vicky Moore was having some internet demon problems, and I think she just tried to upgrade her internet as well. But damn internet. Damn internet, ladies and gentlemen. All right. I tried to make the questions a little bit larger there for you. No promises, little towels. No promises. But there you go. The wording should be just a little bit larger now. Vicky Moore comes in and gets the answer right, grabs her half a point. Can everyone wait until I answer first? Thanks, Paula Towel. Stefan Nunn, you're answering before I even see the question. Oh, that damn internet. Sunken Grave, you might have to, it might either be your internet. You might, even if it says you're live and you're not seeing it, that's your internet. If you have the option to jump forward on the live stream or set the speed to 2x, you might catch up. All right, next question, little towels. Here we go. What was the name of the millionaire character? What was the name of the millionaire character on Gilligan's Island? Was it Professor Roy Hinckley, Ginger Grant, Mr. Greenbaum, Thurston Howell III? Was it Professor Roy Hinckley, Ginger Grant, Mr. Greenbaum, Thurston Howell III? It was Thurston Howell III, little towels. Thurston Howell III. Nope. So if you selected number 4, you got the right answer, ladies and gentlemen. Number 4, and it was Steph Towel. Checking back on my scoreboard. Steph Towel, the first one to get it. Nunya Towel grabbing half a point. Jack D65 grabbing another half point. Jill and Bossy Tex Chicabella both getting half a point. Who else we got? Paula Towel coming in with half a point. Nancy from the 508 picking up half a point. Allie and Bo, half a point. Holistic Psychology, half a point. Excellent job. Sunken Grave, another half a point. Excellent job, little towels. I named my lovebird Lovely Howl, says Allie. I love it. Excellent, Vicky Moore. Vicky Moore is going to be a Super Towel Trivia player come September 6th with her 5G. We all better get worried. Vicky Moore's already kicking butt with delayed internet. Imagine what she's going to do once she takes us on with Steph-style T1 internet. We're all screwed. Here we go, little towels. Next question. Who was the creator of the TV show featuring a castaway theme? Who was the creator of the TV show featuring a castaway theme? Was it Aaron Spelling, Sherwood Schwartz, Gene Roddenberry, or Norman Lear? Was it Aaron Spelling, Sherwood Schwartz, Gene Roddenberry, Norman Lear? Either 2 or 3, I want to say. No, number 2 was the right answer. Steph Towell. Who was the first one to get? Steph Towell picks up 2 points. Bossy, Texas Chickabella, full point. Who else? It was number 2 was the right answer, ladies and gentlemen. Number 2, Paula Towell. Oh, darn, Paula. You did guess 4, but it was number 2. Yep, it was number 2, ladies and gentlemen. Number 2, Jack D65, picking up a full point. Excellent job. Yes, Allie, you did guess wrong. You got it, Jack D65. I saw you in there. Yes, you did, my friend. I went back and found you. Thoroughbred Motorola? Vicky, did you answer, or are you just saying Thoroughbred Motorola? You said number 4. Number 4 for which one? Oh, for the last one, Vicky Towell. All right, I'll give you a half point for that one. Did you get this one, though, Vicky Towell? Nope, not for this one, Vicky. This one was number 2. You got the last one right, but not this one, Vicky. This one was number 2. Aaron Spelling was later. Gotcha. Next question, little towels. What was the name of the actress who played the character referred to as the movie star? What was the name of the actress who played the character referred to as the movie star? Was it Natalie Wood, Tina Louise, Barbara Eden, or Dawn Wells? Was it Natalie Wood, Tina Louise, Barbara Eden, or Dawn Wells? Wow, that's really hard. I think it was Dawn Wells. Tina Louise, ladies and gentlemen. It was Tina Louise. Who got it first? Elijah Towell picks up 2 points. It was number 2 for this one. Bossy, Texas Chickabella, full point. Jill Towell picks up a full point. Allie and Bro, full point. Sunken Grave and Nancy both pick up a full point. Jack D65, and I think Paula already got, no, Paula guessed 2. Jack D65 and Holistic Psychology both get a full point. Excellent, excellent job. No, Jack D65, the first person to get it was Elijah Towell. It just might be your phone showing your response a little late, but your internet is lagging, my dear friend. I feel for you, Jack D65. Yeah, it might be your phone, Vicky. But that's all right. I'll wait to see what you answer for this one. Number 2. Good guess, Vicky. You got it. Full point. Or not even a guess. You probably knew it. Full point. All right. Here we go, little towels. Next question to the Gilligan's Island category. You got it, Vicky. Which character served as the skipper's first mate? Which character served as the skipper's first mate? Was it Mary Ann, Mr. Howell, Professor, or Gilligan? Was it Mary Ann, Mr. Howell, the Professor, or Gilligan? Do-do, do-do, do-do. Which one, folks? Which one? I'm going with Gilligan. Yes, indeed, little towels. It was number 4, Gilligan. The first one to get it was Elijah Towell, ladies and gentlemen. I believe Elijah Towell got it first. Let me just make sure. Yep. Elijah Towell, ladies and gentlemen, gets the full point. Steph Towell comes in, gets half a point. Jill Towell, half a point. Nanya, half a point. Jack D65, half a point. Sorry about that. Sunken Grave, Bossy Texas Chickabella, both get half a point. Who else we got? Paula, Ellie, and Nancy all get half a point. Hello, Bo. So there's Allie, there's Nancy, and where's Paula Towel? I know you're on my list. There you are, half point. Then we got holistic psychology, and yes, Vicky, I did get you for that last one. Holistic psychology, holistic psychology gets half a point. Vicky, you're about like 30 or 40 seconds behind, so it's a little bit hard to track your answers. You got this one, Vicky. If you selected Gilligan, you got it right. I gave you half a point. All right, here we go. Last question of this round, ladies and gentlemen. Last question. Why did Ginger have a million dresses? Who knew? I don't know. Next question. Here we go. What was the primary goal of the castaways on Gilligan's Island? What was the primary goal of the castaways on Gilligan's Island? Was it to be rescued, to build a permanent home, to find treasure, or to create a new society? They were clearly communists. Was it to be rescued, to build a permanent home, to find treasure, to create a new society? To be rescued, ladies and gentlemen. They spent every episode trying to get rescued. Who got it? Steph Towel, first one to get it, full point. Elijah Towel, half point. Nancy, Bossy Texas Chicken, Paula, all get half a point. There's Bossy Texas Chick, and Bella, and there's Paula. Then we got Sunken Grave, Jack D65, and Jill, all getting half a point. All right. And then we got Allie and Holistic Psychology. Excellent job. Both getting half a point. Hello, butterflies. Butterflies are free. It's so good to see you. You did, Paula, but it's a little tricky. We'll wait for Vicky's answer to come in on this last question, and then I'll bring up your scores. Oh, don't hang your head in shame, Paula. We are proud of you, Little Towel. We had fun playing that category. We learned things. That is what life is all about. That's right, Steph Towel. You got the spirit. You got the spirit. All right. Just waiting for Vicky's Towel's answer. Yes, Jack D65. You are a super towel. Yes, to you as well, my friend. You are a super towel. Thank you so much for hanging out, my friend, and for your support. Look how quickly I got that in. I even was able to send hearts in response to the super chatto. Super towel. All right, God bless you, Jack D65. Thank you so much for your support of Towel Trivia. Let me just see what Vicky's answer was. Number one, Vicky Towel grabs another half point. All right, let me show your updated scores, ladies and gentlemen. Oh, boy, this is fascinating here. Who's moving around? Paula and Bossy Texas Chicken Bella jumping up the scoreboard. Who else is jumping? Jack D65 jumping up the scoreboard like a super towel. Super towel. We're going to give you now 9 billion bonus points for being a super towel. All right. Here we go. Let's take a look at your scores. Who's ready? Drum roll, please. Scores, ladies and gentlemen. It's awesome, Jack D65. I enjoy playing as well. We're going to play 3 more rounds today, remember, folks. 3 more rounds in about 30, 40 minutes time, all right? 30 to 45 minutes. Here is your scores, Little Towels. I have your scores for you right here. There we go. Hold on. Got one more person on the board. We have a new person on the board. It's Nunya Towel. There we go, ladies and gentlemen. Nunya Towel on the board. So there you go, Little Towels. Take a look at your scores. Everybody's doing really well. I'm proud of all of you. Here we go. Take a look. First round score, segment 1 scores. We're going to play 3 more rounds in about 30 to 40 minutes time after the opening from the prosecution in the Charlie Adelson trial. But for now, because my voice needs a rest, for now, ladies and gentlemen, first place, just barely. Barely. Tomorrow afternoon opening statements. Wow, Holistic Psychology. They got a jury? They got a jury? Hold on. Is this true? Do we have a jury? Ladies and gentlemen, are we hearing reports that it could be tomorrow afternoon? I'm hearing reports from our German friend, Holistic Psychology, that tomorrow afternoon, is this really what I'm hearing? Hold on. Let us check in. First, we must read the scores, all right? Towel in first place, barely, 22 points, ladies and gentlemen. Jill Towel, second place, 21.5, ladies and gentlemen. Look at how close this is. Look at how close it is. Towel in first, Jill Towel in second, 21.5. Steph Towel in third, 20.5. 22, 21.5, 20.5. First, second, and third. Oh, goodness. Oh, goodness. All right, hold on, ladies and gentlemen. We're going to go over it. We need to have a pause. I hate to do this during the middle announcements of scores, but I'm hearing reports we may have a Donna Adelson jury. Ladies and gentlemen, we may have a Donna Adelson jury. Okay, hold on. I'm checking in on the courtroom pool feed. I'm checking in. I'm hearing reports that we may have a jury. Nothing yet right now, ladies and gentlemen, but as soon as the court comes in, I'm hearing reports opening statements may start tomorrow. Yes. Wow. Oh, my goodness. I am seeing breaking news reports, ladies and gentlemen. I am seeing breaking news reports. I'm going to check the email now. I'm seeing breaking news reports that indeed the trial for Judge Everett just announced opening statements begin after lunch tomorrow. They're processing the last 50 jurors as we speak. So this was about 3:39, so that was about 20 minutes ago. 1 second. I'm going to go back 20 minutes in the feed, little towels. I don't see Judge Everett announcing it on this feed. Hold on. When was the last time Judge Everett talked? I don't see anything. Oh, here we go. Hold on. We're going to go to this one. This is the last update from the Donna Adelson case. It was just over an hour and 40 minutes ago. This is what Judge Everett said in court. Hold on. I found the feed. Hold on, little towels. Pausing on your towel trivia scores.
Yes, ma'am, right over there.
1 second.
Yes.
This was from just about over an hour ago in the Donna Adelson case. I'm hearing that we're going to start tomorrow. Opening statements tomorrow, folks.
56 is on the end.
This was just about an hour ago. Thank you to Vicky Towell for the alert. Yep, 2 to 3 weeks. Yep, we're checking right now, folks. Yep, thank you, Holistic Psychology. You absolutely nailed the news update. We're just going to watch Judge Everett having delivered the news. I think it's going to start any second here now, folks. This was about an hour ago. This was about an hour ago, as I mentioned, so maybe a little bit more, a little bit less. So hold on 1 second. I'm just jumping forward, folks. Here we go.
Good afternoon. Oh, that will not do at all. Let's start again. Good afternoon to all of our prospective jurors that have answered the call to serve. Thank you. Much better. I'm Stephen Everett, one of your circuit judges here in the Felony Criminal Division for Leon County. You have been summoned here this afternoon as prospective jurors in the case of the state of Florida versus Donna Adelson. This is case number 2023 CF 3226. This is a criminal case. The state has charged Mrs. Adelson with the crimes of first-degree murder, conspiracy to commit first-degree murder, and solicitation to commit first-degree murder. You will notice at times during this jury selection process that I will be reading to you. It's not that I do not wish to have a free-flowing conversation with the members of our prospective jurors as a panel as a whole, but rather the instruction on the law that you're to receive during this process must be uniform and it must be specific according to the Florida Supreme Court. Is the state ready to select a jury at this time?
Yes, Your Honor.
Is the defense ready to proceed as well?
Yes, Your Honor.
And for the record, I'm noting that Mrs. Adelson is present in the courtroom with her attorneys. The first thing I'm going to do this afternoon is to confirm the information that took place downstairs during the qualifying. Tricia, who performed the qualifying this afternoon?
Judge Riggins.
All right. I believe you earlier spoke with Judge Riggins. You all remember Judge Riggins, correct?
Yes.
All right. The information that you went over with Judge Riggins, I'm just going to confirm to make sure that everyone is eligible to serve. And also as well, no one needs to be excused at this point for statutory reasons. Please raise your hands by answering yes to the following questions. Are you at least 18 years of age or older?
Yeah.
Every hand should be raised unless you're 17. Please raise those hands again, keep them up so I can actually see them. For the record, the prospective jurors have answered yes to the question. Are you citizens of the United States of America? The record, the prospective jurors have raised their hands and response is yes. Are you residents of Leon County, Florida? Once again, the prospective jurors have raised their hands yes. Do you possess driver's licenses or identification cards that were issued by the Department of Highway Safety and Motor Vehicles, or have you executed an affidavit as to your eligibility to serve as a juror? Once again, the prospective jurors have raised their hands in the affirmative. If your answer is also yes to any of the following questions, please raise your hands as well. Has anyone ever been convicted in any state or federal court of any felony crime or a crime of dishonesty, and you have not had your civil rights restored? None of the prospective jurors have answered in the affirmative to that question. Is anyone at the present time under any prosecution for any crime in either a state or a federal court? None of the prospective jurors have raised their hands in the affirmative. The next set of questions that I'm going to go through with you are bases for which someone can be excused from jury selection based on their status. If your answer is yes to any of the following questions, please raise your hand. Is anyone a full-time sworn federal, state, or local law enforcement officer or investigative personnel? No hands have been raised in response. Is anyone an expecting mother or parent responsible for the full-time care of a child that is under 6 years of age? No hands have been raised in response. Is anyone 70 years of age or older? No hands have been raised in response. Has anyone performed state jury service within the past calendar year? And I'm referring to August 20th, 2024 to the present. No hands have been raised in response. Is anyone responsible for the full-time care of a person with a physical or mental incapacity who is incapable of caring for themselves, and you being present here is creating a hardship for them? No hands have been raised in response. Is anyone a full-time student between the ages of 18 and 21 years of age who is attending high school, any state university, private post-secondary educational institution, Florida college system institution, or career center. No hands have been raised in response. And finally, the last question. Has anyone given birth within the 6 months before the reporting date on your summons, which would be today? No hands have been raised in response. The first thing that we're going to do this afternoon is discuss what you may know about this case. This case has received publicity, and there also was a related case that took place about 2 years ago. This process is going to be handled individually because you don't need to know what others may know concerning this case. However, before we start the questioning, I need to give you some very important instructions. Many of you have cell phones, computers, and other electronic devices. Even though you have not yet been selected as a juror in this case, there are some rules that you must follow about using your cell phones, electronic devices, and computers from this point moving forward. You must not use your phones or devices to search the internet or to find out anything that is related to this case. Between now and when you have been discharged from jury duty, you must not provide or receive any information about your jury service to anyone, including your friends, coworkers, and family members. You may tell those who need to know duty. If you are picked for the jury, you may tell people that you have been picked and how long the case may take. However, you must not give anyone any information about the case itself or the people that are involved in this case. You also must warn people not to try to say anything to you or write to you about your jury service or about this case. This would include face-to-face phone and computer communications. In this age of electronic communication, I want to stress that you must not use electronic devices or computers to talk about this case. This includes tweeting, texting, blogging, emailing, posting information on a website or chat room, or any other means at all. Do not send or accept any messages, including emails and text messages, about your jury service. You must not disclose your thoughts about your jury service or ask for any advice on how to decide the case. Further, you must not read nor listen to any news accounts about this case until you have been excused. Avoid the newspaper and television broadcast, particularly the local news stations. Also, avoid social media or any internet news sites. I am now going to provide to you a statement of the case that has been agreed upon by the parties. On July 18th, 2014, FSU College of Law professor Dan Markell was shot while seated in his car. This happened in the driveway of Markell's home on Trescott Drive in the Benton Hills neighborhood. The killers traveled to Tallahassee from Miami to commit the murder in a rented silver green color Prius. The defendant and alleged conspirator in this murder was the former mother-in-law of Dan Markell. She has entered a plea of not guilty. I will also now read to you from the material part of the indictment that has been filed against the defendant. Count 1. It is alleged that on or about July 18th, 2014, Donna S. Adelson in the county of Leon and state of Florida did unlawfully kill a human being, Daniel Markell, by shooting with a firearm, and the killing was perpetrated from or with a premeditated design or intent to effect the death of Daniel Markell. This is contrary to the Florida statutes. Count 2. It is alleged that beginning in 2013 until October 1st, 2016, Donna S. Adelson in the county of Leon and state of Florida did agree, conspire, combine, or confederate with Charles Adelson and or Catherine McBanawa and or other persons to commit first-degree murder contrary to the Florida statutes. Count 3. It is alleged that beginning in 2013 until October 1st, 2016, Donna S. Adelson in the county of Leon and state of Florida did solicit another to commit first-degree murder, and in the course of such solicitation, commanded, encouraged, hired, or requested the person, Charles Adelson and or Catherine McBanawa and or other persons to engage in specific conduct which would constitute first-degree murder, which resulted in the death of Daniel Markell, contrary to the Florida statutes. The statement of the case and the indictment that I have just read to you are not evidence, nor are they to be considered as evidence or any proof of guilt. You must not be influenced by the statement or the fact that an indictment has been filed in this matter. It is merely informing you of the accusations that have been made by the state against the defendant. We are now going to talk to each of you individually and privately about this case. Some of you may be excused at this point in the jury selection process. Others will be told when to return tomorrow. Individual voir dire is time-consuming, but will go a lot smoother if you are prepared to tell us what we need to know. These are the basic questions that you will be asked, or some variation thereof. What do you know about this case? What sources have you obtained this knowledge from? Based on what you know, do you have an opinion about Mrs. Adelson's guilt or innocence? Can you set aside your present knowledge, disregard it, and render a verdict solely on the evidence presented in the courtroom? Can you be fair and impartial? Do you have any reason that you cannot serve on the jury for up to 3 weeks? It will save us all a lot of time if you think about these questions and you are prepared to give a prompt answer when we call you back. We are also going to discuss with you individually the time period that is involved with this trial. We expect the jury selection process to last until Thursday of this week. After that process is complete, we expect the trial to begin on Thursday and to continue.
Boom, boom, there it is. There it is. The Adelson case starts tomorrow. You know how you have to listen to the same words every time? It's because you're listening for the nugget of gold. There it is, ladies and gentlemen.
Time period that is involved with this trial.
Right.
Discuss when we call you back.
Ladies and gentlemen, let me do the recording. There it is. Let me do the recording for the towel friends. Let me get everything set up here. Hold on 1 second, little towels. Hold on 1 second. All right, here we go. Let me do the recording. Hello. Hello, towel friends. My name is Grant Smith Ellis. If you missed it, we have just had the announcement. I'm going to play it for you right now. The Donna Adelson and Dan Markell trial will be starting, ladies and gentlemen, tomorrow, Thursday, August 21st. It is now moved up from the expected start date on Friday, August 22nd. It is now starting tomorrow, probably in the afternoon. Thursday, August 21st, ladies and gentlemen. Opening statements expected tomorrow. I'm going to let you listen to the announcement right now. Just right now it came in, ladies and gentlemen, about an hour ago. The announcement from the judge presiding over the case that the trial will indeed be starting tomorrow, ladies and gentlemen. Here we go. Take a listen to it right now. My name is Grant Smith Ellis. Here is the confirmation.
We are also going to discuss with you individually the time period that is involved with this trial. We expect the jury selection process to last until Thursday of this week. After that process is complete, we expect the trial to begin on Thursday and to continue for the next 2 weeks. In all total, we expect that these proceedings from today will take up to 3 weeks. We understand that that is a burden for anyone to serve for that length of time.
There you go, ladies and gentlemen. You heard it right there. trial for Donna Adelson regarding the conspiracy murder of Dan Markell, the former husband of Donna's daughter, Wendy Adelson. Of course, Wendy has not been charged in Dan Markell's murder. All eyes on whether Wendy will be indicted for that murder. But Wendy's brother, Charlie Adelson, already convicted in jail right now in South Dakota for his role in that murder. That would be Donna's son, Charlie. And then, of course, Katie Mogbonowa, Charlie's former girlfriend, also already convicted and in jail related to her role in contacting a former boyfriend of hers, who then contacted two hitters or killers from the Latin Kings, who then murdered Dan Markell after driving up from one area of Florida to another, I believe from Orlando to Tallahassee or Miami to Tallahassee, in a green Prius, and then they shot Mr. Markell in his driveway. He did not die. He was unable to speak. He suffered for 24 hours or so and then died the next day from his wounds. And it is alleged this was conspired, this murder, by the Markell family, because as Dan Markell and Wendy Adelson were divorcing, Wendy wanted to move the kids and relocate them, and Dan did not want that, and that caused the Adelson family to proceed to murder Dan Markell via hitmen connected with the Latin Kings. Donna Adelson is, of course, the fifth trial. As I mentioned, Charlie, Katie, and two others, Luis Rivera and one other hitman, were already convicted. Donna is now the fifth trial. There's actually one trial was done twice, Katie's, I believe, but this is the fifth trial. It is now scheduled to start tomorrow in Florida in the afternoon, ladies and gentlemen, Thursday, August 21st, 2025. There's a number of expected witnesses against Donna, including some of her friends. Wendy Adelson will be testifying against Donna. Wendy Adelson moved to quash a subpoena from Donna's defense team. Wendy Adelson will only testify in this trial for the state against Donna with a grant of immunity, limited immunity, use immunity for this trial only. Wendy's had in other trials as well, but Wendy will not testify under subpoena by Donna Adelson's defense team, but although Donna will be able to engage in a narrow scope of certain cross-examination that the judge will determine on a case-by-case basis whether it will pose any potential of going into an area where Wendy would have to invoke the fifth, and then the judge will not allow any questions where that could even be a possibility. So we are going to see a lot of developments, ladies and gentlemen, in the next few days, including, as you just heard, the start of opening statements in the Donna Adelson trial tomorrow, August 21st, Thursday, 2025, in the afternoon. My name is Grant Smith Ellis. Tune in live, youtube.com/@GrantSmithEllis, x.com/@GrantSmithEllis from 8 a.m. tomorrow, where we will watch the end of jury selection, which will probably be panel voir dire, and then we will go right into opening statements. I'll have wall-to-wall coverage. Thanks very much for listening to this clip, and thank you for supporting public information services. Feel free to do so by subscribing, liking the channel, etc. Anything you can do will help. My name's Grant Smith Ellis. All right, folks, I made the clip. There it is. You heard it right there, little towels. You heard it from Judge himself. We are moving to the Donna Adelson trial tomorrow, ladies and gentlemen, Thursday afternoon. So, with that said, we are going to watch the opening from the Charlie Adelson trial. I mentioned we would watch it earlier, so that is exactly what we're going to do. Give me 1 second here. All right. Charlie Adelson trial prosecution opening. That's what we're going to watch. After this, we're going to place our final rounds of towel trivia. Then I'm going for a walk. 52 minutes, folks. Next towel trivia round taking place at 5:10. Then we're closing up for the day after that. So here we go. And just as a reminder, before we begin the opening, I didn't get through all your towel trivia scores. Let me do it quick here.
Let's get right to it.
Oh, hold on. I know that the prosecutor wants to get right to it. I don't doubt that. But here's your towel trivia scores. We're going to play in 52 minutes. So next round, 5:10, ladies and gentlemen, p.m. Next round, towel trivia. First place, Towel, 22 points, but I'm barely holding off Jill Towel, 21.5 points. Steph Towel in third, 20.5 points. Fourth place, Allie and Bo, 16.5 points. 15th, fourth place tie, 16.5 each, actually, Allie and Rue and Elijah Towel. Fifth place, Nancy Towel and Sunken Grave, both tied with 14 points. Sixth place, Holistic Psychology, 13.5. Seventh place, Vicky Towel with 10. Eighth place, Paula Towel and Bossy Texas Chicken Bella in a tie, 4.5 points each. Ninth place, Jack D65 with 4 points and 9 billion bonus points for being a super towel, tied with Peggy Towel with 4 points as well. 10th place, Colleen Henry and Buck Towel, 3.5 points. And 10th place, Nunya Towel, 1.5 points, a position of honor. All right, folks, bringing up the state opening in the Charlie Adelson case, and you know what that means, ladies and gentlemen. It is just 50 minutes until our next round, our final rounds of Towel Trivia, taking place at 5:15 p.m., ladies and gentlemen. 5:15. So now state opening from the Charlie Adelson trial. And then, hold on one second. And then Towel Trivia, 5:15 p.m. Eastern, ladies and gentlemen. Final rounds of Towel Trivia, 5:15 p.m. All right, take it away.
Let's get right to it. The reason that we're here today is because the defendant in this case, Charlie Adelson, hired a hitman to kill his former brother-in-law, Dan Markel. This murder was set into motion because back in 2014, the defendant's family, the Adelson family, had a big problem. And that big problem was Dan Markel. And the solution to that problem was this defendant. This defendant was the solution to that problem because he had a girlfriend with connections to the type of people who were willing and capable of pointing a gun at a complete stranger and pulling the trigger. The victim in this case was known as Danny to his friends and family. He was a loving father to 2 little boys. He was a highly respected professor at Florida State College of Law. And tragically, on July 18th of 2014, Dan Markel was shot twice in the head in broad daylight in the driveway of his home in the Benton Hills neighborhood here in Tallahassee. The last day of Dan Markel's life that day began like any other of his mornings that summer. He woke up, he drove his 2 little boys to preschool and dropped them off, and then he drove over to the gym to work out. After finishing his workout, he returned home. He pulled in his driveway, opened his garage, but little did he know that throughout his just normal routine that morning, he was being followed. He was being followed by 2 hired hitmen who traveled all the way from Miami to Tallahassee for the sole purpose of murdering him. And just like something out of a horror movie, he pulls into his driveway and the car that, unknown to him, pulls in right behind him. Moments later, Dan Markel's neighbor heard a gunshot. He looked out the window and he saw a light-colored Toyota Prius backing quickly out of Dan Markel's driveway and then speeding away. The neighbor waited for a couple minutes to see if maybe Dan Markel came out of his house or backed out of his driveway too. And when nothing happened, this neighbor got that funny feeling that maybe something could be wrong here. So he walked over, and what he found was a gruesome scene. He walked in the garage and saw that the driver's side window of Dan Markel's car was shattered. He saw Dan Markel was still behind the wheel. He was alive, but he was moaning, he was unresponsive, and he was terribly injured. The neighbor then goes and calls 911. Law enforcement arrives, and they find Dan Markel unresponsive with gunshot wounds to his head. He was then taken to the hospital where he survived for several hours before he was actually pronounced dead. Dan Markel was 41 years old, and his little boys that were deprived of their father that day were just 3 and 4 years old. Law enforcement immediately began to investigate to figure out who shot Dan Markel. And the evidence they find sets them down 2 separate paths. One path is that they had to track down that light-colored Prius that the neighbors saw fleeing from the crime scene and identify who was inside that Prius. And the other path relates to Dan Markel's personal life. They looked to see who, if anybody, in Dan Markel's personal life would hate Dan Markel enough to kill him. And after years of tireless investigation by law enforcement, both of these 2 paths led directly to this defendant. So let's talk about the path involving Dan Markel's personal life first. In looking at who might have a motive to kill Dan Markel, law enforcement learned that Markel was entangled in a very nasty divorce with his ex-wife, who is the defendant's sister. Her name is Wendy Adelson. A review of their divorce case file revealed that Wendy Adelson asked the court to allow her to move back to Miami, where she was from, with the kids, in order to be near her parents, whose names are Harvey and Donna Adelson, and her brother, the defendant. Dan Markel was adamantly opposed to his children being relocated to Miami. He was a law professor here in Tallahassee. This is where he lived. This is where his kids have been raised. He wanted his kids to live here with him. And for this custody dispute, the judge ended up ruling in Dan Markel's favor. So Wendy Adelson was not permitted to move to Miami with the children. Unless, of course, something happened to Dan Markel. A review of Wendy Adelson's emails revealed that her mother, Donna Adelson, hated Dan Markel and was desperate to find a way for Wendy and her children, who were Donna Adelson's grandchildren, to be able to move to Miami. Donna Adelson suggests in these emails that y'all will hear about several ways that Wendy Adelson could threaten or bully Dan Markel into submission, into getting what she wanted him to do. Donna Adelson even suggested offering Dan Markel a $1 million bribe to allow the relocation, and even said that this defendant, Charlie Adelson, would pay 1/3 of that $1 million bribe to Dan Markel to make that happen. The evidence in this case will show that Donna Adelson's closest confidant was her son, the defendant. She and the defendant talked multiple times a day, every day. He was the person with whom she would constantly vent and complain to about Wendy's situation. The defendant was also the person that Donna Adelson relied on to solve her problems. And this was a big, big problem for Donna Adelson. And she made it the defendant's problem to solve. So the divorce between Wendy Adelson and Dan Markel was final about a year before the actual murder. But that was not the end of that case. Litigation was ongoing, to say the least. Each side would continue to routinely file violations of the custody agreement, violations of the settlement agreement, and that continued right up until Dan Markel's death in July of 2014. This was a highly emotionally charged situation between them leading up to his death. However, there was no physical violence that Wendy Adelson needed to be rescued from or anything like that. But make no mistake, this was a very messy custody dispute. Shortly before the murder, in fact, Dan Markel, victim, filed with the court and basically asked the court, he alleged Donna Adelson was disparaging him to his children by saying bad things about him. And he asked the court to enter an order preventing Donna Adelson from having unsupervised contact with her grandchildren. This motion was still pending in court when Dan Markel was killed. The murder of Dan Markel ensured that an adverse ruling on his motion would never be a problem for the Adelsons. And just about 48 hours after the shooting, Wendy Adelson and the little boys relocated to Miami. Shortly thereafter, moved into a home within walking distance of the Adelsons' Miami home. Within a year of Dan Markel's murder, Wendy Adelson legally changed Dan Markel's son's last name from Markel to Adelson. And just like that, their father was just effectively erased from their life at 3 and 4. And the Adelsons family, their big problem had been solved. You'll hear during this trial that the Adelsons are a very tight-knit family. The defendant and his parents, Harvey and Donna Adelson, they actually even all worked together at the Adelson Institute, which was their family's dental practice. At the Adelson Institute, the defendant and Harvey Adelson were dentists, and Donna Adelson managed the office. After Dan Markel was killed on July 18, 2014, law enforcement interviewed Wendy Adelson. And Wendy Adelson acknowledged that her family had a motive to kill Dan Markel, or to want him dead. She admitted that her brother, the defendant, had even said that he looked into hiring a hitman to kill Dan Markel as a divorce present to her, but he decided to buy her a TV instead because it was cheaper. And coincidentally, or not, that TV that this defendant bought his sister as a divorce gift instead of hiring a hitman would be Wendy Adelson's alibi for the morning of the murder when the victim was killed by a hitman. So this path of looking into Dan Markel's life to see who would have a motive to want him dead leads law enforcement to the Adelsons, including this defendant, a man who told his family that he'd looked into hiring a hitman to kill Dan Markel. The defense asked yesterday in jury selection, who's talked trash or heard somebody talk trash about an in-law, which is not a rare concept. A lot of people don't like their in-laws. But the difference here is that the defendant's comment stopped being just a little bit of trash talk when Dan Markel was actually killed by a hitman. While the police are trying to investigate, who in Dan Markel's personal life may have a motive to kill him, they're simultaneously going down that second path I described to y'all, which was tracking down the vehicle that the neighbor saw fleeing the crime scene. When law enforcement retraced Dan Markel's steps the morning of the murder, they uncovered some chilling surveillance video of a Prius fitting the description of the one seen by the neighbor, following Dan Markel into the Premier Gym parking lot, waiting for an hour while he was inside, and then following him home from Premier Gym back to his neighborhood. They got these surveillance images from city buses, from Premier, from everywhere they possibly could. And these surveillance images, coupled with a massive amount of phone data and SunPass records gathered in this case, helped police to eventually track down the exact car used in this crime. But police still had to figure out who was in the Prius and why did they kill Dan Markel. As part of this really painstaking review, that law enforcement did of all of these records. And when I say painstaking, finding this Prius and finding all of this evidence and all of these records was not an easy task, and it took longer than your average investigation. It was very difficult to do. They combed through tons of phone records and even did what's called a tower dump, which is where law enforcement collected a list of all of the cell phone numbers that communicated with the cell tower that serviced different spots in Tallahassee that Dan Markell was at that morning, including Premier Gym, when the suspect's Prius were there. Because they thought if the person in the Prius was using their phone at the time, then their number will be somewhere in this tower dump. They combed through all of that data, and they found a number with a Miami area code belonging to a man named Sigfredo Garcia. Law enforcement examined all of Garcia's call logs and saw that he was in frequent contact with another number that was also present at Premier Gym that morning. And that number belonged to a man named Luis Rivera. Luis Rivera is a lifelong friend of Sigfredo Garcia and is also from Miami. Police then looked at all of Garcia and Rivera's phone records, which showed that their phones left Miami about 2 days before this murder, on July 16th of 2014. The phones came to Tallahassee, and on the day of the murder, July 18th, they followed Markell to Premier Gym. The phone data is consistent with both men turning off their phones just minutes before the murder and leaving their phones off until about an hour or so after the murder, when they're well on their way back towards Miami. And then a bank's ATM camera caught both Garcia and Rivera in that light-colored Prius once they arrived back in the Miami area when they stopped at an ATM. So, police figured out the identity, and this should appear on the screens in front of you. The identity of the two men responsible for following and killing Dan Markell. Luis Rivera, his nickname is Tato, and Sigfredo Garcia, his nickname is Tudo. But they continued to look for evidence of why two seemingly random men came all the way to Tallahassee to kill a man, Dan Markell, that they'd never met. What or who is the connection between these killers and the victim? Well, phone records reveal that one of Sigfredo Garcia's most frequent contacts was a woman named Catherine McManua. Her nickname is Katie. Garcia and Catherine McManua have a long history of an on-again, off-again relationship over the course of many years, and they actually share 2 kids in common. And lo and behold, when looking at the phone records, Catherine McManua is also one of the most frequent contacts of this defendant, Charlie Adelson. Law enforcement learned that at the time of Dan Markell's murder, this defendant was dating Catherine McManua. She was his girlfriend at the time. So Dan Markell was a problem that this defendant needed to solve for his family. The defendant was looking to hire a hitman to kill Dan Markell. Dan Markell ends up being killed by a hitman. And who ended up being the hitman? It was someone with a close relationship to this defendant's girlfriend. The hitman was the father of his girlfriend's children. So you can see how both leads in this case, followed by investigators, both of them charted paths to this defendant. Not only did looking into the motive lead law enforcement to the defendant because he wanted to hire someone to kill Dan Markel, but looking into the car, fleeing the scene, also led law enforcement to the defendant through his girlfriend at the time. So 2 different investigations arriving at the same conclusion. Law enforcement also tried to follow the money in this case, and that was a third way that the evidence in this case points to this defendant. Law enforcement reviewed bank records, employment records, DHS-MV records of all of the suspects and saw that in the months after the homicide, Sigfredo Garcia, Luis Rivera, and Catherine Magbanua all acquired some big ticket items. Rivera and Garcia both bought motorcycles and cars. Catherine Magbanua got a breast augmentation surgery and later received a black Lexus sedan whose previous owner was Harvey Adelson. Catherine Magbanua's bank records were analyzed, and there was no check ever written or matching cash withdrawal for the car or the breast augmentation, which was paid for in cash. Bank records also showed that Catherine Magbanua's account had a huge spike in cash deposits right around the time of the murder. She deposited more money into her account in the 5 weeks following the murder than in the entire previous year before the murder. This was during a time when there was no record of her being employed anywhere. Also, about 2 months after the murder, the defendant added Catherine Magbanua to the payroll at the Adlesen Institute. And she began receiving regular checks from their business account every 2 weeks for 2 years after the murder. And this was despite the fact that she did not work at the Adlesen Institute. So, the money was talking, but what were the suspects saying? That's what law enforcement wanted to know. So, as they're examining the phone records in this case, they see a distinct pattern surrounding important events and dates in this case. The phone calls, and they can't see the content, they can't hear the content of these calls in these phone records, but they see that the calls are occurring. And the phone calls always went from Donna Adelson to the defendant, then from the defendant to Catherine Magbanua, then from Catherine Magbanua to Sigfredo Garcia, and back the other way. Kind of like train cars, they only touch the car right in front of them. You know, Donna Adelson never calls Catherine Magbanua or Sigfredo Garcia. Charlie Adelson never calls Sigfredo Garcia, or vice versa. So if this is a murder for hire, as law enforcement suspects, could it be that the defendant was wisely insulating himself from the actual shooters by having Catherine Magbanua act as a middleman between them? Law enforcement decided to launch an undercover investigation designed to clarify who the members of the conspiracy were and how information traveled within this conspiracy. So police applied for and received court authorization to listen in real time to the phone calls of the defendant and Catherine Magbanua. And this is what's known as a wiretap. By this point, the point that the law enforcement received authorization to do this wiretap, it was April of 2016. So it's been not quite, but almost 2 years since the murder of Dan Markel, which occurred in July of 2014. So by April of 2016, the defendant and Catherine Magbanua are no longer dating at that point. They'd been broken up since the fall of 2014. Catherine Magbanua is actually back together with Sigfredo Garcia, the father of her children, at that point. The defendant has moved on to many other girlfriends since Catherine Magbanua, but the defendant and Catherine Magbanua are still in regular communication and have remained very close friends since the murder. And Rivera, who was the second hitman in that Prius, he, in April of 2016, was actually in federal prison doing time on another charge unrelated to this murder. So all of the members of this conspiracy have presumably gone on with their lives, believing they've gotten away with this murder. So even though law enforcement has authority to listen to their calls now, what reason would these people have to still be discussing the murder at this point? So police needed to stage an event that would generate conversation between the conspirators about the murder. And the plan was to send an undercover agent posing as somebody on behalf of Luis Rivera, who was incarcerated, to walk up to Donna Adelson on the street and try to extort money out of her. And law enforcement refers to this as the bump. So this undercover agent walks up to Donna Adelson one day as she's leaving the Adlesen Institute during the day. The undercover agent hands Donna Adelson a piece of paper, and on the piece of paper is an article about the murder of Dan Markel with his picture on it and, FSU professor killed. Also on the piece of paper are a phone number and the amount of $5,000. The undercover agent tells Donna Adelson that he knows that the Adelsens are taking care of Katie, and he's there to extort money out of her on Rivera's behalf in order to even things out. The undercover agent never says the defendant's name or anything about the defendant's involvement to Donna Adelson. Then law enforcement listens to see what will happen next. Will Donna Adelson go straight to the police to report this extortion attempt, or will something else entirely happen? As suspected, based on the previously observed communication pattern, the first person that Donna Adelson calls after the bump is the defendant, despite the fact that the undercover agent never mentioned the defendant to her. On that first call, one would think that Donna Adelson would say to her son, it's so crazy, some man came up to me and he's handed me this article about Danny's murder, and he's seems like he's demanding money from us. She never says any of that. In fact, she never says Dan Markel's name at all. Instead, she tells the defendant that she needs to talk to him in person, not over the phone, about some paperwork that was hand-delivered to her. She said that this paperwork, she says this to the defendant, it involves the two of us, and that he should know what she's talking about. She says that he should bring cash to their meeting. And she also says that this TV is about 5. Donna Adelson tells the defendant that the man who approached her mentioned an ex-girlfriend. Donna Adelson never says which ex-girlfriend she's referring to. She never says Catherine Magbanua or Katie's name to the defendant in that phone call. She only says that the blackmailer mentioned an ex-girlfriend. The defendant never asks his mom, whose ex-girlfriend? My ex-girlfriend? Which ex-girlfriend? He never asked that. Because as the evidence will show, he didn't need to. He knew that this TV is about 5 meant that she was being blackmailed about Danny's murder for $5,000. And he knew that the ex-girlfriend in question was Catherine McBanois. And we know that because after this call with his mother, who's the defendant? The defendant calls Catherine McBanois. He doesn't call his most recent ex-girlfriend. He doesn't even call the most recent ex-girlfriend before the most recent ex-girlfriend, the one before that. No, he calls Catherine McBanois. And his call to Catherine McBanois is the only call that he makes to any ex-girlfriend after getting the information from his mother that the blackmailer mentioned an ex-girlfriend. And he had not dated Catherine McBanois for 1.5 years at that point. And although the defendant threatens to do it often, neither he nor his mom ever report the matter to the police. The only people that he discusses it with on these calls is Donna Adelson and Catherine McBanois. And you'll hear these phone calls between the conspirators, and as you listen to these calls, y'all will notice that they are being cautious about what they say over the phone. It's very apparent that they are very careful with their words because they are immediately suspicious that law enforcement could be listening to their conversations. So Donna Adelson calls the defendant, and the defendant's first call is to Catherine McBanois. After that, the defendant then meets up with his mom in person, like his mom requested, and his mom gives him this paperwork that the undercover agent gave her. Then next, the defendant and Catherine McBanois meet up in person, and they meet up at a restaurant in Miami called Dolce Vita. And while they sat at their table in this, Dolce Vita is a busy, noisy restaurant, an undercover FBI agent sat at a table nearby with a hidden camera in their bag and recorded this conversation. And in the recording, we hear the defendant discussing whether the man who walked up to his mom could be an undercover police officer or someone who's trying to blackmail them. And if it's the latter, if it's a blackmailer, is it somebody who's just trying to make a quick buck, or is it somebody who actually knows information from the inside? The defendant reassures Catherine McBanois that if it is the police, that's a good thing. The defendant thinks that if it's the police, that means that they do not have enough evidence to charge anybody. In fact, the defendant tells her, if they had any evidence, we would have already gone to the airport. The defendant starts giving her some legal advice. He says that, hey, in order to prove that someone committed a crime, you have to be able to put the person at the scene of the crime at the time it was committed, which unfortunately for them is not an accurate statement of the law.
Correct.
It's important to note too, at the time of this conversation at Dolce Vita, no arrests had been made. The only thing that police had released to the public was a photo of the Prius that fled the scene. This was the Prius that Garcia and Rivera rented and used the day of Dan Markel's murder. So police knew at that point that it was Garcia and Rivera who were in the Prius, but the public did not know that yet, and no arrests had been made because they wanted to do this undercover investigation. And so the fact that this photo of this Prius had been released to the public is interesting in light of some of the things that y'all will hear the defendant say to Catherine McBanois in the Dolce Vita recording. He starts giving Catherine McBanois several analogies, all involving rental cars used to commit crimes. He reassures her that, hey, if DNA is found in a car, all that means is that at one point the person sat in the car. And if that car was later used in a crime, police can't prove that just from a person's DNA being in the car. The defendant points out to her that if a rental car is found that was at a crime scene, police also have to prove who was driving it at the time. he gives her a very relevant hypothetical of her renting a car in Miami and someone asking to borrow it and driving to Orlando to commit a robbery, and how she would be innocent in that hypothetical because she wasn't in the car at the time of the robbery. So through these analogies, the defendant is reassuring Catherine McBanois that even if police identify who rented the car that fled the scene, they still would not have enough evidence to hold anybody responsible for the murder, even if they did find out it was Garcia and Rivera. The defendant also says that crimes are tough to prove unless someone actually witnessed the suspect commit a crime, or a suspect makes a confession, or a suspect is caught on a wire talking about the crime. So the defendant's trying to reassure her about the lack of evidence. And hey, as long as we all stay quiet, then we don't have anything to worry about. At one point, the defendant asked her, "Let me ask you a question." And then he asked her about money. He says, "When everybody was there the next day, did you take any money? Like, are any of you driving around in a Bentley? Or no, it's not like any of you are driving around in a Bentley or cruising around in a mega yacht." So here the defendant's pointing out that the money wasn't used to buy anything flashy that would draw the attention of the police. And when discussing, and you all will hear during the course of this trial why his statement or his question about the money from the next day is particularly important. The evidence will show that Catherine McBanois went to the defendant's home the night of the murder, where he paid her in cash. And the next day, Catherine McBanois paid Garcia and Rivera their cuts of the money. When discussing the possibility of whether this is actually some gangster trying to blackmail his family for money, the defendant says that whoever this person is, whoever it is, knows information. The defendant told Catherine McBanois that there are two ways of dealing with this guy. They could call the police, but then the guy blackmailing them would be charged with trying to blackmail his family. And the blackmailer would start talking, and he would start calling out Catherine McBanois's name. And then police are going to be asking questions about what happened. The other option is to pay the blackmailer, but let him know that this is a one-time thing, and try to scare the blackmailer off by saying, "Hey, if you come around again, we're going to the police." So the defendant then gives Catherine McBanois very precise instructions. He wants her to call the blackmailer and tell him that, this would be what he wants Catherine McBanois to say. "My friends," meaning the Adelson family, "have no idea what you're talking about. And I don't have any idea what you're talking about either. But the name of the person who you said is incarcerated sounds familiar. So I'm going to give you this money as charity to help the less fortunate. But don't contact these people again, or they're going to go to the police." And the defendant said he would give Catherine McBanois the $5,000 to pay off the blackmailer, except he's concerned, though, that this won't resolve the issue for good. The defendant is worried that this guy is not going to go away, that he's going to keep coming back for more and more money. And the defendant offers a solution to have this blackmailer killed. And he says he's willing to pay whatever it takes. The defendant tells her that, this is the defendant talking to Catherine McBanois, "This guy," meaning the blackmailer, "is effing with him and his wife. And you'd better kill him or he's going to be a big problem because he knows who you are." And the defendant then says, "If he can't handle this, I'll have somebody else do it." The defendant says, "So help me God, if they fuck with my family, it's going to be Nazi shit because this will be done. I mean, Katie, I don't care what I spend." It's important to note during this conversation and the entire wiretap, the defendant never says Sigfredo Garcia's name. But the evidence will show that the defendant was talking about Sigfredo Garcia when the defendant says that the blackmailer was effing with him and his wife. And if he can't do it, I'll find someone else who will. Because immediately after that, the defendant checks with Catherine Magbanua to make sure that Garcia has no hard feelings towards him, no reason not to help him. He says, hey, I have you on salary. You think he'd be happy about that? And he also says, I mean, our paths never crossed, meaning, hey, Garcia wasn't in the picture when he and Catherine Magbanua were together. There wasn't any overlap. After hearing that the defendant wants someone killed and is willing to pay whatever it takes to get it done, Catherine Magbanua then asks the defendant to help her out. And the defendant reassures her that she'll be taken care of by saying, he says, I don't have to. Sometimes those chairs can be a little wobbly. I know this is taking a bit, but I'm almost done. Thank y'all for being patient. All right, so she asks him to help her out. And the defendant reassures her that she'll be taken care of. He says he doesn't have to tell her the things that he'll do for her. He shows her what he'll do for her. She doesn't have to ask him for anything. He looks for things to do. He says, hey, when someone's birthday's coming up or there's car problems, she doesn't have to ask. He looks for ways to help. And after his meeting with Catherine Magbanua, the defendant immediately calls Donna Adelson to let her know that everything's fine. And he does this using some pretty obvious code words, which y'all will hear, and you'll hear the conspirators often use words to mask the meaning of what they're actually talking about. Catherine Magbanua then, also using these code words, tasked Garcia with calling the number on the paperwork and finding out if a blackmailer is a legitimate associate of Rivera or not. And in the series of recorded calls that follow, you guys are going to hear these conspirators talking and using words like TV, false leads, listings, properties, clients, rap songs, CDs, pot-bellied pigs, relationship advice, all these different terms that are normal terms any of us may use, but they're used in context in these calls that, if you're listening to the conversation, do not make any sense. For example, in the calls, the defendant and Catherine Magbanua don't outright debate the pros and cons of whether they should pay this blackmailer. Instead, they talk about the fact that this property is cheap. They might expect a property like this to even be $1 million. This property seems like a great deal, but if you get the wrong tenant in there, the tenant may keep increasing the rent, and that tenant may become a leash that never leaves you. So it will be up to y'all to decide whether this defendant is actually worried about a future tenant of a property that might raise the rent and pay him more money, or if the defendant is actually worried that if he pays off the blackmailer, then the blackmailer may continue to come back again and again, or send a cousin or a friend to become a leech that never leaves him, that he can't get rid of. In another of these calls, the defendant tells Catherine Magbanua that whoever this person is, this blackmailer is, he's got a lot of effing details. And in another, they discuss the fact that this blackmailer is not from the inside. And the defendant says that this guy is probably not from the first layer, but the second layer. So not someone who got info from Garcia, but maybe somebody who got info from Rivera. But one fact, and let me just say, as the jury, you all will interpret and decide what they're really talking about in these calls. Only y'all can determine the meaning and the weight to give this evidence, and only you can separate just mere coincidences from evidence in a conspiracy. But one fact, though, is really clear throughout these calls, is that all of these conspirators are hopeful that this blackmailer is law enforcement just trying to get information, because they think if it's law enforcement and the police don't have enough to bring charges, just fishing for information versus the other possibility, which would obviously be much worse for them, that the Adelsens are being blackmailed by somebody who actually knows inside information about their roles in Dan Markel's murder and may tell the police what they know. So, after this undercover operation, which was in 2016, Luis Rivera, Sigfredo Garcia, and Catherine McVanois are arrested. They're charged with the same charges before y'all in this trial. And Luis Rivera ended up cutting a deal with the state to tell law enforcement the truth about the murder of Dan Markel and the people responsible. Rivera told law enforcement that he was hired by Sigfredo Garcia to help kill Dan Markel. And Rivera described how Garcia told him that Catherine McVanois, the mother of Garcia's children, secured this job for them. And the job was in Tallahassee, and it paid $100,000, with Rivera's being about a third of it, $35,000. Rivera explained that he and Garcia actually made 2 trips to Tallahassee with the intent of killing Dan Markel. The first one was a month before the murder. It was in June of 2014. And the second was when Dan Markel was actually killed in July of 2014. Rivera said that he bought a gun off the street for that second trip, and Garcia rented a car. For the June trip. Rivera bought a gun off the street, and Garcia rented the car for that trip. Garcia and Rivera did some scouting on that trip of Dan Markel's residence, some surveillance, but ultimately couldn't get the job done. They ended heading back to Miami. During the trip to Tallahassee, he said that Garcia had a piece of paper with a picture of the man that they were supposed to kill on it, and some handwritten notes as well. Cell phone records corroborated Rivera's information about the June trip. Rivera also told a story about an incident in Tallahassee where he and Garcia were riding down the road in the rented Prius, and Garcia accidentally discharged the murder weapon, and the bullet struck the floorboard of the Prius. Law enforcement tracked down that actual Prius again and were able to see evidence in the undercarriage that corroborated Rivera's information about the accidental discharge. So they're looking at the phone evidence, they're trying to find whatever they can to kind of corroborate what he's telling them. I mentioned earlier that both men, Garcia and Rivera, cut their phones off from the time that they left Premier and kept them off until well after the murder when they're on their way back home. Rivera said that the first call that either of them made after the homicide was from Garcia to McVanois, where Garcia told her that the job was done, and McVanois assured them that they would get their money the next day, which they did. Rivera says when Catherine McVanois brought cash to him at his home. And all this information that Luis Rivera provided them was corroborated by, including when the money was dropped off, was corroborated by cell phone records in this case. Luis Rivera told police that the next day after the murder, he was paid in cash by Catherine McVanois, and that the money was packaged in a very unusual way. The money was in stacks of $100 bills, and the money was stapled together. The stacks of 100s, every $1,000 was stapled together. During this trial, y'all will hear that the defendant had access to a lot of cash, and nothing's wrong with that. He had a lot of cash because his family gives cash discounts at their dental practice, and he keeps the cash that he receives in a safe. Again, nothing wrong about that either. However, what is relevant in this case is that the defendant had a very unusual practice of keeping the cash in his safe in $1,000 stacks of $100 bills that were stapled together, just like the money Luis Rivera received. Over the last few years, since the 2016 arrests and interview of Luis Rivera, law enforcement has not stopped working on this case. There were trials in 2019 and 2022, so right before the pandemic and right after the pandemic, of co-conspirators. Law enforcement also continued to try to gather all the evidence that they possibly could. They continued to interview people who may possibly have any information about the case. They tried to clarify any audio recordings that couldn't be clearly heard. While the phone wiretaps are very clear, the wiretap conversations that took place in public places when these people were meeting in person were not clearly audible back in 2016. Some still aren't. But because these public places are often too noisy. For instance, the recording of the conversation between the defendant and Catherine Magbanua at Dolce Vita had too much background noise to be able to clearly hear what the conspirators were talking about. However, since 2016, as technology developed over the years, and thanks to law enforcement's just continued dedication, law enforcement eventually found an expert that was formerly employed by the CIA with improved technology and enough expertise to clarify this recording at Dolce Vita that y'all will hear. And he did that by being able to reduce as much background noise as possible. And once this recording was clarified, which was actually just early last year in 2022, the state arrested this defendant. The presentation of this evidence, as y'all can see from opening, it's a lot. It's a lot of information. It's going to take a little bit of time. And it may be tedious at times. And I want to thank y'all in advance for the careful attention to all of the evidence y'all see and hear during this trial. When you'll see that this defendant carried out his plan to hire a hitman to kill Dan Markel. He conspired and he solicited Catherine Magbanua to get this murder done. And he paid her for the job once it was completed. This defendant acted in furtherance of this murder plot that went beyond just thinking about it or talking about it. And these acts make him guilty as a principal to first-degree murder, just as if he pulled the trigger himself. While the defendant's choices helped solve a problem within his family, they came at a very high price. He took the life of a loving father of 2 little boys, and he caused a lifetime of grief for Dan Markel's loved ones. Y'all heard a lot in jury selection about how important this trial is to the defendant, which I'm sure it is. But Dan Markel was loved. He was a brother. He was a son. And this trial is his family's opportunity to see justice done for the person who set up their son's murder. And at the conclusion of this evidence, y'all will be convinced beyond any reasonable doubt that this defendant is guilty. And at that point, we'll ask you for the only verdict that does justice in this case, which is a verdict that the defendant is guilty as charged. Thank y'all.
Ladies and gentlemen, excellent opening statement. Every prosecutor has a different style. I liked that style. Underspoken, not a lot of intonation. It doesn't necessarily need to have a lot of inflection on the syllables. Okay, I agree that it's very nice to have an extemporaneous speaker like Hank Brennan who knows how to do that. But that's not necessarily required for a good opening. What you need is an overlay of what the evidence is going to show, an understanding of the law, explanations of why the defendant looks as bad as possible. That's how you give a prosecutor's opening statement. Now, not a lot of people want to be prosecutors. I just want to tell you, like, I go to law school, like, when we're in class and they're like, okay, who wants to be a defense attorney? Like 98% of the people will do that. And they're like, all right, who wants to be the prosecutor? Like one of us. One time I was in a class and they were like, all right, who wants to be criminal defense attorney, everyone raised their hand, and then it was like some kind of advocacy class. It was a lot of people, and then the professor was like, who wants to be a prosecutor? And I was like, me. And every single person just turned to me, and they were like, then the professor was like, oh, he's a spy, he's here to learn defense tactics. And I was like, damn right I'm here to learn your tactics, you damn defense lawyers. They tolerate me. Let's just say prosecutor. I wouldn't exactly say people love prosecutors, all right? There's not a lot of them, and it's a very, low-paying job, and there's not a lot of glory in it, and unless you really care, either you really care or, you made a terrible fucking life decision. I'm sorry to use the F word. Adam Lally, I sometimes think, when I look at that man, I know he really cares, but I see in his eyes, he's like, I have made a terrible mistake with my life. I just see it in his eyes. Hank Brennan, even I think when he was prosecuting that case in state court a little bit, was like, oh dear God, what have I gotten myself into? You can just see it. You have to have Georgia, the prosecutor in this case, and her colleague, they have it. You have to have the eye for it. There are certain people I go to law school with. They have the eye for it. You can see it in their eye. They're all business all the time. No BS, no nonsense. Cut your shit. Get to business. Shut up. Do your work. They are the people who are great prosecutors, but they are few and far between. And if you're going to be a prosecutor, you better absolutely be ready to just fucking take hell your entire life. Nobody's going to like you. It's worse than being a defense attorney because you don't even get any money. You just have to be so good all the time, every single day, that you just command that kind of respect. You don't have to be nobody's perfect, everybody evolves as a person, etc. But when you're doing prosecutorial work, you better absolutely freaking nail it. And I'm telling you, some people have it, some people don't have it. There are some people who should not prosecute criminal cases. They just do it for a job, and it screws up the justice system. I know we need people to do it. We really need to pay prosecutors more because we need top talent doing this. Do you really think that people for the most part, with high erudition and intelligence are just going to work for $60,000 a year as a prosecutor, taking on a really big caseload for pennies because they care about the justice system? I wish, listen to the interview with Towel Mom, I wish more people were like that. That is not the descriptive reality. Most lawyers who are that smart are going to go into private practice and be a defense attorney or a corporate lawyer or a contract lawyer or a wills and estates lawyer. Anything but being a prosecutor. There is no glory in being a prosecutor. You might, if you are very lucky and you understand politics, you might get involved in the DOJ. Okay, then you can run train on some people, you know what I'm saying? Then you can really hold people accountable. That's like going to the NFL, all right? Becoming a federal prosecutor because you were a state prosecutor or you wanted to be a prosecutor in law school is like going to the NFL. Do you know how hard it is to get into the DOJ? That's why I'm saying it was a very big deal for me not to do it, but I couldn't. It's wrong for me to put them in the position where I have to use medical cannabis, and that's against federal law right now, and so I cannot be in the DOJ, all right? But to understand how hard it is to get into the DOJ to begin with, nobody becomes a federal prosecutor. It's a very small select group of people. And there's a reason for that. Those are the prosecutors where it's not just you're working day to day for pennies in the state court. You are the most powerful people in the entire United States. And if you get high enough up in the chain in the Justice Department, you're talking about literally making decisions and being able to wield the power of large institutions that can really make some change. You heard Towel Mom earlier today when I was I will start a section of the DOJ just specifically to put cops who take advantage of witnesses and victims in the criminal court process to federal prison, and then I'll put their pictures on the wall. And she was like, you're not going to have any pictures on that wall. And I was like, oh, you don't know what you've started. I'm now going to commit myself to doing this just because you told me I couldn't do it. That's what you call pathological demand avoidance, ladies and gentlemen. My name's Grant Smith Ellis. We're going to watch a video of Bella, and then we're going to play towel trivia. Then I'm going to bed. All right, I got things to do. Oh, that's what I wanted to say. So some of you sent me DMs this month and said, because I told you around the 21st things were going to get hard, and you said if you need help, just say it. So I'm going to send some of you DMs, but if there are people out there who are wondering if you towel, if you need help, could you say it? I love all the super chats, but there's just a little delay in terms of coming in. So the most effective way to be able to help Little Towel right now, and this is only our second donation read in 9.5 hours, is if you could send Little Towel a donation. That would be very much appreciated. If you support the work being done here, Little Towel just needs some help. I think I need to get through tomorrow or the next day. Classes are starting up. Let me just say, I do this at a loss, and some end of the months are hard. I don't even know if I'm going to be able to pay for my parking at the doctor's tomorrow. I have to leave the stream running so that I can go to my doctor's at 8:50 in the morning and then come back. Let's just say it's not that I'm irresponsible. I just have a lot of different bills that I'm managing. My dad's gone, and I just don't have as much help as I used to. So I need a little help. If you like this stream, if you benefit from it, it's a public information service. What you're really doing is supporting my work. So most of the stuff that comes in is going to server expenses, hard drive, streaming software, subscriptions, news subscriptions, the Printful thing to get the shirts out. There's all these different costs that go into this. I don't mind doing it at a loss. There are just some times where if you benefit from the service and you want to help Little Towel, there's a Venmo. All right, that's at Grant-E1. There's a Cash App, # Grant Smith Ellis. There's a PayPal, paypal.me/Grant Ellis. You can find all those links in the description. You can even scan this nifty little link on the Venmo right here. So if you just stick your little, hold on, if you stick your towel phone up to your TV and then you scan that icon with the Elmo, which is in honor of my friend Elmo, you can help Little Towel. And don't worry too much. I only need to get through like 24 to 48 hours. If it becomes more of an emergency, I'll let you know. But I'm literally at negative $44. You might say, why? Well, I thought I had enough to cover my cell phone bill. I didn't, and it put me at negative $44. So I can't even get a coffee tomorrow. I might call my editor to help me, but I don't want to bother him. If you like this service, just help Little Towel if you can. Don't feel it's a burden. Liking, subscribing, all perfect ways to help Little Towel. But just know that, I put in a lot of time to do this. It means a lot to me that we get to play trivia. Some days Little Towel just, needs a little help. So there you go. Don't donate if you've already donated. Don't donate if it's a burden. Please donate to homeless veterans, animals, anything else first. But if you have the means and you want to help Little Towel, this is me following through on my request and saying, please support public information services designed to educate, inform, and entertain the wider public, and designed to help engender, coach, and public discourse to ward off the usurpation of our representative forms of government. God bless you, Little Towels. I try not to ask that much. I think over the past 2 months, we've had 3 days where maybe even less actually, where I've needed towel assistance. And I'll tell you directly. And then when we go periods where I don't need it, it's because I'm doing all right. Oh, hopefully next summer things will get a little bit better, Little Towels. But for now, I'm going to go day to day. We're going to make it. I am going to continue to be a towel. And we're also going to watch this video of Bella Towel, which I hope Bossy Texas Chick doesn't mind I put a giant Venmo logo next to Bella Towel. But, you gotta do what you gotta do. So I'll put those donation links in the chat. We're going to play towel trivia, then we're going to end for the day. Let's watch Bella. She's a beautiful Bella Towel.
Bella, you have nobody to blame for this but yourself. Because I warned you at least 20 times. Stay away from those wires or I was going to put you in hat timeout. And now you're in hat timeout. And you're mad at me. And I get it. You hate the hat. I know. Well, it's not really a hat, it's a sock. But it works well because it completely immobilizes you when you're being a bad girl. And that's what you're being. There's nothing I can do about those wires, Bella. I hate wires, trust me. But if I want my speaker hooked up, there's nothing I can do. And I keep telling you, stay away from there. And you don't. I mean, to the point where you're gonna get electrocuted, I think. So, for your own good, you are in hat timeout. And I'm not taking the hat off unless you give me your word that you won't go over there. And we just did this now 5 minutes ago and you promised and I took the hat off and you just went running right over there. Didn't you, Bella? Fess up, you did. People are probably like, you are so mean to that cat. But it's not true. But she doesn't listen. I mean, Bella, you're exasperating me. All right, I'll take off the hat, but don't you go over there.
You're exasperating her.
You think it was so tight. You're such a little drama mama. It's not even got anything. It's just a little bit on your ears, and you're like I'm torturing you or something, you big baby brat. Listen, Bella, you have...
She knew what she did. Bella Towel knew what she did. Don't get it twisted. Bella Towel knew exactly what she did, little towels. Bella Towel knew exactly what she did. All right. 3 more rounds of towel trivia, ladies and gentlemen. 3 more rounds, all right? That's all we're doing. 3 more rounds of towel trivia. That's it. All right, here we go. So if you've been waiting to play towel trivia, we are going into our last 3 rounds. I'll give the scoreboard one more read. Oh, thank you very much to someone who sent over $5 for towel support. I appreciate it. What I can do is I don't have to send it to my bank. I can use that $5 directly from the Venmo to pay for my Dunkin' Donuts in the morning. That should be enough. And then I think I can even pay for my parking with some of the quarters I have. As long as we get me through tomorrow, I think I should be okay. Because I think tomorrow the YouTube money from 2 months ago comes in, and that should make me okay. All right, but I just don't want to get up and not have coffee. I'm a little bit worried about it. All right, I'll figure it out, though. I don't know why. I drink a lot of Dunkies coffees, all right? Towel is powered by Dunkies, all right? Maybe I should contact Dunkies. They could sponsor Towel. You see what I mean? I just need a business manager of some kind. I have an editor, but Towel Editor doesn't really have a business manager. He's more just like, all right, what are you writing about or yelling about today, Towel? And then I tell him, he's like, oh, that's very interesting. So, hello, Steph Towel. Hello, folks playing Towel Trivia. We were just talking about ways to support public information services, and now a reminder of our scores heading into the final 3 rounds of Towel Trivia. In first place, by just half a point, Little Towels. He's doing his best. He's a little towel, and his name is Little Towel. And I have, ladies and gentlemen, 22 points. Oh, God bless you, towel friend. Someone sent $7 and said this is for 3 slices of pizza at 7-Eleven. With tax, that actually does pay for 7-Eleven pizza. So God bless you for that, towel friends. All right, so I don't want to miss anyone, so I'm switching between the YouTube app and the phone. I appreciate all of you so much. A little Towel. Towel has 22 points. Second place, Jill Towel has 21.5 points. Jill Towel, keeping Towel honest, ladies and gentlemen, 21.5 points. In third place, Steph Towel, 20.5 points. You came back right in time. Steph Towel, absolutely. In fourth place, right outside the podium, they are Allie and Rue. Rue is the future mayor of Boston. Allie and Rue have 16.5 points. Now, Elijah Towel is tied with Allie and Rue in fourth place, 16.5 points. Nancy Towel and Sunken Grave are tied in 5th place, 14 points. Holistic Psychology, 6th place, 13.5. Vicky Towel, 7th place, 10 points. Paula Towel and Bossy Texas Chickabella tied in 8th, 4.5 points. Jack D65 in 9th with 4, but with 9 billion bonus points for being a super towel. Peggy Towel in 10th, rounding out the top 10, 4 points. Colleen Henry and Buck Towel, 3.5 points, 11th place. Nunya Towel, 1.5 points. Tanya, hello, my dear friend. We are playing Towel Trivia today, and then tomorrow, the news, if you missed it, the Donna Adelson trial begins tomorrow with opening statements in the afternoon, Little Towels. So we're about to play 3 rounds of Towel Trivia. Then we're ending the show, and then Towel is mentioning, if you want to scroll up and chat, there are ways to support Towel directly over the next 24 hours while Towel tries to survive. So, God bless all of you. Yes, you do, Vicky Towel. You are hanging on there on that trivia board. 3 rounds to go, Little Towels. All right. The first category is, what should we do? I'll take a look in the chat. What are we feeling? What categories are we feeling? 3 left on the day, ladies and gentlemen. 3 left, Little Towels. Just 3 categories left. What are we feeling? What are we feeling? Who's feeling confident? Who's feeling like we can get some questions done? All right, little towels. What do we got going on? Movies. All right. Dr. Seuss. All right, we got 3 categories left. So movies, Dr. Seuss, and celebrities. All right, movies and music. All right, hold on. All right. So I got 4 category suggestions. I think we can figure out of those 4. We're going to start with movies. All right, ladies and gentlemen, the first category is just in general for all of the towel friends across. Ooh, 70s rock. We're not going to do that first, but I like that. I'm feeling it. All right. Now, movies is the first category. It could be any movies. Who knows? It could be foreign movies. It could be domestic movies. It could be German movies. It could be movies from the 20s, movies from the modern age. Here we go. You know how towel trivia works. Get the question right. If towel gets the question right, you get it right first. You get a point. If you get it right subsequent to that, half a point. If I get it wrong, 2 points for the first person to get it right. 1 point for everyone to get it right after that subsequently. Pick 1 through 4. All right, 1, 2, 3, 4 based on the answers on the board. If it's a double bonus round, I'll let you know ahead of time. We'll have one of those. Not this round, but 1, 2, or 3 will be a double bonus round. Well, since it's not this one, it's going to be 2 or 3. In those rounds, if I get it right, same scoring applies. If I get it wrong, 4 points if you get it right first, 2 points if you get it right subsequent to that. Here we go. Let's do it. Little towels. First category, generally movies. You're a movie. Here we go. What film features a character named Jack Dawson? What film features a character named Jack Dawson? Is it Inception? Is it The Matrix? Is it Avatar? Or is it Titanic? Is it Inception, The Matrix, Avatar, or Titanic? Show me Titanic. It's Titanic, ladies and gentlemen. It is Titanic. The bot loves Leo. Steph loves Leo, and the bot loves Leo, ladies and gentlemen. I don't know who loves Leo more, Steph or the bot. Full point for Steph. Half point for Nancy Towell. Half point for Jill. Excellent job, ladies and gentlemen. Allie and Bro, excellent job. Hit holistic psychology. Absolutely excellent job, ladies and gentlemen. Peggy Towell picks up half a point as well. Who else? Barbara, excellent job. Barbara Towell hopping on the board. We all love Leo, ladies and gentlemen. Vicky Moore picking up half a point. Everybody loves Leo because we all pick up points when Leo is the answer. Basically, Steph hears Leonardo DiCaprio in a question on towel trivia. Steph picks Leo DiCaprio or anything related to him. Oh, and as we learned yesterday, Leo is in literally every movie of all time. Reservoir Dogs, Leo's probably in it. Casablanca, Leo wasn't even born. He probably found a way to be in it. You know what I'm saying? That silent film, Metropolis, Leo's in it. The Charlie Chaplin films, that wasn't Charlie Chaplin. That was Leonardo DiCaprio. Bossy Texas Chickabella. Oh, that's right. You were hiding. Bossy Texas Chickabella actually got the full point, not Steph. So I got to reduce Steph by half a point and add a full point for Bossy Texas Chickabella. Excellent job. All right, here we go. Next question. Which animated film has a character named Simba? Which animated film has a character named Simba? Is it Finding Nemo? Obviously. Toy Story? Obviously. Frozen? I don't think so. Or The Lion King? I'm on the fence about it. So which film had a character named Simba? Finding Nemo, Toy Story, Frozen, or The Lion King? It's obviously Finding Nemo. I'm just tricking you all. It was clearly The Lion King. Towel got the full point. Bossy Texas Chickabella did not get this one right first. They were distracted by Steph's tactical posturing. Steph got the full point. Elijah Towel, great to see you, dear friend, picks up half a point. Bossy Texas Chickabella, pick up half a point. Oh, no. Hold on. Bossy Texas Chickabella, half a point. Who else got half a point? Jill, half a point. Keeping Towel honest. Who else? We got Nancy from the 508, half point, keeping Towel honest. Allie and Holistic Psychology, half point. Excellent job. Who else we got? Ruth, it's great to see you, my dear friend. I'm glad we got to play a few rounds. We'll have more rounds tomorrow. Peggy Towel picks up half a point. Thank you very much, Little Towels. Barbara picks up another half a point. There we go. First time Bossy Texas Chick ever saw two number 4s in a row on Towel Trivia. Next question. Which 2020 film explores the concept of time manipulation via a mysterious device? Which 2020 film explores the concept of time manipulation via a mysterious device? Is it Inception, Tenet, Lupa, Arrival? Inception, Tenet, Lupa, Arrival. It's either Tenet or Looper, I'm pretty sure. It's not Inception. That was in 2020. I'm going with Looper. No, I should have gone with Tenet. That was my initial inclination, ladies and gentlemen. Oh, I took the point away from myself. Inception was from about a decade, folks, so I don't want to scare you, but 2020 was 5 years ago. Inception was from like 10 years ago. I know our senses, our senses of time are getting all out of whack, but no, nobody got it. Wow. Everybody was just so intent on picking the Leo movie, nobody got it right. That was a really hard question. All right. Points up on the board, ladies and gentlemen. Points up on the board. All right, next question. Which film features a heist involving a casino in Las Vegas carried out by a group of thieves? Which film involves a heist involving a casino in Las Vegas carried out by a group of thieves? Heat, Ocean's 11, Inside Man, The Italian Job. Heat, Ocean's 11, Inside Man, The Italian Job. Ocean's 11. Towel nailed it, ladies and gentlemen. Towel nailed it. Yes, Bossy Texas Chickabella. That's a full point. Nancy gets half a point. Allie and Bro get half a point. Excellent job, Allie and Bro. Half a point. Then we got Ruth Lang, half a point. Then we got Jill getting half a point. Then we got Barbara, half a point. Then we got Holistic Psychology and Peggy Towel getting half a point. And then we got, there we go. Yeah, you might get ad merc from time to time. It's different for every stream. Depending on when the ads roll, it depends on like where you are, etc. But ads can run anytime. Yeah, commercials can happen. All right, here we go, Little Towels. Next question. Which director is known for the Three Colors trilogy? Which director is known for the Three Colors trilogy? Is it Alfred Hitchcock, Christopher Nolan, Akira Kurosawa, Krzysztof Kieślowski? Is it Alfred Hitchcock, Christopher Nolan, Akira Kurosawa, or Krzysztof Kieślowski? So it's one of the last two. I don't know if it's the Polish guy or the Japanese guy. I'm going Japanese. No, it was the Polish guy. Damn it, I've seen some of those films too. It's a great filmmaking style. Holistic Psychology nailed it. 2 points, ladies and gentlemen. Sunken Grave, full point. Ruth Lang, full point. Nancy from the 508, full points. Really a good. He's an excellent filmmaker. It's a little bit weird for American audiences. Excellent filmmaker. I've seen those. I just didn't remember if it was the Polish guy or the Japanese guy. The Japanese guy is a great filmmaker as well. So Allie and Rue, full point. Jill Towel, full point. Peggy Towel, full point. Great series of films. If you've never seen it, please, you were Holistic Psychology, 2 points. Yeah, just for once, girls want to have fun. There you go, Holistic Psychology. Yeah, that was a hard, so I have seen some Kurosawa films. Excellent director. I didn't know the names of his films. Now that I'm thinking about it, it could have been Three Colors because he's very artistic. It's like that. But Krzysztof Kieślowski, he's known for this directorial style across that trilogy. I mean, it's just stunning. Okay, it's like oxen, like moving across like towns. It's like very well shot. It's very famous. It's hard to explain because it's a very long film, but it's very famous. Don't worry, Suck a Grave. You'll come charging back after your towel nap. You got Ed. The spirit of Ed is with you. Yes, holistic psychology confirmed what I suspected, which is that Kieślowski is very well known in Europe because his films truly were some of like the most impressive things you will ever see produced by a director. If you have not seen Kieślowski's film or Kieślowski's films, you should check them out. So, all right, excellent job, holistic psychology, big winner in that. All right, one more question in this round. Here we go. Who wrote the screenplay for Chinatown? Who wrote the screenplay for Chinatown? Was it Quentin Tarantino, Nora Ephron, William Goldman, or Robert Towne? Was it Quentin Tarantino, Nora Ephron, William Goldman, Robert Towne? Oof, I'm going Goldman. Robert Towne. I should have gone with my initial inclination. Ed is hiding like Karen Reed. The answer is number 4, ladies and gentlemen. Who's going to get the double points? Who's going to get the double points? Who's going to get it? Lots of answers up on the board. Lots of people thinking 1. Lots of people thinking 3. Nobody picking number 4, ladies and gentlemen, so far. Nobody picking number 4 in Towel Trivia so far. Nobody coming through. We're going to give Vicky a chance to answer. Nobody with the right answer. Good movie. Hard to know who wrote the screenplay. Just 2 rounds of Towel Trivia left, ladies and gentlemen. Just 2 rounds of Towel Trivia left. 2 rounds, indeed. All right. Gave as long as I could for answers to come in. Nobody picked up the double points there. Points left on the board. All right. Let me check the scores. Oh, ferocious. Holistic psychology. Jumping up the board, ladies and gentlemen. Holistic psychology representing the German contingent. Bossy Texas Chickabella making some movement. Sunken Grave coming in, fighting hard, gaining some points. Peggy Towel jumping up the board. Who else? Butterflies are free, jumping up the board. Ruth Towel making some progress. Excellent job, Little Towels. We got a big scoreboard. Going to take me a second to read through it here. Here we go. Scoreboard, please. Scoreboard. Thank you very much. Scoreboard, ladies and gentlemen. Here we go. Our scoreboard is... What's that? Oh, the statement, opening statements. Here's our scoreboard, Little Towels. Hold on one second. For this round of Towel Trivia, this is round 25, August 20th, 2025. In first place with 2 rounds remaining, ladies and gentlemen, Towel with just a 1-point lead over Jill Towel. 25 points for Little Towel. 24 points for Jill Towel. Excellent job. Excellent job. Jill Towel in second place with just 2 rounds remaining. 24 points for Jill Towel. In third place, very close in striking distance, rounding out the podium, 22 points, ladies and gentlemen. Podium, Steph Towel rounding out the podium, 22 points. Excellent job, Steph Towel, our Canadian Super Towel hero. So, first, second, and third, the excellent Towel. Jill Towel pursuing her first ever first place finish. Will it happen? 2 rounds to go. 24 points. And Steph Towel, 22 points. 25, 24, 22. First, second, and third. That's the podium. Right outside the podium, it is Allie and Brew. She's stuck in the middle with you, ladies and gentlemen, in a good way. Allie and Brew, fourth place. Right outside the podium, been climbing up all day. 19 points, 3 places, 3 points off the podium. Allie and Brew, the future mayor of Boston. Don't vote Michelle Wu, vote Brew. Allie and Brew. 19 points. Ladies and gentlemen, everyone congratulate them. They are Super Towels. All right, little towels. And next, 5th place, Holistic Psychology, 17 points. Holistic Psychology climbing up, representing the German contingent, came up out of nowhere, grabbed 2 points at a crucial moment during that round, ladies and gentlemen, and as such was rewarded with a very impressive 17-point finish in 5th place, tied as well with 17 points. Elijah Towell, excellent performance today, came back in at the end of that round, grabbed some points, tied for 5th. Holistic Psychology and Elijah Towell within striking distance of the podium. In 6th, by just half a point behind Holistic and Elijah Towell, Nancy Towell doing an excellent job today, ladies and gentlemen. 16.5 points for Nancy Towell in 6th place, serendipitously enough. 7th place, holding on to his 7th place spot. He has the spirit of Ed with him, ladies and gentlemen. Ed is not in hiding. Ed is with you in spirit. Oh, someone said $5 via Venmo. God bless you for the person who did that. Thank you very much. I appreciate it. I just got the notification now. God bless you, Towel friend. Sunken Grave holding on to his 7th position. Sunken Grave, ladies and gentlemen, 15 points. Excellent job. In 8th place, it is Vicky Towell, 10.5 points. Excellent job. Excellent job, Vicky Towell. In 8th place, 10.5 points. Been fighting hard all day. Representing one half of the Super Towel Canadian contingent, Vicky Towell, 7. What was it? I think it was 1, 2, 3, 4, 5, 6. 8th place. Sorry about that. 8th place. Sunken Grave is in 7th. 8th place for Vicky Towell, 10.5 points. 9th place. They have that place all to their own. They are in the top 10. They are bosses. They are from Texas. They are chicks. They are Bossy, Texas Chick, and Bella. One of them is named Bella as well. She was wearing a sock earlier. 9th place, 7 points. Excellent job, Bossy, Texas Chick, and Bella. 9th place, 7 points. In 10th place, the biggest fan of Pete Bunny Towel outside of Bunny Towel. Well, maybe outside of Toffee Towel. Toffee Towel is a little bit of arm candy, but Toffee Towel is going to marry Pete Bunny Towel. Pete Bunny Towel has been courting Toffee Towel. You don't understand. It's been like 18 months now, it feels like, in bunny years. Toffee Towel is committed. Well, I don't think Toffee Towel. What are you talking about? You are the one who is committed to courting Toffee Towel, Pete Bunny Towel. Pete Bunny Towel starts talking about Toffee Towel, he just loses his mind. I tried to explain to him he's going to have to stay composed if he wants to court Toffee Towel, all right? She's a diva bunny, and that she belongs to Allie Towel and Rue Towel. It's their house bunny, and Pete Bunny Towel loves Peggy Towel, but he's courting Toffee Towel. There's a lot of lore here. It involves a stuffed Pete Bunny Towel, and it also involves Toffee Towel, and a courtship process that's going to involve going to the Four Seasons in Rome. Long story, no time to explain. The Pete Bunny Towel gets very excitable when I start talking about his courtship process with Toffee Towel, all right? He has been thinking about this. He's planning it out. They're going to Italy. There's nothing we can do about it, Allie. I tried to negotiate with him. You don't understand. Once Pete Bunny Towel gets going, he's just one-track minded. He's taking Toffee Towel to Italy. God bless us all. All right, so there you go. Now, wait a minute. I have updates. Allie would like to let you know that Toffee Towel is a looker bunny. You're more concerned with her analytical reasoning skills. What do you plan on quizzing her? All right. Listen, Allie, I don't know what's going to... He has made it very clear that he's going to have to quiz Toffee Towel. He is very interested in Toffee Towel's analytical reasoning skills. All right, that's enough. Enough of your whatever it is, your objectification of Toffee Towel. She is not just an analytical reasoner. She is arm candy. What don't you understand? I will not stand for this reverse objectification, Pete Bunny Towel. In any event, Peep is as pure as the driven snow. Bossy Texas Chick says, Bella was wearing a sock earlier. Grant is breaking news. Yes, Bella was indeed wearing a sock earlier. Bella's like, I think I made the news. She's going to be utterly baffled. Every time Bella's name gets mentioned by the TV, she's probably like, what is going on? I feel like Rue at this point is just acclimated to it. He's like, oh yeah, that guy on the TV who hangs out with the bunny, he just says my name sometimes. He's just used to it by now. All right, where were we? Oh, yes, I was talking about Peggy Towel, and then Pete Bunny Towel got all excitable because he wants to court Toffee Towel. So, in any event, Sunken Grave was in 7th, Vicky's in 8th, Bossy Texas Chick is in 9th, Peggy Towel is in 10th, rounding out the top 10. No. This is a courtship process. Wait a minute. Pete Bunny Towel? Peggy Towel would like you to confirm that your courtship is basically Catholic in nature and that you do not believe in premarital bunny fornication. I'm putting this as gentle. That was very gentle, I know. Yes, you are a devoutly Catholic Towel. You are a Pete Bunny. All right, he's able to confirm for you, Peggy, that he is a devoutly Catholic Pete Bunny Towel, and this is just a courtship process. All right, so moving on. Peggy Towel rounds out the top 10, 6.5 points. 11th place, Paula Towel, 4.5. Excellent job, Paula Towel. Right behind Paula Towel in 12th place, as Sunken Grave noted, Jack D65 has 4 points, but he has 9 billion bonus points for being a super towel. 13th place, ladies and gentlemen, Colleen Henry, 3.5 points with Buck Towel holding on strong. 14th place, Ruth Towel, 2 points. Excellent job. Hold on, that was 14th. 15th place, we have a two-way tie, Nunya Towel and Bobber Towel, 1.5 points. Excellent job. And 16th place in the position of honor, ladies and gentlemen, Butterflies are free, 0.5 point, the position of honor. 2 rounds to go, Little Towels. All right, here we go. Let's get one of our final rounds going. Are we going to do 70s rock? Ladies and gentlemen, the next category is 70s rock. All right, here we go. 1970s rock and roll. All right, ladies and gentlemen. Rock and roll will never die. Rock and roll is here to stay. Pete Bunny Towel likes to rock and roll. We like to rock and roll. Speaking of which, let's rock and roll. All right, the category is 1970s rock and roll. First you got to rock, then you got to roll, then you got to avoid falling down the hill. That's part of the deal. Let's go. Get it? Rock, roll, down the hill. Hilarious. Which band released the album Hotel California in 1976? Which band released the album Hotel California in 1976? Was it Pink Floyd, Led Zeppelin, the Eagles, or the Rolling Stones? Was it Pink Floyd, Led Zeppelin, the Eagles, or the Rolling Stones? Listen, you can check in to Towel Trivia, but you should know you can never leave. It's the Eagles, ladies and gentlemen. Number three, Steph Towel was the first one to get it right. Good timing, holistic psychology. We did start right away. First point goes to Steph Towel. Elijah Towel comes in, picks up 0.5 point. Bossy Texas Chickabella, 0.5 point. Sunken Grave and the Spirit of Ed, that's his Sunken Grave's new nickname, 0.5 point. Nancy from the 508 comes in, grabs 0.5 point. Jill grabs 0.5 point. Keep it Towel honest. Ruth Lang, 0.5 point. Excellent job, Ruth. Allie and Fro, 0.5 point. Excellent job. And Peggy Towel doing really well, picking up 0.5 point. Who else we got? Holistic Psychology picking up another 0.5 point. Ain't that the truth? Towel Trivia is addicting. The phrase 3-dog night came from the fact that it took 3 dogs to keep warm in cold castles. Wow, I didn't know that, Peggy. I have a time lapse. Your vote already and the question didn't even appear. Oh no, Holistic Psychology, you might have to click the live button on your stream or put the speed to 2x in order to be able to get to the live feed. Next question in 70s rock and roll. What legendary music festival took place in New York in 1969 and influenced 1970s rock? Which legendary music festival took place in New York in 1969 and influenced 1970s rock? Was it Lollapalooza, the Monterey Pop Festival, Glastonbury, or Woodstock? Was it Lollapalooza, the Monterey Pop Festival, Glastonbury, or Woodstock? It was Woodstock 1999, ladies and gentlemen. Number four, Bossy, Texas Chickabella, beat out Steph and grabbed the full point. Steph gets half point. Sunken Grave. I bet Sunken Grave would have gone to Woodstock. Half a point. I would have gone with you, Sunken Grave. Elijah Towel, ladies and gentlemen, half a point. Nancy from the 508, half point. Jill picks up another half a point. Holistic Psychology picks up half a point. Then we got Ruth Lang picking up half a point. Then we got Allie and Peggy Towel, both, and Rue, picking up half a point. Rue, you are not an afterthought. You are the future mayor of Boston. Also, I know what our final double bonus category is going to be. Oh my goodness. It's going to be intense. All right. Excellent job. Glastonbury is definitely in the UK, and it definitely didn't take place in the 70s. Monterey Pop was at least somewhat of a good, alternate answer. Lollapalooza, that was until, the 90s, so that was Smashing Pumpkins style. All right, little towels. Next question. Here we go. Which artist founded the group Bluesology before achieving 1970s rock fame with a different name? Which artist founded the group Bluesology before achieving 1970s rock fame with a different name? David Bowie, Elvis Costello, Rod Stewart, Elton John. David Bowie, Elvis Costello, Rod Stewart, Elton John. I'm going Elvis. Elton John. Wow. Ladies and gentlemen, who would have known that Elton John's first group was called Bluesology? Oof, indeed. Who would have known it? Who would have thunk it? I wouldn't have believed it if you told it to me via 1950s newsreel, ladies and gentlemen. Yeah, no, I know. I just thought it was Costello because I liked one of his songs. I was just guessing. I did not think it was going to be Elton John. Allie and Bo pick up 2 full points. The only ones to get it right. Allie and Bro playing tactically, picking up points on the board. There you go. There you go. Nailed it. Rue met Elton John once, actually. Rue and Elton John go way back. They sing ballads together. Rue barks, Elton John sings, Allie plays the piano. Next question, little towels. Next question. Glastonbury started in 1970. Oh, wow, Ruth. I didn't know that, actually. Obviously, it's not in New York, but I had no idea it started in 1970. And Allie's like, yes, I play tactically, quote unquote. Whatever works, Towel, whatever works. Grant listens to Pump It Up before every stream. Towel just gets excitable when playing trivia. It turns out Rue is not actually part of Elton John's band. Oh, goodness. All right, next question. Sorry, I was eating some... I got these cereal for $1.99. It's Cookie Crisp. I think it actually has a little too much sugar for Towel. But it tastes really good. It tastes like a cookie. And it's cereal, you know what I'm saying? And then you just want to eat more and more of it. I'm not really sure we should be giving our children cereal that makes you just want to eat more and more of it and has mostly sugar. I'm pretty sure that's not a good idea. Now, I'm not a child, maybe at heart, but I do like cookie-based cereal. Really, you can't go wrong. It's a cookie, it's bite-sized, and it gives me sugar-based energy. I like peanut butter puffin cereal. Jill, I don't know. That could be your internet. It could be your phone stream. I tried to give you a little time to catch up while I ate some Cookie Crisp there. Now we're ready to go to the next question. I ate Lucky Charms today. Naughty, but nice. I love Lucky Charms. Those marshmallows are really good. Next question. What 1970s rock band was originally named Earth and later gained fame with a name inspired by a horror film? What 1970s rock band was originally named Earth and later gained fame with a name inspired by a horror film? Black Sabbath, Deep Purple, King Crimson, Blue Oyster Cult. Black Sabbath, Deep Purple, King Crimson, Blue Oyster Cult. It was Black Sabbath. Wow, Steph hit it out of the park, ladies and gentlemen. 2 points. Bossy Texas Chickabella, full point. Jill picks up a full point. Christina Towell, loves her Black Sabbath, picks up a full point. Who else? Nancy from the 508, full point. Who else? Peggy Towell with the Power of Bunny, Pete Bunny towel behind her, picks up a full point. Holistic Psychology picks up a full point. Allie and Bro pick up a full point. All right, excellent. Allie was like, we're the Lucky Charms, magically delicious. Next question. What band released In the Court of the Crimson King in 1979, impacting the 1970s rock scene? Which band released In the Court of the Crimson King in 1979, impacting the 1970s rock scene? Genesis, King Crimson, Yes, or Emerson, Lake and Palmer? Genesis, King Crimson, Yes, or Emerson, Lake and Palmer? I'm going to go with King Crimson. That was probably a good life decision. King Crimson. Number 2, ladies and gentlemen. Yes, rest in peace, Ozzy. God bless his soul. Very talented artist. Very talented. Bossy Texas Chicken Bella, pick up the first point on this one. The answer was number 2. Sunken Grave grabs half point. Excellent job, Sunken Grave. Nancy from the 508 picks up half a point. Holistic Psychology, half a point. Christina Towell, half a point. Allie and Bro, half point. Peggy Towell, half point. Did I see Elizabeth Lander pop in? Elizabeth Lander, who selected Towell as an answer yesterday and got 42 billion bonus points, gets half a point. Excellent job, everyone. Next question. I'm a Towell. Who was the lead guitar player on David Bowie's Ziggy Stardust tour? Who was the lead guitar player on David Bowie's Ziggy Stardust tour? Was it Keith Richards, Brian May, Jimmy Page, or Mick Ronson? Was it Keith Richards, Brian May, Jimmy Page, or Mick Ronson? It's either... All right, I don't know if May would have done it. Keith Richards or Jimmy Page. Sounds like Jimmy Page. It was Mick Ronson. Oh, ladies and gentlemen, it was Mick Ronson. All right, so hold on. Who was the first one to get this one right? Number 4, ladies and gentlemen. Hold on, I can't tell who answered this one first. I think it was Steph. All right, so the first person I see getting it right is Steph. That's 2 points for Steph, ladies and gentlemen. 2 points for Steph. Oh, I thought it was Jimmy Page too, Jill. Sunken Grave gets a full point. Who else? Peggy Towell grabs a full point. Who else got number 4? Allie and Bro, full point. Who else? Elizabeth Lander, full point. All right, here we go, folks. Oh, goodness. Oh, goodness gracious me. That last answer for Steph changed the game. Oh, Jill, listen, you are still very much in contention. But listen, Steph Towell is known as the Towel trivia sort of, I wouldn't call her a menace, but you see Steph Towell pop up and everybody just runs the other direction, and you're about to find out why. All right, little towels, let me check everybody's scores. All right, here we go, moving Elizabeth Land up. Excellent job, Elizabeth Land up. Excellent job, Christina Towell. All right. How's everybody looking? Everybody in order? All right. Yep. That all looks good. Everything seems to be in order. All right. Let's take a look at the scores. There are your scores. We have had quite a day. There it is, little towels. There it is. Towel Trivia, round 25, heading into the last round of Towel Trivia. Heading into the last round for today. In first place, by half a point, it's Towel. I'm a little towel. I have 28 points. I'm barely holding on, but let me just tell you the reason why is because of Steph Towel. Now, Steph Towel would be at 25.5 points if not for her last answer that got her 2 points. That's how you play Towel Trivia. Towel Trivia sometimes comes down to the last round. We are going to come down to this last round. Anything can happen. Steph Towel's in the mix. Jill Towel's in the mix. Allie Towel's in the mix. Holistic Psychology's in the mix. Nancy Towel's in the mix. Elijah Towel, Sunken Grave, all in the mix for the podium. First place, Towel 28. Second place, Steph Towel 27.5. Third place, Jill Towel on the podium, multiple days in a row, in the position to potentially take the lead. 26 points, ladies and gentlemen. And yes, I'm sorry about the little fuzziness. There's just so many people on the scoreboard. This is the best that I'm able to do. So there you go. Towel, Steph Towel, Jill Towel. Allie Towel has 24.5 points. In fourth place, Rue Towels cheering Allie on. We're heading to the finish line, ladies and gentlemen. Anything could happen. Sunken Grave says they were in the Spiders from Mars. I'll have to check it out. Fourth place, 24.5 points, Allie and Rue. Fifth place, Holistic Psychology, the champion of the Bavarian Empire, the future queen of the restored Bavarian Empire. Can you restore something that never existed? I can't get into the nuances of that metaphysical debate right now. What do I look like, Immanuel Kant? No, I'm a towel. Anyway, Holistic Psychology, fifth place, ladies and gentlemen, 19.5 points. Excellent job. Sixth place, right behind Holistic Psychology, battling hard all day, in striking distance, Nancy Towel, sixth place, 19 points. 17th place, seventh place, right behind Nancy Towel, 18 points, 7th place, Elijah Towel, excellent job. 8th place, Sunken Grave, the champion of all soap dispensers, the greatest soap dispenser on any ocean, any continent, any planet, and riding strong with the spirit of Ed with him at all times, Sunken Grave, 8th place, 17.5 points. 1, 2, 3, 4, 5, 6, 7, 8. 8th place, 17.5 points. 9th place, battling hard. We have a two-way tie. It's the Canadian superhero. It's Bossy Texas Chica Bella. All of them together are bosses. Only some of them are from Texas. Some are from Canada. Some are chicks. Only one is named Bella. Bossy Texas Chica Bella and Vicky all tied in 9th place, 10.5 points. Now this is wonderful. You love to see something like this. In 10th place, serendipitously enough, bringing out Pete Bunny Towel. Did you know she's in 10th place and she has 10 points? He's banging his head vociferously. He is a thrilled Pete Bunny Towel. He would like to let Peggy know that she, serendipitously enough, is in 10th place, rounding out the top 10. He swung his head around in a circle. He's so excited, Pete Bunny Towel. Peggy Towel, 10th place, 10 points. Great job. All right. Calm down. You're going to give yourself a bunny concussion. 10th place, 10 points. 11th place, ladies and gentlemen, Paula Towel, 4.5 points. Excellent job, Paula Towel, 4.5 points. Thank you for the reminder to appropriately use soap dispensers to keep ourselves clean. Sunken Grave, God bless you for your service. 11th place, Paula Towel, 4.5 points. 12th place, Jack D65, 4 points. 9 billion bonus points for being a super towel. 12th place, Jack D65, 4 points. 13th place, Colleen Henry and Buck Towel. Buck Towel is the ever-vigilant guardian of Colleen Henry and the Midwest in general. 13th place, 3.5 points. 14th place, it's Ruth Towel, ladies and gentlemen, coming in strong at the end of the day. 3 points. Excellent job, Ruth Towel. 15th place heading into our last round. We got a big four-way tie. Nunya Towel, Barbara Towel, Christina Towel, Elizabeth Lander, 1.5 points each in 15th place. And in 16th place, the position of honor with half a point holding strong on the board. Butterflies are free. Excellent job. Mark Ronson is a musical genius, says Steph. Thank you very much, Steph, for that interesting piece of trivia history. All right, ladies and gentlemen, the double bonus round. It's not 1960 news stories, although that would be really fun. It is going to be 1990s Disney movies, ladies and gentlemen. Of course, Ruth, thank you for playing, dear friend. 1990s Disney movies, ladies and gentlemen, and it is a double bonus category. This means if I get any of these questions wrong, 2 points are up at stake if you get it right. 1990s Disney movies, this is the final category of the day. Then I'm going to, hopefully, if some donations came in, go put $5 on a donkey's card and try to get some snacks and get some gas for my car so I can go to the dock. Anyway, let's do it. 1990s Disney movies, ladies and gentlemen. I know some of you are going to get excitable. All right, I'm excited. Can you tell I'm excited? Here we go. I had to give folks a little time. Here we go. 3, 2, 1. First question, double bonus. Which film features a young lion named Simba? We already got this today, so if you were paying attention, which film features a young lion named Simba? Is it Aladdin, The Little Mermaid, Beauty and the Beast, or The Lion King? Is it Aladdin, The Little Mermaid, Beauty and the Beast, The Lion King? It is The Lion King, Little Towels. Bossy, Texas Chica Bella were the first ones to get it. Steph, right in behind with half a point. Jill, half a point. Ruth, oh no, we're not voting. I just picked this holistic psychology. Ruth, half a point. Nancy from the 508, half a point. Sunken Grave, half a point. Holistic psychology, half a point. Allie and Bro, half a point. Elizabeth Lander, half a point. Holistic psychology, I think you answered twice. That's okay. Peggy, half a point. I am so behind. That's okay. We'll give you as much time as you need, holistic psychology. Don't you worry about it. Next question, Little Towels. Next question. Last category of the day. What animated movie includes a street rat named Aladdin? Oh, come on. What animated movie includes a street rat named Aladdin? Mulan, Tarzan, Pocahontas, or Aladdin? Mulan, Tarzan, Pocahontas, or Aladdin? That's no fun. Come on now. Come on, bot. This is our final category of the day. Steph picks up the full point. Bossy, Texas Chica Bella, half a point. Who else did I see? Allie and Brew, and then Jill both picked up half a point. Ruth Lang, half a point. Elizabeth, half a point. Nancy from the 508, half a point. Holistic psychology, half a point. Elijah Towel coming in with half a point. Peggy Towel, another half a point. There you go. There won't be any double points. Right, I was going to say, I don't know what's going on. Sometimes it asks good questions, sometimes it doesn't. Next question. I love it, Steph. What Disney movie has a toy cowboy as one of its main characters? What Disney movie has a toy cowboy as one of its main characters? Is it Finding Nemo, Monsters, Inc., A Bug's Life, or Toy Story? Is it Finding Nemo, Monsters, Inc., A Bug's Life, or Toy Story? It's Toy Story, Little Towels. Steph was the first one to get it right. Full point. Bossy, Texas Chica Bella, half point. Jill, half point. Allie and Bo, half point. Ruth, half point. Holistic psychology, half point. Elizabeth Lander, half point. Elijah Towel comes in with a half point. Nancy from the 508, excellent job, my friend, half point. And Peggy Towel rounds it out with a half point. Next question, little towels. What 1990s Disney film features a daring girl traveling across China? What 1990s Disney film features a daring girl traveling across China? Was it Pocahontas, Hercules, The Hunchback of Notre Dame, or Mulan? Was it Pocahontas, Hercules, The Hunchback of Notre Dame, or Mulan? It was indeed Mulan, ladies and gentlemen. Thank you very much, Steph. Ruth, I appreciate it. Ladies and gentlemen, Sunken Grave comes in and gets a full point. Steph Towel comes in and gets half a point. Jill comes in and gets half a point as well. Bossy Texas Chickabella, half a point. Elijah Towel comes in with half a point as well, as does Ruth Elizabeth Lander and Nancy Towel, all picking up half a point. Ruth Elizabeth Lander and Nancy Towel, all picking up half a point. And then Allie and Brew, Sunken Grave. Were you answered 4 first, or were you answering forward to the last one? Oh, okay. So hold on, I got to fix this a little bit. Sunken Grave got half a point for each one. Steph actually did get this one right first and gets a full point. I got you, Sunken Grave. Don't worry about it. Holistic Psychology, and Steph, I gave you an extra half a point because you actually got that one right first. Holistic Psychology, half a point. Peggy Towel, half a point. See what I mean? I adjust the scores in real time. I'm paying attention. Yep, I got it, Sunken Grave. Not a problem. I just made sure you got a half a point for each question, and then Steph Towel got an extra half point because she was the first one to get this one right. Next question, little towels. Here we go. What 1990s Disney film features a magical number featuring an enchanted chandelier? Which 1990s Disney film features a musical number featuring an enchanted chandelier? Beauty and the Beast, Aladdin, Hercules, The Hunchback of Notre Dame. Beauty and the Beast, Aladdin, Hercules, or The Hunchback of Notre Dame. Beauty and the Beast. Absolutely Beauty and the Beast, ladies and gentlemen. Absolutely. Steph Towel comes in with the full point. Jill almost grabbed the full point, grabs half a point. Nancy from the 508, half point. Elizabeth Lander, half a point. Who else? Allie and Bro, half a point. All right, little towels. Excellent job. Excellent. Good guesses there. Got to give Sunken Grave a little bit of time to see what answer they come up with. But that was very good. Very good. We got some ferocious competition. Are Allie and Rue going to pull it off? Is Jill going to hold on to a podium position? Will Steph be able to overtake Towel? It is our last question of the day. Oh, Sunken Grave already answered. Here we go. Last question of the day. Here we go. What Disney movie from the 1990s includes a character who is a llama? Oh, God. Which 1990s Disney movie from the 1990s includes a character who is a llama? Is it The Emperor's New Groove, Mulan, The Lion King, or Pocahontas? Is it The Emperor's New Groove, Mulan, The Lion King, or Pocahontas? I was just trolling you. I knew it was The Emperor's New Groove the whole time because the commercial had a damn goat in it. Steph, excellent job. Comes in with the right answer on the last question. Jill nailed it as well. Half a point. Ruth Lang, half a point as well. Excellent job. Nancy from the 508, excellent job, half point. Elizabeth Lander, half a point. Sunken Grave, finishing strong, half a point. Peggy Towel, half a point, strong finish. Holistic Psychology, half a point. Allie and Bro, half a point. Llama was the Wordle word today. Llama is the word of the day. Llama, llama, llama. Towel apparently is going to say llama a lot. What an ending. Oh, I got your final scores, ladies and gentlemen. I got them right here. I'm now putting in the order. All right, I'm putting you in order. Elizabeth, Landa, and Ruth made some progress. I'll tell you about that right now. Who else made progress? Bossy, Texas Chickabella, and Peggy both made some progress. Sunken Grave and Elijah Towel fighting it out, ladies and gentlemen. Oh, Holistic and Nancy. Oh, goodness. There were some battles, ladies and gentlemen. I'm putting your scores together right now. Oh, Steph Towel. Oh, Steph. You did it again, my friend. You gave me a run. Do you think you were able to pull it off, Steph? What do you think? What do you think? It was quite a battle, ladies and gentlemen. Let me just tell you right now, that was quite a battle. It's interesting to be able to see the scores before they actually get posted, because I know you kind of can guess based on where you were going into the last round, but there's such a ferocious pace of activity, it's tough to tell who's getting what scores, who's getting points, where you're going, where other people are dropping. I can see the scores. I just finished calculating the top 10. It is a very competitive finish, ladies and gentlemen. I finished calculating the top 10. We're moving into number 14 now. Let's see, any other ties? Oh, that was a tie, actually. Hold on. That's number 13. Who else? Any other ties? Number 14. Yep, we got a three-way tie for 15th. All right, so that should be pretty easy to get done. All right, and then the position of honor, 16th. All right, here we go, little towels. The score reveal. Ready your towels. Here we go. Scores, please. Thank you very much. Here we go. Ladies and gentlemen, scores for the final round of Towel Trivia are as such. In first place, he has taken the crown from Steph by only 1 point. It was absolutely incredible. Also, yes, your English is fantastic, Holistic Psychology, and you're going to get better every day. I mean, you're already speaking and typing excellent English with us. If you do it even more, you're going to get even better. Your syntax is refined. You are an erudite future queen of the Kingdom of Bavaria, which we will establish for the first time. I have plans. You are involved. Anyway, so ladies and gentlemen, here are the scores. All right? Here they are, ladies and gentlemen, the scores for the first time. Here we go. Here we go, ladies and gentlemen. The scores for the first time. Excuse me. The scores, here we go. Towel in first place, 34 points. 34 points. He's a little towel. Barely took the crown. You know why? She wasn't even here all day, and I somehow managed to hold her off. There you go. It was Steph Towel, the Canadian hero. She's on the Canadian Mount Rushmore with Vicky Towel, with Winnie the Pooh, and with Bret Hart. The 4 Canadian legends, ladies and gentlemen, with a tribute to Owen Hart at the base. Steph Towel, 33 points, second place. Third place, ladies and gentlemen, and I'm going to bring up Pete Bunny Towel with me for this. Third place, Jill Towel. Excellent job, Jill. Another podium position, Jill. Absolutely, congratulations. Third place finish, 29 points. You ran into the ferocious force that was Steph Towel. You found out why the Canadians are such a strong contingent on Towel Trivia. There you go, Jill Towel. Excellent job. Well earned. Third position, 29 points. Pete Towel is just banging his head off the microphone. He's very excited for you. Oh, goodness. All right, don't give yourself whiplash. You're just very excited because she's doing so well. Well, Steph and Jill inspire Pete Bunny Towel, and he'd also like to say he hates the communists. You're just shouting him out, Taterbug. He's just sending a message to Taterbug, and that's how you get Taterbug to appear. You just start saying, I hate the commies, and then Taterbug. Listen, if anyone ever wants Taterbug to appear, just start saying things like, I hate the damn commies, and then Taterbug will appear. Oh, Sunken Grave, send a hot dog donation. I will absolutely get a hot dog. I will absolutely do so. Get a hot dog, my friend. And God bless you and all soap dispensers. You all do an incredible service for Towel and humankind. May there you go, ladies and gentlemen. Sunken Grave, the greatest soap dispenser on any side of any continent. God bless Sunken Grave. And God bless Ed. All right, Pete Bunny Towel. You're very grateful. Well, you can't eat hot dogs. You are a Pete Bunny Towel. You eat lettuce. All right. He's not eating any of my hot dog. I will not allow it. I'm pretty sure that will cause you some type of issue. You are literally a Pete Bunny Towel. He begrudgingly agrees, but he still likes hot dogs. All right. Ladies and gentlemen. Oh, Sunken Grave. I am so grateful. You don't worry about it, my friend. Ladies and gentlemen, take a look at that. Towel is in first place. Steph Towel in second place. Jill Towel in third place. There's the podium. First, second, and third. 34, 33, 29. In fourth place. Right outside the podium. He's hippity. He's hoppity. He's courting Toffee Towel. He loves Rue Towel. And he supports Allie Towel's quest for world domination. Pete Bunny Towel would like to say Allie and Rue Towel are in fourth place, 27.5. That's not average. That's a damn good performance. I understand. I know. Pete Bunny Towel says that even those who are the best sometimes don't finish first. They just have to know that in their heart of hearts, they are super towels. So that's his message to Allie Rue and Toffee Towel. And he thinks Toffee Towel has excellent analytical reasoning skills and he wants to marry her. That's a little forward. Well, he said that's what we need to restabilize the world. We just need to marry people. She's a bunny. He thinks that Toffee Towel is actually a human in bunny form. I'm going to have to speak to him a little bit about this. We have a lot to discuss, my friend. All right. Anyway, so Allie Towel, 27.5 points. I'm going to have to restrain Pete Bunny Towel. He is going to attempt to marry Toffee Towel. I don't know what we're going to do about this. All right. Fifth place, ladies and gentlemen, the best German of all time. Literally one of our leading Germans. We may as well make her Prime Minister of Germany. Holistic Psychology, fifth place, 22 points. Now, Pete Bunny Towel is literally going to hurt himself because he wants me to translate something from German into English. All right, hold on. Everybody hold your horses. Pete Bunny Towel has a message that he wants to deliver in German to Holistic Psychology. All right, and this one, I am sure you're all going to enjoy this one. All right, Pete Bunny Towel. All right, give me a second. I need to bring up the... Do you think I am able to translate your German or your English into German? All right, hold on. So give me 1 second, Holistic Psychology. Pete Bunny Towel is gonna sit right here, and I'm going to go over here. All right, wait a second. I'm going to type this up, and then we're going to have Pete Bunny Towel read it. Hello? Okay, hold on. I can't actually say what I'm reading, because then it won't be Pete Bunny Towel delivering it. All right, but I'm doing it right now. I have far too much fun with this. What position? You came in fifth place. You placed fifth in towel today with a score of how many points do you have, Holistic Psychology? Let's see here. Hold on 1 second. Holistic Psychology has 22 points. This I will also, you have the honor of having tied with Nancy Towel. On behalf of all Pete Bunny Towels, best wishes. All right, so I have a message from Pete Bunny Towel to Holistic Psychology. It is going to be delivered in German. Yes, 20 people played today. That was a good round of towel trivia. Here is the message to Holistic Psychology for her fifth place finish. I'll read it in German first, then English. Take it away, Pete Bunny Towel.
Hallo holistische Psychologie. Mein Name ist Pete Bunny Towel. Ich möchte Ihnen mitteilen, dass Sie heute beim Handtuchquiz mit 22 Punkten den 5. Platz belegt haben. Das sollte Deutschland sehr stolz machen, und ich werde Sie für eine Auszeichnung vorschlagen. Außerdem haben Sie die Ehre, mit Nancy Towell gleich aufzuliegen. Im Namen aller Piep Bunny Towels wünsche ich Ihnen alles Gute für Ihre Zukunft.
All right, that was very good. Now, here's what it was in English.
Hello, Holistic Psychology. My name is Peep Bunny Towel. I think it is very important to let you know that you have placed 5th in Towel Trivia today with a score of 22 points. This should make the German nation very proud, and I will be submitting you for some kind of commendation. Also, you have the honor of having tied with Nancy Towell. On behalf of all Peep Bunny Towels, best wishes in your future endeavors.
Oh, goodness. Oh, Ruth, thank you so much for playing. And yes, LS, I absolutely enthrall myself. I promise you. I enthrall myself. Holistic psychology, I think he was just speaking like a politician. I think he wants you to come back tomorrow. Oh, goodness. I think he was just being a little bit overly formal. Oh, goodness. Let's see. Can I speak what was just said in German? All right. Hallo, Holistic Psychology. Mein Name ist Piep Bunny Towel. Ich möchte ein mitteilen, dass Sie heute beim Haddock Quiz Meet 22 Bootkin Day 5. I don't know how to say those in German. Platz belegt haben. Das soll Deutschland sehr stolz machen, und ich werde Sie für ein Auswahl I don't even know what that. I don't know how to pronounce something with that weird squiggly B. Aberdem haben Sie die mit Nancy Towell gleich zu liegen. Im Namen aller Peabody Towels. Vernusch und ein alles gut für alle Zukunft. That's my best. Oh, there is no doubt in my mind that a German person would be like, what the hell are you talking about? I don't think any of those, maybe like 3 of those words were actually right. Those were some very hard words to say in German. Listen, there's like beginner German where you're like, the cow goes moo. All right, I could probably do that. I don't know how to say I'm going to recommend you for a commendation to the German government. Oh, goodness. All right, with that said, Holistic Psychology, 5th place, 22 points, tied with Nancy Towell. Excellent job. 6th place, Elijah Towell, 19.5 points. Actually, we have a 2-way tie for 6th place. It's going to throw off all the rankings, but that's all right. 2-way tie for 6th place, ladies and gentlemen. It is Elijah Towell and Sunken Grave. Excellent job, Elijah Towell and Sunken Grave, coming in a tie for 6th. And you see me multitasking. See how I'm typing things and talking. And not just typing things, I'm rearranging an ordered list and talking. Sunken Grave and Elijah Towell, 6th place, 19.5 points each. Excellent job. LS, yes, that's true. When I was a baby, I apparently spoke a bunch of different languages. I get a little embarrassed when Towel Mom says those stories, but she did enjoy telling them. But yes, excellent job, Sunken Grave and Elijah Towell, 6th place, 19.5 points each. 7th place, they are bosses. They're from Texas. They're chicks. Their name is Bella, ladies and gentlemen. Excellent job, bossy Texas chicken Bella. 7th place, 13 points. Pete Bunny Towel's mad. I forgot about him. He wants to say hi to Bella. Hi, Bella. This is Pete Bunny Towel. He's a bunny towel. He wants to say hi, and he loves little kitty. Oh, you like Bella. Oh, he wants to court Toffee Towel, but he likes Bella Towel. Oh, that's very nice of you. Bella Towel is going to be very flattered. She had a sock on her head today. If I put a sock on your head, do you just go catatonic? You would bite me? Well, he said if I put a sock on his head, he would bite me, so I'm not going to do that. Anyway, excellent job, Bossy Texas Chicken Bella, 7th place, 13 points. In 8th place, right behind Bossy Texas Chicken Bella, Peggy Towel, 12.5 points. Excellent job, Peggy Towel. Peggy Towel. Pete Bunny Towel's literally just going to give himself a concussion. He is very excited that you made it in the top 10. He's basically yelling right now about how he thinks that we should bring back the British Path News Service so that he can yell about how the communists are taking over the world. I'm still a little bit, I hate the commies too. I don't think they're actually well, maybe they are actually. All right, anyway, so Pete Bunny Towel wants to work for the CIA and start up some kind of news service to yell about how the communists are taking over the world. Now that I think about it, maybe you shouldn't think too much about that. All right, excellent job, Peggy Towel, 8th place, 12.5 points. In 9th place, Vicky Towel. You have a great night, Jill. We had a great time playing with you, my dear friend. Definitely play with us again tomorrow. You are going to come in first place very soon. I know it. Excellent job, Jill Towel. Peggy Towel, 9th place, 12.5 points. In 8th place. In 9th place, Vicky Towel, right behind Peggy Towel. Vicky Towel is a Canadian hero. She is on the Canadian Mount Rushmore along with Steph Towel, Winnie the Pooh Towel, and Bret Hart, along with a plaque to Owen Hart. Vicky Towel, excellent job in the top 10, 10.5 points. Now, Pete Bunny Towel is getting a little excitable. I'm trying to prevent him from getting Pete Bunny whiplash, but he's getting really excited because you all did really well. Ruth Towel came in right behind Vicky Towel. Ruth Towel, closing out the top 10, came in at the end of the day. Excellent job, ladies and gentlemen. Ruth Towel closing out the top 10, 5.5 points. Excellent job, Ruth Towel, 5.5 points. Right outside the top 10, came in right at the end of the day, still did really well. 11th place, we got a two-way tie. Elizabeth and Paula Towel, 4.5 points each. Pete Bunny Towel congratulates you. He says you did excellent for only playing a few rounds. Congratulations, 11th place, Elizabeth Towel and Paula Towel. 12th place, the one, the only Jack D65, 4 points, but 9 billion bonus points for being a super towel. Yes, Jack D65, excellent job, my dear friend. 13th place, Colleen Henry, Buck Towel, the super towels of all super towels, guardians of the vulnerable and the Midwest. Elizabeth Lander popped in to say Tiggy Towel and I slept late, so they missed most of Towel Trivia. That's okay. We say hello to Tiggy Towel. I also say hello as Pete Bunny Towel to Buck Towel, the guardian of Colleen Henry in the Midwest. 13th place, 3.5 points. Hello, Tiggy Towel. I hope you're doing well. Are you running around in little circles because the man on the TV is talking to you? I think that's hilarious. Excellent job, Colleen Henry. In 14th place, ladies and gentlemen, we actually have a three-way tie in 14th place. Excellent job. Nunya Towel, Barbara Towel, Christina Towel, 1.5 points each. Excellent job. 14th place. 15th place, the position of honor, ladies and gentlemen. Butterfly Towel. Butterflies are free. 0.5 point, the position of honor. Now, there's one way we're going to end this day. I love ending the day with the Towel Trivia theme song. So let's grab that. All right, ladies and gentlemen, let's take a listen to it. Then let's do our outro. Then I'll see you bright and early for the start of the Donna Adelson trial tomorrow. And remember, lots of ways to donate to Little Towel directly. There's a Venmo, there's a PayPal, there's a Cash App. If you want to help me get through the next day, that's great. I should be okay come tomorrow. Towel Trivia theme song. Excellent job to everyone who played today. Congratulations. All right, we got a number of people. Let's listen. This is one of my favorite songs. Pete Bunny Towel loves the song. Everybody loves the song. Let's play the song. Take it away.
Welcome to Grant's Towel Trivia. All you knowledge junkies, go grab your wrench and your towel. More fun than a barrel of monkeys. He's got lots of questions, so we'll be here a while. All of us contribute in our own special way, and it doesn't matter who wins at the end of the day. We're the top community, and we won't stop. Steph is at the top, she never does flop. Ollie, Ruth, and Nancy are sprinting towards the finish line. Kitty's 1993 is not too far behind. Tater, Bug, and Dewdrops are smart and so kind. For one family, we're family. Ruth and Captain know their stuff. Jeff's waiting on the clue. Claudia's got the answers, but Bunny does too. Lydia's sharp as a tack. Deb Potter's on the ball. Sometimes we grumble when our scores get called. Now Harvard Yard keeps guessing answers that ain't up on the board. Don't ask me how, but she just scored. Bossy Texas Chick and Bell are in last place again. They're always at the bottom, but one day they will win. Ooh, that's alright. That's an Adlesen. Every day's a new adventure in Towel Trivia Town. KR's not guilty, but that won't get us down. From the brightest to the struggling, we all play along in this corner of the internet where we all belong. So here's to all the players and the hosts so fine in this little slice of heaven where we all do shine. Town Trivia time. Town Trivia. Welcome to the Grant Smith Ellis Show. When you know you know. Ooh, ooh, ooh. Towel Pride.
Gotta love it. Gotta love it, little towels. That's the way to whip it up. Whip it up, whip it up. That's the way to whip it up. All right, little towels. Thank you so much for playing today. Thank you so much for being with me. My name is Grant Smith Ellis, and for the last time today, I will see you bright and early tomorrow for more Donna Adelson coverage, although I do have a doctor's appointment, so I will be playing some kind of coverage of prior testimony, probably George's closing or something like that from the Charlie trial for at least an hour because I have to go to the doctor's tomorrow morning. So my name's Grant Smith Ellis, and for the last time today, if you benefited from this stream today, this is a public information service. It's user-supported. It's literally only funded by you. There are no sponsors. There are no ads. I've had lots of offers to do that stuff. I'm not doing it. I want to be a user-supported public information service. Very few times during the month will I say to you, if you want to make a direct donation, I need it. This is one of those times just until tomorrow. Why? That's just how the distributions work for the various things that keep me alive. So if you want to help me until tomorrow, there's a Venmo up on the screen. You can find a Cash App. There's a PayPal link as well. There are ways to support this public information service, which is designed to educate, inform, and entertain the public. We've been going for almost 11 hours today. We'll do it again tomorrow, again the next day, again Monday, again. We'll do watch along on Saturday. I'll keep doing it. Just try to keep me alive. It means a lot to me. If you can't donate, that's absolutely okay. Your support, your chat, your likes, your subscriptions, sharing the channel, telling people about it, playing trivia, that all helps the channel. God bless you for it. I believe that if we use that mechanism of entertainment as a hook to educate and inform the wider public, we can engender cogent public discourse and ward off the usurpation of our representative forms of government worldwide. Now, I added a Venmo thing. It took me forever. Me and Towel Editor had to figure it out. I added this Venmo thing to the screen because someone said the other day, can I just scan your screen? And I said, yes, now you can do that. I'm trying to add the Cash App one. I don't really know how to do it. I'll figure it out by tomorrow. You can also find the links in the description, and I will drop them one more time. Remember, no ads other than what YouTube does. This is a public information service. The Cash App is # Grant Smith Ellis. Oh, God bless you, Bossy Texas Chicken Bella. Thank you so much for your support. All donations, of course, support this public information service. And you can make direct donations through YouTube. You can also make direct donations to Towel via the links in the chat. And remember, it's kind of like PBS. Without viewers like you, this content would not exist. I wouldn't be able to keep producing it. Just the server cost alone, the streaming cost, the space, the hard drive space, all of it would put me under. I literally barely, under anyway. All right? But we're going to make it till next summer when hopefully I'll be okay. All right? So Little Towels, God bless each and every one of you. I'll keep committing myself to these principles of educating, informing, and entertaining the wider public. You keep showing up in any way you can help, whether it's participation, advocacy for the most vulnerable, learning about cases, any way you want to become informed. That's what really makes me happy. All right, I got to live, but more so than anything else, if you're informed, if you can protect your democracy or your representative form of government, wherever it is, then I am living up to my towel eudaimonia, or my towel summum bonum, ladies and gentlemen, which is my greatest good in the ancient Greek or the Latin, respectively, and in that regard, I will be thrilled. So thanks very much. This is Towel. Now I want to say hello to Holistic Psychology, Bossy Texas Chick, Tanya Vincent, God bless you, my friend, Nancy from the 508, Second Beach Gal. It was great that I got to see you. Hello, my dear friend. We'll be live for coverage of the Adelson case starting tomorrow. It was great to see Deaf Otter pop in yesterday. God bless you, my friend. I saw you in the chat scroll back when I was doing my soliloquy. Thanks to Towel Mom for doing the interview today. If you missed it, it was a 4-hour interview. I'll try to get it clipped and uploaded by tomorrow. It's going to take me some time though, because it's 4 hours. Great interview. Peggy Towel, thank you for playing. Vicky Towel, thank you for all the updates today about the Adelson case. You know you were one of the resident experts. So many experts here on the Adelson case. We'll be ready to start coverage tomorrow. I love the peep dancing. It did go very fast. Holistic Psychology, good sign. It was nice. I enjoyed it. You're a dear friend. God bless you, my friend. Steph Towel, Super Towel, great to see you. Julie from the Canadian contingent. It was great to hang with you, Steph. Julie, craziest person on earth. So glad I got to see you at the end of the day, my dear friend. Thank you for watching that interview with Towel Mom. I agree. Very interesting to think about a witness, Miranda. Elizabeth Lander and Tiggy, it was great to see you. God bless you, my friends. Jill Young Smith, great to see you as well. LS, I saw you pop up there at one point. Thank you for chatting with us. Allie and Bro, it was great to hang with you. Ruth Lang, thank you so much. Sunken Grave, you are not dumb. You are the most intelligent soap dispenser of all time, and you're learning just like we do every single day. Thank you so much again for your support, my dear friend. God bless you. I love hanging out with you, Sun Grave. Your humor, your insights, your support of Ed, all of which combine to make you wonderful. Nancy from the 508, thank you so much for playing with us today, my friend, as well as Ruth Lang, Elizabeth Lander. I mentioned both of you. Thank you so much for playing. Bossy, Texas Chicken, Bella, we had a really fun day. Thanks for being here, my dear friends. Elijah Towel, you did really well during trivia. God bless you, my dear friend. Who else was popping up? See, my chat scroll back goes and goes. Oh, Lindsay was here during the Towel Mom interview. Thank you so much to Lindsay for popping by. We all support Lindsay. You can donate to Lindsay Gattani's fundraiser. That link is right up in the pinned comment. Thank you to Bossy Texas Chick, Sunken Grave, Jack D65. God bless all of you. And then thank you again to Sunken Grave for all of your support all day. Each one of you means so much to Little Towel, and I appreciate you. You know what I am going to say, though? If you learned something today, if you benefited from this stream, if you found some camaraderie, community here, ladies and gentlemen, you know exactly what I'm going to say. There's a way you can pay it forward. As Holistic Psychology is saying, you and your mom are so passionate in your mission or profession. Love that so much. I enjoy your passion as well. Holistic Psychology means so much to me. Thanks for your wonderful support and compassion. But you know what I'm going to say, folks. If you benefited from this stream today, if you really learned something, if you found camaraderie, community here, you know how you can really pay it forward. Look for reasons to do small acts of service. Yes, you can look for a reason to donate to homeless veterans, ladies and gentlemen. At least in the United States, if there's one homeless veteran, homeless against their will, we have failed as a society. They want to go live in the woods, that's fine. But one homeless veteran, homeless against their will, we have failed as a society. You can donate to help them. You can donate to animal shelters run by veterans. People like animals. people like veterans, help them both. You could donate to animal shelters in general. That would be wonderful. If you're in the UK, you could donate to the Big Issue, which is a way to help populations experiencing homelessness there. You could also smile at a person on the street. You could reach out to a friend or family member you haven't heard from in a while. You could even donate 200 tomato plants like Francis Fruchel did one time and have them designated honorary towels forevermore during the outro. Yes, ladies and gentlemen, I believe that it's possible in that way for us to change the current realpolitik from one centered on expanding, preserving, and demonstrating our power to one centered on preserving, expanding, and demonstrating our capacity to engage in unconditional love and small acts of service for each other. And in that way, may those unconditional principles rooted in love and compassion ripple outwards and bring about a new digital epoch defined by Aquarius the water bearer standing tall and carrying a towel, proclaiming unconditional love and toleration and compassion as the new central ethos of that epoch. I believe it's possible because of you all, ladies and gentlemen, and may we all find our towel eudaimonia, or summum bonum, the greatest good, in the ancient Greek or Latin, respectively, together. My name is Grant Smith Ellis. Thank you for being on this journey with me together. Thank you so much, Tanya. Towel Mom is a beautiful mind and a beautiful soul. I agree. Towel Friends on the X. We'll be back live together. We're starting trial tomorrow, the Adelson case, 3 weeks together. We got a lot going on. Towel will be with you. Looking forward to it. We'll be here. We'll be providing the coverage. I'll be with you. My name's Grant Smith Ellis. You know you got a few minutes at the beginning of the day, so I'm going to give the Towel Friends on the YouTube a few minutes at the end of the day. God bless you, Towel Friends on the X. Be well. Enjoy your night. Get some rest. Rest up. Adelson trial. Donna Adelson trial for the murder of Dan Markel begins tomorrow. Rest up. Justice for Dan Markel has arrived 4 times prior. Will this be the 5th time? And will Wendy Adelson ever face justice? Questions still remain. Be well. God bless you, friends. My name's Grant Smith Ellis. Until tomorrow on the Towel X, join us for Towel Trivia, youtube.com/@GrantSmithEllis, and be well. All right, Towel Friends on the Towel YouTube. Thank you so much. Holistic Psychology. I said I love that it's such a safe space and a loving place here to just be yourself. I can't be that nowhere actually but here. So thanks, Grant. Well, God bless you, Holistic Psychology. No matter what happens, anytime, you're always welcome here, my dear friend, and good night to you as well. Towel Friends on the YouTube, how wonderful a comment left by Holistic Psychology. That's what I sometimes think about at the end of these streams. With everything going on in the world, how nice it is to have a little space that we can all come together, the community, the bonds that formed here, the friendships you all take away from here. It doesn't all even have to center around me, which is very important to me, that it be more about the relationships you're building outside of here. So God bless you all. Thank you for your patience with me. Thank you for your patience with each other, your compassion, your toleration, your love that you express here. It matters. Thank you again to Towel Mom for the interview. Thanks for making this such a special place in a world that's kind of defined in some way by self-interest and greed. So, God bless you, Towel Friends. Sleep well. Towel loves you all very much. I'll put up the stream for the Adelson trial in just a few minutes here. And until then, be well, God bless, and thank you for being you, and thank you for being with us, and with me, and a friend to so many. My name's Grant Smith Ellis. God bless, and good night, Towel Friends. Until tomorrow.